audible now? Yes. Okay. So let us start the law marathon. So one thing, yes, till now I believe people who are watching this marathon, I'll be trying to cover almost all the topics. I won't be leaving anything. And second thing is that yes, people, if you guys have not learned, or if you guys have not gone through any particular topic, then directly listening to marathon, I'm not sure to what extent it is going to help, but I'll try my best to communicate or to make you guys understand whatever is there in your syllabus. Yes. Okay. So let us start with your marathon. Now first thing, let us just see what is happening around your ICAI syllabus. So they have introduced something called as what is it? 3 attempts in a year. Something which is very good, very good. You can see a lot of traction that can happen because of this move. Because you can just imagine people who were just writing 2 years, 2 attempts in 1 year. Now you get to write 3 attempts, so you can decide everything in 1 year, whether it is going to work or not. Earlier it used to take really, it used to consume a lot of time of yours. Now in that way, yes, it is more or less, it's a very good move for you that is happening around. So make the best use of it. If something goes wrong here and there also, always be assured it's fine, because you have attempts to try it out. If something goes wrong here and there, that is still fine. Yes. So do not decide everything with just one attempt. So that's one thing which I just wanted to say. Okay, next thing there. So coming back to your syllabus. In the previous syllabus, old syllabus, we had done a marathon. The marathon, the law part was only for 60 marks. So now congratulations, it has been now made 100 marks. I know you guys are all loving law. So, so we'll be having 100 marks. Always remember people, law, it might be a little challenging to score. Our whatever the marathon agenda will be, I'll be trying to cover the entire syllabus. The next thing, the last part will be to look into the question papers as well. The main 2 important things you guys will have to focus on is, one is called RTP, one is called as MTP. I'm not sure how many of you have already done it, but yes, that also will be covering it in the marathon only towards the end. So this will be the agenda, people. One is your entire 100 marks and your MTPs as well as RTP. Am I clear, all of you? Wonderful. So and when we are writing also, when we are going through the syllabus, I'll be telling you what are the common points where people are doing mistakes. The second thing is that in law, if you're losing marks, that means you're going wrong in interpretation. That's the biggest place where people will lose marks. And the third part is you will fall short of time. So completing law paper within 3 hours will be challenging. So one thing what I tell you, before you guys take up the final exam, just take up a random paper, whatever paper you guys can find on ICAI question paper only. You just take up one paper, give a full attempt. Have a clock next to you, have a stopwatch, strictly take a paper, start writing it without having a book. Don't take a break. Just imagine that's your exam. Try to write the entire paper and see within how much time you are able to write it down. You will get a fair idea what is the actual time that may be consumed to answer a 3 hours paper. It will never be 3 hours. It can, when you are writing it in your home, if you are working this assignment out, the time you might take will be around 4 hours. That is the rough you will get. You will get around 4 hours. Yeah. So one thing what I am telling you is you will fall short of time. When you are approaching law paper, remember your target should be to write 100 marks. Why I am saying 100 marks is, when we target for 100 people, you will approach 95, 90, but yes, your target has to be to approach 100 marks. Never think, people, that why I am telling you is you would have just been done with your BCom, you'll be doing your BCom, or you'd just be done with your PU or your inter, whatever you say. Now you guys will be thinking, or you'll be with an assumption that if I write 80, I'll get 45, I'll get 50. I would have written 80 only. No, can't I get at least 40, 50% out of it, 60% out of it? In CA syllabus, it doesn't work. Even if you write 100 also, there may be chances of you getting 40 only. That is also there. Because always have this in mind, the number of papers you write is nothing to do with the marks you are going to get, 100%. So what is that one thing you need to improve on? The first one is quality of your writing. The second thing is try to write everything, because you can imagine this way, when you only write 80, whatever score you are getting is not on 100, you are only getting it down to 80 now. Now if you get 40, it is 40 on 80 because you did not answer the rest of the 20 marks. So straight away the 20 is gone in the exam hall only. And the most important thing, remember, whenever the paper is difficult, that is when you guys have to spend more time in the exam hall. You will be seeing the students walk out of the exam hall there only. You should feel happy for it. The reason is your competition is reducing in the class only. So you can imagine this way, right in front of your eyes people are walking out. You have high chances if you can sit for 3 hours. Just write whatever you guys have learned for all these days. Just write that. So the chances of you scoring marks will be high there. Is this clear, all of you? Yes. So keep these things in mind, and whatever I can add on whenever the entire syllabus is going through, I'll try to add on those points. But yes, so keep these basic points in mind. Somewhere in between I'll also tell you some extra things that you guys can do when you're writing the answers also, so that you can get that 1 or 2 marks extra. Is this clear, all of you? Yes. And the next thing, sir, yes, one more thing I want to say. Now people will be asking me, sir, should we remember sections? Sir, should we remember case laws? Are these things important? Now I'll tell you one thing, people. Case laws, very, very important. If at all a similar scenario is given to you in your exam, in any question, you are expected to write the name of the case law. It is important. So what you guys can do, you have to shortlist everything, try to have all the case laws in one place, keep revising it every day for 10 minutes before you take up any subject. Just revise it for 10 minutes, because case laws are important. Now coming back to your sections. Sir, are sections important? I don't know if you guys know it or not. Whenever you see for any question paper, you find something called as guideline answers. If you see ICA website, you will get your guideline answers. What is guideline answers? Based on your past papers, ICA would have told you how to write the answer. That is only called as guideline answer. If you check the guideline answers, people, you will clearly find that the guideline answers will have sections written in it. Every answer will have a section. So ICAI is expecting you to write the sections for all the answers. Correct? But for your level, even if you don't write it is fine. But still, if at all there are some 20-25 questions that is asked, try to write the sections at least for some 10 questions at least. So these things, try to have it in your mind. And the last one more thing I want to tell you, the first question that you guys take it up should be the most confident question you guys know in the entire paper. In the first question, you should not beat around the bush. Meaning you should be knowing some sensible, valid law points in the answer. The keywords, whatever we call. Now what do you mean by voidable contract? Yes, Preetham. Preetham elvena? Chandan. Matte change madkondena? What is voidable contract? At the option of the one party. Option of the one party is the keyword. It has to be there in your answer. I'll tell you what is the biggest mistake CA foundation law students will do. You guys will not write the answer. You guys will write examples. There is lot of difference. What you guys would have been thinking now, voidable contract means what? A contract which can be void or valid. That is what is the interpretation. That is not what the legal language says. You are expected to write the legal language. You will lose marks here. And do not write the answer in the example point of view. Do not write the examples. The provision is important. Examples come secondary. Are these things making sense, all of you? So try to avoid these mistakes. You will definitely find difference in your law answers. Is this clear, all of you? Online now. Bakana? Yes, sir. Done. So keep these things in mind. So with that, let us start your okay, we'll start Lana. Okay, now coming back, people, again I'm telling you, because of the new syllabus being implemented, I'll tell you where you can expect some unexpected questions. Obviously, there are certain new chapters that are introduced. Now, what is that new chapter, sir? Indian Contract Act was there, people. Okay, let's start with the first one only. Indian Regulatory Framework. My guess, you will find at least one question here for 4 to 5 marks. It will be there, pakka. One question you can definitely find. That is your first chapter only, you can definitely find it. When we are doing also, I'll tell you what are the important topics, you can find that. The next one, what are the new chapters added? Again, in Indian Contract Act 789 are the new topics added. You can find questions coming from here. When compared to these 6 topics, you may find some more questions coming from this part. The reason is these are added new. But when I say new, it's not like new. They have taken this syllabus from CA Inter only. So you can get past papers. Agreed? Okay. Next one, sir. The next one they have added is people, negotiable instruments. You can at least find 2 questions here. In negotiable instruments. This is pakka. It will be there. It is clear, all of you? Yeah. So with this mindset, try to go. So these questions are important and these topics are important when compared to all other topics. So pay a little more attention here. If I am not wrong, everything combined together, the first chapter and Indian Contract Act 3 units and negotiable instruments, you will at least find at least 20 marks coming from only these topics. You will definitely find around 20 marks coming from these topics. You will find it. So pay more attention when you guys are reading this particular topics. Clear, all of you? Yes. Okay, done. So with this, let us start. Okay. Before I start, do you guys have any doubt specifically in any topic which you want me to cover more? Any such thing? Negotiable Instruments Act. Okay. Kamran, what's up da? Full studies da? No studies da? Prepared da Kamran? Little prepared. Done with all your exams and all, college exams. First sem is over. So now your exams are over now. Completely CA foundation and all. You don't have any exams clash and all. Okay. Nindo Chandan? Only CA. Correct. Martho. Okay. Okay. Indemnity and guarantee. Okay, we'll do that. That's all. Okay, we'll start with so the first thing, let us start with Indian Contract Act only. Let us keep it simple. Towards the end, I'll also take up your the regulatory framework also. I'll be telling you more points there. The first topic, let it not be a little more detailed one. Let us have a simple one. Okay, let us start with the Indian Contract Act. The first unit, people, nature of contract. For the people who will be watching it as a recorded version, specifically when this video will be uploaded on YouTube, please don't ask for this summary charts, whatever revision notes you guys are seeing. It will not be available as a soft copy because of intellectual property rights issue. In the past, we were sharing the soft copies, but we saw a certain people taking the materials and teaching from it directly, which I feel as ethical grounds, these are not right. So we stopped sharing the soft copies. Plus so because of that, it's a humble request. Please don't ask for the notes specifically on YouTube. This is for you guys. Yes, people. But yes, if that's not the case, when you guys are watching it, no matter where you guys have studied, the content remains the same only. So it will be helpful. Just sit and relax for the next whatever the time. You guys will be revising the entire topic which you guys have gone through. Clear? Okay, done. So let's start the first unit, Indian Contract Act. In that, the first unit is nature of contract. So before we start with nature of contract, we need to know there are certain terms. The certain terms are called as offer, and the next term is called as acceptance, and the next term is called as agreement, and the next term is called as contract. Sir, can we connect all these four words in any way? First of all, what do you mean by offer? What do you mean by acceptance? What is offer? Bhagwan. Offer. First word a bouncer. Amele will start Indian Contract Act. What is offer? It's a proposal made to a person. Macha, what's up? How are you? Okay. So when we are seeing the rules of offer, I'll be taking in detail. But yes, but on the face of it, can I say it's a proposal? Yes, it's a proposal. So when one person proposes something to another person for getting his acceptance, I'm giving him a choice, free choice. It should never be one way, correct? So sir, whenever I'm giving a free choice to the other person whether to accept it or not, so what I have made is called as an offer. And when the other person signifies his acceptance, that is called as what people? Acceptance. Whenever offer meets acceptance, it becomes what people? Agreement. So whenever an agreement which is enforceable by law becomes a contract. Now most of you will have a question here. What do you mean by enforceable by law? What is enforceable by law? Enforceable by law means whenever you guys have entered into a contract, if at all the other parties does not perform, now can I do anything in this regard? Imagine I'll tell you guys that I want to sell this pen for you for say for example 1000 rupees. I have made a contract with you. You have accepted for this particular offer also. Now after entering into this agreement, if I do not keep up my promise, now can you do anything against me? Can you do it? The answer is yes. If at all you can now go to the court, court will help you to win your case because you have a valid grounds. The court will say, Sai, you have to hand over the pen to the other person. Now this is called as enforceable by law. The court will come to your rescue to help getting back the product. Agreed? Sir, but certain contracts are not enforceable by law. What are those contracts? Certain agreements are not enforceable by law. Sir, there are two agreements, sir. I can call it as social or I can call it as domestic agreements. Social agreements and domestic agreements are not enforceable by law. Why? Social and domestic agreements, they are... Why? What are social and domestic agreements? There is no intention of creating a legal relationship. What is this, the legal relationship and all? What is legal relationship?
When you make the proposal or accept, you have to have the intention of suing them if they do not do that thing.
So when you are entering into a contract, you need to have an intention. Macha, if at all you don't perform the contract, I am going to take you to the court. So we assume that in a domestic contract, what is domestic contracts? A contract between friends, a contract between the family. You will be promising 100 things, but you don't have an intention of performing all the 100 things. You will also promise your parents, Papa, dekho is bar sir 100. You do not have intention of performing it. Simply for their happiness, you'll promise. Can they hold you liable? Can they go to the court and file a case on you? The answer is no. These are called as social or domestic agreements. Agreed? Yes, okay. Now, sir, contract. So, what is a contract, sir? An agreement which is enforceable by law is a contract. Now, sir, if a contract has to be enforceable, then there are certain essential elements that has to be satisfied. Now, what are these essential elements, sir? The essential elements, people, are given under which section now? Section 10 of Indian Contract Act. So, there are two types of essential elements that is given. One is given under section 10. One is not given under section 10. Agreed? Sir, first of all, what is not given under section 10? If something has to become a valid contract, there are some essential elements you need to satisfy. Now, what is that? I can classify it as given under section 10, not given under section 10. Now, what are the conditions which are not given under section 10? So these are the conditions which are not given under section 10. What is that? First of all, there has to be two parties. Obviously, Nityananda, me talking to me, like that you cannot make a contract. There has to be two parties involved. The two parties can be natural person as well as artificial person also. What is artificial person? Da? Bulbulaya? Manjulika? No? So two parties can be companies, firm, even they can also enter into a contract. Next one, intention to create legal obligation. What is this intention to create legal obligation? Which case law you will write? Balfour versus Balfour. What happened in Balfour versus Balfour?
The wife will ask for
So there was husband and wife. They went to a particular place in England. So wife was not feeling well. The wife was told to take some medical treatment. Husband had to travel back to Sri Lanka, and husband promised wife that you do not worry, Chinna, I will give you every month some money order to take care of your medical expenses. He went back also. 2 months he sent the medical expenses as promised, but the third month onwards he stopped sending those expenses. Now Balfour called him and asked, you did not send me the money whatever you promised me to send, can you please send it? He failed. He said, I'm not going to send the money going forward. Wife filed a case on the husband to recover that money. The case was filed in the court. Now the question is this case sustainable? Can a wife file a case against the husband in this scenario? The answer is no, because when the husband promised the wife that I'm going to send you money every month, these two people did not have a intention to create any legal relationship. Imagine, when they promised each other, they never had a thought, if you do not fulfill the contract, I'm going to take you to the court. We never had it in our mind. Now for example, I will also promise, this summer I'll take you for a holiday. If I do not take my wife for a holiday, she cannot file a case on me. Because we do not have the intention when we agree that okay, if you do not perform, I'll take you to the court. We do not have those intentions. Now because of that, you cannot call this as a valid contract. But remember, you can link this. Most of you will have a doubt here. You can connect this topic to one more topic. What is that? Every contract should have consideration. But are there exceptions? Whenever I say that every contract should have consideration, that only we can call it as quid pro quo. Give and take has to be there, but there are certain contracts where there is an exception. Even when there is no consideration, the contract will be valid. The first one, what is that? Any contract which is entered with a natural love and affection, provided there are certain conditions that you need to satisfy. What are those conditions? It has to be between near parties, near relation. You can't say, sir, that my Dilka Dhadkan, that and all not happen. It has to be father, mother, wife, siblings. That is what is called as near relation. Next one, it has to be written. Third one, it has to be registered. Now you look at it. If at all they are asking a scenario between husband and wife, if all these three conditions are there, then connect it to not this point. You have to connect it to consideration, exception to a contract without consideration, natural love and affection. Write down these 3 points, it will be valid. Understood? Pakka na? Okay, third one, sir. Other formalities to be complied. Meaning, sir, imagine if at all I am buying an insurance policy. According to the insurance contracts people, it has to be written today's date. Who says? Indian contract says oral or writing. Correct? Oral agreements are valid. Oral agreements. Oral contracts are valid. Revision only. Yes, you have to say. Yes, so oral agreements are valid, people, provided according to Indian contract it is valid. But there is one more act which says there is something called as IRDA. IRDA. Which IRDA? Insurance Regulatory Development Authority of India says all the insurance contracts has to be in written. Tomorrow if at all some accident happens, if you claim the money, that time you will say no, this was not covered. Where will you go? To avoid confusion, everything has to be written. So if other acts are saying something, you guys have to comply with that also. That's the meaning of it. Okay. Next one, it has to be certain. Meaning, sir, sell me 100 liters of oil. Which oil? Now can I call this as a valid contract? Give me 10 kgs of rice. Which rice? So whenever a contract is not specific, it is vague, it cannot give you a valid contract. Next one, possible to perform. Jump from 5th floor, land safely, no parachute, no umbrella. You should not tie anything to your knee, but you should land safely. I'll give you 1 lakh. You land safely. Illa sir, not possible to perform. Black magic. Kamda will pass CA. How? Early morning 4 o'clock, come with 2 lemon, 5 chilies and 2 neem sticks. Every hitting I give you will give you 1 mark. Ooh, so is it possible to perform? The answer is no. So in such cases, people, this is not valid contract. Quickly revise. Yes, tell me, what and all are the conditions, essential conditions not given under section 10? Two parties.
Legal
Intention to create legal obligation.
other
Other formalities to be completed given under different acts. Possible to perform. It has to be certain and not vague. Now the question is, you guys will have this question also. Sir, if the question is for 4 marks, if they are asking us essential elements, how much are we expected to write? Correct? If you look at your institute guideline answers, you are expected to write everything. Now you know that it is going for a very lengthy discussion. So try to minimize the content under that. Meaning headings write down. For example, the contract has to be certain. Write down a very brief description of 1 line or 2 line. What does it mean? Instead of writing 3-4 lines. Getting the point. And remember people, Indian Contract Act, Sale of Goods Act, Partnership Act, Negotiable Instrument Act. All 4. If at all they are asking any question, write an example. Your answers should have an example. Is this clear all of you? Pakka? Okay. Next one. Sir, essential elements which is given under section 10. Now what is it, sir? First one, there has to be an offer, there has to be an acceptance. Indirectly they are telling you, if at all there has to be a contract, first thing there has to be an agreement. Agreed? Okay. Next one, free consent. What is free consent? Consensus ad item, and also your no one should have forced you to enter into a contract. We'll see in 3rd unit in detail. Capacity of parties, again we'll see in 3rd unit in detail. Consideration, 2nd unit. Lawful consideration object, 3rd unit. Not expressly declared void, 3rd unit. But these are the topics overall. But these are important. Correct? Yes, sir. So what are that which is given under section 10, people? First one, agreement. Second one, free consent. Third one, consideration. Lawful object, lawful consideration. 4th one, capacity of parties. Can I say that your major, all those things will come there? 5th one, not expressly declared void. Agreed? And lawful object and lawful consideration. Yes, all of you? Okay, sir, done. Next one, people, types of contracts. Based on validity or enforceability, a contract can be classified into, first one, valid contract, meaning if everything is satisfied. If an agreement satisfied everything, it's called as valid contracts. Second one, void contracts. 2J says void contracts. What do you mean by void contracts? A contract which is initially valid, later on becomes, what is void contract? What is void contract? What is difference between void agreement and void contract? Is there a difference? Void agreement and void contract? Is there a difference? What is the difference?
First, initially the void contract is valid, but then later it's not invalid.
Okay. That is your void contract. Void agreement? It is not enforceable by law. Remember, from day one, if at all you have entered into an agreement which is not supported by the court of law, court won't help you in this regard. Now such agreements are called as void agreements. If I have to give you an example, minor agreements are not valid from day one. You are not supposed to enter into a contract with a minor. If you enter, what agreement you will call this as? This becomes a void agreement. Now second scenario, what is a void contract? I enter into a contract with a person for me to sing one song. Now let us take for this as an example. We enter into a contract with SP Balasubramaniam. Imagine someday we had entered. So let us imagine we are a movie producer. We have asked him to come and sing for us in a particular album. Now we have entered into a contract also. We have everything. Now SP Balasubramaniam sir was supposed to come and sing on a particular day, but because of the fortune, we lost him. Now because of death, what will happen to my contract? When we entered, it is valid, but later on, because of something, the same contract which was valid becomes invalid. Now this is called as void contract. Is clear? Pakana. Examples of void contract. In one attempt they had asked, what are the scenarios agreement will become a void contract? Can you tell me what are the different scenarios where it will become? Important topic. In what and all scenarios an agreement will become void contract? One is death, change in law. If at all today it is valid, Gujarat, till today it was liquor was valid. They said dry state. Law has changed. Then what will happen to all the licenses issued? All the rental agreements you would have entered, it will become void. And alien enemies, insolvent, everything is changing. Sir, all these are the examples. Next one is impossibility of performance, subsequent impossibility. Imagine I enter into a contract. For example, the last building only, there was one automobile, Nexa. Let us imagine, you know that, no, Nexa showroom is there. I had a card delivery that had to happen in a certain time. Imagine a cylinder blast happened. How will they deliver? Impossibility of performance. The contract will become void. Is clear all of you? Yes? Okay. So you guys saw now three things. What is that? One is called valid, one is called as void agreement, one is called as void contract. Now what do you mean by voidable contract? What is voidable contract? At the option of one party, a contract can be treated as valid or void. So at the option of one party, not at the option of both. Any one person has an option to treat it as valid or void. Such contracts become voidable contracts. Example, people, whenever the consent is not free. Imagine there was a coercion. What is coercion? You would have seen our movie style. Wherever a villain forces a hero to sign a contract. So you signed a contract with not your free will. Someone forced you. Now they took the papers. Now can you do anything there? Yes. You can go and tell the court what has happened. Court will help you. Court will summon the other party. Come to the court. Both of them will be put in the court. Hearing will be there. Whoever will win will win. If villain can prove, then the contract will become valid. If at all the hero can prove, no sir, he forced me to sign. Court will take the contract and they will tear the contract. Whatever was valid now becomes void. So a contract which will just, it will be balancing between valid and void. It can be this or this at the option of one party. Now do you have the guts to go to the court, or you fear that I don't know what is going to happen? If you sit in the home, the world will never know what happened between you and the villain. The contract will be valid. If you go to the court, court will take the action, sir. It will become void. Such contract is called as voidable. Agreed? Okay. Next one, people, is illegal contracts. They call it as illegal contract, but they cannot be illegal contract. It is always called illegal agreement. Correct? Illegal agreement means what, people? Something which you are entering into a contract to do a unlawful object. Example, terrorism can come under illegal. Next one, sir, unenforceable contract. Everything is valid, but there are some technical errors in the contract. Example, I enter into a contract with a person. Correct? Spelling correct? No. So is it you only? No. So everything is right, but spelling mistake is there. But technically, someone can come and say, but try to think, people, in this entire country of 150 crore population and still going on now as we speak, there won't be at least one person with this letter as, in his name, E as his spelling. At least one person won't be there. Now he will come and say, it's me, not him. So that's the reason, because of this, these contracts become unenforceable. Got the logic? So what is unenforceable contracts? There can be error in the date, error in the amounts, error in the names. Such contracts are called as unenforceable contracts. Clear? So based on validity, a contract can be classified into 5 types. Valid, void, voidable, illegal, unenforceable. Okay. Next one, based on formation. Express contract, whenever everything is agreed orally or in writing, is called as express contract. So basically this express means nothing but discussed. There is nothing you guys have kept it for understood. Everything is discussed. It's called as express contract. Implied, which is a contract which comes into place based upon the conduct of the parties. Now, if I ask you what is implied contract, you try to explain me. This is what is going to happen in the exam. You will try to write it as an example. What is implied contract? Conduct of the parties will not come at all. But you expect a mark to come there. This is what students go wrong. You will know all the questions in the law paper. Trust me, you will know everything. But where you will go wrong, you will answer it in the wrong way. Getting the point? Now, as a student, what you guys have to do, when you are writing the conduct of the parties, you will have to underline that. Is this clear? Pakana? Okay, done. Next one, sir, that is implied contract. In implied contract, there is one more contract also. What is that? You would have seen. Silent contract. It is also called as tacit contracts. Examples of implied contracts, people, it can be bus. Correct? Bus standing near the bus stop is called as an implied contract. No one will come and invite you to get inside the bus. What else? For example, a vending machine. Off late, you guys can get that Pepsi, Coca-Cola also. Where you put the money, you will get it. You guys are not speaking to anyone there. In the bus stands, you will have that weighing machines. All these are the examples of implied contracts. Your ATM machine is the example of tacit contract. You're speaking to someone with, when you're in ATM, this one, you don't speak with anyone. So these are all silent contracts. Correct? You're just following certain orders. Nothing is expressed, right? That is called as, again, tacit contracts. Clear? Okay. Next one is called as quasi-contracts. Again, we'll be discussing in the last part. Quasi-contracts, we have it in detail. E-contracts, a contract entered into a electronic form is called as electronic contracts. Best example is your Amazon, Myntra, all everyday contracts you guys do over emails, all this acceptance and all is happening over electronic form is called as e-contract. Next one is people based on performance. A contract can be executed contract. Executed means already performed. For example, your regular CA foundation contracts are executed, done. When we were doing in the class, I told you these are executory. It is still going on. Now your classes are done. It's an executed contract passed. Executory can be further classified into unilateral, bilateral. Unilateral, one party has still something to perform. Bilateral, both the parties have something to perform. Example of unilateral contract, imagine if I ordered something on Amazon and I paid online. I have performed my contract, but he is yet to deliver me the product. Executory, unilateral contract. Bilateral, cash on delivery. I should also pay, he should also deliver, but agreement is made, contract is made. Now that is an example of executory bilateral contract. Clear? Classification. Any doubts? Any doubts? No? Okay. Next one, offer. Okay. Let us look at the rules of offer. What are rules of offer? Okay. Offer, people. When one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of the other to such act or abstinence, he is said to make a proposal. Basically, I am making a proposal and I'm making this proposal to get a reply from you, and that reply is your choice. I cannot enforce it on you. If I enforce it on you, it becomes a command. It does not become an offer. And if at all you say yes or no, that is only called as an offer. They have given something called as act or abstinence. Abstain means what, people? To do or not to do something. What is not to do something? I give you money and I tell you not to do something. Now that is also called as an offer only. We had seen the examples also. A movie will be released. directly on OTT platform. Imagine generally if a movie has to be released on Amazon Prime, we pay 20 crores. But one movie, Amazon Prime will come and tell, you do not release this movie in theaters. I will pay you 100 crores. Now this is only called as people an offer which is made not to do something. I'm telling you, do not release it in the theaters. Clear? Okay. So what are the rules, people? Rules of offer. Okay. Essentials of a valid offer, it must be capable of creating legal relationship, which we saw. Example, Balfour versus Balfour. It must be certain, definite and not vague. Agreed? Third one, it must be communicated to the offeree. Example, case law. Lalman Shukla versus Gauri Datta. In this case, what happened? One small child went missing. The servant was asked to go and come in search of the child. Later the owner gave a paper advertisement also, whoever brings back my missing child, I will be giving you a reward of, say for example, 500 rupees. The servant found the missing child. The owner now said, thank you, but I am not going to pay. The servant went and asked, he denied making the payment. Servant went and filed a case on the owner and he asked, I want this money because you had promised, you had given an offer. In this case it was held, yes, there was an offer, but were you aware of that offer? That offer was never made to you at all. So if you are not aware of the offer, you cannot claim it. That's the reason they are telling the rule. The offer must be always communicated to the other party, that is offeree. Clear? Lalman Shukla versus Gauri Dutt, important. Online, no? It must be made with a view to obtaining the assent of the other party. Meaning it cannot be one way. Meaning I cannot say something and I cannot expect you to just perform. If at all I just tell it, if I just enforce it on you, I am not giving you a chance to say yes or no. In this way, they are telling you it is not a valid offer. You should have an option to say yes or no. Clear? Yes. It may be conditional. Meaning if you have to be eligible for the offer, I can impose certain conditions. Meaning free delivery. You will be eligible for free delivery if your cart value is at least 300 rupees. Until you make 300, you will not be available, you will not be able to avail this offer of 300. This is called as conditional offer because there is a condition attached. Okay. Next one, offer should not contain a term that non-compliance of which would amount to an acceptance. Meaning, I'll say in the offer, I'll write you a letter. If you do not reply to me within 5 days, I will assume it as an acceptance. Such things cannot be called as an offer. Silence cannot be called as an offer. I cannot say if you do not reply, then I will understand it as an offer acceptance. That cannot become a valid offer. Clear? Next one, sir. Offer is different from mere statement or intention. So this one we had seen. What is that, sir? Offer is different, people, and statement of intention is different. Statement of intention is different. Statement of announcement is different. And what else? Answer to a question. Answer to a question. And what else? Statement of price. Correct? Statement of price and invitation to an offer. Invitation to an offer. So most of you will find this as difficult. What they are telling you, sir, offer is different and all these things are different. The first one, statement of intention. If I just tell my intention, that is not equivalent to an offer is what they are telling you. Sir, next one they are telling you announcement. What is announcements, people? Now, government will give tenders in public platform. We are going to buy 10,000 kgs of worth raw material from the public this time. Now, just because I give an announcement, it cannot be taken as an offer. Example, I'll tell you, they can ask you exam-based question. A father announces that the next person, the next CEO of my company will be my son. This is an announcement. It is not an offer. Son won't get any right out of it. Are you getting the difference? What is announcement? Because I am not asking your opinion. It is what I think I am announcing. It cannot be considered as an offer. That's what they are trying to tell you. Clear? Third one, answer to a question. Case law? What is the case law? Harvey versus Facey. What happened in this case? So there was a case where I asked another person that there was a land. The land is called as Bumper Hall Pen. I'll ask are you interested to sell this case? That's the way we start, and I'll ask two questions. What is that? What is the least possible price? And second one,
Will you sell?
are you willing to sell it? The person will reply, the least possible price is 900 pounds. I will not reply yes or no. I'll just reply for the least possible price. In this case, it was held, just because you quote the price, you cannot consider it as an offer or an acceptance. Just because someone tells you the price, they are not telling you that they are interested to sell or interested to buy. So, just answer to a question or just you state a price cannot be understood as an offer or cannot be understood as an acceptance. Agreed? Yes, sir. Okay, last one is invitation to an offer is different to an offer. Example, people, invitation to an offer. What is invitation to an offer? Supermarkets, materials displayed in the showpiece, materials displayed, for example, the clothes displayed on a mannequin. So all these are what people, invitation to an offer. They are inviting you to make an offer. The best example I can give you is IPO. What is IPO? Initial public offer. In the newspaper, I will tell you, people, the IPO starts from, say for example, 1st of June to 4th of June. Offer, if you guys apply, I will give you shares. Now just because I gave a newspaper advertisement, now you applied, Chandan applied, but Chandan did not get the allotment because the shares were oversubscribed. Can he file a case on me? The answer is no. Why? What the company made is called an invitation. When Chandan applies, it's called an offer. Now the acceptance has to be given by the company. So try to understand the sequence. Company gives a newspaper advertisement. For you to apply for the IPO, they are giving an invitation. They are making an invitation. Now you guys have to apply for the IPO. Now you are making an offer. You will say, I want to buy your shares for 170. Will you agree? First of all, if the shares are there, he will give it to you. If the shares are oversubscribed, what will he do? He will have to reject a few. So acceptance will be given by the company. Understood, Usman? The same thing will happen even in the shop. If a material is kept in a place, imagine in a wherever, on a display, you go and give it to a cashier, you are making an offer. That means the display piece is an invitation. They are attracting you to come inside. You take it, you go to the cashier, you are making an offer. The cashier scans it, he is making an acceptance. So just because the goods are there on display, that doesn't mean he is under an obligation to sell, because it is not an offer, it is an invitation to an offer. Is clear? When they are asking you the difference between invitation and an offer, you have to write all this and also write examples. Is clear, all of you? Important from exam point of view. Invitation and an offer. Clear? Okay, done. Next one, sir. Okay. Next one is classification of offer. Yes. Offer can be classified into?
Public offer.
First one, express or implied offer. When the contract is express, it can be oral or written, it's called express. If everything is in conduct, it's called as implied offer. General offer, an offer made to the public at large. Anyone can accept it. It's called as general offer. Example, Carlyle versus Carbolic Smoke Ball Company. There was an ad. If at all you take the medicine, you will not be getting influenza. Correct? So after consuming the tablets also, the tablets name was Carbolic Smoke Balls. That's the name of the company as well as the tablets. After consuming also, Carlyle ended up getting influenza. She filed a case. The company said, we never accepted your offer at all. In this case, it was held, a general offer need not be accepted. You just performing the product, whatever they have written. If you just perform, that is only considered as an acceptance. You need not specifically accept the offer. Correct? Next one, specific offer. What is specific offer? An offer made to a specific group or a specific person, opposite to a general offer. Next one is cross offer. What is cross offer?
When two people give offers to each other and this identical.
is a exchange of an identical offers, ignorance of each other's offer. Meaning, I am telling I want to buy your car for 1 lakh. Before getting my offer, you are also making one offer. What is that? Can you buy my car for 1 lakh? Both are talking about the same car, same price. But can I take it as a valid contract? The answer is no, because it is two offers. There is no acceptance, because both of their questions are question marks only. Will you buy? Will you sell? There is no full stop. So it cannot be a contract. So remember, cross offer will never lead to a valid contract. The next one, people, counter offer. What is counter offer, sir?
When someone gives an offer and the other person gives another offer.
Another offer to it. Counter offer is nothing but, people, negotiation. Negotiation is called as counter offer. You will give me something, I will ask you more from it. Then your contract will come to an end. Meaning, let us imagine, I will say, law I will teach you for 5k. You will say, I will buy law, but I want to buy accounts also, both put together for 6k. Now this is called as negotiation. Now you accepted law, but you have your own conditions. Now my offer comes to an end. Understood? Pakka na? Okay. Last one is called as standing or continuing offer. What do you mean by standing or continuing offer? An offer which is open for a certain period of time. So for example, as your exam dates, it can be your prospectus, registrations, 10 days it will be open, right? This is called as what, people? Standing or continuing offer. Agreed? Okay. Next one is acceptance. Let us quickly see of acceptance. Rules regarding acceptance. Okay. Acceptance can be given only by the person to whom the offer is made. Agreed? A random person cannot give an acceptance. If it's all, it's a specific offer, then only you can only accept, another person cannot accept. Okay. We had seen Bolton versus Johns also, that shop example. I had sold my shop, a new person came, he sent the goods, I wanted to set it off with the previous debt I had given. Yeah. So he gave the goods, he asked for the money. He said, why did you send the goods? I had given it to the earlier owner. So he replied saying that I will not make the payment. Matter went to the court. In the court it was decided that when an offer is made to a specific person, when the name is written to Mr. or Miss, a particular name is written, the offer can be accepted only by that person. Another person cannot accept the offer. It is an opposite to the general offer. General offer can be accepted by anyone in the public. Specific offer can be accepted only by the person to whom the offer is made. Clear? Okay. Next one, sir. Acceptance must be absolute and unqualified. Meaning what? You can expect a question here. What do you mean by acceptance must be absolute and unqualified? What do you mean by that? Qualified means what? When you are accepting an offer, you have to accept it without any conditions. If you accept with conditions, it will become what? Counter offer. So sir, unqualified means you should not have any conditions of yours. If you have a condition of yours, it becomes a counter offer. So you have to accept the offer as it is. You should not add your own conditions to it, is what they are telling. Clear? Next one, nil versus merit. You remember case law? What is nil versus merit? Macha, I have a car. I will sell it for 5 lakh. Are you interested? B said, yes, I am interested. Take 2 lakh advance. Check he gave. He said 3 lakh I will give you in 2 EMIs. Is it a valid contract? Is it a valid contract? 5 lakh I agreed, no. 2 lakh, 3 lakh.
But that condition.
So this EMI, did I tell you, you have an option to give me in 2 months. Did I tell you that? No. So how can you assume it? Now you are making your own conditions. This is called negotiation. Now this is called qualified acceptance. This can also be called counter offer. Clear? Important from exam point of view. Remember. Next one, the acceptance must be communicated. Just the way offer must be communicated, acceptance also must be communicated. Brogden versus Metropolitan Railway Company. In this case, what happened? A manager approved one tender. But he kept it in his drawer. That was never posted to the other party. Who applied, we approved. But that was never posted. In this case, it was held. That means the acceptance was not communicated. So, contract never was in place at all. Simple? Yes? Okay. Next one. Acceptance must be in the prescribed mode. Meaning what, people? Whenever you get coupons in Google Pay and all, scratch cards you will get, right? In that you will get McDonald's. This coupon can be availed only on the website. Now can I go offline and can I show this coupon? No. So acceptance has to be given in the prescribed mode. If they say it has to be in writing, it has to be in writing. If they say it has to be through email, it has to be through email. That's the meaning of it. Yes. Next one, sir. Time. If I tell you a time period, it has to be accepted within the time period. Your registrations only. Within 6 days, within 6 days. Mere silence is not acceptance. What is this? Maunam Sammati Lakshanam. Our Samskrita and all does not hold good here. Sir, case law, Feldhaus versus Bindley. What happened? Uncle wrote one letter to his nephew. You have one horse, Noda. I want to buy that horse. The nephew also told the auctioneer. He was selling all away his assets to everyone. So he appointed one auctioneer also. He told, hey auctioneer, leave that horse to my uncle. He wants to buy it, it seems. You sell away all the other assets. The auctioneer people, when he was auctioning the entire product, he also sold off the horse as well. Uncle had written in the letter, if at all you do not reply, I will assume that you are accepting the offer. He did not reply, but he had communicated to his auctioneer. So when the uncle came, he got to know that the horse was sold. Uncle wanted to file a case on his nephew. In this case, it was decided because the acceptance was never made. It cannot be considered as valid contract. That's what in this case it was held. Clear? Okay. Next one. Acceptance by conduct or implied acceptance. Meaning what, people? Offer can be implied. Even acceptance can also be implied. So when a bus stands in front of you, that's an implied offer. Without asking anything, if you get into the bus, that's the implied acceptance. Together it's called implied contract. Clear? Yes, sir? Okay. Next one. Okay. Communication of offer and acceptance. When is the offer communicated? When is the acceptance communicated? Agreed? Okay. When does a communication... Okay. When does the offer come to an end? When does the acceptance come to an end? Can I revoke it? Can you revoke the offer or acceptance? Can you revoke it? What is the time? Within what time you have to revoke? Okay, first of all tell me, when can you revoke the offer?
Before the letter reaches the other person. Before the acceptance is given. Before he reads.
When can I revoke the offer?
Before it comes to the knowledge of the offer.
Before it comes to the knowledge of the offeree. So before that I can revoke the offer. When can I revoke the acceptance?
Before it reaches the...
Now your question should be, who is revoking the acceptance? Correct? Yes, now for example, if I have to revoke the offer, now first of all to understand this, that people, the first question I'll ask you is, when is the acceptance complete? When can I say acceptance is done? Now you tell me in the letter format. When is the acceptance done?
When the letter reaches the offerer, that like he reads it.
When the letter reaches the offerer, the acceptance is complete.
No, when he reads it, like the acceptance.
Okay, when I get the letter and I read it, the acceptance is complete. Correct? You would have seen acceptance, when will it be complete from two persons' point of view? Offerer point of view, offeree point of view. Now what did you say? When can I revoke the offer? Before the acceptance is communicated. Now tell me, when should the offerer revoke the offer? If at all he wants to revoke, by when should he revoke?
Before the offer.
Before the letter reaches the offerer, or before the offeree writes I accept and put it in post dabbana. Before the letter reaches the offerer, I can take back my offer. That's what you guys are saying. Sure, you guys are understanding what you are telling. A told B, I want to sell you my car for 5 lakhs. Are you interested? B replied yes. B replied yes on 1st June at 5 o'clock. He replied yes. The letter reached A on 3rd June at 5 o'clock. He read on 6th June 5 o'clock. Now A got another offer from C that I will only buy your car for 6 lakhs. Why did you offer it to B? Now A wants to take back the offer. Tell me what is the last day that A has to take back the offer?
Question before 5.
That's why I asked you. Then what did you guys say? Before the acceptance?
No, before he writes an acceptance.
So what is the word that is used in the law? before the acceptance is put in the course of transmission. Meaning the moment B has written yes and put it in the post dabba, he cannot take back the letter. Acceptance is complete for the offerer. You can't do anything now. Now you take the other way. So what is the last possible time for A to take back the offer? Before acceptance is communicated. And what is that? When is it communicated? Law says the moment the letter is put in the post dabba, acceptance is communicated. So you have time until 4:59. Once the post dabba mein haath gaya. You cannot now take back the acceptance. Agreed? Now you tell me, B got one more offer for the same car. D is interested to sell it to B for 4 lakhs only. But B has sent off the letter. Now tell me, what is the last possible time for B to take back his acceptance?
6 June 4:59.
Or 3rd June?
6 June. Before he reads the letter.
Before he reads the letter, Yes, sir. So remember people, what is the last possible time for you to revoke your acceptance before the acceptance has come to the knowledge of the offerer? See, once you get the letter, you do not know what is inside. Once you read it is when you will get the knowledge of it. So if B has to take back his acceptance, the last possible time is 6th June 5 o'clock. So 4:59, you can send one more speed courier or whatever you guys call it as. Speed post or whatever you call it. You say no and send one more letter. If that letter can reach on 5th June, then this letter will come to an end. This letter will be valid. In your exam, they will give you a third scenario. What if yes also reaches, no also reaches at the same time? Whichever he reads first. Because the law says knowledge of the offerer. So whatever you read first is what you get to know. Agreed? Yes, sir. So this is important again. What is that? Offer and acceptance, when is it complete? Clear all of you? Important from exam point of view, you can expect a question there. The last one is people, revocation of offer and acceptance. How and all you can revoke the offer and acceptance, people? First one, by notice of revocation. Now whatever we did, I want to take back my offer, is called as notice of revocation. Next one, by lapse of time. Whenever there is a specific time period given, beyond that time period, if it goes, people, offer or an acceptance come to an end. By non-fulfillment of condition precedent. Your cart value has to be 300 to get the offer. Your cart value is 200 only. Will you get the offer? No. Offer comes to an end. By death or insanity, the person only has come to an end. Offer also comes to an end. By counter offer. What is counter offer? We saw qualified acceptance. Your first offer will come to an end. Second offer will prevail over the first offer. Non-acceptance in the prescribed mode. I clearly told you it has to be in email. You did not do it that way. You are giving it in oral. It is not valid. Next one, subsequent illegality. So when you entered, it is valid. Later on, it became invalid. Correct? This can also be called as void contract. When you entered, it is legal. Subsequently, it became illegal. Can I say it's void contract? Cold? Turn off. I'll tell you one beauty of this. I think the temperature is not, from there only you should do. Try to see the temperature. I can't operate from here. I don't think it would have worked. Try to click the power. It's working?
Yeah, it's in 27 now. I cannot see.
Do one thing. First turn it off for some time. And next time when you turn it on, keep it around 27 or 28. Leave it. Yes sir. Now this is clear? Pakka na? Any other doubts in unit 1? This is clear all of you? Okay? Done. Okay. That's your unit 1. Done. Let us taka finish off unit 2 also. Online? Any other doubts you want me to cover in unit 1? Online? Yeah, online. Any other doubts in unit 1? No? Clear? Okay, done. Yes, people. So the next one, people, is your unit 2, consideration. Consideration, before we know the definition of consideration, first let us read the rules of consideration. So that the definition becomes easy. Sir, what is the rules of consideration, sir? Legal rules regarding consideration. First one, people, a consideration must move at the desire of the promisor. What is the thing we saw? Did I ask you? Correct? Meaning what? If I do something voluntarily, later I cannot ask money for it. Marathon, voluntarily. Now later, hey, noda, hey, koda. Correct? If I say voluntary, it is voluntary. Agreed? Sir, now whenever a person does something, now that is, if it is voluntary, people, you cannot again call it as a contract. That's what they are telling you. It must move at the desire of the promisor. So one of the case law was your Durga Prasad versus Baldio. In this case, what had happened, people? There were three people. You can imagine like this. There was one panchayat head, there was one contractor, and there was one tenant. The panchayat head requested a contractor, please build a marketplace. Our people are going from Bangalore to Mysuru to just sell the products. It was actually that time, bazaar it was called. In your case also it is a name used, bazaar. So please build it for the people here so that they can sell the products here. So because of that, the contractor built the bazaar also. But whenever, if anyone wants to use that property, the contractor had two rules. Rule number one, people, you need to pay rent for me. Rule number two, whatever sales you make, you need to pay a percentage as commission for me. For 3 to 4 years, people whoever used that bazaar, they paid him both. Rent also was paid, commission was also paid. But one point, at one person came and he said, why should we pay you commission? Rent we understand, because we are using the property, we are paying you. But commission, why should we pay? What is the use? He said, hey, what are you saying? I built the shop for you. That's why you have to pay me commission. Now this person asked, did I ask you? Did I ask you to come and construct? No. That's the exact word that is taken. The consideration has to move at the desire, meaning I should have asked. Then only you can hold me accountable. I did not ask for the construction. Why are you holding me accountable? On those grounds, tenant were just made to pay the rent, and going forward the commissions were discontinued. And that is this case law, Durga Prasad versus Baldio. Clear? Next one, sir. It must move from promisee or any other person. Famous case ano. Which one? Chinnaya versus Ramaya ano. What happened in this case ano? There was one old lady, one daughter, one brother of the old lady. Old lady was about to die. Daughter asked, anyways you are about to die, can you please give me your property? Unda, yes sir. So she asked for the property. The old lady said, okay, I will give you the property, but I have one condition. What is the condition? You have to give a particular pension to my brother who is also of my age. Every month you have to take care of his expenses. Then I will give you the property. She said, okay. She said, I acknowledge to you also, uncle. And once this was signed, the old lady passed away. Now people, after the old lady passed away, the daughter failed to pay the pension amount to the brother. Now this person wants to file a case on the daughter. The daughter said, hey, what? Didn't you not study Unit 1 Indian Contract Act? Consideration, quid pro quo, quid is there, quo kaha? So people, I am giving, what are you giving? Go get lost, I will not give you even 1 rupee also. My God. He went and filed a case on her in the court, saying, Your Honor, there was a promise and she is not fulfilling the contract. Now in this case it was decided, yes, there has to be quid pro quo, but nowhere Indian Contract Act said it has to move from him only. On behalf of him, someone else can also give a consideration. That is valid. Oh, apdiya. And that's how the second rule came into picture. What is the second rule? It must move from promisee. Promisee is the uncle here or any other person. That is the old lady. Chinnaya versus Ramaya. Clear? Is this clear? Okay, next one. Consideration may be executed or executory. Meaning, same thing. Executed contract, executory contract. A consideration can be directly paid today only, or it can be promised today that I will pay tomorrow, or it could be something which is already done in the past. Agreed? So the best example, past voluntary services. What is past voluntary services? Someone helped you. You decide to pay them. For example, you imagine like this. I lost my purse. Someone found it. I said, hey, thank you so much, I will pay you some 1,000 rupees for finding my purse. Please give it to me. Now, he found my purse. That time there was no contract. But after finding it, I promised him to pay. So for the past service, what he did, I am promising to pay now. Whatever he did becomes past consideration. Clear? Yes, sir. So consideration can be past, present or future. It need not be adequate. Important, they can ask you a question. I have a land. The land value is 1 crore. Can I sell the land for 1 lakh? Can I sell it? Yes, you can sell it. That's why it is called consideration need not be adequate. Adequate means people, it need not be same. You can sell it for a different price as well. Is clear? Yes, sir. If that is the case, your big billion day sale and all, 1 rupee you will get, no, then how will it be valid? It is valid. It need not be the same price. The value of the product can be different. What I collect from you can be different. It is valid. Yes, sir. It must be a real law and not a illusionary. Ooh. What is it? Black magic. It should not be unlawful or immoral or opposed to public policy. What and all can come? Everything can come here. So, for example, your terrorism can come. Your what is it? Money laundering, illegal activities, everything can come here. Clear? Okay. Sued by third party, doctrine of privity of contract. Now, people, important. What do you mean by doctrine of privity of contract? Technically, what do you mean by doctrine of privity of contract?
No third party can sue on you.
Sir, the parties between the contractor, if at all anything should happen, I should file a case on you, you should file a case on me. Macha, neen yaro third party. Who are you the third party? So third party to a contract cannot sue the parties to the contractor. This exact principle is called as doctrine of privity of contractor. Third party, stay as third party. However, there are some exceptions. The contract is entered into between two parties. But still, third parties can come and file a case. They are called as exceptions to doctrine of privity of contract. Clear? The doctrine of privity of contract was seen first in the case law. Dunlop pneumatic tire versus Selfridge. What had happened in this case law? What is the case law? Tire company, wholesaler said the manufacturer told to wholesaler that don't sell the tires for less than 1,000 rupees. Wholesaler said to the retailer, you are not supposed to sell the tire for less than 1,000 rupees. So this was a condition from the manufacturer. Whoever buys from you also, you have to impose the same condition. Okay, wholesaler said, yes, I will also tell it to my retailer also. But retailer, because he wanted immediate money, he sold the tires at 900 rupees per tire. He sold it off also. Now the manufacturer directly filed a case on retailer. In this case, the retailer asked, hey, did you tell me? Go. So obviously people, the contract was between the wholesaler and retailer. If at all anyone should file a case on retailer, it should be the wholesaler and not the manufacturer. Because of that, this manufacturer, this case came to an end, but yes, it was subsequently filed by the wholesaler only. Clear? They are technically telling you who is the right party to file the case. Clear all of you? Yes. Okay. Now, what are the exceptions to doctrine of privity of contract? First one, trust. In the case of trust people, who can come and file a case? Beneficiaries. Beneficiaries means what people? For whose benefit the trust is formed. Example, you can imagine college. Trust is formed by some person. The people who take care of it will be directors and all trustees. But who are the beneficiaries? Students. Can you go and file a case? Infrastructure is not good. Can you guys go and file a case? Yes, you can file, because for your benefit only the trust is made. But did you guys go and sign the contract? No. That's why it is coming under exceptions to privity of contract. Clear? Second one, family settlement agreements. Meaning, whether your name is there or not, if at all you are entitled for something from that particular property, whenever a property is getting, whenever they are, you can say settlement means what? I'll tell you an example. Imagine there was a group of family who were part of HUF. In the HUF deed, people, there is the youngest daughter. So for her marriage, you have to keep aside at least 1 lakh rupees for her marriage. This condition was there in the HUF agreement. But after 4 years, what happened, people? Because of some reasons, everyone fought and HUF was diluted. they all got away. They all departed from that HUF deed. So partition of properties happened. One person took land, one person took business, one person took buildings, and entire property was diluted. Now after 4 years, the daughter's wedding came into picture. If HUF deed was there, 1 lakh condition will come into picture. Now the property is only diluted. Who will give 1 lakh? First of all, whether this lady, is she eligible to get the 1 lakh? The answer was yes, because this comes under family settlement agreement. So whenever you are entitled to get something, whether your name is there or not in that partition agreement, you will still get the right. That is only called as settlement agreement. Clear? You can see this maximum in litigation in India also. That's how it generally happens. Yes, sir?
But who will give the 1 lakh?
Everyone has to take it now. 2020, 1010, whatever, however the partitions happened. Yes, sir? Next one, marriage contracts. Whenever marriage contracts, what is the case law we saw? We had seen some case law?
Person?
No, marriage contracts. Balfour versus Balfour, marriage had happened or no? Khwaja Muhammad Khan versus Hussaini Begum. What had happened in that? Father, another father, son, daughter. Father promised another father. Daughter marries son, I will give daughter 500 rupees. Father promised to another father. After marriage, father passed away. Daughter-in-law went and asked father-in-law, Father-in-law, give me money. What did father-in-law say? Who are you to ask? The promise was made between me and your father. Why are you coming? They are telling you in the marriage agreements, based upon your marriage, if any agreements are made, as a beneficiary, it is for your benefit the agreement was made. You are entitled for the money. What is that called in Islamic wedding? Meher. It's called as meher. So the meher was promised between father-in-law and the father. Just because a father dies, that agreement won't come to an end. Meher is something like a dowry, where a boy has to give it to a girl. That's how it works. Clear? Yes, sir. Understood?
Yes, sir.
Assignment of a contract. Assignment means, we write no sir in the class, assignment means people transfer. Meaning, I purchased, I do not want to go ahead, I transferred my right to someone. Now he has a right to come and enforce the contract. Example, sir, A, B, C are the partners. C sold his property to D. On the day of liquidation, D will come and ask for the share of profits. Will D get? Yes. Because this is assignment. Assignment means I am transferring my right to someone else. Next one, acknowledgement. Whatever daughter gave to Chinnaya versus Ramaya case, I acknowledge. Once you agreed, you cannot go back. So third party, if you have agreed, estoppel also is that only, no. For an outsider, if you prove it by your action that you are going to fulfill a particular contract, later on you cannot go back. Next one, covenant running with the land. May ask, you can expect a question here. What is covenant running with the land? Covenant means condition running with the land. What do you mean by that? Imagine there is a property. A sold a property to B. In this property, 90% of it you can do whatever you want. But this 10% of it should be left to my son as a irrigation land. He does not know anything apart from agriculture. So you do anything in this 90% of the property. 10% don't do anything. He will pay rent for it until he is alive. Now B said okay and he purchased. B wanted money. B further sold it to C also. A died. C started constructing Chinnaswamy Stadium Part 2 here. Now he felt 90% is not sufficient. I want to use the 10% also for parking lot. Now he is constructing the stadium in the entire 100%. The question is, can here C I wrote, okay, imagine D. Can C come and do anything to D? Can he stop this construction? The answer is yes. Covenant running with the land means, people, if at all a condition is imposed on a land, no matter how many hands it changes, the condition also will travel with the agreements. Whoever buys has to satisfy this condition until C is alive. Clear? This is called as covenant running with the land. Done now? Okay, next one, contract by agent. We'll be seeing principal agent again in detail. We'll be seeing in the last parts of the Indian Contract Act. Okay. Next one, sir, validity of an agreement without consideration or exceptions to quid pro quo. What is quid pro quo, people? Generally, quid pro quo means something in return, give and take. Without give and take, there cannot be a valid contract. Agreed? However, there are some exceptions. Meaning, even if there is no quid pro quo, no give and take, still the contract will be valid, it seems. When is that first one? Whenever there is natural love and affection, exam may important, they can build you stories and all. Agreed? Especially in this registration point. They will say, a father has transferred his property to her daughter, to his daughter. It is in written. It is signed. Now, when the property was about to be registered, he met with an accident, he died. The property is not yet registered. Now the question is this a valid contract? Your answer will be no only. Because the property is not registered. The same question can come in your exam. Remember and go. Compensation for past warranty services, whichever we saw. I lost the purse, I promised to pay, I have to pay. Next one, promise to pay time bar debtor. What is time bar debtor? Limitation Act says if a debt is given, you have to recover it within 3 years. If it goes beyond 3 years, imagine people, I give you a loan and I'll say give it back to me within 1 year. Now within 1 year you did not give it to me. I have to go to the court within next 3 years. Now within 3 years, if I do not go to the court will tell you then do not come to me forever. Because if you have to come to me for justice, you have to come in time. You cannot come whenever you want. Where is all this written? It is written in one act called as Limitation Act. For example, if you have any problem, if you want to go to High Court, you have to go within 45 days. Sir, what if I am in hospital? Allah, what if something happened? Another 45 days extension will be given. Maximum. Sir, within that, if you cannot go, you cannot go. You can never go. You can never go. Even if I take a statistics of how many judges are there in India and how many pending cases are there in India, each judge has to solve around 80,000 cases to nullify the balance sheet. 80,000 cases. And when will that happen? And if you come after 5 years, if I tell you to prove with evidence, how will you prove? If I ask you what happened in our regular batch, will you guys remember? Then I will come back after 5 years with evidence prove in the court. How will you prove? So evidences will be destroyed with time. To avoid that, we have act called as Limitation Act. Understood? That's what they are telling you. A contract exceptions without to quid pro quo, promise to pay time bar debt. Within 3 years, I did not go to court. But the other party is a good person. He said, sir, I will still agree to pay. See, I am entering into a new promissory note. I will pay it to you. But for this, again, did you take money? The answer is no. Had already given it to you. I am just renewing the same agreement. Now that is an exception. For the second time, you need not have a quid pro quo. That's what is coming as an exception. The next one, to create agency. I can appoint anyone to act as my agent. There need not be money involved always. You can act as an agent for your father and mother. That is valid. That's called as power of attorney. That's all. So you need not be always getting some money to create agency. It can be with money, without money also. Next one, completed gift. Obviously in gift, what consideration will be there? Quid pro quo. Bailment. Bailment, there are two types of bailment. Gratuitous or non-gratuitous. Here they are telling you free bailment. You ask a notes for your with your friend. Will you give him money for taking the notes? You will ask your friend's bike for 1 day. You will pay for it? Answer is no. All these are gratuitous bailment. It's a valid contract. But are you giving something in return? No. Bailment is an exception. Gratuitous bailment specifically. Next one is charity. Charity, obviously, no. In charity, what happens? I agree to give you money. What do I get in return from a temple or whatever is the place or anything? What do you get in return? I don't get anything in return. So charity is also an exception. But we had seen an exception in that. What is the case law we had seen? We'll see that. Kedarnath versus Gori Muhammad. In this case, what had happened? See, if at all there is one construction that is happening. I say I would like to contribute 1,000 rupees. Write it in my name. I'll come and pay. Now, based on my words, based on words like all of ours, they got to know they can collect around 10 crore rupees. And they started construction worth 10 crore. Now, I have not yet given my 10,000 rupees, but I told them I will give. Based on my word, if a liability has been started, if construction is started, you cannot take back the charity. But take the other scenario. I promised, construction is not yet started. Can I take back my word? You can take back the word. If the liability has not yet occurred, you can take back the promise you made. If the liability has occurred, you cannot take back the promise. Understood? In Kedarnath versus Gori Mohammed, the same thing happened. They promised to build a town hall. One person said, I will contribute 1,000 rupees. After 1 month, when he saw the contribution was coming to crores, he felt, now why should I give? So he said, I do not want to give the money. So a case was filed and it was held, even though it was charity. You promised to pay. Based on that, a liability was undertaken. Now you have to pay. You cannot go back. That is this case law. Understood? Kedarnath versus Gori Mohammed. Any doubts?
No, sir.
Kedarnath versus Gori Mohammed. Clear? Okay. Okay. And there were some differences in first unit. What is the difference between void contract and voidable contract? What is the difference? Void and voidable.
Void is subsequently it will become void. Voidable is at the
Option of the one party. What is the difference between illegal and voidable?
Illegal is unenforceable, like unenforceable by law.
By law?
And what is void?
Voidable.
Void is subsequently.
No, voidable.
Voidable at the
Option of the party. Specifically, there is one point, no, in illegal contract and voidable or contract. What is that one point? Connected the contracts, an agreement collateral to a illegal agreement
is also illegal.
is also illegal. It is tainted with illegality. That is what you would have studied, correct? If there is any agreement which is connected to an illegal agreement, that may also become void, provided you had seen that also. If it can be severed or it cannot be severed, it can be split, it cannot be split. You remember?
Yes, sir.
Imagine people, A, B, C, D. A tells B, go and kidnap, C. Go and kidnap C. Now B says, okay. From where will he kidnap? He will take car from D. Now my question is, does D know that your car will be used for kidnapping? Do you know? If the answer is no, then this part of the contract will be illegal, this will be valid. If at all, I'll ask again D, do you know? If the answer is yes, then both of it will be treated as illegal only. Correct? Yes, sir. So remember that one point. Okay. Other essential elements of contract. Do you guys need a break? What time you guys will take lunch? 12:30, 1 lunch break? 12:30, Then we'll take a break at 12:30 only, Yes, sir? Okay, done. Okay, done. Okay, let's start with unit 3, sir. Other essential elements of contract. Other essential elements of contract. You want AC here? Now it's becoming hotter. Now try to increase the temperature. Other essential elements of contract. Sir, capacity to contract. Okay, the next essential elements of contract, people, there are 3. What is that? First, you have to be a major, sound minder, and not specifically disqualified. Okay, under major, sir, there are some conditions or rules regarding minority. What are those rules? First one, rules governing minor contracts. First one, the contract with the minor will always be called as void ab initio. Void ab initio means people invalid from the beginning. Case law people, Mohiri Bibi versus Dharmodas Ghosh. In this case what happened? A minor misinterpreted his age and he took some loan from a person. Now when he became a major, the major, you can take this way, A versus B. A was a minor, borrowed 20,000 rupees as loan from B. After becoming major, B came and asked the money back. A said, no, I am not liable to repay. When the case went to court, it was held, what you did when you were a minor is always invalid. Subsequently, you cannot make it valid. So what you did when you were a minor, that's always invalid. Subsequently, you cannot make it valid. What is the legal terminology of this? Ratification. A minor contract can never be ratified. But only in one place you will see an exception. Where is that? Partnership. Very good. Whenever a minor accepts to be a partner, you remember after he becomes a major, 6 months, he have to tell his decision. If he says yes, minor will be liable from which day? From the day he is accepted as a beneficiary to the partnership. Imagine if he is taken as a beneficiary at the age of 16. From that day, whatever are the contracts entered into by the partnership, from that day he will be liable. That's the only exception. Is clear? Huh? Remember that part. Okay. So, no ratification. Whatever was invalid can never be made valid in the future. He can be a beneficiary, meaning he can take benefits, but he cannot be made liable. You know what do you mean by that? A minor cannot write a check, but a minor can accept a check. Minor cannot sign a check, but minor can accept a check because he is getting money. That's the meaning of it. And one more example is partnership. He can be a beneficiary, no? Sir, he can plead minority. Meaning what, people? He can say I am a minor and he can escape himself from any of the legal proceedings. Next one, sir. His estate is liable for necessaries. Very important. What do you mean by that? Important. His estate is liable for necessaries. Meaning what? Let us take for example, A borrowed money from B. Okay. Now the question is, first question I'll ask you. Why do you need money? I need money for, let us imagine, education. Education. Is it a necessity? Yes, sir. Can you give me examples of more necessities? Food and shelter, clothing. And don't tell me I'll come up with Zara, Moda, Rapido and all. So I'm telling you, it has to be something which is okay. Second thing, people, okay, I'm giving you necessaries. You should not already have supply of these necessaries from someone else. So for the same thing, you cannot take the money from another person. Okay, if these two conditions are met, now the third thing, sir, now tell me, is A liable to repay the money to B? Is he liable? I've taken the money for necessaries. Am I liable to repay?
To the extent of his profits.
Remember, the word will be A is not personally liable. His estate will be liable. So he is liable for the necessaries to the extent of the estate he holds. Meaning, how much ever property he holds, up to that extent he is liable. Now, for example, how much loan did I take for education? 2 lakh. How much property you have? 1.5 lakh. I am liable only to the extent of 1.5 lakh. Sir, I took 2 lakh for education. I don't have property at all. A is not liable at all. Sir, A took 2 lakhs. For what? A takes 2 lakh for, imagine he wanted a bike from B. Now, A has a property also. The property worth is 3 lakh. Is A liable to repay? I took loan 3 lakh for the bike. I have property also. Now, is my property liable to repay this loan?
So, bike is a luxury.
Am I liable?
No.
Answer is no, because it is not necessity. But I am telling you one thing, people, remember. There is something called as doctrine of equity. What is doctrine of equity? Not in our syllabus. If at all a person is taking a benefit of whatever is a provision provided, law will not let him enjoy that benefit. Bike is there only, no. I need to repay the loan, no. sell the bike and repay the money. A minor can be held liable on these grounds, and that ground is called as doctrine of equity. It's clear? That's not there in our syllabus, but I'm just telling you. This can happen only in the case of a property. Imagine I've taken money. I took 20,000. I spent it. Now you cannot recover it. But if I've taken a product, and if the product is still there, the court can order to sell the product and repay the money. Getting the difference? All of you? Yes? Okay. Next one, sir. Enter into contract by guardian. So, how will a minor enter into a contract? You are allowed in certain places. For example, your school, college. How did your admissions get done? Through your guardians. It can be your demat accounts. It can be your bank accounts. Guardian signatures will be taken. It is valid. You can be a shareholder also. How? Through guardian. Okay. Next one. You cannot be an insolvent. Why? Because you are never personally liable. Next one. No specific performance. If minor said, I will give it to you, he can say, I won't give it to you also. The person cannot come and file a case on minor asking for the money back. No, not liable. Next one, he can be an agent. But remember, he cannot be a principal. Yes, regarding this, we'll be seeing when we are doing principal and agent relationship. Cannot bind parent or guardian, important. A minor cannot go to a shop and say, my parents will come and pay. Give me whatever I want. Even if the shopkeeper gives, parent or guardians are not liable. Clear? Yes. Joint contract, meaning, sir, now a minor can enter into a joint contract, meaning a major and minor together can borrow loan. Minor won't be liable, but the major will be liable. Understood? One adult and one minor borrows loan, 20,000. When you have to repay, minor is not liable, but the adult is liable to repay the entire 20,000. Next one, surety will be liable, meaning what? Let us imagine a principal debtor, I am borrowing the money. Who am I? I am a minor. I am taking loan. There is one person who is a major. He gave a surety to the creditor. If he doesn't pay, I will repay. Just because if this agreement is invalid, this agreement won't become invalid. If minor does not repay, surety will have to pay. You will be seeing this in 7th unit. Shareholder, he can be a shareholder. Not directly, but through a guardian, yes. Directly he cannot be. Through a guardian, he can be. Next one, he is liable for torts. Tort means people, any wrongdoings he does, he will be liable. Defamation, trespassing, for all that you are liable. Clear? Yes, sir? Okay, done. Next one, sir, sound mind. Meaning what, people? A person enter into a contract should be of sound mind. Sound mind means what, sir? Headphone, what is sound mind? Sound mind, sir. Sound, it should be sound. He should be mentally stable. So there are two scenarios where you can see a person mentally unstable. When can you see a person mentally unstable? When can you see? First one, people, is when by birth, because of any psychological problems, a person can be mentally unstable. Now you generally call them as unsound mind. Now they cannot enter into a contract. Example we had seen in the class, Jyotika says, Laka, she cannot enter into a contract. Agreed? So you would see, whenever a person is in possession of something, or whenever a person is not doing in a right state of mind, they are saying they cannot enter into a valid contract. Next one is, a person will be usually sound mind, but occasionally he will be unsound mind. Such person cannot enter into a contract when they are unsound mind. When they are sound, they can enter into a contract. When will we see? Usually sound mind, occasionally unsound. When will it happen? Friday night, Hey. Yes, sir. Whenever Paramatma meets Atma, that is when it becomes unsound mind partially. Correct? So on those cases, yes, you can make sure that the contract becomes void. Yes. Okay. Next one, not disqualified. Certain people are disqualified from law, that you cannot enter into a contract, and that certain people are foreign sovereigns and ambassadors. You cannot enter into a contract with not foreigners. I'm not saying foreigners. Representatives of foreign government. Because if you screw up, the relationship between the two countries will spoil. So, what is the right way? You have to take government's approval before you enter into a contract with such people. Yes. Next one, alien enemy. Alien enemy is nothing but the people with whom we have a war going on. A country with whom we have a war going on, with them we cannot enter into a contract. they are disqualified. So for a reason, Pakistan players will not play IPL here. That's the reason. Clear? Huh? They were playing, I don't know if you guys know it or not. Shoaib Akhtar used to play for KKR. You know Shoaib Akhtar? Okay. So you are not the generation anymore. Okay. Insolvent. Who is insolvent, sir? Insolvent. A person whose liabilities are more than assets, sir. Convict people. Who is? A person against whom the case is proven or he is being found guilty of an offence. Just because you are arrested, you become accused. The case is filed, you will not be disqualified. I'll tell you one very interesting fact. Recently, when CM is arrested, you know, Arvind Kejriwal. Where is Arvind Kejriwal now? Jail. What is Arvind Kejriwal? CM of Delhi. CM of Delhi is in the jail. Who is conducting the affairs of Delhi then? Who is taking decisions? Did you see any temporary CM being appointed? No. Arvind Kejriwal is conducting the business from the jail because he is not yet a convict. He is accused. So he is in the jail and the government is run through jail. Understood? Yes. Okay. Corporations. What is corporations? Basically companies. Here they have just used as corporation, but we should actually write it as ultra vires transaction, that is in terms of MOA. Clear? Yes. Done. Next one, sir. Free consent, people. When will we say the consent is not free? So next essential element of a valid contract. So we saw offer. We saw acceptance. In second unit you saw consideration. You saw capacity of parties. You are now seeing free consent. When will we say that the consent is not free? Whenever there is coercion. What is the difference between coercion and undue influence?
Coercion is forcing a person, and undue influence is like one person is superior to another person.
Correct only. What is coercion?
Coercion is like, it can be like two people on same level or two different people. They just force each other. But undue influence is like between two people, one is superior, the other one is inferior.
So see, coercion is force. The meaning of coercion is force. But when I am writing in the exam, if I ask what is coercion, you are doing anything which is prohibited under Indian Penal Code. You have written that activities which are prohibited under Indian Penal Code, if you are doing that, that is called as coercion. Now what is prohibited under Indian Penal Code? For your information, if you do anything here, then the verdict will be jail, capital punishment, hanging. Example, murder, kidnap, rape, all this will come under IPC. Now that will come under force. That is called coercion. Undue influence is not such a big things and all. I will say, Macha, 1 month salary I will cut. Are you getting the seriousness? That's called coercion. That is called as undue influence. So coercion is a person committing an act which is forbidden under a Indian Penal Code. Murder, theft, if you don't sign, half murder. So now you fear and you sign. Now this is called as coercion. So for this, you will be arrested and you will be also sentenced to imprisonment. You can also be subject to capital punishment. Hanging also is there. What Ajmal Kasab did is called coercion Allah, but it is a IPC. It is punishable under IPC. That is why sentenced to death, no? Nirbhaya case, Delhi. Punished, capital punishment, death. Undue influence, I will remove you from the job. You will kill me or what? Getting the difference, all of you? Yes? So coercion act forbidden by IPC. Contract shall be voidable. Voidable by people. Remember, if free consent is not there, contracts are voidable. So whoever has been coerced, that person has to go to the court and you have to explain everything. Parties shall be punishable. But remember, punishable is not under Indian Contract Act. Under IPC you will be punishable. Okay. Undue influence, first of all, for undue influence to be there has to be some difference. What is the difference? One person should be in superior position, one person should be in inferior position. If at all they are asking you a question from undue influence, give an example of the parties in undue influence. Who can that be? Doctor, patient, employer, employee, master and servant, creditor and debtor. All these are the examples you can give. Where the parties are connected, student and teacher. Student and teacher, your superior position, inferior, yes or no? All these are the examples you can give. See? And one more thing, just because, okay, now tell me one thing. Kamran, how old are you? Da? 9, no, Sabash da? Okay. So, now Kamran has a bike. Can I buy Kamran's bike or not? Imagine he is selling for 50k. I will give it 50k. I will buy the bike. Can we both enter into a contract or not? Teacher, student, undue influence baralva? So remember, just because we are under two different levels, that doesn't mean people that this contract is invalid. If at all the person in the superior position, Kamran, if he uses undue influence on me, now this becomes undue influence. Correct? Yes, sir. So that's one thing, remember. Okay. Under undue influence, you would have seen one more thing also, unconscionable bargains. What is unconscionable bargain?
Doctor or patient.
When
the patient is not well and the doctor tries to.
Unconscionable bargains can come in the case of debtor and creditor relationship. What is that? Taking the advantage of the debtor, if I impose unreasonable rate of interest on you, now that is called as what? Unconscionable bargain. So for example, I know that you have to meet your day-to-day expenses, and the rate of interest I charge you is 4% per month, which turns out to almost 50% per annum. The banks give you at the rate of 9% per annum. Now whatever you did is called as unconscionable bargain. If a debtor had taken loan, later when he is not able to repay, he can go to court and say, sir, there was an unconscionable bargain. If I file a case, remember, the person in superior position has to prove that no sir, this was not unconscionable bargain. Always a person who files the case has to prove an evidence. But in undue influence, whoever is in the superior position has to prove the evidence, not the person who files the case. That's the difference. The onus of proof or burden of proof is on the person or the party in the superior position. Important from exam point of view. Fraud. Fraud. What is fraud? Doing something knowingly. I know it is true, I say false. I know it is false, I say true. Is called as fraud. Now tell me one thing. In a contract, I'm selling a particular product. A buyer comes to my premises to buy this product. I keep quiet. Now let us imagine I am selling a sofa. Sofa has a crack. I know it. A buyer comes and buys it. I will not tell even a single word. He buys it, he takes home. After going home, he says it will break. Now whatever I did as a seller, is it fraud or not?
Fraud.
Yes or no? Because I knew it and I did not disclose it. It been too much of time, no? So this is meant to happen. Hey, if I just remain quiet, is it fraud, Ada? Does silence amount to fraud? KVA tempter. Who is this KVA tempter? My tata? What is KVA tempter, Ada? Let the buyer be aware. Macha, sit da. I've seen in IKEA, I've seen people sleeping on the bed there. You at least sit and test a sofa. You go to IKEA. Afternoon if you go, people will be lying on the bed.
But if at all I ask you specific questions.
You asked me in this case. You asked me, Ada. Illa no. So remember, a mere silence does not amount to fraud. Why? The next topic is KVA tempter. Let the buyer be aware. Just because the seller is silent, it does not amount to fraud. He is under no obligation when he has given you an opportunity to check the product. He will not tell you anything. Silence does not amount to fraud. But in certain cases, silence amount to fraud. When no? contracts of Uberima Fidus. What is this, sir? Uberima Fidus? Sir, in this, sir. So, it's nothing but a contract of utmost good faith, it seems. Example, prospectus. If you hide any details there. Now, imagine I'm telling you I'm paying dividends for the last 3 years. How? That is hidden. I'm taking loan and paying you dividends to make my company look very fancy. I'm hiding that fact. This is fraud. Because you are not disclosing you how you are paying dividend. Next one, insurance contracts. Terms and conditions apply. Star mark hakpidodu, bitpidodu. Sir, these conditions are not covered in insurance. It used to happen. Now it cannot happen. That's the reason I told you insurance has to be in written. And what else? What else are the contracts of utmost good faith? They are online, no?
Fiduciary relationships.
Correct, that is also. Contracts of fiduciary relationships. What is fiduciary relationship?
Trust and
Contracts of trust. Banker and us, customer. Hey, your login ID password is there with banker. Can't I give it to anyone else? OTP, instead of sending it to you, he'll send it to someone else. Okay. Contract of trust. Your auditor. Your CA. CA da. Hey, you only da. You and your client, you enjoy a relationship of trust. They give you all the details to you. Their income tax, everything will be with you. What if something happens? Where they are telling? Understood? Family settlement, marriage contracts, you have to disclose everything. After marriage, you cannot say anything hidden and all. Correct? Kambrano. Next one is misrepresentation. What is misrepresentation? What is the difference between fraud and misrepresentation? Fraud is fraud, sir. Misrepresentation is misrepresentation. Fraud, 5 letters. Misrepresentation takes time to tell. What is misrepresentation? Without knowing. I think it is false. Hence I said false. But it is true. What to do? There was a defect in my bike. I didn't know. I said there are no defects. What to do? That is called as misrepresentation. Understood? When you are going in a bike, you hit someone. You will say, sir, beku anta marde. Will you say, did I do it? Wantedly I did it, sir. What did you, the first thing you say, sir? Unknowingly it happened, sir. Gottilde what bitte. Correct? So anything that happens without your knowledge is called as misrepresentation. Clear? Next one, mistake. What is the difference between mistake, misrepresentation? What is mistake? First of all, okay, forget this difference. What is mistake? Misrepresentation, you didn't know that it is true, hence you said it is true. Mistake, people, there is a difference of opinion between the parties only. Imagine, I will tell you, I want to sell you a car. The car I have in my mind is BMW. But what you know, I will say I want to sell my car. You will think, okay, he wants to sell probably what? Okay, Swift. So when I say car, now whenever I say vague, we are not in consensus ad idem. That is called mistake. It's called mistake of fact. I will say I want rice. Now in rice, you know what and all quality of rice can come. I have asked for a particular rice. You sell me rice, but the quality what we have asked is not what you have sent. That's called mistake. That's again mistake of quality. So mistake can be in number. One is called mistake of fact and mistake of law. Under mistake of fact, mistake of quantity can come, mistake of quality can come. I asked for 50 kgs of rice. You sent me 40 kgs. What will you call it as? When I ordered Zomato, I ordered 3 plates of idli. I got 2 plates of idli. Now what do you call it as? Mistake of quantity, mistake of fact it is. I got idli only, but I got less quantity. Getting the point? 100%? Yes, sir. Okay, mistake of fact, mistake of law. Mistake of fact is, people, where both the parties are not on the same mind. So mistake of fact can be considered as a void contract because it's never a valid contract at all. This is clear? Because both of us are not on the same grounds. There is no consensus ad idem. I am telling you a different product, you are telling me a different product. The next one is called as mistake of law. Mistake of law can be mistake of Indian law or it can be mistake of foreign law. Mistake of Indian law people, they will say it is not an excuse. For example, I travel in train. I will not take a ticket. I will say, sir, mistake. I didn't know that I have to take a ticket. Will the authorities leave me? Ignorance of law is not an excuse. I will not be left if I say it's a mistake. I have to pay for it. So, mistake of Indian law, the contract will still be valid. Mistake of foreign law, I might miss out knowing something that is not acceptable in foreign law. Imagine I am exporting some chemical to foreign laws. Now I might be wrong, I do not know whether that chemical is valid or invalid in that country. Someone is buying, he is paying me money, I am also sending. I got to know later that is invalid in that country. What do? They are telling you mistake of law, mistake of foreign law will be treated as mistake of fact. Meaning, if one party knew, then it will be treated as valid. If both the parties knew, then it will be treated as void. Understood? Pakka na? So this is your mistake part. The next one, people, legality of object and consideration. Forbidden by law. So, when will an object be considered as unlawful? Or when will a consideration be considered as unlawful, people? Whenever it is forbidden by law. Example, child marriage is forbidden. If at all you do a contract for that, it is considered as what? It is considered as unlawful. Defeats the provision of law. Meaning, minor agreement says, you saw Indian Contract Act only. Minor agreements are invalid. But in your contract you are saying, Indian Contract Act won't apply for our contract. Even if you are a minor, you need to pay money for me. If at all you are defeating any purpose of the law only through your contract, such agreement will be invalid. Still, he can claim minority according to Indian Contract Act. Next one, fraudulent. Imagine there is a contract for smuggling. Fraudulent. Obviously, they are unlawful. Involves injury to a person or property. Take money, go and destroy that building. Immoral, which is not accepted by the society. Difference between illegal and immoral. What is the difference between? What is the difference between illegal and immoral?
Illegal is not enforceable by law. Immoral is like not accepted by the society.
Illegal is not legal according to the lawmakers. They have given it clearly in the law. Immoral, there is nowhere it is written what is right, what is wrong. But the society has said what you are doing is not right. Is it written somewhere? The answer is no. They are called as immoral. Is it clear? For example, one person gives money to a husband to divorce your wife and come, let's get married. Are you getting the point? Now this is immoral. But is there a law which stops this? So this is immoral. Understood? Okay. Next one, consideration opposed to public policy. If I allow this, public policy only will come to an end. Public will suffer. So such considerations will be considered as consideration opposed to public policy. What are that? First one, trading with enemy, alien enemy. TikTok was banned. Best example. If I allow it, it is creating a huge, you can say, privacy matters were being breached by this Chinese apps. That's why TikTok, all these were banned. Your data was being transmitted to China. And you guys enjoyed it. Correct? Trafficking of public offices and titles. Trafficking means what? Selling. Public offices and titles means what? Titles. Padma Bhushan, Padma Vibhushan. How much you have? 1 lakh. Take. Padma Bhushan, Padma Vibhushan. Take Vibhushan. V is extra. Can we sell it? Can I buy a title? They're telling you cannot sell it. If at all you have a contract for such things, it is immoral. It is opposed to public policy. Next one, public offices. Obviously, what do you want? Deputy CM, CM. What do you want to become? But does it happen like that? No, I don't know. Agree? Is it? I don't know. They do it that way, Is politics, money involved in politics? No, it happens so fairly and all. Where is money involved? Huh? Good people. Good people are running the country. What are you saying? My God. See da? Agreement. How dare you tell about politicians? Agreements creating monopoly. Agreed? An agreement cannot be there where competition ends. Marriage brokerage agreements. I had given in detail explanation in the class also. Basically, there cannot be a broker between two people wherein he just does anything just for money. Whether a boy has certain assets, he promotes saying certain assets are there. So why? Because he gets that commission. So that's the reason they said marriage brokerage agreements cannot be valid. I told you the exception for Shadi.com and all, because they are just the sites which sell the data. They are not promoting marriages. You pay money, you get a data to see the details of the girl or the boy. They are not promoting the marriage there. Why does smiling come from? Not today, but someday you will register. Telling you data, that's all. Consideration unlawful in part, which I already told you. What is this unlawful in part? Kidnapping. The car. Did you know it? So unlawful in part. Whatever is legal will be valid. Whatever is illegal will be invalid. So kidnapping part is illegal. Car part, renting the car. Whether the Zoom car person knew about the kidnap, if he knew, it is contract will become illegal. If he did not knew the purpose, it will become legal. He can get the money. Next one, interference with in the course of justice. Witness, you are bribing the witness. You are bribing the judge only. All this is not valid. Next one, stifling of prosecution. What is stifling of prosecution? Prosecution means people nothing but crime. Crime. Meaning, if a crime has happened, you cannot settle that crime. That is only called as what people? You cannot make a trade of felony. If a crime has happened, you have to go to the court. You cannot settle it out of the court. Imagine a person kills a person, he will say, anyways he will not come. Take 1 crore rupees. What will you get sending me to jail? Is it a valid justice? Society will lose faith on the leaders. That cannot happen. So you cannot settle the matters. That's the meaning of you cannot make a trade of felony. Clear? Next one people, maintenance and champerty. Maintenance and champerty, I told you. What is that maintenance and champerty? Imagine there is a poor man, there is a rich man. Is it always like this? No. I'm just telling you for the example. Now this person wants to file a case against a rich person. Do you have money? The answer is no. One Punyatma will come and say, hey, you go and fight. I will give you the support to go and fight against him. The poor person will ask, oh sir, that's so kind of you, but what do you want in return? Nothing, whatever I'm giving it to you, you just give it back to me. If your case takes 1 lakh, you give me 1 lakh once you win the case. Or, how much are you getting? Sir, if I win the case, I will get 10 crore worth property. Okay, give me 1 crore. I will give you money today. You fight, you win. Out of 10 crore, you give me 1 crore. Sir, now whatever you're asking, if you're asking for the money in return, it is called maintenance. If you're asking for the share from what you win in the case, it's called as champerty. Now maintenance and champerty, is it opposed to public policy? Is it opposed to public policy? By default, they are not opposed to public policy. They are opposed to public policy only if it is unfair. Second one, it is made with malicious motive. Yaru sir adu malicious? Kaun revo malicious? Malicious means people, if you have made this with a bad intention, your intention is not to help the poor person, your intention is to take revenge on this person. In the past, he had cheated you. You wanted to take a revenge on him. That's the reason you are instigating him to go against him. If you have made this with that intention, then maintenance and champerty becomes unlawful. If not, maintenance and champerty is lawful only. Understood this whole scenario, na? Pakka na? Yes, sir. Generally, you know who will make maintenance and champerty? Generally, who offers? It is lawyers who offers. I will tell, come sir, I will fight this case for you. In return, give me this. Is it illegal? I am not saying illegal. Provided if it is whatever is reasonable, it is valid. Unreasonable, then it becomes unlawful. Clear? I have my friends only who are fighting such cases. They do it. It's clear, huh? Next one, sir. Last one, sir. Wagering agreement. Wager. What do you mean by wager? What is wagering? Wagering means, people, nothing but betting. Section 30 talks about wager. What is wager, people? You entering into a contract based upon a uncertain event. What is uncertain event? You never know. It may happen, it may not happen. Example, CSK versus RCB. Do or die match. RCB wins. Take da 1 lakh. CSK wins. Take da 10 lakh. Chandan will come and say, it will rain. Take that 20 lakh. Now whatever you are saying, all these are uncertain events. Now whatever we did is called as wager. Is it for the benefit of the society? Wagering. Does it happen? Benefit happens, Sada? Yes, sir. We get money, no? Society does not get money. And one person wins means other person has to lose. So such wagering agreements are considered as illegal. Agreed? Sir, can you give me examples of agreements which are similar to wager? Yes. The first example is lottery. Lottery transactions are illegal in India. That is what your book says. But in the class we had seen multiple transactions regarding lottery. In certain states it is legal, certain states it is illegal, certain states it is void, as the case may be. Correct? Whenever a lottery is conducted by the government only will conduct a lottery. Yeah? Government will conduct a lottery. Government conducts lotteries. I only said that. Kerala government conducts. In Kerala, lottery is a very huge revenue for the government. Very, very big revenue. Yeah, Punjab government conducts. So yes, governments conduct. According to the law, if at all conducting lottery is illegal. Illegal means punishable. Sir, a private person conducts lottery. It is still illegal only. He is punishable also. Government conducts lottery. Illegal only. But person conducting will not be punishable. Meaning government is not punishable. Anyone else conducts punishable. Yes, sir. Sir, so lottery is always illegal, sir. I am telling you, according to your book, it is illegal. But you always, sir, there is one state which runs on lottery only. Which state? Goa, casino. You have gone or not, Kamrana? Yeah. Poker and all you would have paid, no? No. So entire state runs on lottery, casinos, poker games. Then what is all this? Then everything. In Goa, you need a license to run these casinos. So government gives a license for that. So in that state it is legal. Overall they are given under Indian Contract Act as illegal. You are writing it as illegal. Here, yes. The next transaction, people. Crossword puzzle. Is crossword puzzle legal or illegal? Is it considered as wager or not? First of all, if it is decided, if at all the winner is decided based upon his skill and talent, it will not be considered as wager, provided the prize money does not exceed 1,000. Up to 1,000 rupees, people, it is not a wager. If at all the winner is decided based upon the competitor's puzzle. What is based upon the competitor's puzzle or pre-solved puzzle? I will take all your puzzles, solved puzzle, I will put it in one box. Bhagyalakshmi bumper draw. I will take one. Whoever gets it, people, is the winner. Now, are you winning based on merit? No, you are winning based on luck. Now, this is lottery. If at all you are winning based on skill, meaning first come, first serve. Answer it first and get it. Yes, you are winning it on lottery. I mean, you are winning on skill. If you are winning based on luck or competitor's pre-solved puzzle, meaning the chances of you winning is very, very less. Now, these are considered as what, people? Lottery, wagering. Clear? They are void. And skill or talent, sir? Okay, based on skill or talent, the prize money is 50,000. Is it valid? Up to 1,000 it is valid. Beyond 1,000 it is invalid. Next one, sir, horse race. Horse race, people. Horse race. 1,000 money is 500.
Less than 500 is valid.
More than 500 valid. Now I'll ask you a question now. Yes, sir. Exact 500. Is it invalid or valid?
Valid.
Valid.
Less than 500.
No, invalid.
Exact 500 to 600.
Exact 500.
Exact 500. Is it valid or invalid?
Valid.
Valid, huh? Valid, huh?
Yeah.
Pakka, na?
Yes, sir.
100%, huh?
Yes, sir.
Okay, remember, less than 500 is invalid, 500 or above is valid. So, crossword puzzle, more becomes void. Horse race, less becomes void. You can imagine this way, rich man only have to participate in horse. People in 18th century, they are telling you 500 rupees. Law is not amended. 18th century. For your information, I don't know I told you or not also, my father's salary in 1980s was 400 rupees. 1980. Now I'm talking about 1870. Was 500 valuable day? Extremely valuable da. 500 in 1960, around 90, you can take 1950. One big site, 1 acre site in Baswangudi or your Jainagar. You used to get it at 100 rupees, 150 rupees. I am telling you 1960. 1 acre you used to get. Now you take 500 rupees. It is very, very valuable. It is the point. They have not changed it. That's all. It is still there.
Why they didn't change it, sir?
There are some laws like that. In India, there are, the best example is labor laws. Labor laws also they have amended. It is not yet notified. It's like that only. If you see labor law, you will see in labor law there is something called as Maternity Benefit Act, meaning pregnant women has to be given some special care. I should not give hard work like that and all. It's there, and you have to give them paid leaves, 6 weeks or whatever that their timelines and all are there. Now, if I violate, the penalty is 500 rupees. I will definitely violate. You take it this way. If I do not give you leaves, paid leaves, how much will be the paid leave? I'll have to give you around for 24, around 6 months, divided by 4, whatever, the number of weeks. It is, I think, more than 24 weeks is what they are eligible now. And how much will that be? Today's date average salary will be 30,000. Take it into 6 months. And if I don't pay that, I have to pay 500 rupees.
500 is
I'll pay 500 only. Now, is this amended? The answer is yes, but not yet notified. And amended now. And how old is the legislation? Almost 60-year-old. It's going on. Why? Because what happens is, for every time, the lawmakers find the new things which are to be addressed immediately, and the old things become old and they go for the back seat. And it continues. It is changing, but yes, it has to change even more. Is clear? Horse race. Okay, the last ones are transactions resembling a wager. Speculative transaction, people, nothing but share market. In share market, if you do, it is valid. Out of the share market, if you do, it becomes invalid. Meaning, now imagine I invest 1,000 rupees on Infosys, it becomes 1,200 in stock market. It is valid. But now me and Kamran will bet out of the stock market. Macha, if at all Infosys becomes 1,200, you have to give me 200 rupees. If it becomes 800, I will give you 200 rupees. Where are you settling? Out of the stock market. Now this is invalid. Why? Money is not coming into circulation. Now this 200 rupees if you make in stock market, the immediate thing that will come is tax. They will debit everything and they will pay you. Now in this transaction, can I tax it? No, I don't even know you guys are doing it. That's the main reason. Clear? The last ones are transactions resembling wager but are not void. Meaning they are similar to wager but they are not void. They are valid. Which are that? First one is chit fund because they are regulated by state governments. Next one is share market transaction, as I told you. Inside it is valid, outside it is invalid. Game of skill provided does not exceed 1,000. Up to 1,000 valid, 1,001 invalid. Less than 500 invalid. Horse race, 500 valid. 499 invalid. 500 valid. For your level they will not go to that, but I am just telling you. Clear? Sir, next one is contract of insurance. Contract of insurance is also uncertain. No? If I take a policy this month, for sure I will meet with an accident. No. Yes or no? For example, now I have been paying my insurance for the last 8 years. But every year I do not claim it. It's there. So it is for the benefit. So it's valid. Understood? Pakkana? Okay, done. Okay, done. Next one, sir. Let us do unit 4. After unit 4, we'll go for a break or something. Or you'll sit for the marathon completely. You don't want break only. Sir, in comedy, you know how difficult it is. For 1 month syllabus, if you tell in 1 day, how fair is it, sir? Okay. Performance of contract. Next chapter, people. Unit 4 and unit 5, little. Yeah, okay, done. Sir, performance of contract, people. A performance can be classified into 2 things. One is called as actual performance, one is called as attempted performance. What is actual performance? Actual performance is nothing but I executed contract. Meaning, you had asked for something, the contract is also complied. You also performed, they also performed. It is called as the actual performance. Contract is done. Attempted performance means, people, a contract was there, the other party tried performing it, but you rejected the other party. How can it happen? Imagine I ordered something on Flipkart. The person came to my home for delivering the product. I am not there. Immediately you will get a message. What is that? There was a failure in the delivery. Sir, we attempted performing, but you were not there. Now, his obligation will come to an end. If anything happens, he is no longer liable. The liability is on me because I denied the performance. So, in attempted performance, remember, the seller or whoever is the party who tried performing, his obligation comes to an end. Now, it is my responsibility to get the product delivered. Correct? Okay, sir. Next one, who can perform the contract? By default, the contract has to be performed by the promisor and the promisee. That is, the parties to the contract only should perform. However, is it always like that, sir? Whenever people, there is no special skill or talent involved, or there is no confidence involved on the other party, such contracts, people, even others also can perform. If at all any special skill or talent is involved, then only the parties to the performance only should perform the contract. Example, sir, imagine A borrows loan from B. A dies. To repay the loan, you need special skill and performance. No, that's the reason A's legal representative will be liable. It can be children, it can be parents. They will be liable to repay the loan. Agreed? But sir, now imagine I borrowed the loan 10 lakh. Now the children, C, is C liable to repay the entire 10 lakh? Yes or no? Yes, provided A has assets. If at all my assets are 5 lakh, the liabilities I am passing is 10 lakh. The legal representatives will be liable only to the extent of the assets they inherit. Their liability will stop at 5 lakh. It will not go to 10 lakh. Is this clear? Pakkana? Okay, done. So, promisor himself, whenever there is any special skill involved. Whenever there is no special skill, in such case, it can be performed by legal representatives. Sir, agent, I can take up a contract, I can send someone else on my behalf. It is valid. Meaning, whenever you want to sell your house, you will always appoint a real estate agent. You will not go and show your house to everyone. There is another person who will show it on your behalf. That's what they are telling you. You can performing it on your own, or you can perform through the agent also. It is valid. Next one, third person. What is third person? I should have done it, people. Now imagine, I sign up for a contract. Okay, you can imagine this way. I will come and take a business loss for you. Now because of some commitment, I was not able to come. I will send my friend. Now my friend will come and teach. Even you guys find it good, even the academy finds it good. It's absolutely fine. So I should have performed, but I sent someone else to perform. You guys accepted it, then that's well and good. It will go forward. So that is what is called as third person. Understood? Pakkana? The last one is called as joint promisor. What do you mean by joint promisor? A, B. Together they borrowed money from C. We borrowed 2 lakh rupees. Okay, you can take it this way. A, B, they borrowed money from C. Now who is C, sir? Let us take for example, C is B's friend only. He said, hey, I know my friend, let's go and tell what we want, he will give us loan. So they went and borrowed the money. Now these people are called as joint promisors. Now when we have to repay the loan, people, Now imagine we told we will repay within 1 year. In 1 year if you don't repay, after that C can come. Whomever he finds. Now imagine I found Mr. B. On 1 year, within 1 year they did not repay. I can come and compel B to repay the entire 2 lakh. Now B has to repay the entire 2 lakh. He cannot say, sir, I took 1 lakh, he took 1 lakh, I will give only 1 lakh. That is between you guys to decide. But I can recover the entire money from B. Later on, B can recover that money from A. That's a different story. But yes, I have to recover entire money from B. Clear? Huh? So now what happens if B dies? Who will repay the 2 lakh?
He is a legal representative along with A should repay.
So sir, A will repay 1 lakh. B's legal representative will pay 1 lakh. That is D. B's children will pay that 1 lakh. Provided there are assets. What if B has no assets at all?
Then
A will have to pay the entire 2 lakh. Is this clear? Huh? Pakka na? 100%? Okay. Sir, let us imagine B is C's friend, no? C will tell, Macha, you do one thing, you go. I will recover the entire money from your friend only. I will let go your right. I will collect the entire money from A. So, I can discharge you from the liability. Even if one party is discharged. Now, A will pay 2 lakh. But B is not discharged to A. B has to pay the money to A. Even if you are discharged from the other party, amongst you, between you, you are liable to the other party. Is this clear? Pakka na? 100%? So these are the rules of joint promisors. Sir, take the joint promisee. Imagine there is C and D. We borrowed a joint loan from them. C gave 1 lakh, D gave 1 lakh. Now imagine, sir, if D dies, what is going to happen? Legal representatives will be eligible to recover. Sir, if E dies, sir, the entire money will be recovered from C. The same thing applies for joint promisees as well. Promisor who borrowed the money. Promisee who has to receive the money. Is this clear? Pakka na? What is third person? Third person basically is nothing but I had to perform the contract. I send someone else on my behalf to perform the contract. So when a contract is flexible, it allows anyone to come and perform the contract. It is called as what? Third person. Now for example, let us imagine, now this cafes will be there, correct? In cafes off late you can see this live music's being performed. Have you guys heard something like that? These restaurants and all, they will call these guitarists to come and give a live performance. So I entered into a contract with A to come and perform in my cafe. On that day he is not feeling well. As a backup, he sent Mr. B to come and perform. Now the cafe owner, for him his respect is important. Someone should, because I sold tickets, I have charged for the food, saying it's live performance. Now if I do not allow these people to come and perform, that means my respect is going for a toss. So B comes and performs. The cafe owner does not stop him. He allows him to perform. Now is this contract valid? Yes. But imagine, sir, A sent B. The cafe owner said, no, you are not, I did not enter into a contract with you. A should only come and say, because it's a special talent. Singing is a special talent. Now can the cafe owner stop B here? Yes, you can stop. But if you did not stop, he will come and perform, then that means you are allowing him to perform. You cannot file for a compensation going forward. Remember this. Understood the scenario, na? Yes, sir. So on my behalf, if someone else is coming and performing, is called as third person. If my legal representatives are coming, that means it can happen in the case of death and such scenarios. Is clear? Understood? Okay. Sir, joint promisors, rules of joint promisors, we saw now. Okay. Rules of joint promisees. I can recover the money as a whole. If I die, legal representatives will be coming to recover. Okay. Next one, time and place for performance. Where is the contract to be performed, people? Where should you perform the contract? First of all, now imagine, people, A agrees to deliver goods to B. Now my question is, at what time should I deliver? Which place should I deliver? How will I know? First one, if at all in your agreement it is clear, it is to be delivered at this place, it is to be delivered at this time, then A has to deliver it at that time, at that place. The second scenario, the delivery is not accepted. A says only if you ask me to deliver, that time I will come and deliver. Now it is B's responsibility to request for home delivery, because by default A is not delivering the goods. Agreed? So whenever there is a contract which is made that you have to request for the delivery, a delivery will not be offered until you request for it. That's what is the scenario. See here. Sir, time, place, whether should you ask for it or it is agreed in the contract. Next one is what is the result. Okay. Sir, time is not specified. Place is also not specified. Sir, application is also not agreed. Then it is to be delivered within the reasonable time and promiser to ask promisee where to deliver. Meaning, we did not agree on where the product is to be delivered in the contract. Now I will ask you, sir, where do you want me to deliver? And within what time I have to deliver? It depends upon the product, nature of the product. That's the reason they have used the word called reasonable time. For a perishable goods, imagine if it's fruits, milk products, the reasonable time can be even 1 hour. If I'm talking about mobile, if I'm talking about any other goods, then the time can be even 2 days, 3 days also. So reasonable time, when time is not agreed, reasonable time depends upon the nature of the product. Next one is, if time is specified, place is specified. I'll have to deliver it in that time, I'll have to deliver it in that place. When the time is not agreed, when the place is also not agreed. But in the contract it clearly says it is the buyer's responsibility to ask for the delivery. Then until you ask for it, a delivery will not be made. So it is the promisee, that is the buyer's responsibility to make an application, meaning to request for the delivery. Is this clear? Pakkana? Okay. Next one, sir, reciprocal promise. What do you mean by reciprocal promise, people? A agreed to deliver the goods after 1 week. B agreed to pay the money after 1 week. A contract is made today. Let us imagine Amazon cash on delivery. Cash on delivery is what? Reciprocal promise only, no? I am agreeing to sell the goods after 1 week. You are agreeing to pay the money after 1 week. Both of us today are just promising each other. Is called as reciprocal promises. Simple, na? So reciprocal promises, what are the rules? Simple thing, they might not ask in detail for reciprocal promises, but just know and go. Promise not bound to perform unless reciprocal promise is ready and willing to perform. I will not deliver the goods until you are ready to pay the money. When one fails to perform, he cannot compel other party to perform. If I do not pay, can I tell you to give the goods? Order of performance. Who should first give? Should I first deliver the product, you will give the money? Or should you first give the money and then I will deliver the product? It is according to the contract. Flipkart terms clearly says, once the money is delivered, a product will be given by the delivery boy. I mean, first the product will not be given and then not the money will be collected. First the money will be collected and then the product will be delivered. It is as per the contract. Sir, what if contract is silent? Then it is according to the nature of transactions. Meaning, if you go to hotel, if you go to service section, first you eat, then you pay. If you go to your no service section, you will have to first pay and then eat. So it is nature of the transactions. Next one, reciprocal promises which are legal in part if separable. Then whatever is legal is enforceable. Whatever is not legal is unenforceable. You can take the same thing, kidnap and Zoom cars. If at all a contract has two parts, one is legal part, one is illegal part. Legal part can be enforced in the court. Illegal part cannot be enforced in the court. Next one, liability of party preventing the event. Meaning people, imagine if one party is stopping the other party from performing the contract. In such case, whoever is being stopped, he can count this contract as voidable. If he thinks this cannot be, it should not go through, I can say I do not want to go through the contract. I can even claim compensation. I told you example also of this, right? What is that? I'll tell you one best example. I'm planning to sell one sofa. Yeah. Now I'm telling you it's ongoing. There is one buyer who said I want to buy the product also on OLX. And he took the number on WhatsApp also that I want to buy. I had another 3 or 4 offers I had. I said, this product is already sold. And from the past 1 month, this buyer is telling, sir, I'll come tomorrow. Today I have met with an accident. Like this, from the past 1 month, this person is telling, sir, I'll come tomorrow. I'll come tomorrow. Now people, liability of party preventing the event. He said he want to buy. Is he coming to buy? The answer is no. Now what do I have to do? I will wait for 1 week. And after that, you know what I'll do? I'll say, I don't want to sell you the product. We have agreed. In OLX, I have agreed on the price. I'll say, I do not want to sell it to you. I will sell it to someone else. But you know what? Imagine we agreed for selling the product at 10,000 rupees. But now I know I have removed my ad on OLX and all. OLX does not let me post another ad for the next 60 days. There is a cool off period of 60 days. Now because of that, I was not able to get a right platform. I sold it to some carpentry shop. Now you know what is the price they take. Now they took it for 7,000. Did I made a loss? How much? 3,000. I can recover it from the previous person. If I go to court, can I prove it? Yes, I can prove it. I have everything in written. I have everything chats. That's what is this. Understood? Party preventing means you entered into a contract and you are only not allowing the contract to go through. Understood? Yes, sir. Next one, sir. Impossible act. If it is initially impossible, people, it will be called as void agreement. You entered, it was valid. Later on, it became invalid. It becomes void contract. That's why it's called as initial impossibility, subsequent impossibility. Okay, next one. Effect of failure to perform. Time is essential, time is not essential. Time is essential, voidable plus compensation. Time is not essential, not voidable plus compensation. What is the example? That wedding thing? That wedding suit and all, something you had ordered. So imagine for your wedding you have ordered for a dress. Is time essential? Is it okay if they give you the suit after your wedding?
No.
You should get it within the time. So if a product is depending upon the time, if time is very crucial, if that is not done within the time, you can cancel the contract. You can also claim compensation. Sir, mental trauma, mental distress. Sir, if the time is not essential, on a normal day you guys will be buying 100 things on Flipkart and Myntra. 1 day delay won't change anything in your life. You cannot cancel the contract, but you can claim compensation. 50 rupees, 100 rupees, one coupon, that you can claim. But you cannot say I will not accept the product at all. That's the difference. Clear? Yes, sir. So next one is called appropriation of payment. What is appropriation? Important from exam point of view. What is appropriation? Now imagine people, A, B. You tell me a scenario. B has given loan to A. 3 loans he has given. 1 lakh, 2 lakh, 50,000. He has given 3 loans. One was given in 2020, one was given in 2021, one was given in 2022. Yes, sir. Now A is repaying the loan, people. A repaid 50,000 loan. Now you tell me towards which transaction is this 50,000 repaid? Is it towards 2020? Is it 2021? Is it 2022? So first priority is given to whom? No, I am telling you to name towards which transaction I am paying this money. The first priority is given to which party to choose. Is it A or B? Debtor gets to choose first or creditor gets to choose first? Who gets to choose first? Creditor or debtor? Debtor. Remember, the first priority is always given to the debtor. Debtor comes and says, I am repaying the loan towards this transaction. It is considered to be for that transaction. Sir, if A does not tell anything, then it's B's wish. That is creditor. He can take it towards any transaction he wants. What if B also does not say anything when he is taking the loan? So that time you have to go according to the time of transaction. Whichever was taken first, it will go accordingly towards that transaction. Understood? Pakkana. Now I'll give you a scenario. Exam based question. Try to think and answer. A took all these loans. A repaid 50,000 back to B. A did not say anything. B also did not say anything. Now towards which loan will you take this 50,000 towards?
1 lakh.
1 lakh? Pakka na?
Yes, sir.
50,000.
50,000. Why? Why 50? Why da? Ah.
When better means the payment of the debt which is similar to the payment
Ah.
should be considered to that.
Very good. Correct only. Understand? Okay. Now people read this people and see if you are able to understand anything here. Where a debtor owing several distinct debts, correct? 1 lakh, 2 lakh, 50,000 to one person makes a payment to him, either with express intimation, macha, take it towards first debtor, take it towards second debtor, towards third debtor, express, or under circumstances implying that the payment is to be applied to the discharge of some particular debt. The payment, if accepted, must be applied accordingly. You know what is the second thing means? Or under circumstances implying, one is express, one is implied, that the payment is to be applied to the discharge of some particular debt. Meaning what, people? One, I get a chance to say. Second one, I have 3 debts. One is 1 lakh, one is 2 lakh, one is 50,000. When I am specifically paying 50,000, what is implied? There are 3 debts. What is that can be implied that when I pay 50,000, towards which transactions I might be repaying? Correct? So when I have exactly 150,000 debtor, it has to be understood accordingly that you are paying for the last transaction.
Okay, suppose you are paying back 60,000.
Now
then
take
it will go to the
2 lakh 60,000. Okay, now you take it is 50,000. Correct? This was a debt. Now let us imagine I am repaying 60,000. Is there any debt exactly for 60,000? Now A did not name. Now B did not name. 60,000 will go towards first transaction. Understood? So the implied condition is that whenever there is an exact amount, when he pays the exact amount, take it towards that because it is implied. Whenever there is no exact amount, you are paying a random number, then you will go through this model. First in, first out. Clear? Pakka na? Very good. Okay. Next, what else is there? That's all. Appropriation of payment. So one is debtor, one is creditor, next is according to the FIFO method. Contracts which need not be performed, one is mutual agreement. Section 62 says mutual agreement. What is that? One is called as novation. What do you mean by novation? Novation means in the place of an existing contract, new contract comes into picture. So it's like you guys had entered into a contract. So A and B had entered into a contract. A had taken loan. A had to repay that loan to B. C will come and say, A, you come out, I will pay this money on your behalf. Now the contract is entered not between A and B, it is between C and B. Now this is called as novation. Agreed? Next one is called as people. What is the difference between novation and alteration? Novation, there is always change in parties. Alteration, there is change in terms. A loan was taken. The rate of interest was 10%. Now you want to make it 8%. It comes under alteration. Now I have a bank loan. Next year, RBI changes repo rate. My rate of interest will decrease. Now this is called as alteration. Now imagine I have taken a house. I have a housing loan. I sell my house to Kamran. Going forward, this house loan has to be paid by Kamran to the bank. This is called as novation. Same housing transaction, same loan, change in interest, alteration, change in party only. Going forward, Kamran has to pay. That's called as novation. Clear? Understood? Okay, next one, rescission. Rescission means what, people? Cancellation. Where a party does not perform a contract, I can cancel the contract. I had a wedding. A person has to deliver me the suit within a certain time. If you do not deliver the suit within that time, I will not accept the suit if you give me the next day. I don't have any use of the suit now. If you give it also, I will not take it. Why? I am cancelling the contract right today. After I cancel the contract, I will not accept the contract. Yes. The next one is called as remission. Remission means what? Waiver. Give up. Vijay Mallya had taken 9,000 crore loan. He could not pay 9,000 crore loan. He went with a proposal to the bank. Macha, the last amount I have is 5,000 crore. If you accept it, I will pay 5,000 and we are done. That's all. You should not ask the rest of the 4,000. If the banks had accepted, this is called as remission, waiver. They are giving up their right. Tomorrow when Vijay Mallya has money, you cannot ask for the 4,000 crore. Because you accepted a deal today. It's done. Understood? Pakka na? So these contracts need not be performed. What need not be performed? 4,000 need not be performed tomorrow because you accepted it today. That's only called as novation, remission, rescission, alteration. Understood all four? Novation, new contract comes into picture. Alteration, change in terms of the existing contract. Next one is rescission, cancelling the contract. Remission, giving up the right. The last one, promiser need not perform when promisee neglects performance. Correct? I think I had given the example of teacher-student. Student neglects revising and coming. Promiser is discharged from the liability. Correct? Yes, sir. Yes, sir. Next ones are discharge of a contract. When and all a contract will be discharged, it can be discharged by performance. Discharge means again same thing. Contract is coming to an end. You guys both perform your contracts. I do my service. You pay the fees. We are done. Next one, mutual agreement. Whatever we just saw. Alteration, waiver, remission and all. Impossibility of performance. Subsequent impossibility. Contract comes to an end, right? Death. SP Balasubramanian sir passed away. What will happen to the contract? It will come to an end. Discharge by lapse of time. What is this? Time bar dates. Or by operation of law. Change in law. Subsequent impossibility. Change in alien enemy. All this will come here. Breach of contract. That's your next unit. Merger of rights. What is merger of rights? A, B. B is the landowner. A is a tenant. I stay for a rent in B's house. Now Vastu Prakara it worked for me. I asked B, sir, can you sell me your house? B agreed also. So we entered into a sale deed. Now at the same point of time there is rental agreement also. There is sale deed also. So should I be considered as a tenant or owner? Whenever there is two rights, as a tenant and there is owner, whichever is superior, is tenant superior or owner superior? Whatever is superior will go through. In merger of rights, the superior agreement will be valid. The sale deed will go through, the rental agreement will come to an end. Clear? Yes, sir. So that's your end of unit 4. I hope you guys understood. Any doubts? Any doubts? No doubts? Okay. Let's go for a break and come on. Okay. So let's resume Indian Contract Act. Unit 4 done. Let's start with unit 5. Yes, sir. Okay, so let's start with unit 5, breach of contract and its remedies. So in the last part we saw certain contracts are discharged, certain things by notice, by time, by various other scenarios you saw that the contracts will be discharged. And one of such scenario was breach of contract. Now what do you mean by breach of contract? In short, a person has promised that he will be doing something, he will break the promise whatever he has done. Now that is called as what people? Breach of contract. Whenever there is a breach of contract, the other party, whoever has been in a right position, will always enjoy certain rights. Whenever there is a breach, there is certain rights that is enjoyed. Now what are those rights? What happens is what this particular unit is. So types of breach. I can say that breach are of two types. One is called as actual breach, one is called as anticipatory breach. What do you mean by actual breach? When the performance of the contract is due or during the performance. Meaning what? Let us imagine when the contract is going on. Now let us imagine this way, the contract is going on, I am taking the class for you. Now something which is disturbing that happens, there is some rupture that happens. Now what will I do? I will just walk out from here. I have just done half thing, I will not continue with the half thing, I will just walk out. Now what is this during the performance? When the contract is going on, see, before starting, during the contract going on, one is after the contract. Imagine a contract can be divided into 3 phases. Before the contract starts, when the contract is happening. So when the contract is happening also, if you end the contract, it will come under actual performance. Next one is, imagine today morning at 10 o'clock the class has to start. At 9:30 I say, no, I do not want to do it. So I will tell on the day of the performance, before the contract starts, I want to stop the contract. That also is called as actual performance. So then what is anticipatory performance? Now imagine if the marathon was, it was scheduled on say 12th of May. I intimate on say 8th of May that I cannot do this marathon. I'll intimate well in advance that I cannot do it. Before the due date, I'll be intimating that I'll not be able to perform the contract. That comes under anticipatory breach. Understood? One is during the performance, one is before the performance starts, next one is during, basically in advance. If at all someone communicates before the performance begins, is called as anticipatory performance. Is clear? Yes, sir. Okay. Sir, okay, anticipatory breach, sir, will give me two rights, sir. What is that? One is you can resign him. First of all, anticipatory breach will give me two rights. One is you can cancel immediately and you can claim compensation. So we had seen one example. What is that? Imagine A orders for some 1,000 shirts from B. The due date to deliver the 1,000 shirts will be, say for example, 10th of May 2024. Now, 1st May is when the order is made and 10th May is when the order has to be delivered. So B will take up the order and he will say I will deliver the goods, but on 5th of May he will call and say because of some reason I am not able to deliver the product. Now when he informs in advance that he will not be able to perform the contract, and this will be termed as what? Anticipatory breach. Now what can A do? A has two rights. B has intimated he cannot perform the contract on 5th, correct? Now A has two rights. Right number one, on 5th of May only, he can straight away cancel the contract. That means tomorrow if B is able to do, A will not accept the contract. Even if you are able to perform, I will not accept it. The second one, instead of immediately cancelling the contract, I will wait till the last day. I will give you a chance. You try. Even on the last day, if you are not able to perform the contract, then I will cancel the contract. Sir, whether I will cancel immediately or whether I will cancel on the last day, still I will be entitled for compensation. Whether I do it immediately also, I will be entitled for compensation. Whether I do it in the last day also, I will be entitled for compensation. Sir, what do you mean by compensation here? Compensation here means, people, now B did not deliver the goods. Imagine one pant was sold at 200 rupees. That was the price of a pant. Now, this amounts to 2 lakh rupees. Now, because B did not deliver, A had to buy the same pants from Mr. C for 250 rupees per pant. Because you did not give it, I will have to buy it at 250 rupees per pant. 50 rupees extra I am incurring. That I can recover from you as compensation. Understood? However, here there is one risk. What is that risk? If I wait and cancel, there is one risk involved. What is that risk? The risk of subsequent impossibility. What do you mean by subsequent impossibility? Let us imagine B informed me that he cannot perform the contract on 5th May. But I kept the contract open till 10th May. If I had asked now only, on 5th May, if I had cancelled and if I had asked money, I would have got 50 rupees per pant. That is equal to 50,000 rupees I would have got. But what did I do? I said, no, I'll wait until the last day. Now imagine, people, on 8th of May, what happened? The entire factory, people, was caught fire. There was a short circuit. The entire factory caught fire and the entire godown is gone. Plant and machinery, everything is gone. Now, B is obviously not able to deliver the contract. Agreed? Now, A, can he claim compensation in this case? The answer is no, because a valid contract, because of impossibility of performance, now becomes a void contract. Void contract discharges the party, contract comes to an end. You will not be benefited with 50 rupees. That's the risk of keeping the contract on until the last day. If you are ready to face that risk, then yes, you can take up until 10th May. Is clear? Pakka na? Understood the scenario? However, remember, impossibility is different, Difficulty is different. Now B's employees went on a strike. They did strike, dharna. We wanted price increment, wage increment. On 7th, 8th, 9th, they went for a strike. Because of which B could not deliver the shirts on time. Pants on time. Now people, B is telling A is so sorry, I am not able to deliver the goods on time because of impossibility of performance. Now tell me, can A claim compensation or not? Can A claim compensation or not? A can or not? He can because of the workers I am not able to deliver the contract. Yes or no? No people, A can deliver. What did you say? A can. Yes people, A can claim the compensation. The reason is, this is not impossibility, it is difficulty of performance. You can hire new employees, you can give them extra wage and you could have made them do it. You had an option, you did not do it. COVID lockdown, impossibility or difficulty? Impossibility. Entire country was shut down. If you go out, Anna came with lathi and hit you on the back. Correct? So impossibility, you cannot perform. That is the difference between impossibility, difficulty. Difficulty will not discharge you. Impossibility will discharge you. Exam important, remember the points. Clear? Yes sir? Okay, done. Sir, now whenever there is a breach of contract, nanagenu, what are the remedies? Remedies people, first one, you can sue for damages. Yes sir? What are the damages? We will see. Next one, you can rescind the contract. What do you mean by rescind the contract? If you legally, properly cancel the contract, tomorrow he cannot come and compel you to accept the product. Cancel it. Just be done with it. Okay, next one. Suit for specific performance. What is suit for specific performance? Now, A and B, there was a contract for the 1,000 shirts. Now, B says, sir, I will give him compensation, sir. Tell him to go. A says, no, sir, I want shirts only. Because of the material he might use. Now imagine, shirts, you might think everything is common. Imagine A placed the order with B for Kanchipuram saris. Now not everyone can give this particular variety of sari. Agreed? Now for me that sari has a special value. Now wherever a product has a special value, I can go and request to the court, I don't want monetary compensation. I want you to tell the other party to perform the contract only. Specific performance, tell him to perform. I don't want money in return. Remember, courts will not order for specific performance unless the product has some really special value. If at all it's a regular product, if at all it is a regular product, meaning available anywhere, court will not order for specific performance. Court will give specific performance only in two places. When money is not the right compensation. Second, when the product is really unique and it has a special value, like antique or emotional bonding, only then the court will order for specific performance. Clear? Next one, suit for injunction, stay order. Sir, tell him to stop, sir. Forget about until we fight, we will fight. But they cannot construct the building. You know Vega City? Vega City Mall. Vega City Mall was the first mall of Bangalore. You know? But the first mall which actually was launched was Forum. But technically the construction was first the Vega City Mall. Vega City Mall construction was completed when I was in school. I'm telling you, when I was in school, Vega City was completed. Bannerghatta Road, I don't know if you guys know it or not. When I was in school, the construction was done. That means there was a litigation between two people. As long as the case was going on, the other party got an injunction order. What is injunction order? So they had completed 80%. They said, sir, going forward, they cannot complete any other thing. Interior, so other thing, it has to be open. And it took them around 16 years for that case to get settled. 16 years. You imagine even now how much ever he recovers, it's a loss only. Rent, how much he could have recovered. How much of investment would have gone in. Now what did one party said? Sir, until the case is clear, the construction should not proceed. Correct. Until the case was clear, construction did not proceed. The court ordered so. And what is the order passed by the court? Was called as injunction. Stop. Stay. Constructing. No, stop your construction. Understood? Next one we will, quantum merit. What is quantum merit? Quantum merit means as much as performed. What do you mean by that, people? Imagine I am hired for 1 month of employment. Because of some reason, not my fault, not the company's fault, but something technical error, they had to remove me. Did I do something wrong? I did not do anything wrong. Okay, when did they remove me? Imagine they removed me after 15 days. I worked for them for 15 days. After that, they removed me. You tell me legally, am I entitled to some remuneration? Should they pay me some? How much? Whatever. See, I am technically entitled for 1 month's salary. But you at least took my services for 15 days. Rest of it I did not work. But I at least worked for 15 days. At least pay me for that 15 days. Now that is only called as much as performed. See, contract came to an end. But for that you cannot say I will not pay you at all. You have to pay me at least for what I have worked. Sir, now I have a problem. What if I worked for 1 month also? But they did not like my performance. So they removed me. But they didn't pay me at all. Is it valid? 30 days I worked. I did not do proper work. Can they remove me? Okay, they removed me. Should they still pay me? How much? Huh? They should not pay? How can you say that? You don't have any soft corner towards me? Yes sir. ಮತ್ತೆ ಅದೇ ಮತ್ತೆ so they will pay me something. They can deduct for whatever are the mistakes I have done. Imagine I did a wrong poster. Because of that you lost some money. You deduct for the sloppy work I have done. But you cannot say you are not entitled for the money at all. I think in your example I had given you the paint example. I hired a services of a carpenter or a painter to paint this entire building. He did the work. But I can see patches. Here and there I can see patches. He has not done that. Now what do? I'll say, Goda, I'll not pay you at all. 4 lakh deal it is. Now because he has done that, I'll say, I'll not give you 4 lakh. Will he? Night only he'll put one atom bomb. So I can reduce some. Now what I will do? I'll call another person in the market. He charged me some 50,000 to cover these patches. So how much I will pay him now? Whatever is the deal we spoke. 3 lakh minus 50,000, which I had to pay to someone else for his sloppy work. So I will pay him 2,50,000. I have to pay. That's called as quantum merit. That's the remedy you have. It's clear? Yes sir. Okay sir. Next one sir. The suit for damages. So whatever the suit for damages sir. So you can ask for some compensation. What compensation I'll ask for? First one is general or ordinary damages. Meaning what? Whatever is compensation directly proportional for your contract, that will be awarded. That will be given to you. Sir, there was one case law, people. The case law is called as Hadley versus Baxendale. What happened in Hadley versus Baxendale? There was a factory. There was a flour mill. In that flour mill, one equipment was not working. And that equipment is called as crankshaft. Now this person had to service it. There is no one in this town, so I had to send this to a service to another city where a person is ready to service this particular equipment. So what did I do? A went to a courier person and said, can you please go and deliver it to this city and get it repaired and get it back. And I asked him how many days will it take. He said 2 days. Now technically I gave it also, but in reality by the time I got back the goods, it was around 15 days. There was a 13 days delay. And why was this delay for? Not because of the repair, it was because of the courier agent only. He did not take it on time, he did not bring it on time. Now the factory person filed a case on the courier person. Why? He filed a case saying, because of this person, I did not have this equipment. Because of that, my factory was closed for 15 days. He has to give me the remuneration I would have got for this 15 days if at all my factory had worked. The matter went to court. Now you tell me, what should the courier person pay? Should he pay for that entire 15 days turnover that the factory should have made? It would have made. Should I pay for that? ordinary or general damages says people, did you intimate the courier person this condition that if at all you make a delay, your factories will be shut? Did you inform him? Now the question I'll ask you, did you inform him? If at all, if you have informed him, the matter will go to the next damages, that is called special damages. When special conditions are communicated, you can even take compensation for the special conditions. If special conditions are not communicated, then you will get damages, not for your factory being shut, he doing a delay in delivering. Imagine if at all he is charged 2000, that will be reduced to 500 rupees. That is called ordinary. Whatever I agreed to do, for that I will be charged. For your factory, I am not responsible. Whereas if at all the condition is communicated, then it will become special damages. Then yes, you can recover for that also. Clear? Yes sir? Hadley versus Baxendale, important from an exam point of view, remember. Special damages is when you communicate a special circumstance. Next one, vindictive or exemplary. What do you mean by vindictive or exemplary? These words means people, revenge. So when will you take revenge? One people is marriage agreements. When someone promised to marry you and if they do not marry you, what will happen? Buddy sir, oh my god, too many things will happen. Correct? Now I want to take revenge on the other person. What will you do? You can file a case. Obviously you cannot force someone to get married. Courts cannot order that. Impossible. Court cannot say no, you guys have to get married. That is impossible. Court can always tell you not to do something. Court can never tell you to do something. It is your right, it is your fundamental right to choose to what to do. Understood? For example, a film actor would have signed a movie. He would have signed. A producer will go to the court and it will ask, please tell this person to do this movie. Court cannot go against your will. Court can say, you do not want to pay him compensation, pay 10 crores also. But I cannot force you to do something. Court does not have that power. Understood? Pakka? Yes? I'm telling you, wherever your not products, but your it's not materialistic things that is involved. It is something to do with your will. If that is the case, courts can't force you. The acting comes under that. Understood? Yes, okay. So vindictive or exemplary damages comes whenever you break a marriage contract, or it can come in a case where, imagine I give you a check. Now you go and deposit the check in the bank. My account has balance, but the banker wrongfully types one number wrong and he says my account does not have balance. In spite of having balance, he says this account does not have balance. My reputation in the society is gone. So if you are a businessman, the compensation will be more. If you are a normal layman, the compensation will be less, because it is directly paid to the reputation. Yes? Okay. Next one is called nominal damages. Nominal means what, people? We generally say nominal charges. Here they give you compensation. Courts will order compensation just to satisfy your ego. It can be even 100 rupees also. But in the court, in public, they will say, yes, you are right, he is wrong. That is what you want, that ego. That ego will be satisfied. Money is secondary here. That is called nominal damages. Next one is called as, people, deterioration caused by delay. What is deterioration caused by delay? Deterioration caused by delay is nothing but whenever you have ordered something, it can be a product or it can be goods or it can be perishable goods, whatever it is. By the time the goods reach your place, the product has lost its value. Imagine milk or imagine any fruits. So whenever the product reduces the value, deterioration happens, people, you can recover the money from the carrier, the courier person. You can collect the money from him. That is only called as deterioration caused by delay. Agreed? Yes, sir. Next one, prefixed damages, liquidated damages and penalty. So here again, people will find it difficult. What is it, sir? First of all, what is prefixed damages, people? In the contract only. Now whenever you join the Arivu, imagine there is a clause which says, people, if at all you do not pay the fees on time, you are liable to pay. Imagine if the fees is 20,000 rupees, you'll have to pay extra 5,000 rupees as penalty. Yes, sir. Now this is only called as what people? Prefixed. If you do not do the contract on time, you know what is going to happen. Agreed? These are called as prefixed damages. In the contract only everything is there. Sir, now I have a doubt. What? Let us imagine a scenario that A ordered shirts from B. The value was 2 lakh. In the contract it was written, if at all any party fails to perform the contract, you need to pay a compensation of 1 lakh rupees. It was written in the contract. Clear? Now because of some reason B did not perform the contract. A had to get the product from someone else. A had to incur 2.5 lakh as his cost. Now A wants to recover money from B. How much will A recover from B?
2 lakh.
No, 2 lakh he has not yet paid. So whatever I have not paid, that I will not recover. Compensation will only be for what has cost you more expense. 2 lakh anyway I had to pay. Now what is the extra money I had to pay? One is 50,000. The second thing I can recover is 1 lakh. So what can I recover? 50,000 or 1 lakh? 50,000 only, not 1 lakh. But in the contract we have agreed as 1 lakh. Whichever is less. Do not write that whichever is less thing in the exam. I told you guys also that is only for our internal understanding. We have written there, no. In the exam, don't write that whichever is less concept is not there. That is only for our understanding. Yes, sir. So what is that whichever is less concept? Indian courts will never order more money than what you lost. Again I repeat, Indian courts will never order more money than what you lost. Here you guys have agreed for 1 lakh, I agree. But how much have you lost? You have lost only 50,000. So for you to make compensation for a justice, 50,000 is justice. 1 lakh is not justice. 1 lakh is extortion. Agreed? Now take the second scenario. What was agreed was 1 lakh. What I actually lost was 1.5 lakh. How much will the court order for recovery? 1 lakh or 1.5 lakh?
1 lakh.
The maximum you guys have agreed in the contract only is 1 lakh. Why will court order for 1.5? 1.5 will never be ordered. That's the reason to understand this we said actual damage or whatever is the prefixed damage, whichever is less. And that's
What
how.
if the actual damage is more than the prefixed?
That's what is the case, no? Actual damage is 1.5 lakh. Prefixed damage is 1 lakh. You guys have only agreed. If anything happens, you have to give me 1 lakh. Then why did you guys agree? So court will never order more than what you guys agreed. Agreed, huh? Sir, now I have a doubt. What? First of all, is there a difference between the words liquidated damages and penalty? Is there a difference between these two words? Liquidated damages and penalty. Is there a difference? In Indian scenario, there is no difference at all. For us, there is no concept called as liquidated damages and penalty. But this exists in people in UK. Liquidated damages and penalty. Sir, first of all, what is the difference, people? Simple. You look at the amount used. 2 lakh is the contract. If 2 lakh contract is not performed, compensation is 1 lakh. Papa B, as long as the contract is going on, he will have a heart attack, mini heart attack every day. He knows if I don't do this, I'll have to pay 1 lakh. Don't you think it is creating a sense of fear in your mind to complete the contract? That is the purpose of the word penalties. Meaning it is used for creating some terror. That's the word used, terrorism, to create fear in your mind. That's why we use penalties. Liquidated damages, people. Now imagine, if at all you did not pay 2 lakh, if you do not deliver the pants within time, you will have to pay me a compensation of 20,000. Why? Because if I am not giving it to you, you will go to another person, he might charge another 100 rupees extra. Reasonable. How did you arrive? I did a market research. I got a common average price. I know the maximum that any other vendor will charge is 100 rupees more. Agreed? Now this 20,000, does it induce fear in B? The answer is no. It is reasonable. For not delivering the order, I have to pay 20,000. Now what is the difference between 1 lakh and 20,000? 1 lakh is creating fear in your mind. 20,000 is nothing like that. There is no fear that is created. It is used only for giving a proper compensation to the other person. Second one, how did I calculate 1 lakh? Nothing. Hey, take one random number, inki pinki ponki, I take the 1 lakh. That's all. How did you calculate? There is no calculation. It's an arbitrary number. It's a arbitrary number. This is a calculated number. How did you calculate it? You took a average of your competitors. You did your research, and that's how you arrived at this number. Agreed? Yes, sir. So that's the reason. Always remember. First of all, this difference does not arise in the case of Indian scenario. And what is the basic difference? The basic difference is that penalty is used to create some fear in your mind, terrorism. It's not a logically calculated number, it's an arbitrary number. On the other hand, liquidated damages are the calculated numbers. They are reasonable. This is called as liquidated damages and penalty. Exam point of view, important, remember. Clear? Yes, sir?
Yes, sir.
Done. Okay, that's all. That's your unit 5. Next one we will unit 6. Any doubts? Online? Any doubts online? They online? Clear? Okay. Okay. Quantum merit is nothing but as much as performed. Meaning whenever there is a contract which comes to an end abruptly, should you pay some money? Yes, you need to pay money for whatever work you got it done. So quantum merit stands for as much as performed. So for whatever is the work you have taken from the other party, at least for that you need to pay. If not the complete payment, at least for the work you have taken, you need to pay. That's called as much as performed. That is called as quantum merit. Clear? Okay. The next one, people, is contingent and quasi-contracts. So what do you mean by contingent contract, people? A contingent contract means nothing but an contract which is depending upon an event which may or may not happen. So if I have to tell it this way, a contingent contract, I can give you some examples of contingent contract. Example of contingent contract is indemnity contracts. Another example is guarantee contracts. Another example is wagering agreements. Wager also contingent only. No, what do you mean by contingent? What do you mean by the word contingent? May happen or may not happen. So all these are the examples of contingent agreements only. Any examples of indemnity contracts? Insurance contract is an indemnity contract. Guarantee is nothing but surety contracts. Wagering is nothing but your lottery betting, whatever we have seen. Section 30. Is clear? Yes, sir. Our indemnity and guarantee is only our next unit. We will see in detail in our unit 7. Okay. Essentials of a contingent contract. Contract depends upon an happening or a non-happening of some event. The event is collateral to the contract and it should not be part of consideration. Event should not be a mere will of promisor, not under party's control. What do you mean by that, people? When will I call any event as uncertain event? It should not be under my control. It should be beyond my control. Whether CSK versus RCB will win, it should be beyond my control. I'll bet that it will rain today. Do I know when it will rain? It is beyond my control. It may rain, it may not rain also. So it is not under my control. So if at all it is completely under your control, it cannot be called as a contingent contract. It should be beyond your control. You should not have any personal interest involved. Is clear? And such things are called as what, people? Contingent contracts. Yes. Okay. Rules relating to enforcement of contingent contracts. You guys remember this? You want me to cover this? Rules relating to enforcement of contingent contracts. You remember this? You want me to cover? You remember? Sir, technically we don't remember anything. Sumne ella madi. Okay. You remember or not? You remember?
So this frost and night, will it be even for vindictive damage?
Yes. Frost and night will come under vindictive. Because a person promises to marry as long as my father is alive. As the father was alive, he married a different girl. So he broke a pact of getting married. So can the girl now go and file a case? Yes, she can file a case. It will also be coming under contingent on a living person. Yes, okay. Yes, people. You guys remember this or you want me to do this? Rules relating to enforcement of contingent contracts. Sir, when we are silent, you should understand we want it to be done. Yaki, sir, you will do this way. Correct? Okay. Rules relating to enforcement of contingent contract. Okay. Let us take the first example only. First, we will take one thing, a guarantee contract. Now, let us take it this way. Let us take let us take a loan agreement. Now, for example, imagine this way, that I want a loan. So, I have gone to a bank. I have submitted a loan application. The banker has told, sir, if you want a loan, you also have to give us a collateral. If you give us a collateral, something as a security, we will be able to give you the loan. I said, is it a sir? Yes, sir. Okay. Sir, by when do you want the collateral? Sir, now whatever is the agreement we have entered, it will be valid for 10 days. Within 10 days, if you give us the collateral, we will give you the loan. If not, this loan agreement will come to an end. I said, okay, sir. Just give me 10 days time because I have ordered for some goods which is coming via ship. I have imported. It is coming on the way. I can give that only as collateral and I can take loan. The bank asked, okay, what have you imported, sir? Sir, I have imported gold. You have imported gold? Yes, I have imported gold. So let the gold reach home safely. It is coming in a ship. It is coming in a ship. Let it reach safely. Once it reaches safely, I will give it to the bank. You can give me the loan. Agreed? Till now clear? Now, when can I enforce this is a contingent contract. Again, it may not happen. Why it may not happen? There is no guarantee that the ship is going to reach to the shore safely. There is no guarantee. It may reach, it may not reach also. Such agreements now becomes contingent contracts. Now I can take loan provided the ship has to reach safely. Agreed? Yes, sir. Now you tell me, there is a contract that is made for a loan. Gold has to reach safely. Imagine people on 4th day, Pirates of Caribbean, they came, Jack Sparrow, he came and he took the entire gold, people, he left. Now what will happen to the contract? The contract, can it perform now? Can you get back the gold? Can you go and do some dealing with Jack Sparrow and all? Impossible. Or Titanic, people, breaks to dubuk, it goes to dube, it goes inside, people. Now tell me what will happen to the contract? Subsequent impossibility, no way you can get back the gold. Agreed? Now contract becomes what, people? Void contract. If at all anything happens to the ship, contract becomes void. You cannot enforce this contract. Sir, I want to enforce the contract. What should happen? The ship should reach safely. So the rules of enforcement of contingent contract, the first rule says, on an event happening, the ship happened to reach the shore safely, I can go and get my loan. I can enforce the contract. If the ship does not come and reach the shore safely, I cannot enforce the contract. So when can I enforce? The first rule, if it is depending upon the event happening, the ship should come. If it doesn't come, I will not get the money. So on an happening of an event. And within how many days it should come? 10 days. Next rule, on an event happening within fixed time. I have given you a timeline. If it comes within the timeline, you will get the money. If it does not come within the timeline, you will not get the money. Within fixed time. Understood? Pakana. Sir, within this fixed time, anything that happens to the ship which makes it impossible to come to the shore makes it void. Understood? Pakana. Okay, next scenario. Sir, now I am feeling scared. Why? What if this happens? I will never get the money. And you know what is the value of the gold that is coming there, sir? The value is 100 crores. What if something happens to this gold? What do I do? So, you go and take insurance, da macha. Why take risko? Take off insurance. If something happens, you will get insurance money. Now tell me, people, when can I go and sit in an insurance company officer and when can I tell them, hey, paid our money, see it happened. Paid. When can I go and ask that?
When ship does not come. When ship does not come.
So, enforcing of third rule of a contingent contract on an event not happening. Insurance company told me, if at all, sir, Kamran sir, if at all your ship does not come, we will pay you money. Kamran sir, insurance, if your ship does not come, we will pay you money. That's what is the insurance, no? If it doesn't come, we will pay. So you can enforce the contract when the ship doesn't come. So when will you go and enforce? Imagine now the same thing happened. Jack Sparrow, he came and he took the entire gold. Now can you enforce the contract? Yes. Now imagine Titanic, it breaks. Can the ship still come? No. It becomes impossible. Now I can't take the money because that was the insurance contract. Agreed? Now I can go and ask for the money. When the event becomes impossible, because that is what is the contract. Now he told me, sir, when the ship doesn't come, we will pay you money. When the ship is sinking, where will I get the money from? Where will I get the gold from? It is impossible. No way it can come to the shore now. I can go and enforce the contract. Now look at the third rule. Read. On an event not happening. So it can be enforced when event only becomes impossible. So shipper breaks. No way it can come and reach the. I can go and enforce the money. Next one, within 10 days. Because insurance contracts will always be valid for a certain period. So if it does not come within this time, we will give you the money. If it does not come within that time, we will get the money. If it comes after that, we will not get the money. If it comes within that time, we will not get the money. Correct? Yes, sir. Now imagine they have given us 10 days time. Within this 10 days, if it does not come, I will get the money. Within this 10 days, if the ship comes, I will not get the money. Agreed? Yes, sir. Confusing,
Within 10 days it does not come and you get the money, but after the 15th day it comes. What is that?
So the contract was what? I'll get the money if the ship does not come within 10 days. It did not come, so I'll get the money. Is it how the marine contracts are made? Yes, marine insurance is made like that because of the delay. I'll tell you a simple thing. Imagine you order something from Alibaba. Now for you, I never know. Now most of the times what happens is time will be essential. I don't know. I would have ordered something. I have to gift it to someone. Now the event only happened. Now I am getting the product. What do? The first thing I will do is return the product. You put yourself into a customer shoes. If there is 1 day delay, will you take it? So if ship is coming late to the shore, the products in the ship will also reach the customer 1 day late. I don't know, I think I told you guys in the class also, there was something called as a Suez Canal. A ship was stuck for almost like 2 weeks or something. Because the ship was stuck, all the ships coming behind also was a very difficult task for them. They had to go very long route to cover that. So if those things happen, the people who are waiting for the products, your value will keep on going down. Understood? Okay. Next one, on an impossible event, obviously impossible events are always void contracts. It cannot be enforced at all. Next one, upon conduct of the living person, frost versus night. Meaning what? If at all a contract is made based upon a conduct of a living person. Say example, in this case what happened? A boy promised a girl, as long as my father is alive, I can't marry you. As and when the father dies, I will marry you. So this was a contract. Now what is this? This is called a contingent contract based upon the conduct of a living person. As long as he is alive, this contract is not enforceable by the girl. Correct? But what did the boy do, people? As and when the boy father was alive, he married a different girl. Now it is so obvious that as long as he is alive, he said, I am not going to marry you. He married another girl. So it becomes impossible for her to marry this boy. No? Now can she file any case? Yes, she can file a case, vindictive or exemplary. Revenge. She can get a compensation. Understood? Yes, sir. Now that is this particular case. These are the scenarios and these are the rules of enforcement of contingent contracts. Clear? Yes, sir. Once they have asked the rules, entire rules they have asked. Clear? Okay. The last part, sir, is quasi-contracts. What do you mean by quasi-contracts, people? What do you mean by the word quasi? Quasi stands for semi or similar to. Meaning, in terms of contract, whatever are the essential elements, all the essential elements are not present in this contract. But still, the law is telling you these will be considered as contracts. Sir, for example, whenever I find a lost goods, imagine I find some purse. According to the law, what is expected out of me? According to the law, it is expected you to go and give back the purse to the owner. Will you give? Hey, Kamrano, will you give? Illa sir, money in Gitcon will just throw it away in the same place. Yes, sir. So, this is only called as quasi-contracts. Quasi-contract says it is your responsibility to give back the product to whom it belongs to. So, quasi is nothing but similar to. So, in certain contracts, so in a general contract, there are essential elements involved. In a quasi-contract, essential elements won't be involved. But still it is a contract. I'll tell you one example. Minor's agreement is void. But minor is liable for necessaries. Where is it written? Minor technically should not pay even 1 rupee also. Where is it written? It comes under quasi-contract. Understood? Understood this one? Clear? Yes. So let us see what are the examples of quasi-contract. They can ask you a question here. So what and all are the scenarios where you guys can see a quasi-contract? First one is claim for necessaries by a minor and unsound mind. Why unsound mind? Imagine a person is not doing good. You help them to get their treatment, or you might be helping them to maintain their food and butter and shelter. Once they are doing good, can you recover the money from them? Yes, you can recover the money from them. Agreed? Yes, sir. So, sir, minor and unsound mind. But yes, people, both of them only to the extent of their property, not beyond that. Next one, payment by interested person. What is this payment by interested person? You take it this way, people. Now you look at the amount of investment we have made into this building. Agreed? Every year, people, you need to pay property tax to the government. Now imagine this owner of this building, he does not pay the property tax to the government. Government will send you a notice. Within this time, if you do not pay, we will seize this entire property. Owner will lose money, okay, but you look at our investment that is going for a toss. Now what will we do? Instead of our owner paying, we will only make the payment to the government. Arivu will make the payment to the government. Now tell me, who should have made the payment? The owner. But who is making the payment? Me. Now why am I making the payment? He cannot say, who are you? Who did we ask you to pay? He cannot say that. Why? Because even I have some interest in this property. That's the reason the word used is called as interested person. I am also having some right over this property. Now if I pay, tell me one thing, can I recover the money from the owner or not? Yes, you can recover. Now the question is, what if the owner says, did I ask you? Did we have a contract? The law says, even if there is no contract, that is only called as quasi-contract. Technically, you should have paid. On behalf of you, someone paid. It is your responsibility to repay it. And that is only called as quasi-contract. Clear now? Pakka na? Okay now? Okay, next one. Person enjoying the benefits of non-gratuitous act. Meaning, I ordered some food. In our academy only one day it happened. There was one person called as, I believe, Madhu. Yeah? Madhu had ordered food and they asked in the down floor, who is Madhu? There was one more Madhu in the down floor. The Zomato person delivered the same thing. It's Arivu only. There are two Madhus. One is student had ordered. There is one more person called Madhu in the down floor. So that person in the down floor took the food and friends opened, friends ate off also. And this person called the delivery guy. Where are you? Said, sir, I delivered. Where? And because it was within the organization, okay. Imagine if it happens in your society, your offices in MNCs or your house. Now what should this Madhu do? Down Madhu to up Madhu. That's what they're telling you. Person enjoying benefits of non-gratuitous act. Who in the world will come and give you food free of cost when you have not ordered? You should have ordered. If not, someone has ordered. If you have taken the benefit of it, it is your duty to pay back for that. Clear, huh?
So what's the case? Shamla and state of versus state of routine?
Shamla versus state of routine.
We have written it this here. Huh? I told you we'll do it in this one, partnership or something.
I don't understand the case.
Wait. That is also regarding employment only, I believe. Huh. Okay. The above can be illustrated by a case law where K, a government servant, was compulsory retired by the government. He filed a writ petition and obtained an injunction against the order. He was reinstated and was paid salary but was given no work. And in the meantime, government went on appeal. The appeal was decided in favor of the government and K was directed to return the salary paid to him during the period of reinstatement. Now what is that, sir? Now what are we seeing? Obligation of person enjoying the benefits of non-gratuitous act. Now what happened, people? There was an employee, let us take A, he was working for one government. Now there was some case going on between the A and government. So government removed A from his job. He said because of some reasons you are not supposed to continue. A went and filed a writ petition on government and said, whatever government writ petitions are nothing but you are going and asking the courts that whatever the company is doing, the government is doing, it is not right. Please come and tell the government to stop. The court said until the case is decided, you cannot remove him from his job because case is going on. Case is one thing, him working there is second thing. Until the case is completely decided, you cannot remove him from the job. So government said, okay, Your Honor, we took him back to the job and government did not give him work at all. But for entire time, it took around 3 months. For the entire 3 months, on the first of every month, they continued paying the salary to this employee. After 3 months, the case where government versus him, the case was going on, government won the case. Now they went back to the court and said, Your Honor, we have been paying him for the last 3 months without him working anything. Non-gratuitous act. Zomato. You did not earn it, but you got money. So please we request him to repay the money he has taken for all these 3 months. Court also said, yes, that is also right. Pay back because you did mistake. So the entire money was told to be pay back. Again, non-gratuitous act, you are taking benefit of it because you did not work. That's what they said. Now you could have looked at it in a second scenario. When he also knows that he is not working, why did he accept the money for all 3 months? Doesn't your consciousness say every month they are crediting you the salary but you are not working? Both of it is true only. That's what happened in this case. Okay, next one. Finder of lost goods. Haul-in versus Howler. Case law. Important exam point of view. They will twist to the scenario, but question is same. It will come as diamond or ring or gold, something around that only. It will come. Yeah. No. You will get. See, in your exam you have to write haul-in versus howler. Facts you can write it as whatever. As I say, I will never take the name and explain you. You can write the facts like that. But the case law you cannot deviate. You have to write haul-in versus howler. And remember, in your exam they will never ask you to write what is haul-in versus howler. Such questions will never come. The scenario will be asked, you will be expected to write the case law name, that's all. You are not expected to again explain what has happened in that case law also. That is not there. What happened here? One customer got one diamond ring in a hotel. He went and gave it to the manager. He said, sir, I think someone has lost. If a owner comes, please give it to him. The manager put one newspaper advertisement, whatever flyers, brochures, and he said, if at all anyone can prove that this is your ring, you can come and take back the ring. After 2 weeks, I again went back to the hotel and I asked, sir, did anyone come? He said, no one came. A right person did not come. So he said, sir, then give back the ring. He said, why should I give back the ring? It is not yours. Why should I give it to you? So in between them they fought. You will not believe they went to court also. That's a right owner is not there, but now who should this ring be taken? Who should take the ring? They went to the court, and in this case it was decided, remember, whenever the owner is not found, first of all you have to try, not like putting in the pocket and going home. You have to try. When after putting reasonable effort, if the owner is still not being able to found, whoever finds the product becomes the next owner. Provided whoever put efforts in searching the owner, if he has incurred any legal expenditure, whoever is taking the product now should pay for that legal expenditure. So in our case, the manager has given some newspaper ads and all. If he has spent some money, you have to pay for that money spent. Here, that is what happened in this case law. The last one is people, money paid by mistake or coercion. Money paid by mistake, I go to a shop, I buy a product worth 60 rupees without knowing which color notes, I pay 100 rupees. Now imagine 50 rupees is the bill, I paid 100 rupees. Did I intend to pay this 100? No. I thought I am paying 50 and I paid 100. Such scenarios happen, yes it happens. 2 days back it happened with me only. I took tea, in a mistake I just transferred 100 rupees. Instead of doing a 10, I did 100. And I sent it to the cashier. At least, okay, I immediately got to know I paid more. And they gave me back the money. Now imagine if I had not asked, can he say, hey, why did you pay? Did we ask you? Go. Once given is given. Can he say that? That's what they are saying. Yes, so if at all I have paid any money by mistake, other person, he cannot say, did I ask you? Is there offer, acceptance, consideration? I cannot say all that. You have to give it back to me. That is only called as quasi-contracts. Clear? Yes, okay, that is your Hollins versus Howler.
Exactly from inter we have taken and put it to.
Yes. Not even a letter change. However, they have taken for inter to foundation, they have taken from final to inter. Earlier some topics were in final, that they have taken put in inter. But not everything. But overall, if you ask me if there is a change, there is no much change and all. So okay change. But this is okay only, no?
Yes, sir.
Oh my god. Okay. So what happens is beyond some 3-4 hours it becomes very straining. Okay. Will you send the summary PDF in the group? No. First opening statement only was that. No. But if you guys have attended the classes, this is the material you guys would have written in the class also. There is nothing more you guys would have written. The same thing you would have seen in the class also, no? Your book is, I think, as it is, copy paste. Sir, this is a neat handwriting, sir. My handwriting is not neat today. They first and all I used to send. I'm not saying no also.
Can we take picture?
Okay. So, one more thing what I'm saying is, as it is, this will be uploaded on YouTube. Even when you guys want to watch also. For you guys I'm telling not needed, because if you guys have written what we have been writing in the class, it will be cut, copy, paste. Of course, here it will be aligned. Apart from that, one letter extra difference won't be there. To be very frank, in the class you would have written even more. I mean, from the exam point of view, you would have written or you would have covered everything in your book more than this. So you can rely on that. That's more than sufficient. Yes. Yeah. Okay. Yes, people. We'll do the next part. Okay. So let us do the next part. Contract of indemnity and guarantee. Online, you guys have any doubt today? Online now? Able to hear? Audible? Yes. Perfect. Okay. Turn the ACs for some time now. Keep turning on and turning off. That's the problem with this class. Only this class. No. This is that old model, and because of some reason I don't know, temperature is not working. I don't think you try to do.
Try to increase.
In this it is changing, but there I don't
That
know.
sound has to come.
That sound came.
Then I think it should work. I don't know. Okay, so let's start the next one. We will Unit 7, Contract of Indemnity and Guarantee. So contract of indemnity and guarantee. First let us focus on what is contract of indemnity. In contract of indemnity, how many people will be there? How many parties? In contract of indemnity there will be 2 parties. First of all, what is contract of indemnity? Contract of indemnity means, people, one party is promising the other party that anything happens in your life, macha, any loss you undergo, you don't worry. If that loss is because of me or any other person, if at all your financials or anything of that sort is impacted, I will come and bear the loss. Why do you have to take tension? I will give that money to you, da. If one person has promised this to the other person, now this type of contract is called as indemnity contract. Now when I'm telling you only, see, one person is telling the other person that if at all you suffer any loss, I'm going to give you the money. So it is very evident, indemnity contract, the best examples are, people, insurance contracts. Yes, sir. So where insurance companies will tell you, sir, if you meet with a bike accident, if anything happens to your bike, we will pay the entire cost. You need not worry. Now this is the best example of indemnity contract. Now the previous example, contingent contract, ship we saw, marine insurance it's called. Sir, yes, this comes under what? Insurance contracts only. Sir, life insurance is a indemnity? Allah. How will I make good the loss? If a person dies, sir, you don't worry, sir, what will you do? Remember, insurance, life insurance is never an indemnity contract. Indemnity contract is very simple. One person promises to make good the loss. Anything that has happened, you should make good. How will you make good the life? Impossible. So LIC is not an indemnity contract. Life insurance is not a indemnity contract. Is clear? Okay. And in indemnity contract, there are always 2 parties involved. One is called indemnifier and one is called as indemnified or indemnity holder. Agreed? Okay. So meaning, a contract where one party promises to save other from any loss due to the conduct of promiser himself or any other person. Act of God. Imagine, people, earthquake comes. This building full shakes. In between it splits. Chandan down. Dubba will go. Now Chandan lost his notes. Now tell me, people, what happens with insurance contract? First of all, does this earthquake come under insurance contract? Will it be covered? Now you look at the word. Why words are very important. What is an indemnity contract? When one party, we'll see that. A contract where one party promises to save other from any loss due to the conduct of promiser himself or any other person. If I do any loss to you, I pay. If anyone else do the loss to you, I will pay. Is called as indemnity contract. Earthquake, who did the loss? God. Yes, sir. No person did. It will not come under indemnity contract. Act of God is excluded. Understood the reason? Yes, your that whatever. Oh my God, Mukunda, Murari, Gopala, all this come under the same scenario. And of course, you will redirect to the insurance contracts. Yes, so today's date, explicitly, certain companies will cover Act of God also. Because it is a money-making strategy. Not every day earthquake will happen here. At least for my lifespan, I have not seen. So that's an easy bet. Even if some 1 lakh people take insurance on this Act of God, one day when it comes, we'll see. The money they would have recovered. That's the bet. Clear? Okay, parties involved in indemnity contract. One is indemnifier. Indemnifier means, I am telling you, macha, I will indemnify. So the person who promises to give the money is called indemnifier, insurance company. Indemnity holder, meaning insurance holder, me, whoever is willing to take the money for the loss happened. So basically here he is a consumer. Okay, special points. modes of contract, it can be express or implied according to Indian Contract Act, but reality illa. Next one, LIC. LIC here is like the life insurance basically, not considered as indemnity because you can never make good the loss. I hope you are understanding the logic. It must fulfill all other essential elements of the contract, basically lawful, free consent to all that. Right of indemnity holder when sued to recover from promisor, meaning sir, first thing, imagine something happened to my bike. I go and ask the money from the life insurance, the insurance company. What will they say? Sir, no sir, this is wrong sir, this is wrong sir, this is wrong sir. If they pay people, I don't have a problem. But in spite of having a contract, if they don't pay, what will I do? I will directly go and file a case in the court. Now they are asking you in the court, what and all I can recover from the insurance company. What and all I can recover? First one, people, I can recover whatever I had to recover legally. My compensation cost, my bike repairs has come to, say for example, 50,000. Can I recover this? Yes, you can recover this. Next one, Macha, if you had paid there only, everything could have settled easily. What did you do? You made me come to the court. Do I have a LLB degree? I have. Will everyone will have a? No. Now what should they do? They have to represent through a lawyer. Money is involved, court fees is involved. Who will pay for all of that? Paid extra 10k. Sir, when this case is going on, do you know how much headache I got? I got migraine inside brain, is a swelling and all it has happened. Who will pay for that? Paid. How much? Take 10k. Mental trauma. Now this is an all completely what I can recover, and look at the words used. You can recover damages compelled you to pay in any suit. What is damages? Mental trauma. Over and above what you are entitled to compensation. So I am entitled for 50,000. What comes more than that is damages? No. Next one, costs in defending the suit. Lawyer. Third one, all sums paid under the terms of compromise of suit. Whatever had to be paid according to the contract, 50,000. You have to pay all three. So all this I am entitled as an indemnity holder. Question can be asked. In this chapter where I told you the chances of questions being asked is there, you can remember this point can be important. Clear? Done. Next one, contract of guarantee. Again in indemnity and guarantee, the weightage of guarantee is more, concentrate more on guarantee part. Yes. Now what do you mean by guarantee, people? Guarantee. Guarantee means what? My guarantee. Now politicians are coming and telling no. The campaigns only are made like that. My guarantee. Hamara guarantee. After vote, no one will look at us. Okay. Now people, okay. Now what do you mean by guarantee, people? Now whenever there is any loans taken, need not be loan, I am just telling you loan. Guarantee we have all associated always with the loan only, but it need not be loan always. It can be anything. Imagine tomorrow you guys go for a work, articleship. Your senior might come and ask, I want someone to give a guarantee that you are a good resource. It does happen. It's not. It doesn't happen also. So you might come asking for a reference. Now I am telling yes, I give a surety. I have seen this person. I know the conduct of this person. Now this is again a guarantee. If anything happens in your office, I am telling I am there. Now this is a surety only. No. Yes. So yes, this is a surety. Now it can be loan also. Loan is for us from our exam point of view easy to understand. So what is guarantee, sir? There is one person who has borrowed loan and another person who has given loan, and he has agreed that I will give you loan provided if you do not repay, someone else should repay on your behalf. So the person who is repaying on your behalf, and this person can be called as what, people? Surety or guarantee. So in a guarantee, people, always three parties exist. One is called as principal debtor, the person who borrows the money, and the next one is called as the creditor, and the next one is called as, people, the surety or the guarantee. Yes, Pakana? Yes, okay. Now in contract of guarantee, technically how many contracts exist? Inside this, there are more contract systems. How many? There are technically three contracts. The first contract is between the principal debtor and the creditor. This is called as primary contract. So whatever the loan agreement I have taken, that is the first contract. Now the second contract is between the creditor and the surety. If he doesn't pay, I will repay to you. This is called the secondary contract. And the third contract is the implied contract. What is the implied contract? Imagine if the principal debtor does not repay the loan, I will repay the loan on your behalf. Agreed? Hey, but why should I take that cost? Technically, you should pay. Why should I pay? I can recover that money from the principal debtor. Here is the third agreement, and it's an implied agreement. Nowhere it will be written. Whether it is written or not, I can recover the money from you. And this is called as what people? Again, a third implied contract in the contract of guarantee. Clear? From the exam point of view, both are important. Parties involved as well as the contracts involved. One is called as principal, one is called as secondary, one is called as implied. Is clear? Remember, wherever the word implied comes, this only is called as subrogation. Heard of it as subrogation? What is subrogation? Understood implied contract? Implied contract is where a surety has paid money on behalf of the principal debtor and I am recovering it back from the principal debtor. Now this right given to the surety to recover the money from the principal debtor, this right given, it is called as what people? Subrogation. Practically what do you mean by subrogation? Till today, whatever were the rights given to the creditor, the surety will now be put into the shoes of the creditor. Going forward, you will be treated as a creditor. You will enjoy all the rights enjoyed by the creditor. So the process of you enjoying his rights, putting the surety in the shoes of the creditor. Tomorrow even I am a creditor to you, I can recover the money from you. This process is called as subrogation. I have a right to recover the money from you just like a creditor does. What and all he can do, I can do everything. Is called as subrogation. Remember the word, underline whenever you are writing this point. Keyword, very very important. Next one, essential features of a guarantee. If a guarantee has to be there, what are the features? The first one, existence of a principal debtor. When debtor only is not there, surety from where will it come? Obviously, principal debtor is very very important. Now my question is, people, you tell me, can a principal debtor be a minor? Is it possible? Can a principal debtor, can he be a minor? He can be a minor. Okay. Can a surety be a minor? Can a surety be a minor? No, not possible. Remember, even on this, they can ask you a case-based scenario. A principal debtor can be a minor, but a surety cannot be a minor. A surety should always be a major. That is mandatory. Is clear? Yes, sir. This point you guys saw it even in the rules of minor also under your third unit, where you saw that whenever there is a surety involved, if a minor is borrowing the loan, minor will not be liable to repay, but surety will be liable to repay. So surety can never be a minor. Remember, exam point of view, case-based scenario, very very important. Clear? Day online. Next one, consideration. Guarantee, people, quid pro quo. Quid pro quo, meaning what? Give and take. Sir, you're telling, surety has to pay money if principal debtor does not pay. Creditor is getting money from me. What am I getting from him? So the surety said, sir, based upon the grounds of quid pro quo, our contract is not valid at all. So if you put the exception here also, that will be valid. Chinnaya versus Ramaya. The consideration need not move from me only. Instead of me, you have taken money. Principal debtor has taken money. No, on behalf of me. The same exception you can put here also. That is what they are also saying. Read here. Guarantee without consideration is void, but no need of any direct consideration between surety and creditor. So between them there is not any direct consideration, but creditor is giving money to principal debtor. No, that is sufficient. Agreed? Any confusing point here? Confusing? See, in between us, there is no consideration involved. Tomorrow if principal debtor does not repay, I am agreeing that I will repay. But when that day came, I am telling, sir, this contract between me and you, whatever you said, secondary contract, that is not valid at all. Because I am giving. What did you give me? He said, I didn't give you, but I gave your person. Chinnaya versus Ramaya. Uncle, you are not giving me anything, but auntie gave you. Old lady gave you. So the consideration need not move from me only, promisee or any other person. Understood? Next one, existence of a liability, meaning surety has to be given as long as that liability is still existing. It should not have become a time bar debt. You should go to the court within 3 years and all is there. It should be within that time. So if at all a loan has happened, you should have given a guarantee within a certain period of time. It should not be very late also. That is what they are telling. It should not have become a time bar debt. Next one, no misrepresentation or concealment. Meaning, now whenever I am obtaining a guarantee, the creditor should have not concealed anything. Let us take an example. I told you the articleship. Let us imagine there is an intern. He wants to join a CA firm. He came and asked me, sir, can you give a reference? Can you give a guarantee? I said, okay, why not? Now I gave a guarantee also, people. But after 2 months I got to know, first of all, why did the CA ask for guarantee? The reason is, in the last month, this intern had done a particular matlab in that company. What? He had escalated the bills. So technically, the bills were around 2000 rupees. He has made Photoshop. He has edited to 3000 rupees. Now CA has noted this. He has identified this also. He has done something like this. So to make sure that this does not happen, he is asking for a reference. Going forward, if you have to continue, go and get a guarantee that if something happens, I should hold someone accountable. Now I am coming. Papa, I know him as a student. I am giving a reference. Now people, first of all, do I know all this has happened? It is the creditor's responsibility to tell me. If at all you don't tell me, people, my liability will end on that day only. Why? Because you are concealing a fact. Concealing means what? You are hiding some facts. That is what is the point. See here. No misrepresentation or concealment. Any guarantee obtained by creditor by silence or misrepresentation shall be invalid. You should have disclosed everything. Next one, need not be in writing. Oral is also valid according to this, but yes, in reality that does not work. Guarantee is not valid until some other person joins as co-surety if such condition is imposed by surety. Meaning what? Now even I am scared. I'll say, sir, if you have to take me as a surety, alone I will not come. I am signing the form, but my form will not be valid until one more co-surety joins. Because alone I cannot take this much of risk. If another surety also joins, then my signature is valid. If another co-surety does not join, my signature is also invalid. You cannot treat my signature as valid going forward. If at all I have signed with that condition, I will not be liable until a co-surety joins. That is what they have given. Is clear? Yes, sir? Okay, so that is what is the essential features of guarantee. Any doubt in these essential features? Correct. One is existence of principal debtor. First, a debtor has to be there. Consideration. Quid pro quo is not there. It is still fine. Next one, existence of a liability. Liability is very important. Next one, there should not be any misrepresentation or concealment. If at all you hide the facts, then the surety will not be liable. He is discharged. You will see this again coming also. Need not be in oral, it can be in writing as well. Guarantee is not valid until some person joins as co-surety if such condition is imposed by surety. So until the next person comes, I will not be held liable. Yes, sir? Clear? Okay, next one, types of guarantee. There are two types of guarantee. One is special guarantee, one is continuing guarantee. Under continuing guarantee, they can ask you a question. Now, sir, what is special guarantee, continuing guarantee? Me giving one referral for a specific transaction. Let us imagine one mergers and acquisition transaction is going on in the CA firm. I will say until these mergers and acquisitions are going on, you can believe this this intern, he is good. Once that is done, I don't know, because I know he has experience in that. For other things, I cannot give you a guarantee. Now, whenever I am giving you a guarantee for a specific transaction, that is called as what people? Specific guarantee. What is the continuing guarantee? Sir, as long as he is working with you, it can be 2 years, 5 years, 8 years. For all the transactions, I will be guarantee. I will be the liability. If something happens, I will come and pay. Now, this is called as what? Continuing guarantee. Specific guarantee, people remember, cannot be revoked. if it has happened, if the transaction has happened, you cannot revoke it. Or you can take an example of loan transactions only. A and ICICI Bank and B. Sir, ICICI Bank has given one loan of 1 lakh rupees. I have given this guarantee for this 1 lakh loan. Has this loan been given? Yes, it has been given. I cannot take it back. Once given, it is given. That's all. I cannot take back the guarantee. Whereas look at, there is something called as continuing guarantee. Now same thing A, ICICI and B. B told ICICI, I will be liable for 1 year. How many ever loans you want to give? But in this 1 year, I will be liable for all the loans. Sir, 2 loans have already been given. 2 lakh and 3 lakh. It is already being given. Still 6 months more is there. I will come and say, sir, I would wish to revoke my guarantee. Can I revoke my guarantee? The answer is yes, you can revoke the guarantee. But remember, in continuing guarantee, you can revoke the guarantee, but only the future transactions, but not the past transactions. 2 lakh, 3 lakh is done, you are still liable for that. For the next 6 months, yes, you can revoke possible. Is this clear? Pakka na? 100%? Yes. Okay. So that is one thing they can ask you. It continues till performance discharged or revoked. Yes, and revoked only for future. Okay, next one. Nature and extent of surety's liability. Nature and extent of surety's liability. To what extent the surety is liable? They can ask you a question here. Liability of surety is coextensive. What do you mean by the word coextensive? Imagine surety I gave a guarantee to repay 1 lakh rupees loan. Agreed? The principal debtor did not even pay the interest. Interest is 11% per annum. He did not even pay 11%. Now the matter did not settle here. I had to go to court. Now I had to recover 5,000. Now total people, whatever is the amount coming to, surety cannot say, I guaranteed only 1 lakh, I will pay only 1 lakh. Coextensive means people, whatever he is liable, I will be liable for everything. If he is liable for 50,000, I am liable for 50,000. If he is liable for 1 lakh 50, I am liable for 1 lakh 50. Understood? Okay, done. Next one, liability of surety is secondary in nature. Agreed? Why is it called secondary? Primary is always the debtor. He has to pay first. If he doesn't pay, I will pay. But remember, I am given a loan for 1 year tenure. I have to repay the loan. Imagine on 31st March 2025, I have to repay the loan. On the last day, if I do not repay, the principal debtor does not repay, from the next day, the secondary liability will be on the surety. On the 1st April 25, the banker will directly come to the doorstep of surety. Remember, once the loan is matured, it is the bank's option whether he can go directly file a case on principal debtor, or he can even directly come and file a case on the surety also. Nowhere it is written you have to go first there and then here. They can ask you a question there also, wherein they can say the surety says first to recover the money from principal debtor and not from me. Is there a law in support of the principal debtor statement? The answer is no. Surety statement. The creditor has a right to recover the loan directly from the surety also upon the maturity of the loan. You have to pay on the last day. Is clear? Yes, sir? Okay, see here. Liability arises immediately on default by the principal debtor, 31st March 2025. If you don't do, from that day you are liable. Defect in document. What is defect in document, sir? Whenever the documentation there is any problem, that means the contract is unenforceable. If the contract is unenforceable, principal debtor is discharged. If principal debtor is discharged, even surety is also discharged. Debtor and surety both are discharged. Logical. Creditor can sue directly, without proceeding against the principal debtor. Very important, a scenario based question can come. Understood how they are asking you? They will ask you directly that the bank filed a case directly on the surety without going to the principal debtor. Is the bank's action tenable? Is it valid? That's how they'll ask a question. You'll be writing, yes, it is tenable. Upon the maturity of the loan, the bank is free to directly charge the surety without first charging the principal debtor. It is valid. Clear? Yes, online? Clear? Okay, next topic we will discharge of surety. When does the surety gets discharged? Meaning I have given a surety. When will my guarantee will come to an end? There are three headings. All three are important. You can expect a question here also. Sir, when will the surety be discharged? First one, people, continuing guarantee means by notice. Agreed? You have seen this? No. Future transactions. There are two types of guarantee. Noda. Specific guarantee, continuing guarantee. Continuing guarantee, you can revoke the future transactions, not the past transactions. So you can revoke, possible. Next one, death of surety. Again, people, specific guarantee. Imagine on this date of specific guarantee, the transaction has already happened and death of surety happened. The surety is still liable. Sir, what surety is liable? Can I go and ask from the body? Hey, Kodo. Where will I go and ask? Sureties, representatives will be liable. Whatever is the assets you get from him, this will come as a liability. Again, the logic is same. Wherever you go, people, the legal representatives will be liable to the extent of the assets passed as inheritance. To that extent, you will be liable. It's clear, Yes, Sir, in the case of continuing guarantee, upon the death, until the date of the death, for all the transactions, legal representatives will be liable again to the extent of the assets. But after the death, the surety will come to an end. Understood this one now? Okay. The next one, sir, by novation. Obviously, what is novation, people? So, the contract was between A, B and C. Now, a new party is coming in. When will this generally happen? Imagine there was a partnership firm, A, B, C and Co. They have taken a loan from ICICI Bank. Mr. D has given a guarantee. One C partner goes out, another partner E comes in. This is called as what, people? Reconstitution of partnership firm. It's called as a change in partnership. Sir, now what happens? Change in partners are happening. You have to take D's approval for this continuing guarantee. If you don't take approval, people, the surety's liability will come to an end because it is considered as change in partners, change in parties. Understood? Yes, sir. Example. Okay. Next one, by conduct of the creditor, meaning the creditor has done something wrong, because of that surety is getting discharged. What is that? First one, variance in contract without surety's consent. Simple, Variance in surety's contract. What is that? Meaning, whatever you agreed between me, I gave a guarantee, but the contractor, Macha, you guys have changed in between you. They have agreed for something, but they have done something else. Now imagine, people, I told I will give a loan up to 50,000, I will give guarantee. They also told that the loan is 50,000 only. But without me knowing, people, they have given 1 lakh loan. Should I be held liable? The answer is no. I will not be held liable because you guys have changed the terms without my approval. Okay, sir, I have a doubt. I have given guarantee for 50,000. I said I will be liable up to 50,000. But they changed the mind and the loan was actually given for 25,000. Now tell me, am I liable? I have given guarantee for 50, but if there is a change in terms, the loan is given for 25,000. Am I liable? Liable or not?
No. They did not inform him.
Correct.
How much ever the amount is not liable.
Remember, alteration beneficial for the guarantee will not discharge you. I agree. Whatever we said, alteration should be informed. Agreed. I understand. But you were okay to pay 50,000. Now altered amount is 25,000. Whether are you liable? You were liable for 50. 25 you will be happy to pay. Sir, where is it given, people? There is a case law. Tomco's Bank, if you remember. Anirudhan versus Tomco's Bank. Important, remember case law. They can ask you a scenario here. Yes, important. Next one. By release or discharge of principal letter or enters into a contract with principal dishonor or does any act omission, legal basically, people, nothing but I enter into an agreement. ICICI Bank tells, hey, Goda, I will not take any action against you. You are not paying loan, no. You go home, da. You go, da. You go, da. I'll take care of B, poda. Now, people, I'm telling you, I'm releasing you. I'm discharging you. Why? Don't be unfavorable. If you discharge him, I'm also discharged. That's what they're saying. Next one. Creditor compounds. What is compounds? Compromises. Vijay Mallya had to pay 9,000 crore. Banks said, give me 5,000 crores, sufficient. Rest of the 4,000 crore are coming to me. Why da? Why did you compromise? If you have compromised, go and compromise with him only. Next one, gives a timer. He should have repaid the loan on 31st March 2025. He said, sir, I need one more year. After one more year, he directly became insolvent. Why did you give time? Da? At least you could have got some assets. You gave time. Now he doesn't have anything. Even I am also not liable. Third one, agrees not to sue principal debtor. Meaning I am saying, I will not file a case on you. Then you cannot file a case on surety also. Next one, Creditors Act of Omission impairs surety's eventual remedy. What is this, sir? There is one more case law also here. What is the case law? Sir, now imagine what is surety, creditor's action impairs surety's eventual remedy. Now imagine A, ICICI Bank, and B. ICICI Bank totally gave people loan of 10 lakhs. And they said we need surety also. Along with that we need some collateral also. So what did A do? A gave some gold as well as surety. Now because of the bank's mistake, they misplaced the gold. Now when they are asking for money, people, they are asking the entire 10 lakh from B. They are saying, if at all because of the creditor's negligence, if at all you do some mistake and you lose out some asset of that principal debtor, my liability will also reduce by the value of that asset you lost. Because you could have recovered, my liability also could have gone down. It was your mistake. No. Imagine the gold value was 1 lakh. I will be liable only for 9 lakh and not for 10 lakh because you lost it. That is what it is here. Creditors Act or omission impairs. Impairs means even I could have had that right. Now because of you, even I am getting detached of that right. Surety's eventual remedy. Even I could have been benefited. Because of you, even I am not getting benefited. It will reduce by that extent. Clear? Next one, by invalidation of contract of guarantee. Meaning, when will the surety rights come to an end? Surety's liability come to an end? Guarantee obtained by misrepresentation. Meaning what, sir? We already saw, no? Misrepresentation and concealment. What is that? The past he had done some mistake. The creditor is not bringing it to my notice. If you conceal a fact or if you misrepresent a fact and you take my guarantee, I will not be held liable. Next one, contract that creditor not to act until co-surety joins. I have clearly put in a contract. Until another surety comes, I should not be held liable. Before another surety came, you gave a loan. I cannot be held liable because I have clearly put a statement there. Understood? Yes, sir. Sir, rights of a surety. Now, sir, what are the surety? What are the rights that will be enjoyed by the surety? First one, sir, again, so basically, the rights of the surety people are 3. One is against the principal debtor, one is against the creditor, one is against the co-surety. What is the right against principal debtor? This is only nothing but right of subrogation. Understood? What is that? I repay the money on behalf of you, Noda. I have a right to recover that money from you. I pay on behalf of you. I can recover it from you. Understood? Yes, sir. Next one. Against the creditor. What is the right against the creditor? Simple, people. Imagine the creditor has taken some gold as guarantee. Yes, sir. Now the total loan was 10 lakh. The gold value is 1 lakh. My loan, whatever I have to pay, will also go down by 10 lakh minus 1 lakh. If at all principal debtor has given you any collateral, even I am also entitled for that collateral. So if at all he is not repaying the loan, you have the collateral, no. Even my liability will reduce by that amount. Even I will also pay only 9 lakh. Next one, let us imagine principal debtor actually became an insolvent. Now what will happen? All the principal debtor assets will be sold. Now imagine his land was there. ICICI went to the court, he fought and he was able to get some 2 lakh from the land. Still 8 lakh is to be paid. Now ICICI filed a case on the surety to pay the entire 10 lakh. The surety will say, no, Noda. Whenever a principal debtor becomes insolvent, if you got money from his property, even I can also enjoy that. My liability will also be now 8 lakhs only and not 10 lakhs. Simple, huh? That's only called right to share reduction when principal debtor becomes insolvent. Understood? Next one, sir, right to set off. What is right to set off? Sir, I had to pay 10 lakh loan. Principal debtor had paid 2 EMIs of 50,000 each. He has paid 1 lakh. So when I am repaying,
Only 9 lakh.
9 lakh only I have to pay. That's the reason the first word only I told you. My right and liability is coextensive with the principal debtor. If his money goes down, my money also will go down. Increase. Clear? Huh? Next one, sir. Right against co-surety. Important. They can ask you a practical question here. Remember here. A took loan from B and the guarantee was given by 3 people. C, D and E. What is the total loan taken? 6 lakh. The guarantee was given 1 lakh by C, 2 lakh by D, 3 lakh by E. Now A did a default. A did a default of how much, sir? A paid 3 lakh people. He paid 3 lakh. He was not able to pay the rest of the 3 lakhs. Now C, D and E has to repay the rest of the 3 lakhs. In what proportion are these 3 people liable? How much will each of them pay? See, one scenario is very simple. First scenario I have not even covered. When they are liable equally. C has taken 2, D has taken 2, E has taken 2, you are liable equally. You all will pay 1 lakh each as the case may be. My scenario is when the guarantee is not equal. There is a difference amount of guarantees you guys have given. Now to what extent you guys will be liable?
50,000,
50,000?
1.5. Sorry, 1 lakh, 1.5.
1.5 lakh. Okay. Any other answer? Same answer? 1 lakh, 1.5, 1.5. Okay. Any other answer? No. Always remember how much money has to be paid? 3 lakh. Until 3 lakh. See how much each of the person has given a guarantee. 1 lakh, 2 lakh, 3 lakh. Correct? Up to whatever is the least possible person guaranteeing. He is selling 1 lakh. Up to that extent, all of them are equally liable. You are liable to pay entire 1 lakh. You are also liable to pay entire 1 lakh. You are also liable to pay entire 1 lakh. First you said that only. You said that only. Sorry, Kamrano, I am very sorry. Understood the scenario, na? All of you will be liable equally. Now let us increase the difficulty. Let us imagine A paid 4 lakhs, 2 lakhs is not paid. In the classes generally this will not be done. That's the reason I am asking you. We would have done, I am just telling you. But you will not remember. 4 lakh, okay, sorry, how much we repaid? Allah, imagine we paid 2 lakh, 4 lakh is yet to be paid. We did not pay 4 lakh. How will you divide the 4 lakhs? How will you divide the 4 lakhs? How will you divide? 1 lakh, 1 lakh. Understood? So first one, all of them are liable equally. 1 lakh, 1 lakh, 1 lakh. Because that's the least possible person involved. Now how much more is to be paid? Another 1 lakh. So next, this person says 2 lakh I am liable. This person says I am 3 lakh liable. Agreed? So up to that extent, they both are equally liable. So the total contribution will be 1, 1.5, 1.5. Now imagine 5 lakh only. How will you distribute?
1 lakh.
1, 1, 1.
1, 2.5.
1 lakh, 2 lakh, 2 lakh.
1 lakh, 2 lakh.
So I will distribute another 1, 1 here. Correct? So this will become 5 lakh. Understood how it is? Equally you will have to distribute. That's the meaning of it. Is clear enough? Now when it becomes 6 lakh, obviously you will do one more here. So as long as we can cover for everything, it has to be equally covered. You cannot say because you are 3 lakh, you have to pay proportionately. That cannot happen. It has to be equal. Important practical scenario, you can expect a question here. Clear? Yesam? Done? Sure? Okay. Done. Okay, we'll do the next chapter. We'll probably do till 3:40. Yeah, the next class starts at 4 or 4:10 is what they said. So we'll do till 3:40 or something. Yeah, we'll try to just finish off these through 2 units. If not possible, at least let us try to finish off bailment and pledge. Yes, sir. Okay, unit 8. Bailment and pledge. We'll start. Okay. Now, first of all, what is bailment, sir? Bailment is nothing but people. What is bailment? Tell me examples only. What else? What is bailment? Given bike to friends. You go for a drive and come down. Results would have come. I'll also come with you. Day. What is bailment? Change of possession. Transfer of temporary transfer of ownership. ಕೊಟ್ಬಿಡು ಓನರ್ಶಿಪ್ ಕೊಟ್ಬಿಟ್ಟು ನಾವೆಲ್ಲ ಹೋಗ್ಬೇಡ ಪಿಕ್ನಿಕ್. Temporary transfer of possession. In the bailment, the only thing that will not be transferred is ownership. That only you transferred of. Temporary transfer of possession and without change in ownership. The ownership should be with you. Yes, sir. That is called as bailment. Examples of bailment can be renting a bike, renting a car, taking your friend's notes to your home to copy, giving bike to service, giving your mobile phones to service. All these are the contracts of bailment. Bailment can be of 2 types. One is called as gratuitous bailment. Next one is called as non-gratuitous bailment. Gratuitous bailment means what? There is no money involved here. You are doing it for free of cost. Imagine your friend comes to your home. While going back, it's heavily raining. You will give your umbrella and send. This umbrella is a bailment. Will you charge for that? We have not gone to that level, but we will give it for free only, no? Kamra, no? Giving it or not, we are giving it for free of cost. Now this is also called as bailment. Your macha will ask, macha, give me your bike for 1 day. Morning I will take and evening I will give it to you. Now you give your bike for 1 day. Now that is also called as what? That is also called as gratuitous bailment. You are not charging money in all these cases. And next one is called as non-gratuitous bailment. Non-gratuitous bailment is where you are charging some money in this transaction. So they are charging the money. Example, you are giving service. Your phone for service, your watch for service, laptop, your bike for service. All these you are paying some money there. That is called as non-gratuitous bailment. Now sir, in a bailment there are 2 parties involved. One is called as bailer, one is called as bailee. Bailer is the person who gives, bailee is the person who takes. Agreed? Yes or no? Okay, delivery of goods by one person to another, some purpose. When the purpose is accomplished, the goods shall be returned. Bailer, the person delivering. No. Essentially, when a bailment contract, whether express or implied consideration is not mandatory in bailment. Cross reference in exceptions to quid pro quo, bailment also came. Yes, gratuitous bailment they are talking about. Delivery of goods, only movable. Actual delivery is important, or it can be constructed delivery also. What is the delivery now? We'll see in Sale of Goods Act. The purpose, possession having just custody is different from possession of goods. This is again one point where people will feel a little difficult. What is the difference between custody and possession? Are these 2 different things or they are one and the same?
Custody is just having the
Custody.
product with you. Possession is like
Having.
allowed to use the good.
Okay.
Custody you cannot use the good. It's just you're just having it there.
Okay.
But possession is you can use it.
Okay.
Possession.
Which one?
Possession.
You can modify the goods. You take notes and do rocket and give it back. Modify, sir. So remember, Custody and possession, the difference is, imagine now I have some gold. I want to go and keep it in a locker in a bank. Now the bank is having my gold with them. Now should I consider this as a bailment or not?
No.
Huh? Pledge alla. I'm keeping it in a locker.
No.
There's a difference. I'm not taking loan on it. You have that locker facilities. No, I kept the gold in that locker. Now can I consider this as bailment or not?
No, that's custody.
Why? Because bank has no control over that gold. Absolutely no control. What is the difference between custody and possession? In possession you have some degree of control over the product. Take the other example. Imagine I take loan from a bank. I give gold as a pledge. I give this gold as a collateral. If I do not repay the loan tomorrow, bank has a power over that gold. They can do anything to that gold. But in this case, they don't have any power over that gold. They have a custody. Custody is that you just have to keep it. You don't have any other power. Don't have control over it. That's called as custody. Possession is you have a degree of control. Get it? Okay. Next one is you have to return the goods once the purpose is served. You cannot keep it permanently. Classification of bailment based on reward. Gratuitous, non-gratuitous. Yes, Next one, rights of the bailer. Who is the bailer? The person who is giving the goods. What are the rights he enjoys? To terminate the bailment. If bailee acted inconsistent with the terms of the contract, he can terminate the bailment. Meaning what? I have taken Zoom cars for rent. There is a clear instruction. You are not supposed to go beyond 80 kilometers per hour. You are trying to break that. I have taken the car saying it is intercity transport, but I have crossed the city limits. They have GPS navigation, they can track you. I have crossed the limits. So if you are acting inconsistent with the terms, the bailer here is Zoom car, he can terminate the contract. Yes, sir? Premature termination. Premature termination means people, premature, meaning I have taken the goods actually for 3 months. Before 3 months only I am terminating. Remember, there are two types of bailments, gratuitous, non-gratuitous. Non-gratuitous is for money. You cannot pre-terminate a non-gratuitous bailment because money is involved. Zoom car cannot come and say 5th day only. I have booked the car for 10 days. They cannot come and ask the car back the 5th day. Non-gratuitous, you have paid money for 10 days. You have a right to enjoy 10 days until you have done something wrong. You have a right to enjoy. Whereas gratuitous bailment, your friend has taken. He asked, Macha, 3 months, can you give me your car? You said, okay, take the. You gave also. Gratuitous bailment, nothing is involved. You can take back the goods whenever you want. However, if that person has invested any money on your product, imagine he serviced your car. To use it for 3 months, he serviced. Now, if at all you're asking back your goods, you have to pay for that and you have to bring it back. Remember that one point. Clear? Yes, sir? Okay. Suit against wrongdoer. Meaning, if now imagine, there is a CCTV camera clearly given. I had parked my car, that is Zoom car, in a place. The person from opposite lane came and he hit the car. I was not in the car. I had parked and I had gone some other place. It is everything covered in the CCTV footage. They have a dash cam. Now who should fight the case? I have taken the car for the rent from Zoom car. Should I go and file the case on the person or should Zoom car go and file the case on the person? For your information, both of us are entitled to file a case. I can also file because it was in my possession. He can also file because he is the owner. They are telling you he has a right to sue. Clear? Next one. Right to sue the bailee. Now he is trying to file a case on me only. Why? Compensation for loss by negligence of bailee. He had given me some product. I lost it. File a case. Compensation for unauthorized mixing of goods. Unauthorized mixing means, imagine if at all you have got some goods, it can be mobile parts. What if I just interchange? Can I do it? His battery is good, your camera is good. Change, make it a new mobile. Unauthorized mixing. Clear? Compensation for unauthorized use of goods. For example, he told you, you asked the service person, how long it will take time to repair your bike. He said, sir, 7 days. 2 days he repaired. He's just roaming around in the city only because yours is a very good bike. Did you authorize him to use? No. If he uses, he has to pay for it. To demand back the goods. Once the purpose is served, your purpose is done. Your service time is done. Whatever you have given the purpose for, they have done it. Once it is done, they have to give back. If they do not give back, I can file a case and I can get it back. Next one, right to accretion to the goods bailed. What is this? Right to accretion to the goods bailed?
Example, the goods value increases or something like a cow gives calves, you should return everything.
Correct. So this can happen in why these things also. See, these acts are on all 1872 and all very old times. So what used to happen, even today it happens. Even in my uncle's place and all, even today happens. Imagine if there is any event. Now these people are proper villagers. So now if I take it, you can't even say village, these are like forests only. If my uncle's house is here, for the next 2-3 kilometers there will be no other house. That's how it will be. Now they have those cattles and all. Now imagine if there is any event, family function, everyone from the house can never come. One person should stay back to take care of the cattle. Now imagine a scenario where everyone decides to come. Now what they used to do? They used to tell the neighbor to take care of the cattle, cow or whatever it is. So imagine if one cow was a pregnant. Imagine if it delivers a calf. When I gave you, there were totally 6 cows. Now when it was with you, there was +1. When I am returning, what should I return? The contract was only 6, no? So to avoid that, these laws are there. Understood? Yes, sir. Okay. Next one, duties of bailee. Always remember in exam, rights of one person becomes the duty of another. Duty of one person becomes the rights of another. If I have a right to pay, as a bailer, imagine I am giving my bike for service. It's my duty to pay. Right of bailee, duty to receive compensation, duty to receive money will be, right to receive money will be his right. My duty will become his right. His duty will become my right. For example, my duty is to give back the goods after the service is done. Your right is to collect back the goods after the purpose is served. Agreed? So in the exam, if you are not able to remember everything, remember one person rights and go. Remember one person's duties and go. Try to write it as other way if at all they are asking. If you are knowing rights of the bailer, read and go the rights of the bailee. So you can write the duties accordingly. Understanding? Okay. Duties of bailee. Take reasonable care of goods. So what is reasonable care of goods? You will be seeing reference of this in Sale of Goods Act. What is reasonable care of goods?
When the goods are in possession of the seller, he has to take good care of the.
That is what you will be seeing in the Sale of Goods Act. Same thing will come here also. Same thing only. What is that? You took your friend's bike. You kept all your bike inside your compound. Friend's bike, no, it's okay. You kept it out of the compound. Night someone came, he took the bike and he went. Are you liable for this?
Yes.
The answer is yes, because you did not take reasonable care. What is reasonable here? You are treating your bike and your friend's bike absolutely different. So whenever you do that, if there is any loss, you will have to bear that loss. That's what they are telling you. That's clear? Next one, not to set up adverse title. Adverse title means don't sell it to someone else. Don't go pledge it to someone else because it is in your custody. Not to make inconsistent use of the goods. Agreed? Not to make inconsistent use of the use. Whatever I have given it to you, you have to use it for that only. See here, right to sue for unauthorized use of the goods. Duty. Not to make inconsistent use of the goods. That's what I am saying. If you remember one right, it will become a duty for the another person. Okay. Return on accretion from the goods. It's your right, it is his duty to give. Return the goods according to the bailor's direction or before the promised date. If not, he shall be liable for any loss. Meaning, sir, he says that this is the day after which I'll give you the goods. The bike takes 3 days. Once the 3 days thing is done, you have to return the goods. If not, you will be liable for any damage that happens to the bike or car, whatever it is. Not to mix the goods. Agreed? Yes. Not to mix the goods. Sir, what if I've mixed the goods? Imagine people, they'll ask you in the exam from serials point of view. Serial, sir, which channel, sir? Not that serials, grains, rice. They will say that there was one quality 1 rice, there was quality 2 rice. They will mix these two. So a bailee, without knowing, when it was in my custody, I will mix off these 2 rices. Now what do I do? Simple. If at all you can separate it. Is it able to separate it? If you can separate it, then separate it. The cost of separation will be borne by the bailee. Whatever is the cost, you have to bear it. Sir, if at all I am not able to separate it, then you will have to directly pay the compensation. How much ever it comes to, you will have to bear the compensation. It's clear? Yes, sir. Okay, done. Next one, sir. Something called as finder of lost goods. What is finder of lost goods? We have seen. Okay. Now, sir, remember 2 things here. Let us imagine, sir, finder of lost goods. I found a purse. Yes. Now, to search the owner people, it costed me somewhere around 1000 rupees. Now, in this purse, there were some valuables as well. Now, I went to the owner people. I asked him, sir, can you give me this 1000 rupees because I had to spend 1000 rupees to find you. And you can take the purse. The owner said, no, I am not going to give you. Now, the first question, can I go and file a case on the owner that, sir, I have spent 1000 rupees, you have to give me 1000 rupees. Can I go and file a case on the owner for this 1000 rupees? The answer is no. Because you have spent this money voluntarily. You cannot go and ask. However, lawmaker gives you one right. What is that? If at all the other person is not willing to pay this 1000, then you have a right to retain the goods with you only. You don't have to give back the goods to him. Keep the goods with you until the money is paid. Understood? Sir, now I have one question. What? So this person, he has put advertisements in a newspaper, sir, that anyone who finds my purse, they will be rewarded with a 5000 rupees cash. He has given in the newspaper. I found it. I went to him. I asked. He is saying, no, I will not give. Now can I file a case on him, sir? Yes. For a reward, you can file a case. For the expenses, this is voluntary. This is a contractor. There is a difference. This is a general offer. Understood? Because you made an offer. I agreed. By following the terms, I agreed. Now, if at all it is something which is promised as reward, you will have to pay. If you don't pay, I can file a case on you. I can recover it through court. Whereas if it is the money incurred to search you, I cannot recover it from you. I cannot file a case. But you can retain the goods. Clear? He has no right to sue the owner for compensation of expenses incurred voluntarily. But he may retain the goods against such expenses, 1000 rupees. If owner has offered a specific reward, 5000, finder of lost goods may sue the owner for such reward. Understood? Pakkana? Sir, now one question, sir. We'll see that. One question, sir. I am not able to find the owner at all. Now what to do? If you're not able to find the owner at all, after reasonable search, then they are telling you one thing. What? You only keep the product. Howda, sir? Yes, people. And one more thing. Even if you are found, he is not giving you the money. And the cost involved in searching the owner is coming to how much? 2/3 of the value of the product. Meaning, sir, the value of the product is 1000 rupees. In searching the owner, I spent 666 rupees. And the owner is not repaying the money. They are telling you, do one thing, you only keep the product. Understood? See here. Finder of lost goods has a right to sell the property. When? You can sell. When? First one, owner cannot be found. When he is not found, then what to do? You can only do it. Owner refuses to pay. You found him. But he is not paying you the money. owner refused to pay the money and they are perishable in nature, just sell it off. Irrespective of the value, sell it off. Or lawful charges and finding the owner amounts to 2/3 of the value of the thing. Then they are telling you, you sell off and recover your money. Understood? Sir, connect it to the previous example. I incurred 1,000 rupees and I went to the owner and asked for money. What did they say? If the owner does not pay, you only keep the goods. Now what will I do with the purse? What can I do? They are telling you two things. Is the purse perishable in nature? Is it perishable? No, it is non-perishable. Okay. How much did you incur to find the owner? Sir, 1,000. If the cost involved to find the owner was 2/3. 2/3 of what? Of the value of the product. Now if I ask you what is the value of the product? Sir, the value of the product comes to, let us imagine, 1,500. Sir, I spent 1,000 to search him. If it is at least 2/3, that is the amount you spent. Then in this 33%, what will he also do? Do one thing, you sell off and you recover the money. Because what will you do with the product in your possession for such long time? That's what they are saying. Understood? Pakkana? Sir, whatever it is perishable in nature, don't look at this proportion and all, just sell it off. Because the goods are going to deteriorate. Perishable can be, it can be milk products, vegetables. They are the things they are talking about. Clear? Yes, okay, done. Sir, next one, sir. Rights of bailee. To deliver the goods to any one of the joint bailers, if there are more than one person who has given it to use for service, you can give it to either of the person. Two friends came and gave the bike for the service, you can give it to either of the person. Right to indemnity. If bailer has no title and bailee delivers them back to the bailer. Meaning what, sir? Right to indemnity means you gave me the bike for service. I gave it back to you. But we got to know later that this bike was given or he got it by theft. And I told him some modifications. He made also. Change in color, paint, everything he changed. So the actual owner filed a case on the bailee. So it is bailer's responsibility to indemnify him. Because of you he is suffering. You have to pay the legal costs to protect him. That's what they are saying. Understood? Yes, sir. Can you turn on the AC? Claim compensation in case of faulty goods. Bailee gets a right if bailer has to disclose the fault known to him. Remember, there can be a question here also. Now what is that, sir? Now imagine people, there is a car a friend gave to you. You took a car from Zoom Cars. What is the difference? Here there is no money involved, here there is money involved. Now let us imagine you took a car from your friend. In the car the brakes are not working. Does your friend know about it? The answer is no, he does not know about it. You took the car when you were driving, you found that there was no brakes, you met with an accident, so there was some injuries involved. Who will pay for this cost? Will your friend pay? The answer is no, because he did not charge you for the car. Whatever he gave it to you, he did not charge for you. It was a gratuitous bailment, he will not be liable. Whereas Zoom Car, I'll ask the same question. The brakes were not working. Does a Zoom Car CEO sitting there, does he know about it? The answer is no. I met with an accident. Can I collect the money from him? The answer is yes. Why, sir? Remember, in a gratuitous bailment, if at all there are any defects in the product, if you do not know, then you will not be liable. If you know and you do not tell, then you are liable. If you do not know, then you will not be liable. Whereas in non-gratuitous bailment, whether you know, you do not know, you will be liable for whatever are the defects in the product. Yes, Pakka, in this topic, that is what is the expected practical question they can ask you. Next one, claim extraordinary expenses if any, meaning if at all you spend anything apart from what you can, what you had to spend, you can collect it from the person. Yes, for example, I take Zoom Car. Petrol is my ordinary expenses. If at all imagine there is a service, engine had to be checked. For this, these are extraordinary expenses. I need not pay for it. That I can recollect it from the Zoom Cars. Next one, right to apply to the court to decide the title of the goods. Imagine people, I told you know that service, bike service was given. Another owner is coming and telling this is my bike. But the person who gave the bike for service is different. The person who is coming and claiming is different. Now whom should I give it to? You do one thing, you can apply to the court and you can ask, sir, I am stuck. I don't know to give the goods to him or him. You tell me to whom to give, I will give. You can ask the court's help to decide the owner. Court will help you to decide the owner. Clear? Yes, sir. Next one, sir. Right to lien. Right to lien can be two things. One is called as particular lien. One is called as general lien. Particular lien means, people, when I have a product, if I have to get back some money. Now imagine the bike service person. I have to pay him some 1,000 rupees. Until I pay him that 1,000 rupees, he has a right to keep the product with him only until the money is paid. That is called as particular lien. We'll be seeing more about that lien in Sale of Goods Act. Right of unpaid seller. We'll be seeing it there. What is general lien? Now imagine you have to pay me money. Not for this. For example, imagine I have taken a loan from a bank. And now I have to pay interest to them. I did not pay. In the same bank, I have done a FD also. It is nowhere related to the loan. But bank has a right. For my one transaction, they can take money from another transaction. They can say that until you repay my loan amount, we will not give you your FD amount to you. So for one transaction, they can take the money from another transaction. That is called general lien. The products need not be linked. Particular lien, I can retain that goods towards which you need to pay me money for. Only towards that I can retain the goods. General lien, I can retain the goods towards any transaction. That's the difference. Yes. Okay. Next one is duties of bailer. Same thing. Whatever is the rights here will become the duties here. To receive back the goods after the time and purpose. That's your duty. To indemnify any loss suffered. Duty to disclose faults in goods billed. Agreed? Here it was your right to any faulty goods. You had a right to recover the money. Here it is your right to know if at all there is any faulty goods. Here it is your duty to tell the faulty goods. Brake is not working. Pay necessary expenses. Indemnify bailiff for premature termination. Yes, sir. Premature termination. Correct? If at all you have put any money on your car service and all, I have to give back that money for. Okay, termination of bailment. When can the bailment come to an end? On expiry of period stipulated 10 days, 10 days. On fulfillment of purpose. I have given it for the bike service. Once the bike is repaired, bailment comes to an end. By notice. Gratuitous, anytime you can take it back. Non-gratuitous, you can cancel it only if at all there is a inconsistent use of the goods. If not, you cannot terminate. Correct? By death of bailee or bailer in case of gratuitous bailment. In Zoom car, whoever dies, it does not make difference because you have paid money for it. Gratuitous, if the person dies, the goods will be returned. On destruction of the subject matter, obviously it becomes a void contract. Correct? Yes, sir? Okay. The last part, sir, is called as pledge. What is pledge, people? Pledge is what, people? It's a bailment of goods for a better security. So, I'm taking loan. I'm giving my gold as a security so that if at all I do not repay the loan, you can take my gold as a return. That's why we give. That's the reason it's called as pledge is always called as bailment of goods as security for repayment of a debt. Definition should be there. Sir, parties, sir, pawner, pawnee, borrower, creditor, also called as pledger, pledgee. It's a bailment of security. Subject matter is goods, always movable. Delivery of goods from pledger to pledgee. You have to give the goods. Technically, these are nothing but Muthutu, Manappuramo, all those people will come here. Yes. Next one, pawnee's rights. Who is pawnee? Pawnee is basically the person who is giving you the loan. Basically the creditor. What is his right? Right to retain pledged goods for principal, interest and expenses. So, I have given you loan. I have taken the gold. Until you repay my interest amount, my gold amount, my loan amount, my interest amount, any other expenses involved, I will not give you back the gold. Manappuram says. Okay. Right to retention of subsequent debt. Right to retention of subsequent debt means, simple people, there are two transactions, two loans. One loan you have repaid. Second loan you have not yet repaid. I can still keep the same gold until you repay the second loan also. Imagine one I have taken collateral, another loan I have not taken collateral. You repaid the first loan. Second loan you have not yet repaid. I can still keep the same gold. That's called right towards subsequent debt. You can also call it as general lien. Yes. Right to extraordinary expenses, he can't retain goods for it. Extraordinary expenses to maintain the gold. I have a right to receive the money, but towards that I cannot keep the gold, I have to return back. When pawner makes default, if at all pawner does not repay the loan on time, then what is the rights I have? You can file suit and retain the goods, keep it with you. Sell goods after giving notice. Very important here. File suit, retain the goods, or sell goods after giving notice. If proceeds are less, you can recover from the pawner. If proceeds are more, surplus goes to the pawner. What if you do not give notice?
Then
That's
that's not valid.
not valid. Duties of pawner, liable to pay the debtor. It is your liability to pay the debtor. Disclose all the faults. Agreed? Next one, pay extraordinary expenses. Here it was right to receive, here it is your right to pay. I mean duty to pay. Indemnify pawnee if loss occurs. Pay deficit if pawnee sells the goods due to the default. Meaning what, people? Here you had taken loan of 1 lakh. When they sold the gold, they could recover only 80,000. Here they said it is the right to recover the money from the pawnee. Here it becomes your duty to pay the extra, that deficit whatever has incurred. If at all they are able to sell it at 1.2 lakh, here it becomes your right to get the profit also. Correct? Yes, okay, next. Pledge by non-owners. The same thing will also come in next topic also, agency also. Yeah. Pledge by mercantile agent. Agency or next thing we'll see. Person in possession under voidable contract. What is pledge by non-owners? Technically only owners can go and pledge. Even if he is not a owner, he can still pledge it. When a people, example, one is pledged by mercantile agent. Agent is what? A person who is acting on behalf of you. You have given a power of attorney. Next one is called as person in possession under voidable contract. What is that? B forced A to sell his gold chain. Now B has the gold chain. He went and pledged it in Muthoot. Did A go and complain to the court? No. Is B the actual true owner? Depends time. If at all he has gone in reasonable time to the court, then the contract would have become cancelled. So now what do I call him? Is he a owner or non-owner? I cannot completely accept B as owner also because it is voidable contract. A has to be given reasonable time to go to the court. What if he just takes like this in day one only he'll go to Muthoot Manappuram? That's what is the scenario they are giving it to you. Yeah. So is the pledge valid? Yes, it is valid. Because on the paper it is valid. Next one, pawner has limited interest. Limited interest we'll be seeing that when I'm doing agent. I'll tell you. When we are doing agency, I'll tell you this. Pledge by co-owner in possession. What is co-owner? When one product is purchased by two people or it is in possession of two people. He can also come and give. He can also come and give. This can happen in your PG things and all. In your room when you are sharing. You guys would have purchased something together. Pledge by seller or buyer in possession. Now what is that, sir? Imagine on OLX, you take my sofa ad only. I agreed to this person to sell this sofa for 10k. When Sale of Goods Act comes, you will understand this. Again in Sale of Goods Act it will come. The entire scenario will repeat. Sale by a non-owner, it will still be considered as valid. When the goods are existing goods, the moment you enter into a contract, the ownership passes. So whenever I agreed on OLX to sell at 10k, the ownership has passed. But where is the sofa? It is still in my house only. Someone near my house came asking for 12,000. Now should I sell? Yes, I can sell. Now whether will he get ownership? Yes, because it is still in my house only. How will he know about OLX transaction? So whether is this sale valid? Yes, it is valid. Understood? Yes, but this I will tell you more when we are doing even that Sale of Goods Act also. Is clear? Yes, okay. I don't think we can finish in 15 minutes. Okay, no issues. So let us do one thing. We can stop it here. Tomorrow let us start from agency. Tomorrow let us have target as agency. We will finish it. Let us also try to take up Sale of Goods Act. And let us do Indian Partnership Act. and let us try to do Companies Act. Yes. So towards the last day, we'll not have much. We'll be having, or we'll see. Probably tomorrow we'll be doing Sale of Goods Act, and let us do Negotiable Instrument Act, and let us do Partnership Act. And based on the time we'll see, or else on the last day we'll be doing Companies Act and LLP, and let us do the question papers. So last day, third day, let us keep more towards the question papers. Clear? Yes, sir. Okay. So now let's meet tomorrow, same time. Yes. Thank you so much. See you all. Bye bye. Yes, people. So welcome back. Let's start with the chapter agency. Okay. Now, first of all, what do you mean by an agent? What do you mean by agency? How was it created? Now, what is an agency? Agency is something where one person who is not able to, or who is not working on his own, so what does he do? He tries to enter into a contract through someone else. So there is always one maxim here. What is that? Qui facit alium facit per se. Okay. So here what do you say generally? Whenever someone else is working on behalf of me, the responsibility is also mine, profit is also mine, loss is also mine. Qui facit per alium facit per se. Whoever faces the world through a third person is facing the world by himself, not through the third person. So what do you mean by an agent? Chanda, neenu ikkade bandbuda? Paravailva? So now what they are saying is, now whenever I am facing the world, so whenever our agent does anything on behalf of me, it's like me only doing it and not the agent doing it. For that, everything what the agent does, I will only be held personally liable. Profits also I will only take, losses also I will only take, provided the agent acts within the scope. Now what is the scope? Whenever I appoint an agent, imagine I have a house to sell. Now what will I tell the agent? I will tell him all the parameters. Now what are the parameters? The price I am looking at is around at least 20 lakhs. I am not okay to sell the house for less than 20 lakh. Now his scope, he can do anything, but the minimum price he has to aim for is 20 lakh. If it goes below 20 lakh, imagine he tried for a month, he tried for 2 months, he was not able to sell. Now he sold a house to one party, maximum now it went for was 18 lakhs. Now whatever he did, he went below his scope. For the 2 lakhs, he will be responsible for the principal because he did not act within his scope, or he did not act as per the directions given by the principal. Agreed? But there are some exceptions. We will be seeing that in certain cases, the agent also will be held liable. In the cases of undisclosed principal, or whenever there is the principal is a minor or things like that, yes, agent can also be held liable. Correct? So that was the overall scope. Yes, let us see what is there in this particular chapter. So parties in agency people, one is called as principal. The principal should always be a competent person, major plus sound mind. Agent people, should an agent also be a competent person? Should he be a major always? Can a minor become an agent? Possible? Yes. Remember, possible. However, let us revisit the same example. Imagine there was a scope. A principal told you have to sell a land for a price not less than 20 lakh. Imagine the agent sold it at 18 lakhs only. Now if an agent is a major, he sold it at 18 lakh. The 2 lakh has to be paid from his pocket to the principal because you went beyond your scope. Now imagine that agent is a minor. Now you sold it at 18 lakh. The 2 lakh people, the principal cannot recover. What do you mean by that? If at all a minor is an agent people, you cannot hold the minor personally liable, no matter what he does.
But you can take his property.
No. No. So whenever, no, not at all. Because you appointing a minor, you are appointing at your own risk. Because law clearly said, try to appoint who is qualified. If not, you will only bear the loss. So that's what is the entire principle that stands on. So one party is principal, the other party is agent. So if incompetent, then principal shall be liable even for an unauthorized act. Got this example? Yes. Okay. Next one, how is the agency created? One is very simple, express by the oral or written. One is implied. Implied is what people based on circumstances. Example can be implied. Example can be necessity. What is necessity, sir? Now imagine, now a person was standing here. Now his name is Babu. Now he is the operations manager. Now imagine whatever was required to set up this class. Now imagine, now the team has not yet come. He has to make certain changes. He has to take a decision at here at this point of time. Now whatever decisions he take, the management will be liable. Now how was this agency created? This agency was created by necessity. Now what is implied, people? Implied means estoppel also will come here. What is estoppel? In your partnership by what is that? Types of partner. There is one partner called as partner by holding out. What was the example? Now imagine there is one manager in my partnership firm. Whenever I go out, I introduce. So we are the partners. Let us imagine A, B and C are the partners. There is a person called D who is a manager in our partnership firm. Now whenever we meet outsiders, we introduce D also as a partner. Agreed? Now for the outsiders, they do not know. Technically we are the partners, he is a manager here. We made outsiders believe that he is a partner here. Now sir, this is only called as what people? Implied partnership. Same thing is called as implied agency. You gave him a power which he does not have actually. But you are creating a scenario where others are believing that he has a power. Now that is only called as what people? Your implied authority. That is what is the example of estoppel also. Agreed? Estoppel means what? You are creating in the other's mind that this person has power. So that is the example for both. You guys can take it. Next one is called as agency by necessity. What do you mean by agency by necessity? Let us imagine your neighbors, when they are going to some other place, they give their house keys and they go. Just in case if at all something is needed, if at all you are really trustworthy, if you have not done anything wrong in the past, they might rely on you. So they will give the keys and go. Now what happened, people? Inside you see that there is some short circuit that has happened and the house has caught fire. Do you really think you will give a call to your neighbors? You will try to check. Immediately whatever comes to your mind, you will try to take the decisions. You will probably call fire extinguishers, fire engines. You will try to take the decisions whatever you can at that point of time. Your neighbor will not come back and question you, why did you do this? Even if he come back and question you, you can always say, I had the power to do it because that is what was right at that point of time. And how did you get that power? That power only is called as agency by necessity, also called as an agency at the time of emergency. Understood this one? Pakka na? Okay. Next one is called as agency by ratification. What do you mean by generally the word ratification? When I did something, I did not have the power. Later on something happened. Someone gave me the power and made all the actions valid in the future. Example, sir. Now imagine I have a house. I want to travel to US. I won't be there in India for 3 years. So what did I do? I asked Chandan. Chandan, there is this apartment, there is a building. There are 3 floors in it. Can you please take care of this? Keep maintaining it. If something is required, just look into it. I'll come back and collect the keys after 3 years. Now what did Chandan do? Chandan thought 3 years, 3 floors. Why to leave it just idle? So Chandan turned this into a service apartment where people can book, people can come and stay and people can go. So in 3 years for the 3 floors, Chandan literally earned around 25 lakh rupees for all the 3 floors. Now after 3 years I came back. Chandan meanwhile vacated everyone. Now Chandan gave me the keys. Now with the keys, people, Chandan also gave me 25 lakh rupees bundle. Now people, what do I say? You tell me. 25 lakh rupees he has kept in my hand. Now tell me what will be my reaction towards Chandan. Wow, Chandan, wow, so beautiful, so elegant. I'll say, thank you, Chandan. Correct. Will I question him? Why did you do? I may question, I don't know. I may not question also. If at all I say, Chandan, you are excellent. You are the built-in CA. If at all I say that, if I take the money, people, that means for 3 years, Chandan did not have the power to do this. I did not authorize him to do this. But the moment I took the 25 lakhs, I am authorizing whatever Chandan did in the past. He did not have the power. In the future, I'm validating everything what he did in the last 3 years. Now this action, this tick mark in the future is called as ratification. In the past it was invalid. In the future I'm making it valid. Is clear? Pakkana. But for a valid ratification, there are certain conditions that has to be satisfied. What is that? It can be express or implied. In writing or oral, I can say, yes, Chandan, what you did is right. Or I can even take the cash and just leave it. When I accept the cash, that means I have accepted everything. Next one, complete knowledge for valid ratification. Chandan has to say, how did I earn this 25 lakh? Sir, 3 years ganja bidda, sir. That is not possible. So that's what they're telling you. Complete knowledge is important. Third one, rectifying in entirety and not in part. What happened? People, 3 floors are there. Now remember, what do you mean by ratification? If at all I am accepting 25 lakhs. Now people who would have stayed there. Now few people would have hit nails. They would have used the house in the as ugliest way as possible. Now whatever is the maintenance, that might charge me around 5 lakh rupees. When I accept 25 lakhs, this 5 lakh burden also I have to accept. So when I say you have to accept as a whole, you have to accept the profit also, you have to accept the maintenance that comes with it also. Second thing, complete ratification means, imagine 2 floors are maintained good. The 3rd floor people is extremely in a bad position because the tenants who stayed there, they have literally exploited it. I'm saying, Chandan, I will take only 20 lakhs, the 5 lakh you take, because the 3rd floor repairs will cost me around 15 lakhs. I cannot do this part ratification. If it is full, it has to be full. If not, it should be no completely. That is what they are saying. Yes. Now, yes, you guys can have a doubt. What is that? Sir, what if Chandan says no? He will not accept 25 lakh. If Chandan says no to 25 lakh means people, that means Chandan did not have the power to do this particular activity. Now, you logically think, when will you say no? Whenever the liability is more and the profit is less. Imagine if the maintenance is costing me 30 lakhs and the money I earned is 25 lakhs, that time I will say no. Now what will you have to do? Chandan will have to take the 25 lakhs also from extra 5 lakh he has to put from his pocket, and he will have to make good the loss because I never gave him the authority to do all of this. That is only called as unauthorized acts. Understood? Pakkana? Okay. Next one, to be done in reasonable time. That is, I have to say yes within a reasonable time, not after 5 years. Should be communicated to the other party. I have to intimate to the other party also. Act should not be void or illegal. This is very important. You cannot ratify a illegal activity. What did you do? Whom did you give this house for? Sir, I gave this house for terrorism. You cannot ratify it. What is illegal is illegal. You cannot make it legal in the future. It is not possible. So whatever is void or illegal cannot be made legal. So these are the rules of ratification, important from your exam point of view. Rules they can ask you. Clear? Yes, sir? Okay. Next one, appointment of sub-agent. I expect a difference based question also here. A difference between sub-agent and a substituted agent. Is there a difference? What is sub-agent first of all?
For the agent, one more agent will be co-agent.
For agent, one more agent will be there.
Under the agent,
So this is meaning, pakka, perfect. That's what I say. This is example. What is agent? A agent delegates his duties further to another person, becomes a sub-agent. Difference is yeah. Yes, sir. Now that is what I say, people. Law, what is very, very important are the keywords. Vocabulary, I'll not say complete it is vocabulary. Keywords, if it is there, now I'm saying, I further delegate. Delegate is the keyword. Hinde you write Ramayana, afterwards you write whatever. Oh, it is still fine only. I'm telling you the word, whichever is the keyword has to be there, if possible, underline them. They are very, very important. Is clear all of you? Okay. So, technically, in India, a sub-agent is not valid because what does the rule say? The rule says delegatus, what is the rule? Delegatus non potest delegere, meaning what? delegatee cannot further delegate. Meaning, Macha, I have given it to you, believing in you. You cannot give it to someone else again, because I do not trust the third person. I trust you. Like I gave the work to Chandan to take care of the house. Chandan will again further give it to someone else. I don't know how is that person going to handle it. I do not have the trust over him. That is what is the rule. Okay, what does it say? Delegatus non potest delegere. That means an agent cannot further delegate. This is very important. Okay. Sub-agent, legal validity. First of all, can we appoint a sub-agent? Is it recognized in the law? If properly appointed, principal shall be liable to the third parties. Technically, no authority to appoint agent shall stand in the relation of principal, and principal is not liable. Now, what do you mean by that? First of all, sub-agent people in India is not recognized. It is not allowed. However, there are some exceptional cases where even sub-agent is considered as valid. His appointment will be considered as valid. Whenever I've asked the principal, sir, I will be appointing a sub-agent, is it okay? And the principal also agreed. In such case, what will happen? The principal will be liable for all the activities of sub-agent. Whatever he does, principal will be liable. Let us imagine a scenario, the appointment of sub-agent is not recognized or it is not valid. Now, whatever the activities he does, will the principal be liable? No, but someone should be held liable. Who will be held liable? The agent, the first agent will be held liable. They are telling you in what capacity he will be liable. The agent will be put in the shoes of principal, and the sub-agent will be called as an agent. So for whatever he does, he will be liable. But ultimately, will the principal be liable? The answer is no. He should only bear the loss. Whatever is the money lost, I have to pay the money for it. Understood this one now? Yes, sir. Okay. Next one, exceptions, sir. This is what I told you. In certain cases, you can appoint a sub-agent. Now, what are those certain cases, sir? First one, terms of appointment allowed it. Whenever the principal appointed me as an agent, that time I also told him, sir, I cannot do it on my own. I'll be further appointing one more person also. Are you okay with it? Principal agreed for it. In such cases, sub-agent will be valid. Second case, sir, custom of trades provide for appointment. Custom of trade means what, people? Now imagine in the case of construction, it is meant to happen like this. Whenever you give work to the main contractor, he will further divide it into various departments. Various departments will be there under construction only. Now I know for a fact, if I give my work to one person, everything won't be done by him. He will call assistance from some other persons also. The other example I have to give it to you. Event managers. Imagine you are planning for a wedding. You take one person's help called as event manager. He will only come and cook also. A catering also he'll only do. Tambula bani sir, please tagoli tenginkai. Everything he'll only give. No. He further divides or allots into different department. Under him everyone are answerable. Agreed? There is one event manager. Under him there will be various tie-ups. But if food goes wrong, I'll question you only. If that goes wrong, I'll question you only. Now that is how the sub-agent works. Whatever he does, I can hold the agent liable. The third one, unforeseen emergency. Unforeseen emergency is where a case, in a scenario where, now say for example, now let us imagine, say, okay, I am shipping, now whenever we are exporting, let us imagine we are exporting some tomatoes to a different country. Or okay, we generally export tomatoes to Pakistan. Now whenever we are exporting these tomatoes, now because of some scenario, probably whatever the lorry person, what do we say, that carriers, I have given the job for one carrier to go and deliver this particular tomato consignment to another country. In between, what happened, there was some problem with the lorry and the lorry broke down. And what did the lorry person do? Now, whichever place the lorry broke down, he had some contacts there. He said, Macha, please come here. I had to deliver this consignment. So they transferred all the tomatoes to the another lorry, and the another lorry actually went and delivered it on behalf of that particular actual person. Now, whatever they did, now this is only called as what, people? Unforeseen emergency. I have to deliver a product, and this is also perishable goods. I don't have a choice. We have to deliver. At that point of time, whatever is the best alternative, I did that. So I appointed an alternative person. He went and he delivered. Now this is also called as what people? Again called as sub-agent only. So these three are example, you can expect a question.
Unforeseen emergency can only be seen in perishable goods.
Not necessarily, it can be even based upon scenario also. Now imagine if at all there is a scenario, you take that fire extinguisher thing. I am not there. There is someone else on my behalf. Responsibility is given to me. There is one more person there. I was not there. Now they do anything, that time also it can come under unforeseen emergency. Clear? The next thing is called as what people? Substituted agent. What is the difference between sub-agent and substituted agent? Substituted agent means people take it in this way. Say for example, you will be seeing this in movies and all. There will be one very rich person, and the rich person will always have one lawyer around him. He will be writing some will, he will be advising something. So a rich person will always have one lawyer going around him. Now the rich person will ask the lawyer, what? A lawyer, we have certain items in that palace, we have to auction them. We'll no longer use it, and we can also get some good value for it. So can we auction it? So what does the lawyer do? Sure sir, I will see who is the best in the market and I'll get them. Now what will the lawyer do? The lawyer will do his research. Who is the best auctioneer in India right now? And we got to know, I forgot his name, the person whoever was conducting IPL is one of the most renowned auctioneer. Technically, I'm telling you really also, I forgot his name. He's very, very famous. He did IPL auction for more than 15 years. This year the auctioneer changed, because he has also aged. Now I say, okay, this person is a right auctioneer. Now what I will do, sir, you can contact this person. He is the best person to auction it. Now the rich person will contact him. He will say, this is my expectation for this water bottle. I'm expecting around 2 lakh rupees. Like that I will say whatever is my expectation, and then finally auction will start. Now what do you mean by substituted agent? I gave you the work. You said you cannot do it. Lawyer will do an auction. No. But you said, I will do one thing sir. I have someone in my circle. I will give you his contact. You directly contact him. But the reference I will give you is a tested one. So if you gave a contract, if you gave a reference, whoever is tested, and this is the right reference, you are not giving a random one. Just like that you Google and you give off a number. You are not doing that way. You took your own time, you did your research, and you gave a number of this person. Now this person becomes a substituted agent. Now you guys can ask a question, sir, isn't it similar to sub-agent? This is also similar to substituted, and sub-agent are sounding similar. Remember, substituted agent will never report to the lawyer. There will be a direct reporting. In catering, the caterer will report to the event manager. He will not come and eat your head. You will communicate everything to the event manager. Correct? Second thing, for whatever the caterer did, event manager will be liable, and ultimately principal will be liable. Agreed? Sir, if at all the agency is not rightly appointed, then the principal is not liable at all. For whatever sub-agent does, directly the agent will be liable. Principal will not always be held liable. Remember, in substituted agent, for whatever substituted agent does, the principal will be held liable. Sir, now I have a doubt. Can I not hold the lawyer liable in any cost? Lawyer won't be liable at any time. He won't be liable at all. Lawyer can be held liable whenever you gave me his reference, you gave me his number. No, you gave a alternative meaning people, you did not do the research at all. You just gave some random number. You did not do a prudent search. You were not right. You gave some random number, and the random reference turned out to be bad. That time you will have to take the onus. That time you will have to take the responsibility. So in this case, in the case of substituted agent, the first agent, if at all he did the ordinary work, that is by searching properly, by doing diligently, he did not do any negligence, his liability is not at all involved. He is free from his liability. Now whatever substituted agent does, for that the principal will be held liable. Got the difference? Pakka na? Yes. So that's the important thing. Remember, the substituted agent and sub-agent, they can ask you a question also. Important. Sub-agent, substituted agent, let us cover up that also. According to me, if at all they are asking differences, this difference has maximum weightage. They may ask you. Sub-agent, substituted agent. A sub-agent does his work under the control and directions of agent. Agreed? A substituted agent works under the instructions of the principal, directly reporting. Okay, the agent not only appoints a sub-agent but also delegates to him a part of his own duties. Macha, whatever I gave you, that only you are giving. Tomato, I told you to deliver. You are telling the other person your duties only, nothing extra. Getting the point? Sub-agent is doing the work. Principal gave some work to agent. The same work is being further delegated. He is not being hired for doing something more. Sir, whereas substituted agent, lawyer is different, auction is different. The agent does not delegate any part of his task to a substituted agent. Are you able to understand? There is no privity of contract between the principal and sub-agent. Meaning what? If at all the appointment did not happen properly, there is no connection between principal and agent, meaning sub-agent. Dunlop pneumatic tires. There is a manufacturer, there is wholesaler, there is retailer. I cannot come and file a case on a retailer. There is no privity of contract. Principal, agent, sub-agent. Contract is here, contract is here. He cannot come and file a case. Whereas in substituted agent, I am referring and you are directly contacting him. There is a privity of contract. Very, very important. This difference has to be there in your question. Clear? Next one. The sub-agent is responsible to the agent alone and is not generally responsible to the principal. Here, he is responsible to the principal. The agent is responsible to the principal for the acts of the sub-agent. So for sub-agent, agent is responsible. Agent is responsible for the principal. Here the agent is not responsible to the principal for acts of the substituted agent. Agreed? This is important. For whatever the substituted agent does, the agent will not be responsible. He will not be liable. That's what they are telling you. The sub-agent has no right of action against the principal for remuneration due to him. Sir, who will pay sub-agent? Money who will pay? I am not responsible. I will pay event manager. How much he pays to you, I am least bothered. But I will just pay to him. In this case, obviously everything is directly related. The substituted agent will directly get the remuneration from the principal. Agent remains liable for the acts of the sub-agent as long as the sub-agency continues. Meaning, sir, as long as there is a sub-agent, for everything agent will be liable. Here, the agent's duty ends once he names the substituted agent. Once I give the reference, my duty is done. Provided, yes, people, you should not have referred a wrong person. That's all. You have to pay proper attention in naming that person. Is clear? Pakka na? 100%? Yes. Remember, exam point of view, very, very important difference between sub-agent and substituted agent. Clear? Okay. Rights of agent, sir. Simple. What are the rights of the agent? Right to remuneration, obviously. Right to retain out of sums received principal amount. What is it, sir? Now, I have a right to receive money. What if you do not give? What should I do? As an agent, what can I do? They are telling you, right to retain out of the sums received. When you are doing the business, on behalf of the principal, there will be so many accounts or different amount that you will be receiving from different person. Now, before settling that to the principal, they are telling you, you can withhold some money. Now, for what? Towards what you can withhold? Imagine if at all agent has paid any money on behalf of the principal, any advances he has paid, I can take that money. If at all I have incurred any expenses, imagine I paid electricity bill, I can take that money. If at all, whatever is the remuneration I have to get, you have not paid, I can take from the money that I need to pay to you. To understand this, I am telling you, imagine I appointed someone as a manager for my cafe, my hotel. Now when I am not there, there will be so many customers that will be paying the money. At the same time, there will be so many vendors we need to pay the money. Raw materials we need to pay to the salaries of the different person. Now what they are telling you, if at all the manager has paid all of this, and we have also received money from lot of people. Now this money should technically come to me. They are telling you, before I get this money, from whatever the money he has collected, he can first pay, or he can only take for whatever is the payments he has made. If he has made any advances, if he has made any expenses, if at all any remuneration has to be paid to him, for towards all of that, he can take the money. If something is left, that will come to the principal. That is what they are telling you. Clear? Okay, next one, agents lien on principal's property, meaning, sir, I don't have money. The principal has not paid me also. Now, how do I get my salary? Then what do they say? Hey, agent, do one thing, da. You have principal's laptop, keep it with you only. You have principal's any other goods, keep it with you only. Until when, sir? Until your money is paid. Sir, what if my money is not paid at all? Then do one thing, you only keep that particular products with you. But remember, what a agent enjoys is called a particular lien, not a general lien. Just remember that. What is the difference between particular lien and general lien?
Particular means only that, like what in the business, whatever is there, that he has to hold. If general means anything he can hold.
Okay. So particular lien is basically where you can hold for whatever services you have given. Only that product should be retained with you. General lien people, towards a service done for one product, you can retain another product also which belongs to the principal. Correct. Bank example, FD. Loan is there. You can retain the FD also, which is nowhere related. So what right the agent enjoys is a particular lien and not a general lien. Okay. Next one, sir. Right to indemnity. What is indemnity, people? For whatever is the loss that the agent may suffer, the principal has to pay the money for it. For lawful acts, against acts done in good faith, non-liability of employer of agent to do criminal act, compensation for injury caused by the principal's neglect. Now, what is this, people? For lawful acts, let us imagine, now principal is there, agent is there, there are vendors. Principal said, I will be sending you the raw materials. So you enter into a contract with the vendors, you try to get the contract for us, we will supply the raw materials. Papa, agent went and got so many contacts also. And we had to deliver everything on 10th of May. We had to deliver these products. But on 10th of May, what happened, people? The agent did not get any materials from the principal. Principal said, I will be sending you the products. I did not send the product. Now, what will the vendors do? Vendors started filing a case on the agent because he was the face of it. Now, whatever is the loss that the agent will suffer, everything principal has to bear or principal has to pay. And that is what is called as indemnification. So whatever is the loss suffered by the agent, you will have to make good the loss. Understood? Pakka? Yes, sir. That is what they have given here. For lawful acts or any acts against done in good faith, meaning I have believed in you and I have done. If I have to give you one more example, let us imagine a scenario where principal gave his car to sell. Now who is this agent? He is a second-hand car showroom person. I told, can you please sell my car? He sold the car also to another person, to a consumer. After 10 days, we got to know this car does not actually belong to me. This was a stolen car. I remodified it and I sold it. Now, who will the consumer come and question? Obviously, it does a second-hand car showrooms. You wouldn't have seen the owner also. You will see only the second-hand car showroom person. He will come and file a case on you only. They are telling you, principal has to bear the loss. That's what is the second one. Against acts done in good faith. I believed in you and I sold. And if I suffer any loss, you should have to take the hit. Non-liability of employer of agent to do criminal act. What is this, sir? Imagine, people, there is A. A tells B, Macha, go and kill C. Now who is B? B is an agent. A tells B to kill C. Now Papa, B went and killed C also. Police people came and arrested him. Now B is telling, sir, not me, sir. It is A, sir. Please arrest A, sir. He has to pay the money, sir. I am not at all liable, sir. They are telling you, agency thing won't work in criminal activities. He will also be held liable. He will also be held liable. But what does generally agency mean? Profits also belong to me. Losses also belongs to me. Agreed? In this case, I am telling you, according to Indian Contract Act, you cannot say, no, sir. Technically, it is principal, sir. For all the actions, he is only liable. That won't work. You will also be liable. Under IPC, it is there, people. You are also liable. A will also be held liable. Understood? Pakka na? That's working, ada? It's very nice, sir. Sir, it is very nicely working, sir. That here only is not coming. Okay. Okay, then hey online, you guys have any doubts, Online, is there any doubts,
Principal won't be liable even in case of illegal acts also.
No, he won't be liable. That's what you can take, the illegal thing will come here only. Yes, compensation for injury caused by principal's neglect. Compensation for injury caused by principal's neglect, what is that? If remember, I think in the class I would have given you an example of that scaffolding. What is that? What is scaffolding? Imagine people, okay, say for example, I will tell the person to come and repair these ACs. I will tell the person to come and repair these bulbs and all. Imagine this is at least reachable heights. If it is a little tall, so I will tell him, sir, I only have the ladder, chair and all. You come, you just have to repair the ACs, the ladder, chair, everything I will only give. Papa, the person came, he is fixing on things, but the ladder broke. Now, it is my responsibility because I told him I will be giving him some material. And if at all, if that material is not right and if he suffers any loss, as a principal, I will only be held liable. The example you would have seen in your book was scaffolding is nothing but people. Whenever a construction happens, in front of the building, there will be that pipes. You remember? Something like this, the pipes will be there. The workers will be standing in front of that wooden thing or pipes. So, whenever the construction or painting is happening, or out structure of this particular building, there will be these pipes and all for the support. Now, in this case, what had happened, the principal said, your duty is to come and paint. The pipes and all, I will get it done from someone. So, he said it is my responsibility. So, throughout the building, the pipes or the wooden structures were provided. One of the labor, when he started painting, the entire scaffolding fell. So in this case it was held, principal will be held liable. If at all, because of your neglect, if at all any damage happens, for that you are liable. That is what they have given it here. Compensation for injury, he fell caused by principal's neglect because you provided that. Understood? Yes, okay, done. So duties of agent, simple. Duty to execute mandate. What do you mean by duty to execute mandate? If I told you to do something, you have to do. You guys would have seen a case law also in your book. What is that, sir? Duty to execute mandate. In this case, the principal had told the agent that, hey, there is a go down there, don't take risk, take insurance. The agent people did not take insurance on it. So, at the end of the day, in the go down people, the entire stock was burnt. In this case, it was held that whenever there is a mandate given to you, what do you mean by mandate, people? Mandate means whenever there is a command given to you, whenever there is something to be, you should have done something. If there is something you should have done, if that is told to you, if you do not do, whatever happens, you are only responsible. So this was act of God. There was in this case, what had happened, there was an entire go down. There was an electric shock, short circuit that took place. The entire go down caught fire. It is not in the hands of agent, but agent was held responsible for the entire stock. The reason is the principal had told agent, take insurance on priority. Agent missed taking insurance on priority and hence agent was held liable. Understood? Next one, duty of reasonable care and skill. Reasonable care and skill means people nothing but don't be negligent. So whenever you are acting, you have to be always correct. So they are telling you whenever you are doing something, you should always be careful, diligent and not negligent. You have to do your research properly. Next one, duty to follow instructions or customs. Meaning, now if for example, if I have to combine these 2 points, let us imagine people, in every business, a principal will tell the agent how to do, how not to do. Let us take for example, ArivuPro. Now ArivuPro, there is a policy. Now let us imagine, if the principal said, the owner said, strictly do not take admissions without taking the fees. Now agent has a specific instruction. You have to act according to the instruction. Now let us take an example. What if with regards to the credit sales, the principal did not say anything? He said take up admissions. What if few people ask, sir, I want 1 month time. Should we accept it or not? Principal did not say anything. Now what should you, now what do you want me to do? When there are no instructions, then follow customs. What is customs? How does your competitors work? Such sales, does it happen? It may happen. Yes sir, it may happen. Credit sales will happen. Few people may ask time. We have to respect that. Okay, now combine the second point. Okay, you give it credit sales. I'm not saying no. What is his reasonable care and skill? You have to do a little background verification of the person. Now what happened? One student came for 1 month. After 1 month, people did not turn up. Now the principal can hold the agent liable because you did not do proper research about the person. You acted negligently. Got this, all of you? Next one, avoid conflict of interest. What is conflict of interest? When I tell you to do something, you have to do it properly. You should not make secret profits. Now, for example, I will tell my agent, I want to buy a car. My budget is 10 lakhs. Now, what will the agent do? He only had a car. He sold that car only to me. But he did not tell that. Now what did he do? He know what is the maximum I am willing to pay. He did not negotiate at all. He only took the 10 lakh. His car was only 8 lakh worth. He transferred that car only to me. Later on I got to know it was his car only. Now this is only called as people avoid conflict of interest. You should not make money for yourself. So whenever I am telling you to do something, do not do or do not look for a personal gain in that contract. The same thing is avoid conflict of interest. You would have seen, where is that avoid conflict of interest? See, not to make secret profits. I'm not telling you should not make profits. Sir, can I sell my car to you? Yes, you can sell. Then what is the right thing? Disclose it and do. You cannot make it secretly. Next one, sir, communicate with principal in difficulties. Whenever you are not able to take a decision, it is your responsibility to speak to your principal, to render proper accounts, don't cheat him, not to delegate. Obviously, no. What is the general rule? Delegators non potest delegere. Generally, you are not allowed to appoint a sub-agent, but we saw exceptions. That's the reason you are seeing sub-agent not valid generally, but there were 3 exceptions. Okay, pay some receipt for principal. Whatever you took, fees and all, you have to transfer it back to the principal. It is his money. Not to use confidential information against principal. The best agent that is working for all of you is nothing but your banks. Bank is your agent. He will collect on behalf of you money. Is it? Will the bank collect the money on behalf of you? Yes, no. If your friend has to transfer UPI 150 rupees, is he giving in pocket directly from his hand to your hand? No. Your bank is collecting on behalf of you. Imagine for business, you guys will give a check. I will go and deposit. My bank will come to your bank. It will collect the money. It will deposit in my account. Who is doing all of this? Bank is doing all of this. Now can bank use all this information against me? Tomorrow can it blackmail me? Because there is so much of transactions they know. They are telling you do not use confidential information against the principal. Understood this one now? Okay, done. Next one, sir. Principal or agent's liability to third parties. Principal or agent's liabilities to third parties. We are entering into a contract with an outsider. For him, who is liable? They are telling you principal's liability for agent's activity. Meaning, whatever agents do within the scope, principal will be held liable. I'll tell you one more information. I told my agent to sell a car. I told him do not sell this car for less than 5 lakh. My agent sold this car in fact for 5.5 lakh also. But you know one thing, the car's mileage is around 10 liters per kilometer. 10 kilometers per liter. But the agent to sell it, people, he told wonderful car, sir, this will give you 15 kilometers per liter. He actually cheated the client and he sold the car. Sir, later on it was found that yes, this car won't give 15 kilometers per liter. Now the question is, whom should that buyer, the consumer, whom should he file a case on? Is it agent's liability or is it principal's liability? Who is liable? Agent or principal? Agent or principal? Remember, sir, whatever agent does within the scope, within 5 lakh only, no? Whatever word he says, principal is liable. That is only the meaning of qui facit per alium, facit per se. Correct. Criminal activities are different. Cheating is different. Now you imagine, for the world, I am only telling that he is my agent. I appointed him for that. For whatever he does, I should bear the risk. It can be good things also, it can be bad things also. When he sold it at 5.5 lakh, I took 5.5 lakh. No, it comes with cost also. Understood this? Do not confuse this with criminal activities. Clear all of you? Okay. Agent is not personally liable by contracts on behalf of principal. Meaning, sir, whatever agent does, agent will not be held liable. It is always principal who will be held liable. But there are some exceptions. That means who will be held liable? Agent will be held liable. When very, very important, you can expect a question. First one, pretended agent. What do you mean by pretended agent? Means people, I am pretending to be someone's agent. Pretended agent means what, people? I am not naming the principal at all. I am telling I am agent. I am pretending to be the agent. But is there a principal? The answer is no. I am pretending. Pretending means what? In reality, it is not an agent, but he is just pretending to be an agent. In such case, he is only responsible. Why? In a pretended agent, there will be no principal at all. Example, I am pretending to be a student. Am I a student? That means I am acting. In such case, he is telling, I am pretending to be an agent. There is no principal at all. I am acting like an agent. But is it true? No, there is no principal at all. In such case, whom will I hold liable? I will hold you only liable. Next one. Foreign principal. Macha ange irukku. What do I do here? Kari ninna. Hey, you are only liable. Who? Agent. Agent does not disclose the name of the principal at all. I am interrogating. I am just taking cutting plier and pulling his nails. He is not telling who is the principal. Then what do I do? What can I do? You will only be held liable. Incompetent principal. Obviously, but remember one thing. Here, incompetent principal, instead of minor, I can actually say it also as an unsound minded person. Technically, when we started this unit, what did we say? A principal should always be competent. What if after the contract is entered, the principal becomes unsound mind? Getting the point? Scenario can happen. Now what to do? They're telling in that case, people, I will hold the agent only liable because I cannot do anything against the principal. Understood all of you? Okay, done. Next one, sir. Principal liability when agent exceeds authority. Sir, oh sir, I told him to buy a car for 7.5 lakh, but he got a car for 10 lakh. Now tell me, to what extent is a principal liable? I told my budget is 7.5 lakh. He got a car worth 10 lakh.
7.5 lakh, the principal is liable. The next 2.5 lakhs,
the agent will be liable. Now what does the law say, people? If at all you have to hold the principal liable, the first question I will ask you is, can you separate the contract? What do you mean by separate the contract? In the 10 lakh, can you separate 7.5 lakh and 2.5 lakh? Can you separate? So 2 seats you separate, 1 seat in it ko macha, 1 wheel for you, 3 wheels for me. Can you do that? When the contract is non-separable, for the entire 10 lakh, the agent will be held liable. If the contract is separable, then for the 7.5 lakh, principal will be held liable. For the 2.5 lakh, agent will be held liable. Understood the example of separable and non-separable? Whatever, now imagine I told the agent, please get me 10 lakh worth any goods. Let us imagine benches. I am starting a college. I need 10 lakh worth benches. He got in fact 12.5 lakh worth benches. Now how many benches I got? I got around, let us imagine, some 10,000 benches. Now can I separate 9,000 and 1,000? I can separate. Now I will pay only for 9,000, I will take this. For the 1,000 agent, you deal with him. I don't know. I told you this is what is the scenario. So in this case, what they are telling you, for this I am liable, for the 1,000 agent will be held liable. Is this clear? Pakkana? Okay, done. Next one, sir. Any notice given to agent is equivalent to giving it to the principal. So vendor says, sir, there will be 10 days delay. The vendor will not again come and communicate to the principal also. If you tell it to the agent, that means you have told it to the principal also. Effect of misrepresentation or fraud by the agent. Ayoyo. If acted within the course of business, sell the car for not less than 5 lakh. Principal to be. Remember, not this attempt, but some attempt they will ask this question. Pakka. Whatever the scenario I told you only. Sir, why do you have to tell that to us, sir? Not this certain. Why did you have to tell us, sir? Okay. Someone else does. Sometime when they are watching a video, for them I'm telling. Not something like that. What is that? Something like intuition or some gut feeling. Okay. Beyond the scope of authority. What is beyond the scope of authority? I told you to sell the car for 5 lakh. You sold it at 6 lakh. If it is going beyond, for that, whatever you have done, whatever you have stated, for that everything is you are only liable. Clear? Okay. And the last part, rights of the third parties, whoever we are entering the contract with. What are his rights? Contract made by undisclosed agent. If agent does not disclose that he is an agent, if principal is disclosed before contract is completed, the third party may refuse to fulfill the contract. I told you also this in the example. What is that, sir? Imagine agent is not disclosing that he is an agent at all. And he entered into a contract with a third party and he never disclosed that he is an agent. If at all tomorrow the third party gets to know that he is not the actual person, there is a principal hiding behind him. If I get to know, and technically I do not like this person, technically we are not allowed to enter into a contract. If I get to know who the principal is, even after entering into a contract, the third party has a choice to cancel the contract. The example we had seen was, imagine, sir, there was one celebrity, let us imagine Shah Rukh Khan was not allowed to one stadium for a certain time. There was a ban. So now what did Shah Rukh Khan do? Shah Rukh Khan sends his agent to get some tickets. Wankhede Stadium gave the tickets also. Because they did not know, the person who booked the tickets were different. But later on the match day they got to know Shah Rukh Khan is coming for the match. If I get to know who the principal is, I have a right to cancel the contract. Understood? Yes, sir. Okay. Performance of contract where agent is supposed to be the principal. Meaning, sir, right of third parties, performance of contract where agent is supposed means assumed to be the principal. In short, people, I do not know who the principal is. I am assuming that the agent only the principal. So I do not know. When will this happen? It will happen in the case of undisclosed principal, or whenever it can happen in the case of, we saw it here, no, pretended agent. I do not know that there is a principal at all. In such cases, I will hold everything. I will hold agent only liable for everything because I do not know who the principal is. The last one is option of third person to the agent to sue the agent or principal. Now, whoever is a third party, if at all the contract is not performed, whom should I file a case on? Should I file a case on agent or should I file a case on the principal? Whom should I hold liable? They are telling you, case where agent is personally liable, consequence of inducing agent or principal to act on belief that principal or agent will be exclusively liable. Meaning what, sir? They are telling you, whom should I generally file a case on? The third parties generally should file a case on the principal. That's the first liability. But there are certain scenarios, the third party can file a case on principal also or agent also. Technically, the first person on whom should I file a case on is always principal. But in certain cases, I can file a case on principal also or agent also. So, when are those scenarios where I get a right to choose on him or him? When will that be? It will be in the case, first one, cases where agent is personally liable. Wherever agent can be held personally liable, in all those cases I can file a case on agent or principal. Whenever I'm a pretended agent, whenever I'm acting on behalf of a foreign principal, agent is liable. In this scenario, the third party can file a case on agent or principal. On a normal scenario, he will generally file on principal only. But in some exceptions, I can file a case on agent also. Understood these exceptions. Sir, second case, when can I file a case on whether principal or agent? The second scenario, agent personally told me, sir, if anything happens, come to me. Sir, anything happens, come to me. Something happened, I'll come to you only. Why will I go to principal? Because you only gave me that belief. Nan idinalva, sir. Come to me, no, I came to you. That's what they're telling you. See here, consequence of inducing agent. Inducing agent means, people, he is telling you or making you believe that if anything happens, come to me. In such case, I will come to the agent only. If the same thing is told by the principal, I will go to the principal. Understood? Okay. Next one, termination of agency. When will the agency come to an end? First one, on completion of business. Activities achieved. Expiry of time. I have appointed you for 2 years, 2 years is done. Principal becomes insolvent. Obviously, for everything what agent does, principal is liable. If he becomes insolvent, then obviously everything will come to an end. Revocation by principal. Revocation means people, I have appointed you for 2 years. By the end of 1 year, I decide to take back the agency. Can I take it back? Yes, you are free to take it back. But remember, I appointed you for 2 years. I am taking back your appointment within 1 year. So this is also a breach of contract. That means you will have to pay compensation for the rest of the 1 year. Sir, now agent's ego got hurt. If he has a right to take back, I should also have a right to give back. I will have to have a right to resign. That is only called as renunciation. Renunciation means to give up. Sir, same thing will repeat. When you entered into a contract, you were appointed for 2 years. Now you are giving it up in 1 year only. Again, you will also have to pay compensation. The last one, people, death or insanity of principal or agent. He dies, the agency will obviously come to an end. Clear? Yes, sir. Sir, effect of termination. Remember always, sir, principal said no to the agent. I have appointed you for 2 years. I have done a revocation, meaning I have taken back the agency. Agreed? Sir, when will this be effective? The day I wrote a letter, the day the letter reached you, the day you read the letter. When will the agency be terminated? What is the date?
The day he read the letter.
So the day you read the letter. Sir, this is for agents. But till today, the agents are doing the business with a third party. For the third party, what is the effective date from when the agent is terminated?
When the agent communicates it to the sub-agent.
Remember, whenever the third party gets to know that this particular thing is terminated, until that day, whatever agent does, the third parties can still hold the principal liable. What do you mean by that, sir? Let us imagine I terminated the agent on 1st January 2025. Sir, I have terminated. Agent also got to know. But what did agent do? He immediately did one more contract with the third party. Does the third party know this? No. Every day he is only doing the business with him. So until the third party is aware, principal is still liable for whatever the agent does with the third party. Sir, when will the third party be aware? The day he gets to know. That means write a letter to him also. Now you tell me, how many letters should principal write?
2 letters.
2 letters. Now imagine there are hundreds of third parties. How many letters you will write? Adikke, publish it in newspaper. Understood? This is practical knowledge. Clear all of you? Pakka? This attempt to know, but some attempt they can ask you this as a practical question. Sir, Venda. Tension ಮಾಡಿಸ್ಬೇಡಿ ನಮಗೆ. Okay, clear all of you? I knew this was a new chapter. That's the reason I have tried to cover it in detail. I hope you guys understood. Any doubts in agency?
Sir, when the agency is irrevocable.
Okay, agency is irrevocable in certain scenarios. When is that when is that scenario when the agency is irrevocable? Whenever the agent is also personally interested, the agency is irrevocable. Agreed? When is agency irrevocable? Meaning when you cannot cancel the agency. Whenever the agent is personally interested, you cannot revoke the agency. When is that? Let us imagine there is principal. Let us imagine there is an agent. Agent had given some money to the principal, say for example some 2 lakh. Now I am not yet repaid this money. Now what did I tell the agent? Do one thing, I have one car. Sell this car to a third party. My amount I need is 5 lakh. You sell any amount, you sell it to 10 lakh also. Give it to me 5 lakh. Whatever 2 lakh I had to pay to you, you take that money from the sale you make. Now what I have done, now the sale has to take place because his interest is also involved. Now this agency I can never terminate because his benefit also is involved. So this agency is irrevocable. Meaning you cannot cancel this agency.
Like after he sells the car, it can be revoked.
No, because after he sells the car, it can obviously be revoked because on the job is completed, completion of the business. Agency is revoked, yes. Is clear? Pakka na? Online, any doubts, Ada? So by this we complete your agency. The next, let us do Sale of Goods Act. Let us do Taka Taka. That's not. It doesn't take much time. Any doubts, people? Online? No doubts? Okay, perfect. I hope you guys are able to understand. So the next topic, people, let us do unit chapter 3, unit 1, Sale of Goods Act, formation of contract of sale. Okay, Sale of Goods Act, as I always tell you in the class only, Sale of Goods Act is a continuation of Indian Contract Act only. Earlier, Sale of Goods Act was also part of Indian Contract Act. Later on, they took it out of this Indian Contract Act, they made it a different legislation, and that's how we got Sale of Goods Act 1930. Okay, the first thing, people, there are some definitions that is very, very important from the first unit. Now, what is it? We will see. First one is goods. Now, what are goods, people? Goods means movable property. So, one is very clear. Immovable property cannot be called as goods according to Sale of Goods Act. Next one, other than actionable claim. Actionable claim is your promissory notes, negotiable instruments, check, all those are called as actionable claim. They are telling you those cannot be called as goods. Other than money in circulation, meaning what? Certain currencies that are accepted in the country today is not called as goods. What about the currency which is not in circulation today? Example, your antique coins can be considered as goods. Someday this can be tested. Till today I don't know why. It's a very simple point. I'm not knowing the reason why they are not asking a question here. It should be asked someday. It's a technical question actually. Correct? No, money in circulation. Correct. That's why they are not asking only. I have to write one letter. Okay. It also includes stocks and shares. Your shares are considered as goods. Next one, growing crops. Next one is grass. Next one is things attached to the land, agreed to be severed. What is this, sir? Growing crops, vegetables, grass, cattle feed, whatever you sell. Next one, things attached to the land. What is this, people? Nothing but timber. What is timber, sir? Timber means nothing but wood which is grown and agreed to be cut for the purpose of constructions and furniture. So as remember, as long as trees are in the land, they come under immovable property. The moment a contract is made to cut them, or you cut them, contract is made or you cut also, it becomes movable property. Clear? Okay, next one, sir, classification of goods. Goods can be classified into existing goods or future goods or contingent goods. Existing goods can be further classified into specific goods, uncertain goods, ascertained goods. Now, try to remember, try to concentrate, very, very important. Now, what do you mean by existing goods? Existing goods means, here again people will say a different thing. You need to focus on the definition. What are existing goods? The goods which are existing, owned or possessed by the seller at the time of the contract of sale. Meaning that when I am signing the contract with you, the goods should already be there in existence and it should be mine. It should be here. If it is there, if it is existing at the time of contract of sale, that is called as existing goods. Sir, when the contract was made, the goods are not existing at all. They are called as future goods. Understood? Okay, we'll see an example also. Sir, under existing goods, you can further divide the goods into three categories. One is called as specific goods. What are specific goods? Goods that are identified at the time of the sale. Meaning, sir, you go to a shop. You physically go to a shop, you pick whatever you want, specific packet, whatever you want, you pick it. You go to the counter, you pay the money, you get the product. When the sale is happening, you specifically know which product you are going to get. It is already identified. That is called as existing specific goods. The next one, sir, whenever the contract of sale is made, is your goods identified? No, sir, my goods is not yet identified. Give me an example. Now, whenever I go to a shop, let us imagine grocery shop only. I will ask for rice. Now, rice, people, you would have seen in the shops, grocery shops, they will keep it in cups as a sample. Agreed? They will keep it in cups as sample. Now, our parents, they will take some rice and they will select, yes, we want this variety of rice. Now, what will the shopkeeper do? He will go inside. We will say, we want this rice. Let us take, for example, basmati rice. Now what will the shopkeeper do? He will go inside the godown. There are hundreds of bags. Out of the hundreds of bags, he will take one bag. He will come and keep it in the counter. Now people at the time of sale, meaning I said I want basmati rice. I was not sure which bag I was going to get. Inside the godown there are 100 bags. In that 100, any bag can belong to me. Now this is called as what? Unascertained goods. What do you mean by unascertained goods? When the contract of sale happened between the buyer and seller, the exact goods you are going to get is not yet identified. Then where is your goods? Your goods is still in the bulk. That is called as what? Unascertained goods. Sir, what do you mean by ascertained goods? After the contract of sale, from the bulk, if at all your goods are identified, separated, now that is called as what? That is called as ascertained goods. I'll repeat it. One is called as specific goods. At the time of contract of the sale, a packet is already there in your hand. Goods are identified at the time of contract of the sale. Unascertained goods. At the time of the contract of the sale, the goods are not yet identified. Then where are the goods? The goods are still in the bulk. That is the rice bags. Sir, after the contract is made, the person is going to separate your goods from the bulk. That is the time when it becomes ascertained goods. So whatever is the goods that is separated for you from the bulk, now this is called ascertained goods. Clear? The next one is called as future goods. What is future goods? I enter into a contract. Kisan company enters into a contract with a farmer. In the next 6 months, whatever is going to be your tomato crop, everything should be sold to me. Sir, today when the contract is made between the farmer and Kisan company, today you entered into a contract. Is a tomato, is it existing? No. At the time of the contract, the goods are not existing at all. It is going to be produced. It is going to be manufactured. It is going to be acquired. Now they become what? These things become future goods. Example, carpenter. Imagine a sofa. You give an order today. He will take your order and he is going to manufacture the sofa. Agreed? Future goods. The last one is called as contingent goods. Contingent goods means people, whether you are going to get the goods or not, depends upon an uncertain event. Example, I want to buy Virat Kohli's bat. I want to buy. I will tell my manager, not my manager, RCB manager, sir, please ask Virat Kohli's bat, sir, I will pay. Because I want it with signature, I will frame it, I will keep it biggest fan, sir, Isala cup namda. So I will tell everything, people. Now the question is, now the manager will say, okay, I will try. If Virat Kohli agrees, I will get you the bat. If he does not agree, I can't give you the bat. Now contingent means people, I may get it, I may not get it. Such goods are called as contingent goods. Understood? Pakkana, 100% done. So these are called as contingent goods. Next one is called as delivery. Delivery, people, is how you transfer the possession of the goods. The possession of the goods can be transferred in 3 ways. One is called as actual delivery. Next one is called as constructive. Next one is called as symbolic. Actual delivery, you wanted a remote. I take the remote, I keep it in your hand. That is called as what, people? Actual delivery. Next one is what, people? Constructive delivery. What do you mean by constructive delivery? Constructive delivery means, people, what? When delivery is effected without change in the custody of the goods. For example, let us imagine A and B, A purchased around 1 lakh kgs of tomatoes from B. A purchased 1 lakh tomatoes from the B. Who is B? Let us imagine farmer. Where had the farmer kept all the tomatoes? Farmer had kept all the tomatoes in a warehouse and he had appointed one manager. Yes, sir. Now people, the sale is happening between A and B. They are meeting outside and they got a good deal. 1 lakh kgs of tomatoes were purchased by A. B will call the manager and say, manager, tomorrow A will come and collect the goods, hand him over the keys. So the entire godown keys will be handed over to Mr. A. So the goods were there only. They did not move an inch. So one call changed the delivery from, so going forward, they are telling you, the entire warehouse does not belong to me, it belongs to A. So the entire possession changed by just one call. The physical position of the goods did not even change 1 inch. It was there, it is there only. And such type of delivery is called as what? Constructive delivery. The next delivery is called as symbolic delivery. Symbolic delivery means what? I want to buy a car. They will keep the car on you. No sir, they will give keys to you. Any other examples of symbolic delivery?
Reality shows, cash price.
Cash prizes, kaun banega crorepati. They will not take your bank account and they will show you the bank account and all. No, they will give you a check. That means we believe. IPL 1 lakh, hit 6, take 1 lakh. Do you check any time whether the money has reflected in an account or not? We believe. It's called symbolic delivery. Other examples can be, there is something called as document of title, document showing title. What is this document showing title, document of title? Examples for document showing title? Share certificates, meaning your RC card, your bike RC card or RC book or whatever you call, you have that. No, you lose it, that means you lose your bike. I've lost 3 times, that means I have lost my bike. No, I'm still shamelessly holding my bike. No, so that is only called as what? Document showing title. It just says who is the owner. You lose it, you don't lose anything. You lose one ID card, that's all. Now imagine I lose my DL, my driving license. Chandan gets it. That means he got to know how to drive. It just says who is the owner. If you lose it, it doesn't make any difference in your life. The next document is everything. Document of title. Example is bearer check. You lose it, whoever gets it will go and encash it. That's very important. You lose it, you will lose everything. Next one is your railway receipts. Meaning acknowledgement. Go and give it to the go down. Whoever gives it will get that entire consignment. Same thing. Warehouse keeper certificate, wharfinger certificate, dwarf certificate. You would have seen so many. Basically, what is this warehouse or what is that wharfinger certificate? What is all this? Warehouses, your normal go down. Wharfinger certificate or dwarfinger certificate, all this is basically something which happens in a harbor, port. So a warehouse in a port is called as wharfinger certificate. Rest of it is same. Everything is same. Yes, so if you lose the document of title, you lose the goods also. Document showing title, you lose it, you don't lose anything. Document of title, if you lose it, you lose everything. Clear? So for symbolic delivery, document of title is also an example. Is this clear? Pakkana? Okay, sir, done. Okay, next one, delivery we saw, document of title, document showing title. Okay, contract of sale. The contract of sale can be of 2 types. One is contract of sale and next one is agreement to sell. Differences, exam point of view, important. What is the difference between contract of sale and agreement to sell? What is the difference there? In contract of sale, ownership is transferred immediately. In agreement to sale, the ownership is transferred in the future date. Agreed? Actual delivery, constructive delivery, symbolic delivery. See, this is how you take symbolic delivery. Okay. Agreement to sell. Okay. Important, sir. Yes, people. What is the difference between sale and agreement to sell? What are the differences? First one, ownership is transferred immediately. Here it is transferred in the future date. First thing, people, in Sale of Goods Act, they would always write something called as property. In Sale of Goods Act, property means ownership. Remember, that is how it is defined. Wherever they have written property, that means it is ownership they are referring to. Is this clear? Okay, sir. Next one, it is executed contract. Sale, money is paid, goods are given. Agreement to sell, you are telling that farmer, I will give the tomatoes after 6 months. Executory contract. It can be unilateral as well as bilateral. Seller can sue the buyer for the price of the goods because passing of the property therein to the buyer. The aggrieved party can sue for damages only. Now what is this, people? In sale, ownership is passed. Seller can ask for the entire price from the buyer. Imagine my product is 10,000. I can file a case for the entire 10,000. Sir, whereas here, imagine the farmer entered into a contract. Farmer did not give the tomatoes. Now the buyer wants to file a case. On what will he file a case? Yesterday we saw when we were doing damages also, ordinary damages. Shirts were 2 lakh. I had to purchase it for 2 lakh 50,000. How much did you file a case for? 50,000. You will not ask for 2 lakh also because 2 lakh was never given to you. You will only file a case for damages, what you suffered. Because goods were not given to you. Agreed? Okay. A subsequent loss or destruction, the liability is always on the buyer. Meaning ownership is transferred, people. Anything happens to the goods, the loss is on the buyer. Here, the loss is still with the seller. If whatever is the natural calamities that happen, floods happen, the tomatoes, it's still in the risk of the farmer only. Risk of loss is that of the buyer, here is that of the seller. Jus in rem, jus in personam. Meaning this creates a right against the whole world. This creates the right against a particular person. I will try to explain this in a simple way. If you don't get it, don't worry. Jus in rem means once I get a ownership of anything, to the entire world I can go and say this product is mine, I purchased it. Let us take for example, I took this remote. I can go and tell to the entire world this remote is mine. In a agreement, in a contract of sale, ownership is already transferred. I can claim to the world this product is mine. In agreement to sell, it is only between you and me that in the future date I will get the ownership. I can only fight against with you that the ownership is mine. I cannot claim it to the entire world. Why? Because I am not yet the owner. So you can claim the ownership in contract of sale with everyone in the world because you have already got the ownership. In agreement to sell, you have not yet got the ownership. You can only fight against the seller alone. That is why against one party you can claim ownership. That's why it's called jus in personam, a right against a person. Here it is a right against the world. Yes, sir. Okay. Next one, the seller cannot resell the goods. Here, seller may sell the goods since the ownership is still with the seller. Another difference is between, okay, sale and bailment. Any differences? Sale involves transfer of ownership. Bailment, temporary transfer of ownership. Once the ownership possession. Once the purpose is served, the possession will be retransferred. Agreed? Sale will always be for money, whereas bailment can be gratuitous, non-gratuitous as well. Yes, sir. And here, yes, there is ownership being transferred. Here only possession gets transferred. So these are some examples between bailment and sale. Next one is hire purchase. What is hire purchase, people? There will be some installments you need to pay the money. After paying the last installment is when the ownership gets transferred. If you fail to pay the installment any time in between, the seller will come and get back the product because the ownership will not yet be transferred until you pay the last EMI. Agreed? Sir, whenever a person becomes insolvent in a hire purchase, seller is not at all under the risk. If a buyer becomes insolvent any time, he can still go and get back the goods. That's the main difference. Clear? Meaning if at all a buyer becomes insolvent after paying 15 EMIs, that's still okay. I can go and still get back the goods. Because in hire purchase, the ownership won't get transferred until you pay the last EMI. Whenever he becomes insolvent, it is nothing to do with my ownership. I can still go and get back the product. That's the biggest advantage of hire purchase. Why is it called a hire purchase, sir? Imagine now 15 installments he has paid. Should I return that 15 installments back? No. Because you used it for this 15 months, that will be treated as rent. That rent only is called as hire. If you pay the last installment, it is called as purchase. Clear? Yes, sir. So that is this particular thing. Anything else in this chapter? Bailment. Subject matter. If at all goods are perished means people, you will have to, before the contract, before the transfer of the ownership, if anything happens to the goods, it is always the risk of the seller and not the buyer. Ascertainment of a price, very important. How do you ascertain the price, people? First one is contract, very important. Second one, it can be according to the course of dealing between the parties. Third one, whenever the seller does not quote a price, the buyer has to pay a reasonable price. Fourth one is you involve a third party. Whatever he tells, you will buy the product for that price. Third party is also called as valuer. Agreed? Yes, sir. According to the contract, you can decide what is the price. What is this course of dealing, people? Course of dealing is, you take it this way. We have a vendor who supplies us. You guys get textbooks, no? So you guys will get pages. Pages, people, is a highly fluctuating and a speculative market. This month the papers will be one price. Next month the papers will be one price. Now he cannot give it us in writing that I will supply the goods, papers at 100 rupees. Course of dealing means, people, this month it can be 100. Next month it can be 120. Nothing will be in writing. We will say whatever is valid for this month, we will collect that price. That is called as course of dealing. So what if we did not agree anything and the buyer took the price? Then it is, the buyer took the goods. The buyer has to pay to the seller whatever is reasonable. Understood? Do not write off in the exam that there is no consideration, hence the contract is void. Do not write that. Whenever it is sale of goods act, when the goods have been transferred and the buyer and the seller has not quoted a price, the buyer has to pay a reasonable price. That is what is this. And the last one is third party. Third party is nothing but, people, valuation. Meaning, you take the help of the external person. You do not know how to arrive at a price. You will say, whatever our CA says, we will buy the shares at that price. Sir, whatever they decide, that will be the price. And remember, if anyone stops this person from doing his job, the other party can claim compensation also, or can even avoid the contract as well. Is clear? So, how will you decide the price? One is contract, course of dealings, whatever is reasonable, the buyer has to pay. The last one is third party, that is nothing but valuation. Clear? Done? So, that's your...
The course of dealing and reasonable are reasonable price. Like
Course of dealing is where the seller and buyer both negotiate. Every month we will negotiate. The third one is where seller does not quote a price. We will generally see this in our local sales. The seller will say, no sir, nodi sir, yeno on price kodi. Something which is reasonable, give it. So that is when these things will come into picture. Clear? Yes sir? Okay, done. So that is your unit 1 of Sale of Goods Act. Any doubt? Yes, online, do you guys have any doubts, Zada? Online, do you guys have any doubts?
ಸರ್ ಇದು ಸಿಸ್ಟಮ್ ಒಂದ್ಸರಿ ನೋಡಿ ಲ್ಯಾಗ್ ಆಗ್ತದೆ. ನಿಮಗೆ ನನ್ನ ಕೈ ಮೂಮೆಂಟ್ ಗೊತ್ತಾಗ್ತಾ ಇದೆಯಾ?
ಸ್ಲೋ ಆಗ್ತಾಯಿದೆ.
ಗೊತ್ತಾಗ್ತಿದೆ ಇವಾಗ ನೋಡಿ.
ಅದೇ ಲ್ಯಾಗ್ ಆಗ್ತಾಯಿದೆ.
ಹಾಂ, ಅದು ಯಾಕಂದರೆ ರೆಕಾರ್ಡಿಂಗ್ಸಲ್ಲೂ ಆಡಿಯೋ ಹಂಗೆ ಬರುತ್ತೆ, ಸ್ಟಕ್ ಆಗುತ್ತೆ.
ಅದು ಲ್ಯಾಗಿಂಗ್ ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮು ನಾನು ಚೆಕ್ ಮಾಡಿದೆ, ಅದು ಆಗಿ
ಇವಾಗ ಇದೇನು ಮಾಡೋಣ ಮತ್ತೆ
ಅದು
ಇದು ದೇರ್ ಇಸ್ ಅ ಲ್ಯಾಗ್. ಯು ಕ್ಯಾನ್ ಸಿ ದ್ಯಾಟ್.
I think it's the laptop, so because
1 second.
because the same thing happened on room number 3.
No, my
So
question.
students also.
No, my question is this being reflected in OBS?
I don't think so, sir. Because the same happens in room number 3. The laptop is a bit slow because I think the storage and graphic card maybe it's low.
In one video, what I had seen was whenever there is a lag, even on the video, there will be a lag in the audio.
Sir, I can check on Zoom. I will join. So when you start the class, I will check if there is any lag is coming.
Yeah. Okay.
Can I?
Yeah, sure. If there is nothing, you can just message me here only. It's clear. Yeah. Thank you.
Yes, people. Online now. Okay, back on. We'll start the second unit. Yes. Okay. So the next unit, people, conditions and warranties, important again from exam point of view. They can ask you a question. Okay. Now, what are this? Huh?
This unit they can ask.
From this unit. Sale of Goods Act also, even otherwise, it's an important topic. So, in terms of importance, the highest weightage will go towards your Indian Contract Act. That's your maximum weightage. The immediate thing after that is your Sale of Goods Act. And after that, we'll have Indian Partnership Act, Companies Act, Negotiable Instruments Act will almost have the same importance, equal weightage. And then yes, you can say the other thing will come. Now I can say LLP and Indian regulatory. I think there will be one question at least from Indian regulatory. So this will be your order. This is where the questions will also come. Clear? Yes, sir. Okay. So the next one, sir, chapter 3, unit 2. Let us talk about conditions and warranties. Now, what is conditions and warranties, people? Now, whenever during the sale of goods, a seller will tell hundreds of things to the buyer. To convince you to buy, he will make hundreds of statements. Now, whatever are these hundreds of statements made by the seller to the buyer, the statements will be called as stipulations. Meaning the words, whatever he has said, the promises he has made. Now, certain promises can be very important to the contract. Certain promises are just supporting, but they are not the main element of the contract. Whatever are the main element, the main purpose, the main promises you are making, the main things are called as conditions, and whatever are collateral, supporting, are called as warranty. Sir, now let us imagine I go to buy a bike. And I will say specifically, I need a bike which is good for the Bangalore traffic jam, which can also give me easy on my pocket maintenance. The third thing, which gives me a good mileage. But the bike he suggests people is a very high maintenance bike because he has a good commission. The next one is he gives me a bike which has a very pathetic maintenance. The reason is because he gets a good commission. Or it can be an old stock. He needs to just push it away. Now what should I do? Now I purchase this bike. After using it, I got to know this is nowhere serving my purpose. Now here, the promises he made, it is a very good bike for the maintenance. It is a very good bike for mileage. Whether it is being met, no. But that's a main condition on which my entire contract is standing. I wanted a bike for these purposes. That was the main purpose for me. If that is only not met, then why should I buy this bike from you? Agreed? Yes, sir. Now in this case, what is going to happen? I can go and give back the bike. I can get back my money. I can also claim compensation also. Very, very important. Whenever the condition is not met, whenever the conditions are not met, you can repudiate the contract. Always remember, cancel, repudiate, resigned, all means same. You can cancel the contract, get back your entire money. Along with that, you can also claim compensation. Sir, next one, sir. What if I got the bike, people? Thank you. What if, sir, I got my bike, sir, and in the bike, people, horn is not working. Indicator is not working. Now what to do? In fact, I am telling you in my case only, when I got my bike, people, there was a minor defect in my bike. Initially, I am telling you, I am teaching you condition, stipulation. New bike, if something is not working, my petrol cap will be there, no? That petrol cap, the gasket was loose. That means whenever it was summer, typical summer, whenever I park it under the direct sunlight, there was this, this petrol tank gets heated because mine is a metal petrol tank. The metal petrol tank gets heated and it gets vaporized. The gaseous sound will come, and it used to make a sound called tss. You can hear it from the petrol pump. I said, hey, what are you selling? Anything happens, what does it happen? He said, sir, nothing will happen, sir. Baro, neen bandu vote, sir. Yeah, nothing will happen. Anything happens means when I am driving, So he said, sir, nothing, sir. That's just a matter of 120 rupees gasket. So I went, I got it serviced, and he gave me a bill of 120 rupees. I said, I'll hit you. First of all, new bike. And I'm giving you a problem on the second day. Why should I pay 120 rupees? And then I called his manager. I said, sir, Sale of Goods Act, beda, beda. So he said, okay, sir, don't worry. We will change whatever it is. So they had put a bill of around 450 rupees, labor and the consumables, that is how they do it. And that entire thing was waived off. Yes. Now, if you take at it, the same. I mean, see, it's always, you ask. See, in India, I'll tell you people, you ask for it, you get it. Until you ask. In Kannada, there is a saying, Kelde Ammanu Uta Hakalla anta. There is something like that, right?
I don't know.
Or I don't think it's in Kannada. Telugu. Adigite gaani amma annam pettadu. Correct? Adigide gaani amma annam pettadu. What do you mean by that? Until you ask, even your mother, movies it is correct. Mother will know that anything happened to you. In reality we know. We'll only eat kurkure and lace and go home. That's a different story. Correct? No. So there's a saying, in the same way, until you ask, no one will give you anything. Correct? You should ask for it. You should demand. And never get your self-respect when you're asking something. Always question yourself whether it is your right. If it is your right, ask. It's nothing to go wrong. Even today when I go for a little nice restaurants and all, if I find the service is not good, I will call the person, manager. I don't hesitate in saying, remove the service charges. You have a right to get your service charges removed on your bill. You go to a dine-in restaurant, wherever it is, they'll put service charges. Service charges is your, It is your discretion. How much you pay, it is your choice. For your information, whatever you eat in a, one is directly you go and take and one is service hall. Whatever you take without service, the price of a product will be 50 rupees per dosa. The moment you go to a service hall, already the price is 65 rupees. Upon that they will put service charge. Then why is this 15 rupees then? Correct? They will do it. You go and observe. There will be that difference. Then why? So if you think they did a good job, and upon that you guys will, he will expect a tip. And that is all service charge only. What I will do, you take away. For your serving, I'll give you a tip. But this is, I am not okay with it. Because a hotel takes it. And that they are already operating on a very good profits. Is what my way of looking at it. I might be wrong also. Okay, so in case of breach of a warranty, cannot cancel the contract. I could not, in fact, I wanted to return my bike only. Who will accept when I were paying 2 lakhs and something of this and all happens? But yes, I could not do it. But the maximum I could do is, I can get a gasket and that 450 rupees free. But technically, if I look back, what I got is right. Don't you think so? Because if I just have to return the bike, there are so many procedures involved. The entire bike could be registered in my name, in RTO's records. I cannot go and cancel all that. So, whenever a warranty is not met, the maximum you can do is you can get compensation. In my case, compensation was free gasket and a free labor. Correct? Yes. Next one, sir. When breach of conditions can be treated as breach of warranty? Always remember, breach of condition can be treated as breach of warranty, but breach of warranty cannot be treated as breach of condition. When is that, sir? When buyer waives off the stipulation, meaning it's nothing but where all of us will fall. Let us give up. Ogli bido, let us adjust. Adjust only is called as give up. So you have a right to cancel the product, but you won't cancel the product. This happens even today with my father. According to him, if he buys anything online, it is wrong to return. Why? Because there is so much of cost involved. He will make me feel so guilty if I return a product. You should be responsible when you are buying a product. Why did you buy? I'll say that is your right. But yes, with generation, things change. For them, no. So they give up. We all fall here. That's what they say. Next one, treats breach of condition as Warranty, meaning you have a right to return the product, but you are, now I took the bike, heavy maintenance, no mileage, but macha, full recognition in society. Okay, let me enjoy. So you are okay. You give up your right of treating it as breach of condition. You instead go and say, sir, you cheated me. Beda. Let us compromise. Give me back one voucher. Give me one free helmet. Give me one free jacket. Yes, let us win. Win-win situation. You will instead go for ask compensation. Next one, contract is non-severable and buyer accepts it as a whole. Now what do you mean by this, people? Generally you will get buy one get one free. You buy a product, you will get a jar. Yes sir. So whenever you want to buy something, you cannot say I want this, I don't want this. If you want, you have to accept as a whole. When you accept as a whole, if there is any defect, that means you are okay to accept it as a whole. That means you want a product. You cannot return it because you want one aspect of it. You will have to accept it as a whole. You cannot return it. So you treat the breach of condition as breach of warranty. Fulfillment is excused by law. Nothing but impossibility. Why I could not perform the contract? Why there is breach of condition? Because the law has changed. I cannot come and hold the seller liable. It is because of the change in law. The maximum I will be entitled to is compensation. Next one, sir. Stipulations can be further classified into two things. One is called express. Next one is called as implied. Express is whatever we discuss specifically. Implied is what is expected to be there in your contract by the law. Now the implied stipulations can be further classified into implied condition, implied warranty. The first one is implied conditions. First ones are implied condition as to title. What is that? Whenever I am selling a bike, for example, yesterday I gave you an example of sofa. He asked me 5-10 questions, people. Are there any damages? When was it bought? He asked me everything, but he did not ask me one question. What? Sir, is the sofa yours? He never asked me. But technically think, will any one of you ask that question? Is this yours only? No. It is expected and it is always agreed by the law. It is there in your contract. What is that? Whenever you are selling a product, you will be the owner of it. It is expected to be there, whether people discuss or they don't discuss. Clear? Okay. Next one is description now. Whenever I am selling a goods as basmati rice, Darjeeling tea, Mysore silk, whatever, I don't know, whatever other things you can ask. Who knows that this is Assam tea, Darjeeling tea? Yen difference their leaves will be bigger. How will we know? As a consumer, how do you know? So the lawmaker says if a tag is attached as a Darjeeling tea, it should be Darjeeling tea. You don't know how to check, but if you are cheated, you can go and file a case. Basmati rice. Basmati is a description of a rice. If it doesn't match, you can go and file a case. Next one is sale by sample. Sample, as I told you, whenever I want to buy a rice, I go to a provision store. I will see this, what is that bowl. We go and taste the rice and we used to get the bag. Now what I taste, what is the guarantee? The same thing is inside the bag. So sale by sample, the implied condition is whatever is there in the sample, the same thing is there in the bulk. If at all it does not meet, I can go and file a case, I can give back the goods, I can get the compensation. Next one, sale by sample and description. In the bowl, he gave me a rice to taste. In that, he has put one small flag also. On this, it is written as basmati rice. It has to meet with the sample also. It has to meet with the description also. We had seen one example also, one exam-based question also had come here. You remember, one person was on a call, she tasted, there was long grain or short grain, I think you only know. The same thing was? Yes, the same thing it was. Sir, quality or fitness? Important, concentrate for 2 minutes. What is quality or fitness, sir? Very simple. Now, whatever is the purpose I purchased the product for, does it fit my purpose? For example, by default, quality or fitness does not apply to a contract. I go to a bike store, I select a model, I buy it. Is the seller responsible for that? The answer is no. Seller is not responsible. By default, a seller is not responsible whether the product fits your purpose or not. Then when will the seller be responsible? Seller will be responsible when you told the purpose to the seller and you rely upon his judgment. and the seller's duty is to deal in this product every day, and you relied upon his judgment. In that case, if you went wrong, then you can hold the seller responsible. In this case, I went to the showroom, I said this is my purpose, I don't know, I have not tested. How do I test the mileage? They will say 25 kilometers, I will drive for 25 kilometers and can I test it? How will I test? I will believe in what you say. Now if you go wrong, I can hold you liable, because I relied upon your judgment. Agreed? Yes sir, pakka na. Next one sir, so by default the seller is not liable. Seller will be liable whenever the purpose is communicated. Now if that purpose does not, if the product does not serve my purpose, that means the product is unfit. That's the word they are using here, fitness. The next one sir, whenever the goods are, what is that? Whenever the goods having single purpose, the goods has single purpose people, then I need not communicate my purpose also. If the goods does not serve my purpose, the seller will be responsible. What is the case law you had seen? Priest versus last. What had happened? Remember flask? Now I buy a flask. What is the single purpose of the flask? This flask is there. What is the single purpose of this? I have to put hot water in this. I put people, this bottle exploded. Then why did you give me this bottle? In this case it was held. When the product has single purpose, the consumer won't tell you why he is buying the product for. If it does not serve the purpose, I can hold you liable, even if I do not communicate the purpose to you. Is this clear? And last thing sir, remember the quality or fitness won't apply for the products purchased under patent, meaning brand name, goodwill. So these four conditions, remember when it quality or fitness. Condition number one, people, by default not applicable. Why is it by default not applicable? Because there is a condition called caveat emptor. Next one is called as purpose. When the purpose is communicated and I believe on the seller's decision, and that is his regular job. If I rely, and if the purpose is not served, I can hold you responsible. Third one, if at all the product has a single purpose, I need not communicate. If the purpose is not served, I can still hold you responsible. The fourth one, people, whenever I purchase a product under a patent or brand name, basically here the goodwill is attracting you. Seller is not attracting you. You go and directly specify. You go to Sangeeta Mobiles or something and say, I want this phone only. There are so many phones. You asked for the brand because you believe it. I did not market it. In that case, this particular thing will not apply. Clear up? Yes sir. Okay. The next one, people, is merchantability. Merchantability means what, people? Whenever I am buying a product, the product has to be free from defects. You order something from Amazon. Imagine you get a broken mobile. Will you accept it? You need not accept it. That's the merchantability. Wholesome. You order food on Zomato. You get a stale food. Food which is spoiled. Should you accept it? The answer is no. Again, it is your right to deny the product. Immediately raise a concern on Zomato, you will get the money. For your information, I am saying, for what and all you can raise a concern on Zomato. Recently, I ordered some food. I will show you in the break. I got a food, people. You will not believe. It was something sold as a salad. So around 6 to 7 items were shown in the bowl, where they had put all the 7 items. Picture, you know how they put? Even ange box mail bandbidide. Food, the box is this much. In the picture, the food is here. I was like, okay, good deal. And the discount was also good. Offer was also going on. I purchased it. I got it, people, one spoon. Literally one spoon. Immediately I wrote the mail to the Zomato customer care. What is this? Entire money I got refund. Because this is a complete deception. Why, if at all I had not got refund, no, consumer court I would have gone. Because how fair is this? You show something in a picture, you know what these people do? They will give discounts. And how should they match it? They will reduce the quantity. Simply they will say 500 rupees, you will get it at 300 rupees. And how are they rectifying it? By reducing the quantity. If 100 plates get sold at 500, they are giving at 300, 70 plates worth food. End of the day, one and the same, no? That's what happened. I'll show you the picture also. I have it. Recently it was.
Sometimes they might put a picture of very appetizing, like full bowl, but they'll put grams. They'll mention only so much grams. Or
Correct. That is also there.
Then we'll think it'll come so much. Then we'll see after ordering, okay, it is only so much.
The grams also, yes, that is also there. But you always have in Zomato customer care, you have that option also that the product did not meet the picture. You have that. And you have it on Myntra and Amazon also, no? Whenever you buy clothing, it says that the product was deceiving. The model will be foreigner. Naan hakkondre? How color difference da? It will be blue. When we get it will become black. Something and all they will do.
So your Momo's case?
Yeah,
Momo's case, they gave me a settlement. Around 1,200 or something they gave. Nice.
What
No?
was the case, sir? You didn't tell
It was that stale momos.
You didn't tell the shop name. You
shop
told
names and all.
raw momos, right?
Raw momos, which was not cooked. Uncooked momos they sent. So I had filed a case. It went consumer court. First thing I had filed a direct thing to them. So Zomato said, no sir, we cannot give anything because we cannot test what is cooked and uncooked. I understand their thing also. I said, then what do I do? Sir, the maximum refund we can give is 20%. I said, that is absolutely unfair. So I directly asked the restaurant, can you guys do anything? They said, no, we have given proper only. Then what happens is it is a complete fear. I lodged a case on Consumer Forum. They will get a notice. And immediately they only called. Sir, why? I said, I called you. Why did you do this? They said, okay sir, you can take it. That's
what
how.
did you do with the raw momos? You steamed and you ate.
I don't know. Obviously. Okay, the next one is called as implied warranty. What is implied warranty? In this case, I cannot cancel the product. The maximum I can do is I can get the compensation. What is that? First one, warranty as to undisturbed possession. So whenever I buy a product, no one should come and keep disturbing me saying that this product does not belong to you. Technically it is mine. He sold it to you by mistake. In that case, what should do? Now for example, imagine sofa. It is not mine. I sold someone else's sofa. Now what should I do? Remember, whoever is the buyer, innocent buyer, it is his duty to return the product to the actual owner. You can claim compensation from the seller. That is what they may ask you as a scenario. If at all there is a stolen product which has been sold, the right is you have to give it back to the seller. You can recover the money. You have to give it back to the actual owner. You can recover money from the seller. Clear? Next one, sir, non-existence of encumbrances. What is encumbrances? Whatever is a product being sold, on that people there should not be any pledge, mortgage, hypothecation, banks, lien, nothing should be there. If it is there, you have to disclose it to me. For example, you see people selling bikes on OLX. You have seen, they would have put it as 45,000. Correct? Now, how did he purchase the product? He would have purchased the product on EMI. So he is expecting me to give him also 45,000. After buying, I have to continue paying the EMI to the bank. Will that be disclosed in OLX? 99% cases, no. It's a cheating only. The first thing you need to check is that. And when you call, he will say, sir, bank EMI is also there, sir, you need to pay. That's how these people do. Yes. Next one, sir, quality or fitness by usage of trade. What is usage of trade, sir? Sir, fitness means people, certain products, throughout the usage of the particular product, from the time immemorial, a particular product has been used for a particular purpose. Whenever a seller is deviating from that purpose, it is your responsibility to intimate the buyer that, sir, we have deviated from the regular way the product is used. For example, if you actually see, if you try a large or XL shirt for every brand, now for example my shirts for each brand will differ. XL is not XL for throughout the brands, large will not stay large throughout the brands. Now, how do I know? They are telling you, you have to intimate to the buyer, sir, this is regular fit. Sir, this is narrow fit. Sir, this is slim fit. You have to intimate the buyer that I am deviating from the regular fit. If at all you do not intimate, you have to pay the compensation. That is, exchange is allowed. Understood? Pakkana? 100%? One more example I can give you is, I think I had given you in the class, that Adidas and Gucci had come up with umbrella. What is the umbrella used for generally? Generally, umbrella is used for stopping the rain. But this umbrellas did not stop the rain. They were not waterproof. And the umbrellas were around 1 lakh rupees. Pictures were also there. Yes, I think it is there also. Yes, these umbrellas. The content is gone. Gucci Adidas face backlash for over 1 lakh umbrella that doesn't stop rain. See, the custom is what people, the custom is that it has to stop. When it doesn't stop, what you have to do? You have to disclose. If you do not disclose, they are telling you it is not, it is a breach of implied warranty. That's what they are telling. Understood? Kana? Okay, next one, sir. That's for Sunitsms. That's what they say, 1 lakh. Disclosure of dangerous nature of goods. Imagine smoking kills, alcohol is injurious to health, things like that has to be given. Sir, KVA tempter, sir, let the buyer be aware. Exceptions to KVA tempter means people, even in these scenarios, the buyer need not be aware, seller only will be held responsible. What are the scenarios? First one, fitness as to quality or use. Priest versus last, that was the last case law. And fitness can also, you can read the same thing. What is that? That umbrella. By quality or usage, meaning a particular product is accepted in a particular way by the customs. If at all you are deviating, the seller, the buyer need not be aware. But which umbrella store you will? Decathlon, I purchased umbrella. They don't let me pour water on it. Will anyone test you? Let you test the umbrellas? No. Then how will I test it? Yes, you need not be aware. Goods purchased under brand or patent name. I told you this is actually a wrong thing they have given here. You remember in the class also I have told you? Heading says exceptions to KVA tempter. That means seller will be held liable. When I told quality or fitness, there I told you something under patent or brand name. What did I just tell? Whenever you purchase a product under patent or brand name, seller will not be liable, buyer only will be liable. So this does not come under exceptions to KVA tempter. Sir, in exam, what are we expected to do? Write down patent or brand name for exceptions to KVA tempter. Write down. Because even in the old syllabus this mistake was there, even in the new syllabus the mistake is there. But if you read the description, description says it is buyer will be liable. But it is put under exceptions. So in your exam, write this. Don't miss this. Okay. Goods sold by description, which we have seen. Merchantable quality, sale by sample, sample and description. Trade usage is what that. Seller actively conceals the defect. This is nothing but fraud. Correct? Yes, sir. So by this we complete your unit 2. Next one, let us immediately do of unit 3, transfer of ownership and delivery of goods. Sir, now whenever you are transferring a particular product, now whenever I am selling a particular product, they are saying there is one rule. What is the general rule, people? Whenever you transfer a ownership, risk also transfers along with the ownership. Now, sir, the problem is there are so many different types of products. One is specific goods, one is existing goods, one is future goods, one is contingent goods, uncertain goods, ascertained goods. Now, how do I know for each of the product when is the ownership transferring and when does the risk transfer? So, to that, know that only, people, is this particular topic, passing of property. When does the ownership pass in each type of the goods? The first one is whenever there are specific or ascertained goods, when does the ownership pass? It depends upon what is the status of the goods. If the goods are in deliverable state, what do you mean by deliverable state? The goods are ready. Nothing is to be made to the goods. It is just to be picked by the buyer. In such goods, people, the ownership passes whenever the contract is made. When is the contract made? When the offer is there, acceptance is there, agreement comes into picture, plus enforceable by law becomes a contract. Sir, whether have we ever seen whether you have delivered the goods, whether you have paid the price. It is nothing to do with whether money is paid, whether the goods are delivered or not. Whenever the goods are in deliverable state, the ownership passes irrespective of the money is paid or not, irrespective of the goods is delivered or not. We had seen the case of certain digital products. You go and buy a TV from Chrome. They say, okay, you ask for a home delivery. Now you leave your TV back in the chroma and go. Night short circuit happens. The entire digital goods are gone. Your TV is also gone. Who will bear the risk? You will only bear the risk. And also remember one thing, the entire Indian Contract Act and Sale of Goods Act, it starts with one line, that is, unless otherwise agreed between the parties. The first preference is always given to your contract. If your contract is silent is when you guys will refer to Sale of Goods Act or Indian Contract Act. Yes, sir. So in general scenarios, they will only be liable. But if the contracts are silent, in that scenario, you will be liable as a buyer because the goods were ready. You should have taken. Clear? Okay. Next one. Whether the goods, when the goods are to be put into the deliverable state. Example we had seen. I go to a shopping complex. There are a lot of belts that will be available. I will take a particular belt. Now I have identified from the bulk which I want. The goods is identified. Now what do? I'll go and tell the shopkeeper I want to buy this. He will say, okay sir. And after that he will take one belt that he will say that buckle thing. He will press some holes. He will punch some holes into the belt. Sir, now the ownership does not pass until the goods are put into the deliverable state. So the goods are identified, but there is still something to be done to the goods. There are still holes to be put into that particular belt. The ownership does not pass until that holes are put and the buyer has given an intimation of it. In the class, one more example we had seen was that the pant, when it is to be stitched. Once the pant is stitched and you have been intimated that the product is ready, until that the product's ownership won't pass. They can ask you a question here and they'll specifically put a scenario, the product is ready, the buyer is still not yet aware of it. When will the ownership pass? The product should be ready, buyer should also be aware of it. Next one, goods in deliverable state plus seller has to do anything to ascertain the price. What is it, sir? Goods are ready, people. Goods are identified. Goods are also manufactured. Whatever you need to do, it is ready. But the seller still has to do something. Example, people, now whenever I have to buy, now I go to a shopping complex. Let us imagine something like a Star Supermarket or D-Mart. I want to buy rice. I take one bag. I try to put the rice from the jug how much ever I want. Now there is something called as weighing that has to be done. Now imagine I take a rice pack. Before I weigh it, the rice pack breaks from my hand. Now who will bear the loss? In a general scenario, I have not yet ascertained the price. I don't know how much I have to pay. If at all the price is ascertained, I am liable. If the price is not ascertained, I don't know how much to pay. In this case, seller will be liable. Understood? Now take the second scenario. Rice, I have put it, I have weighed it. A sticker is also put. It has 1.5 kgs. You know which variety you have taken. You have taken Basmati. Basmati is 100 rupees. Weight is ascertained. You know what is the price you need to pay. Now you drop the bag. The responsibility will be yours. That is what is the scenario. Clear? Pakkana? 100%? Okay. Next one. Unascertained or future goods. Sir, meaning what, sir? Now whenever you have entered into a contract for a unascertained or a future goods. Imagine, people, the tomato example. We have entered into a contract for buying a tomato. The farmer company. Now there are those 5 loads of lorry of tomatoes. Now I need to take those lorries, people. Minus I need to take only 3 lorries here. There are more than 6 lorries. So when will the ownership pass in the case of unascertained goods or future goods? First thing, people, the goods are to be in existence. Until the goods are in existence, the ownership won't pass. Now the tomatoes have come into existence. Now, people, the goods are to be appropriated, meaning selected. It is still unascertained, Noda. There are 7 trucks. So in this, which one belongs to me? I will say truck number 1. I will say truck number 2. I will say truck number 3. Now the goods are identified. Once the goods are identified, now the ownership will pass. Sir, now my question is, how did you identify the goods? If the seller identified the goods, farmer only will say, sir, take that, take that, take that. Buyer was buyer okay with farmer selecting it? If yes, then okay. Sir, how did you do? Buyer selected it. Was seller okay with it? So, whenever you are appropriating, whenever you are selecting the goods, you should have selected the goods with the other person's approval. If they are okay and if you select the goods people, then they are telling you, yes, the ownership passes. Until the goods are appropriated, the ownership does not pass. Is clear? Pakkana? Okay, the next one, sir. Sale or return basis. What do you mean by sale or return basis, people? On certain cases, the seller will give you an opportunity to keep the goods for a certain period of time. You try. If it doesn't work, send me back the goods. For example, all our Flipkart sale, Amazon sale will come in this particular category. Meaning, sir, you have 10 days time. Within that 10 days, keep the tag. Don't remove the tag. Even on the 10th day, you can return it. When is the ownership passing? So the ownership passes in 3 scenarios. First one, sir, the buyer accepts it. So in Myntra, you have something called as you can claim the coins. Once you claim the coins, people, you cannot return the product. Sir, so you accept the purchase, imagine on the second day only, the ownership passes. Second one, you keep the product beyond the return period. If the return period is 10 days, you keep it for 15 days, the ownership passes. The third one, sir, you sue, you do something equivalent to the acceptance. What is that equivalent, sir? You further gift it. I take a shirt, I gift it to my friend, obviously done. Next one, I take it, I further pledge it. If it is gold, I further pledge it. So I am doing something equivalent to an acceptance. So on sale or return basis, that is how the ownership passes. That is what we had seen, if you remember. I agree, or you keep it beyond the replacement period, or you do something equivalent to a sale, or you do something equivalent to a acceptance, like pledge or something like that. Agreed? Yes, okay. Next one, reservation of right of disposal. What is that, sir? When Flipkart, I purchase the phone from Flipkart. The Flipkart sends the phone with one condition. What is that? This person has put a condition that it is cash on delivery, it seems. Do not give him the phone until he gives you the money. So, sir, reservation of right of disposal means, people, until the last moment I am not giving you the ownership, because I have reserved the right of giving you the ownership. Until some condition is met, I will not give you the ownership. So what is the condition here? Pay the money and get the ownership. Until you pay the money, you will not get the ownership. That is only called as reservation of right of disposal. Is this clear? Yes, sir? Okay. See, property does not pass until certain conditions are fulfilled. If buyer rejects the bill of exchange, the bill of lading shall be returned back to the seller. What is this scenario? Imagine, if at all, in general case, a seller and buyer is there. The seller sent the goods to the buyer. Along with that, I also sent him one bill of exchange. I told him, sign in this that you will pay me the money after 1 month. Sign and send it. If he rejects to sign, people, he cannot even accept the goods also. That's what they have given here. If buyer rejects bill of exchange, he has to send back the goods also, or if he had got document of title, he had to give back the document of title at least. Imagine I gave you railway receipts, I gave you warehouse certificate. If I have given that, if you reject bill of exchange, that certificate also should be given back. You cannot go and take the goods from that warehouse. Understood? Next one, sir. So risk prima facie transfers with ownership. But this rule has a qualification. What is that, sir? Now imagine, sir, I am telling you that there is this tomato. So the tomatoes are here. Now I came and I took the goods. Now imagine, people, I came up with one lorry. See, this is my lorry. I came up with one lorry. I have to transfer the tomatoes from this container to this container. So technically I have to transfer 3 containers of tomato. What I could transfer was only 2 containers of tomato. 1 container I had to leave here and I had to go. Now my question is, the ownership transferred for how many containers? Is it for all 3 containers? Is it for 2 containers?
All three.
All 3? The only thing you need to check is what were the conditions between them. Was part delivery considered as full delivery or was part delivery considered as part delivery? Whether the farmer said, you take how much ever you want, from my point of view, I have given you all three. Headache is yours. If you want to keep it here only and go. I will not even touch anything here. I will not touch anything. I will keep here only. In the sun only I will keep. Anything happens to the tomato, it is your responsibility only. So, part delivery is considered as full delivery. Even though he took 2 trucks, he is liable for this 3rd truck also. Or the farmer said, okay sir, you take 2, the risk also is given for 2 only. When you come back, I will give you 1 more truck, no problem. In that case, the part delivery is considered as part delivery. I am giving you the ownership only for the 2 trucks and not for the 3 trucks. The 3rd truck is under my liability. Sir, now I have a question. What? Let us imagine we have considered part delivery as full delivery. Meaning, you have taken 2 trucks only. 1 truck is left behind. Technically, it is your loss only. But he has left that 1 truck in your custody and he has gone. Now, this truck is here only. Now, people, what did the farmer do? Once the seller left, he took one big tarpaul, a cover, and he closed all his tomatoes. He closed. Now, this is to be taken by the seller. No, he did not close it. The other things he closed again. He closed everything with a cover. Because for the sunshade, the tomatoes will probably dehydrate or something, whatever you call. So, he covered all his tomatoes, but not the seller's tomato, what he left here. Now, you tell me, whatever the farmer did, is it right? Now, this is only called as long as the product is left with you, you had an opportunity to take reasonable care. If you don't take reasonable care of the product, as a bailee, you will be responsible for the loss. Now this product, this contract is now called as bailment because the seller's product is in your custody. Ownership is with him only. You have transferred. Part delivery becomes full delivery, agreed. But the possession is with you now. Temporary. Tomorrow he'll come back and he'll take. But did you take reasonable care? No. So for this you are liable. Understood the complete logic? Technically I have explained 3 concepts here. Part delivery, full delivery also. Concept of bailment also. As well as when will the buyer be liable? When will the seller be liable? It's clear all of you? Yes? Okay. Next one, who can transfer the ownership? Yesterday only I told you, when we are doing the chapter of who can create the pledge, answer is same. Non-owner can create a pledge. Here also non-owner can sell the goods. When? Mercantile agent, correct? No? I told my agent to sell my car. Can the agent sell my car? Yes, I only appointed him. That's what is the agency chapter only. One of the joint owners, PG, 2 owners own 1 product. And the product is in my custody. Can I sell? Yes, I can sell. Now I will come and sell you this laptop. You check the ownership, whom does this laptop belong to? How will you check? I will do restore. That's why it's whosoever custody, I will sell this bottle. You see OLX, yesterday I was seeing, people are selling plastic bottle, whatever they have used, Tupperware, 80 rupees. And to go there and collect only my money will go. What and all people will sell. Sale by person in possession under voidable contract. I told you this yesterday only. I forced someone. Now this is Chandan's bottle. I forced him. Hey, Kodo. I took it. I go to that class. I close the door. I sell it. Will they know what happened in this classroom? Because it's a voidable contract. No, meanwhile Chandan has to run and go to the management and say, complaint, sir, what is happening, sir? The faculty is taking the bottle from me. So within this time, if I go and sell, how will that innocent person know? That's what they are saying. Sale by person obtaining possession before passing of property. Now what is this? Sale or return basis? Technically in sale or return basis, Amazon says you have 10 days return period. For the 10 days, Amazon only is the owner. On the 3rd day, I went and I gifted it to my friend. Technically, I am not at the owner. I did something equivalent to an acceptance. That's the reason they are telling you, on that day, 2 things are happening. According to Amazon, I am becoming the owner. Also, I was not the owner. I gave him the gift also. So, both are happening on the same day. Yes. Sale by person who has already sold the goods but continues in possession. Yesterday I told you, imagine sofa. Sofa is an existing goods in deliverable state. The moment we made a contract on OLX, contract is made. Now can I file a case on him? Yes, I can file a case on him. No. Because through OLX it is very difficult. The thing is you cannot prove. He can be a dummy user also. That's a problem. So that is what is happening. Is this clear? So it is with still with me. Now imagine he sent me 1,000 rupees advance. I got a very good deal. Will I sell it here? I can sell it. Does he know Sale of Goods Act? I know. Correct? No. Estoppel. Estoppel is what people, I promise based on my actions. Best is your partnership. Manager will come and do something. I introduce the manager as a partner to the entire world. Tomorrow he will come and sell some partnerships assets. Can he sell? Yes, he can sell. Who said? We only gave him a right. Next one, unpaid seller, next unit. Other acts. Liquidator. What is liquidator? Under Companies Act. If at all you guys are not able to pay back your liabilities, court will appoint a liquidator. He will sell the company's assets. Technically it is not his. Then how is he selling? It is still valid. I can give you more examples also. Auctioneer. IPL. How did he sell Dhoni? Does Dhoni belong to him? But he only sold Dhoni. Correct, huh? Next one, sir. Finder of lost goods. Whenever if the value of the product is 2/3, he rejects. They are telling it is yours. You take, you sell, you get back the money. Sale by pledge. What is pledge? Your pledger, bailment and pledger. I gave my goods, I took loan. You never repaid. What do? I'll go and sell your gold. I can, yes. Where is that given? It is given in Indian Contract Act. Sir, rules regarding delivery of goods. Buyer to apply for delivery. Until you ask for delivery, seller is not liable to deliver the goods on his own. According to seller, he will deliver it to you. Now imagine you guys buy books here. According to the contract, we have to deliver it to you here in the reception desk. But you want delivery, we can do the delivery, provided you need to pay for it. Unless you ask it, we are not liable to do that. Next one, place of delivery. First one, subject to contract. If contract is silent, wherever the goods were at the time of the contract, that is where the goods will be delivered. Meaning, sir, farmer, when the goods, whenever the contract was made, where were the plants? It was roaming around Bangalore. Where was it? It was in the farm. So where should I go and collect the delivery? Nothing is agreed. It is a buyer's responsibility to go and collect wherever the crop will be grown. Take sofa. Nothing is agreed. I have to go to a godown where the sofa will be manufactured. If nothing is agreed. If agreed, you'll have to deliver at the agreed place. Next one, time of delivery. If agreed, at that time. If nothing agreed, reasonable time. Time for tender of delivery. Meaning, if I have to ask, imagine a buyer asks for delivery. Should the seller be bound by it? Whenever I ask for delivery, is the seller bound by the request made by the buyer? The answer is yes, provided he asks it within the reasonable time. I cannot make a request in the morning and ask the delivery by next 1 hour. That time I need not take up the delivery order. Next one, effect of part delivery, which we saw. Part delivery is equal to full delivery. Part delivery. Goods in possession of third party is nothing but constructive delivery. Warehouse. Next one, installment deliveries. Unless otherwise agreed, installment deliveries are not allowed. You order for a phone, you get mobile, you get charger, that is not allowed. You order for a bike, first you get one tire, later you get one more tire. Office ge cut get what do I do? Next one is delivery to carrier. Meaning, if at all I have to deliver the goods to a buyer, I can deliver it to the buyer also, or I can deliver it to the courier person also. Dunzo. Deterioration during transit, meaning what? Anything happens to the goods in the transit, the carrier will be responsible. However, if the goods are expected to deteriorate because of its nature or because of its distance, and you still order it, in such case, you will only be liable and not the carrier. Example, you order ice cream on Zomato, you order iron, iron get shipped between countries.
Dubai.
Dubai, now whenever there is iron, iron is meant to get rusted. So you cannot say you gave me a bad quality product because it is the quality of the iron. You cannot ask for damages or compensation. Next one is buyer's right to examine the goods. Whenever you see the sample and you buy the bulk, you have a right to examine the goods before you buy. Not only that, whenever you are buying the product without seeing it. For example, Amazon Flipkarts, you have a right to examine the goods. That's why now you guys, if you guys ordered laptops or Amazon, phones and all, you get a OTP and the delivery agent will open the product in front of you. And if you do not report anything that time, you cannot return the product for damages. This applies to all the electronic items. So in my case, what happened recently, we purchased a refrigerator. The product was delivered inside the freezer. You know that ice tray. The ice tray inside was broken. Now how will I know how is it broken inside? So later on, their technician will come who will fit everything. The technician, when he opens, he saw that that thing was broken. He immediately reported and the return request was raised. And that's how now the electronic gadgets are being dealt. If there is any mistakes in that, in such cases, you will have to give the OTP only after verification. If you give it, later you cannot return it for physical damages. If the OTP is given. Remember that. Yes, sir. That's the rules regarding delivery. We'll finish off unpaid seller also and then go for a break. The last part in Sale of Goods Act, or you want a break? Sir, silent ಆಗಿದ್ದೀವಿ ಅಂದ್ರೆ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನೀವು.
ಎಲ್ಲ ಹೇಳಕ್ಕಾಗತ್ತಾ?
We'll see, we can complete Companies Act also. So that tomorrow we'll be left with small content, MTPs and RTPs we can do. If not, we could have finished in one day only, no?
Yeah. Last time you did that, you extended the time till 5.
Yes. Okay. The next chapter, people, unpaid seller, the last unit in Sale of Goods Act. We'll do off, no?
Yes.
You want a break, huh? Priya? You are Indian, sir. 2.5 ಗಂಟೆ ಅಂತ ಹಾಕಿ ಹೊಡಿತಾನೆ ಇದ್ದೀರ ತಲೆಗೆ. ರೆಸ್ಟ್ ಬೇಡವಾ? ತಲೆ ಅನ್ಕೊಂಡ್ರೆ ಏನು ಅನ್ಕೊಂಡ್ರೆ? ಅದಕ್ಕೆ ನಾನು ಹಿಂಗೆಲ್ಲ ಬರಲ್ಲ ಅನ್ನೋದು. That's why it didn't come. Simply ಮತ್ತೆ ಅದಕ್ಕೊಂದು. Okay. We'll just finish off the Sale of Goods Act. After break, fresh mind, fresh day. We can come and meet for Indian Partnership Act. Okay. So the next one is, people, unpaid seller. What is unpaid seller, sir? In a sale, whenever a sale is made, a seller would have transferred the ownership to the buyer and the buyer has not paid the money. How much, sir? Focus on the word what they say. When the whole of the amount is not received by the seller, then the seller will be called as an unpaid seller. What do you mean by the whole of the amount? If the product value is 100, if I have received 99 rupees, 1 rupee is not yet received, what will I be called as? I will still be called as unpaid seller only. Now if I am an unpaid seller, what are the rights I enjoy? If you are an unpaid seller, you have 2 rights. Right 1 is on the buyer, next right is on the goods. One, against the buyer, what you can do? Against the buyer, you can ask for damages, you can ask for compensation, interest, you can cancel the contract, all that you can do. Against the goods, what you will do? Against the goods, you have again 2 rights. One, the first question they will ask you, has the ownership passed or the ownership is not yet passed? If the ownership is passed, then I will have 3 rights, 4 rights. What are the 4 rights? Right to lien, right to stoppage and transit, right to resale. When the ownership is passed, when the ownership is not yet passed, I will have 4 rights. One is right to lien, right to stoppage and transit, right to resale, Right to withholding of property. Now withholding of property, people, there is nothing difference between right to lien and right to withholding of property. Both are same. Who said? Your textbook only said. Technically they can even avoid also what is withholding property. There is no difference between right to lien and right to withholding of property. The name itself says what is withholding. Until the money is paid, I will keep the goods. I will not give it to you until the money is paid. That is what is withholding of property. What is lien? Until money is paid, I will not give you the goods. Both are same only. So there is no much difference. Clear? Yes. Okay, sir. So rights of unpaid seller. One is against the buyer, one is against the goods. Now let us focus on right to lien. Section 47 focuses on right to lien. What is right to lien, sir? Until the complete money is paid, it is the right of the seller to, the keyword, retain the goods. In your exam hall, you guys have to underline the word retain. That is, the product was with me, I will keep it with me until you pay the complete money. And that right is called as right to lien. Sir, next one, sir. When can the right to lien be exercised? It can be exercised in three scenarios. What is that? The goods should not be sold on credit. I can withhold the property. If the goods are sold on credit, but the credit period has been expired, I gave you 3 hours, I gave you 5 hours time, you do not come within that time, that means I can keep the goods with me only. Third one, the buyer became insolvent and the goods are still with me. Then I am telling you, I will not deliver you the goods until the complete money is paid. So in these three cases, right to lien can be exercised. Remember the difference between right to lien and sit. Right to sit can be exercised in only one case, and that is when the buyer becomes insolvent. Right to lien and right to sit. Difference between them is a possible question. Clear? Okay. Sir, termination of lien. When does the lien come to an end? Whenever delivery, the goods, as long as they are with me, I have a right to lien. The moment I lose the goods, the right to lien come to an end. How can I lose the goods? You can either give it directly to the buyer, you lose the goods. You can give it to the delivery person, the courier, the carrier, the middleman, you give it to him, the right to lien is lost. And sir, the buyer or his agent obtains the possession, seller waived the right to lien. Waived means, people, Karunamayi, he gave up his right, or he just kept quiet. Estoppel means, people, this is express, this is implied by seller's conduct. Meaning, the buyer is coming and taking the product. I just kept quiet. That means my actions is telling I'm not going to take any action against you. You take. So in these four cases, right to lien gets terminated, meaning it comes to an end. The next right is called as right to stoppage in transit. Now what is right to stoppage in transit, sir? The difference between right to lien and right to stoppage in transit. Remember, the goods are with you. It will be with you is called as right to lien. The moment the goods, they depart from you, that is, the delivery will start. Imagine the delivery person will come, they will take from the seller's premises, they have to go and deliver it in the buyer's premises. Now, the moment the goods depart from the seller and it is yet to reach the buyer, from this position to this position, here is the seller, here is the buyer. Once it departs from here, sir, the time period between this is called as stoppage in transit. This time period is called as transit. The second right will come when the right to lien ends, right to sit starts. So when the goods go away from my possession, the right to stoppage in transit will start. That's the first difference. Here it ends, sit starts. Second difference, people, when can I exercise right to sit? Only when the buyer becomes insolvent, I can exercise right to sit. There, you should have not sold on credit. If sold on credit, the credit period has expired, or the buyer becomes insolvent. So all those reasons will come. Here it is only when the buyer becomes insolvent. Credit period, all that won't come at all. Second difference. Third difference. What is right to lien? Right to lien is a right to retain the goods. What is right to sit? Right to sit is right to regain the goods and retain them until the money is paid. Regain means what? It went away from me, I am getting it back, regain it. and keep it with you until the money is paid. This is called as what? Right to sit. Try to remember the differences. Differences are important. They may ask you from your exam point of view. Clear up? Yes, sir. Okay. Now, what is right of stoppage in transit? Only when the buyer becomes insolvent. Technically, what happens when right to stoppage in transit? The goods will be on the way. You will go like a Singham. Inge chase. The jeep will come. Yes, sir. So you will go and chase it. Our hero won't do it now. He will not even wait for the jeep to stop. Hey. Singham da, one punch kotte ange, he will only drive the lorry and come back. Agreed? Jeep again they will dunzo it. Now people, whatever he did is called as right of stoppage in transit. You can stop the goods in two ways. One, you go only get it personally. Second one, call and get it personally. That is also possible. Yes, that is how you exercise right of stoppage in transit. Sir, so it is stop the goods while it is in transit. It is right to see. Retain and regain should be underlined in your exam. Retain them until the price is paid. So you got it back. Keep it with you only until the money is paid. Sir, now you are saying no. What is right of stoppage in transit? It is the right to stop the goods while the goods are in transit. My question is, what is this transit? Transit?
When the goods are going from the seller's place to the buyer.
So the goods until it has reached the buyer or the buyer's agent or there is any bailey or any such person, the goods are not yet taken the possession until the time, that is called as transit. Once they come and take off, transit comes to an end. Until it is reaching their destination, it is called as transit. The reasons, what and all is considered as transit, sir? The transit comes to an end when the buyer or the bailey obtains the delivery, whether at the destination or even before the destination. Carrier or bailey acknowledged to the buyer that he holds the goods for him and seller has not reserved the right of disposal. This can happen in the case of railway contracts, or it can happen, now imagine, have sent my goods from here through the railway courier, and I have also sent to the railway receipt also. Now what happens, people, this person will call the railway person, whoever is the manager in the destination, he will call the buyer and say, sir, your goods have reached, kindly come and collect it in platform number 2. Once the call is made, it is clear that the goods belong to him and not to me. So once the acknowledgement is made by the middle person, the delivery has happened, the transit has come to an end. Next one, goods delivered to carrier hired by the buyer, meaning the carrier is only belonging to the buyer. Why will he listen to you? Come back means. Carrier wrongfully refuses to deliver the goods to the buyer, meaning I should have given it to you, but I wrongfully refused to you. They are telling you again this will come to an end. Next one, part delivery considered as full delivery. We saw that whenever you have transferred the risk for this one lorry standing in your possession, you said for this also your risk only. That means ownership is also transferred. You cannot withhold it. Next one, goods delivered to the ship chartered by the buyer. One was road, one was ship route. Both are same. This and this are both are same. Clear? Okay. How stoppage and transit is affected? One is Singham style, one is sensible style. You call. Next one is effect of subsale or pledge by the buyer. What is this, people? Now imagine, sir, A sold the goods to B. Now B did not pay the money. A became what, people? A is an unpaid seller. So B further sold the goods to C. Now the question is, should C get the goods or not? I did not pay to you, but C has paid to me. Oh my God. Now should C get the goods or not? This is called as sale. This is called as subsale. Understood? Manufacturer entered into a contract with wholesaler. Wholesaler entered into a contract with retailer. So, manufacturer gave the goods to the wholesaler. Wholesaler settles the money once in a quarter. So, he got the goods. He also have taken money from retailer also. Next stock is coming back, I will be giving it to you. Pay me advance. He has paid the money also. Now the question is whether the retailer should get the money or not. The answer is, people, The first question, has the manufacturer agreed for subsale? Has he agreed? If the answer is yes, then yes, retailer will get the goods. If the answer is no, no retailer won't get the goods. Is this clear? You guys should have seen one case law also here. Mount. Mount DF Limited versus J&J Co. You would have seen somewhere. When seller has agreed for the sale, Mount DF Limited versus J&J Co. Limited. When you have agreed, you don't have a choice. You have to give it to the retailer in this scenario. Understood? Next one, sir. Exception. When document of title has been transferred to the buyer and he further transfer it to a person on good faith, then if it is a sale, the lien stoppage in transit is defeated. If it is pledge, then you can go and make a request. What is this, sir? A has shipped the goods, imagine through railways. And whatever is the railway receipt, document of title, also I have given it to B. B has further sold the goods to C. I have even given the document of title to C also. But B has not paid the money to A. Document of title is given, people. They are telling you your right to lien and right to sit will come to an end. However, now my question is, what did B give to C? Was it pledge or was it sale? If it is sale, people, then lien and sit directly comes to an end. Sir, what if it is pledge? Pledge also, people, lien and sit will come to an end only. But what can A do? A can just go and request C. Anna, you have so many goods that belongs to B with you as a pledge. Please sell all those goods and try to recover the money. If still you have some money left, please give that money to me, Anna, because even I am an unpaid seller like you. If Anna agrees, people, you will get the money. If Anna does not agree, you will not get the money, because it is directly a discretion. He is not under an obligation. It's clear? Understood? Okay. The last one is right to resale. Right to resale is, people, where I got the goods back. Retain or regain. What will I do? If it is perishable in nature, I will not even ask the buyer second time. I will directly sell it off. I will get the money back. Sir, what if I made a loss? Imagine I sold the apples to you for 300 rupees per kg. But because you did not pay to me on time, I resold it after 1 day. Now, I could sell it at 260 rupees per kg. It is perishable in nature. Now, who will give me this 40 rupees? I can recover it from you. But should I give a notice of resale to you? Not at all required if it is perishable in nature. Sir, should notice of resale generally be given? Notice of resale is not required in two scenarios. One, if it is of perishable in nature. Second one, if right to resale, it was, right to resale was, it was reserved in the contract only. Meaning, when we entered into a contract, I have said, Macha, if you don't pay, I will just sell off. I will not keep asking you and all. If it was reserved, I need not ask you when I am reselling it later point of time. Is this clear? So the third scenario, what if it is not falling in perishable or no right was reserved? Then, people, it is the buyer's right to be asked before you further sell it to someone else. So you have to further ask people before you sell it to someone. Sir, if I ask and if I further sell, if there is a loss, you can recover it from the buyer. If there is a profit, you can retain the profit. Sir, what if I don't give the notice? If there is a loss, you cannot ask it. If there is a profit, you need to give it back to the buyer. If the notice is not given. Clear on this one? Pakkana? Okay. Next one, right against the buyer. What is the right? Suit for the price. That is, if the ownership is passed, I can ask for the entire money. Damages, compensation, ordinary, extraordinary, specific, vindictive, everything. Repudiation of a contract, you did not give it to me on time. If the time is essential, I do not want the product at all. I can cancel the contract. Suit for interest, meaning I can ask damages, or if it is prefixed, we will generally say 12% per annum. This generally happens in the case of shares. If shares are not allotted in time, you are eligible for 12% interest. Imagine if a company declares dividend, they have to pay it within 30 days. If they don't pay it, you are eligible for 18% return per annum. So over and above whatever the dividend they have to pay. So these are given in the acts or in the agreement only. That is called as suit for interest. Sir, what is the right of the buyer? Damages for non-delivery. If at all you don't deliver, I can ask you for damages accordingly because I will buy it from someone else. If I pay extra, again same thing. Ordinary, general, same thing will come. Suit for specific performance. Sir, humko goods hi chahiye. We don't want money. Who wants money, sir? I want the goods. That is only called as specific performance. Will the court order for specific performance? It only order when the goods are of special value and money is not a valid compensation. If at all court feels if I give money, ayo papada, he will suffer. Then only they will give specific performance. Next one, suit for breach of warranty. Sir, compensation aru kodi sir. My gasket is not working. Repudiation before the due date. The way he can cancel, you can also cancel. Suit for interest. Imagine you have paid advance. If at all I had invested in stock market, I would have made money. Give me that, he will give you. Understood? Last one is called as auction sale. Section 64. What is auction? A goods can be sold for a higher price by doing something called as bidding, auction. So whoever quotes the highest price, for such person we will transfer the product, and that is called as an auction sale. Section 64. Next one. So what are the rules of auction sale? First one, goods are sold in lots. Meaning people, in an auction sale, a goods can be sold either individually or you can tag it up as a lot. Meaning as one, you can say what is that? One group. It can be sold individually also, it can be sold as a group also. Anything is fine. Imagine I sell a painting. I can sell it individually also. I can sell 3-4 paintings together also. Both are valid. Completion of a sale. In an auction, how is a sale complete? I think in your thing I had showed you, no?
Yeah, one
Shredding of a painting.
Yeah.
That was actually a very good scenario to understand the auction sale. So anything that happens to the product before the third hammer fall happens, that means the ownership is not yet passed. If anything happens after the third hammer fall, the ownership is transferred. The risk is on the buyer. That is what we had seen the example of the painting in the class. Okay, next one was right to bid may be reserved. Meaning what, sir? A seller in some scenarios may reserve a right to bid. What do you mean by that, people? In some scenarios, you will see that the seller also wants to take part in the auction. Sir, can that happen? Yes, it can happen, provided you need to intimate the auction house that I am also coming and participating. When will this generally happen? Imagine people, income tax authorities, whenever you do not pay tax, they will come and seize your assets and they are going to further sell it. I had showed it to you in your class that the cars and all of a particular celebrity is being sold. Now it is, auction is still happening, e-auction. If we are interested, we can go and buy. In the same way, for him also it is his car. He will have some emotions attached to it. A house can be sold. Can he come and participate? Yes. He needs to intimate and he needs to participate. That is what they are telling you. Yes. Next one, reserve price. What is reserve price, people? Base price from which the auction starts. Yes. Dhoni is for sale from 5 crore. It will go to 20 crore. The reserve price, base price is 5 crore. Pretended bidding means, people, a person who, for the sake of increasing the price, he just tells 5 crore, Anna 15 crore. He says 16 crore, Anna 25 crore. At the end of the day, do you have an intention? No, sir. Just to increase the price. He should suffer. That's why we do it. In IPL, does it happen? Yes, to an extent it will happen. To an extent they will take and they will leave it. Papa, another players, like in the last auction, Pat Cummins and Mitchell Stark, their price went to 25 crores. For your information, Mitchell Stark and Pat Cummins, Australian players, are more expensive than Kohli and Dhoni in this IPL. More expensive than Dhoni. 5 crores more expensive. Yes, sir. 5 wala. Now highest in them is not Dhoni. Dhoni is around 17 crore. or 18 crore. Highest is the captain. Whomever you retain first will be, Jadeja was offered 20 crore last season. Yeah, so now he gets 20. So he's more expensive than Dhoni. Pat Cummins anna matte Mitchell Stark anna. Yes, sir. But yes, they are doing justice also. I think Pat Cummins is doing justice. Mitchell Stark, I don't think so. KKR bowler. Yes, sir. Huh?
She's telling she doesn't even know who they are.
Who they are? Ille irtare. Nearby the stay. Okay. Yes, people. So by this we complete your Sale of Goods Act as well. So, yes, we'll do that. So let's go for a break and come. And after that, let us start with Indian Partnership Act and let us see the time and let us also try to do the Companies Act also. I think we can do it, but we'll try. Yes, people. Yes, we will back. Had good food. Ready to sleep. Your tea. Okay. Yes. You'll not believe inside certain times there are certain classes where when I'm teaching I only felt sleeping. Yeah. All that happens. Then what do you do? Now imagine now this session only how many? I think we sat for 2.5 hours. You imagine from my end. If at all it is not interesting, what do I do? Even for me also it will be boring at times. Yavdo is batch. That and all we'll feel. 100% we'll feel.
Or at least now we are there. If it's no students only, you'll actually sleep. It will be too boring with us.
We are used to it. I mean, there are some things. At times, what happens when there is no one also, that's a different game altogether. Now, I'm doing one such subject called as CS Professional. I'm recording it also. Mornings I'll be recording for that. So there are no students for that. It is only camera and me, no online also. So that's a complete model of 120 hours which will be recorded with everything. Question papers, everything solved, I'll just give it, that's all.
You'll not get bored also, like only camera.
So there are two things. Now for example, now it's a fast track, it's okay. Now in your usual class what happens? Now whenever I'm talking, if I'm just talking content, you also will get distracted. You also will feel bored. Now to do away with that, what do we have to do? We'll have to speak about something, we'll have to talk about Lokabhi Ramayana, so that you guys will be a little engaged. Now, in that classes what will happen, it will be only content. It is purely content. There will be nothing else apart from content. Of course, here and there we'll be sharing things, but there will be nothing like a spontaneous conversation or a joke or something that will come up. But that is also not meant for initial level of students, it is meant for the final level students. So that's the reason it's CS Professional. Earlier I had done it for CA Final, 160 hours. Earlier you had law in your CA Final. So that also I had done the same way. But the approach will be different. It will not be the way we are doing now. It will be more towards exam and content. So if your law, if I take 100 hours to deliver, without students, without anyone, I can deliver the same content in 60 hours. Because there will be no, even when you are watching, you just want the content. You know, for you the time is very important. Now questions will be more, exam oriented topics will be more. That will be the advantage of the only recorded. So that's the difference. Okay, yes people, Okay, the next one we will, chapter 3, chapter 4, Indian Partnership Act people. Let's start with Unit 1, General Nature of Partnership. Unit 1, there is almost nothing, but just let us go through and see what it is. Okay. So what is Indian partner? What is a partnership definition, people? It is an association of two or more persons coming together to carry on a business and to share
of a business.
To share profits, losses also?
No.
Okay. So can one partner take all the profits?
No.
One partner cannot take all the profits. One partner can take all the losses, because the definition says it is only to share profits. It is not included as to share losses. So one partner people cannot take all the profits, you have to share, but one partner can take all the losses. Then what will be the other partners called? Other partners will be called as beneficiaries, that's all. So remember, one more wrong notion we always have. A beneficiary to a partnership need not be always a minor. It can be anyone with whom we are not taking losses is a beneficiary only. Yes. Okay. So carried on by all or any of them acting for all. This only is called as cardinal principle, also called as mutual agency. Correct? Yes. So association of two or more person, the person can be natural as well as artificial, that is company, LLP, but it cannot be partnership because partnership is not a legally recognized entity. Elements of partnership, yes sir, next one is agreement. It's a voluntarily contractual partnership. No one should force you to enter into a contract. Existence of business is mandatory. Not for profit organizations cannot function in the form of partnership. Next one is agreement to share profits. So that's what we saw. Business carried on by all or any of them acting for all. This only is called as cardinal principle, also called as mutual agency concept, and that's only the main important aspects of a partnership. Next one, true test of partnership. An agreement has to be there. Next one, sharing of business, sharing of profits of business has to be there, and mutual agency is mandatory. In this sharing of profits of business, in various cases in the past, it was held that a few people were giving money to a few people. Whether this giving money, will it be considered as sharing of profits or it won't be considered? They have tried to give you some examples which were held in the past, and they have tried to tell you why it is not considered as sharing of profits and then what else it is called as. They have given you a list of such items. What is that? First one, following does not constitute as sharing of profits. If they are asking you a practical based question, they can expect a question here. They can give you these scenarios and they can ask whether a partnership exists in these scenarios. First one, sharing returns from property. No, it is not called a partnership, it is called as co-ownership. What do you mean by that? Now imagine there was a father, A, father died. There are two children, imagine B and C. Father died, the property went to B and C now. From the property, a rent is coming and the rent is being shared between B and C now. Now whether is there a partnership between them because they are sharing the rent? No. No people, just because they share the rent, there is no business carried on by them. The property is just giving them a rent. Are they thinking every day on what to do, what not to do? No. So this cannot be termed as partnership. Next one, receipt of money by a lender. Obviously, they are nothing but creditors. When creditors give money, you give back interest. Now you are giving back interest. Giving back interest, is it like sharing profits? The answer is no. Whether your profits are there or not, you have to pay interest. That's what they are saying. Receipt of money by a servant or agent as remuneration. For people who work for you, you pay them salaries. Is it considered as sharing of profits? No. When there is losses, even then you need to pay the salaries. Then where is sharing of profits? Receipt of annuity by a widow or child. Generally, this is called as a pension. In a partnership firm, whenever there are partners who have worked for us, if they die, as a goodwill, the partnership firm decides to pay a certain percentage to their families. Now, just because I am giving it to them, does the family become partners with us? No, because what you are giving them is nothing but pension. It is nothing to do with business or the profits that the company is making. The last one, receipt by previous owner as consideration for goodwill. Now, generally what happens, whenever a person is selling their business, they will say, I will sell the business, but for the next 2 years, whatever are the sales you are going to make, 10% of it should be given to me as royalty. Now even after selling my business, I am giving it to you. Should I consider you as a partner now? No. It is a part of settlement of selling the business. It is not considered as sharing of profits. They can give you these scenarios. They can ask you a question here. Remember and go. Next one, sir. One case law. Santiranjan Das Gupta versus Dasiran Murzamul. In this case, it was decided whether a partnership exists between these people or not. In this case, the court decided, they considered certain matters. And after considering those matters, they finally decided, no, because this is not there, and because of that, this cannot be called as a partnership. Now, what is that this is not there? First one, there is no record of terms and conditions, meaning partnership deed is only not there. Next one, the company, that is the partnership, has not maintained any accounts at all. the court considered that also. So they went a little ahead from true test of partnership. They considered more aspects as well. The third one, no bank account of partnership was opened. Then how are you doing business? The last one, no written intimation was conveyed, meaning there it was not registered, there was nothing as a written document which was communicated to any of the authorities. So considering all of this, in this case it was decided that there is no partnership that exists between these parties. That is the case law. Next ones are kinds of partnership. The partnership can be divided into four things. One is partnership for fixed period. Whenever you are opening a partnership firm, you say that this partnership will be valid for a period of 3 years. After 3 years, people, remember, after 3 years, you have a choice. What is a choice? You can either wind up your partnership, or even after the fixed period, if you guys continue your partnership will automatically now become partnership at will. Meaning whenever you want, by just giving a notice, you guys can wind up your partnership firm. Next one is called as partnership at will. Partnership at will means nothing but where one partner, he gives a notice to all other partners intimating his intention of winding up, dissoluting the firm. He will intimate to all the partners, and accordingly these people will take a decision. That is called as partnership at will. What is partnership at will? You have not decided on how are you going to dissolve the partnership firm. It is nothing related to the activity, not at all related to the time. Then how are you going to dissolve the partnership firm? There has to be one way. No, that way when there is nothing is called as partnership at will. Next one is called as particular partnership. When group of people come together to do one single activity or a specific activities, it is called as particular partnership. General partnership, under one name you guys are going to do multiple businesses, that is called as general partnership. Yes sir, Pakana. Okay. Next ones are types of partners. The types of partners, one is called as active partner. Active partner is a person who actively takes part in the business decisions of the company. Important point, questionable point here is, whenever an active partner resigns, he leaves the firm and goes, the active partner has to give a public notice. Until the public notice is given, the active partner is not, basically he continues to be liable. He will not be exempted from the liabilities of the partnership. Even after resignation, he will be liable until the date of him giving a public notice. Very important exam you can expect. Sleeping partner is a person who does not take active part of the partnership firm, and sleeping partner, if at all he resigns, he need not give any public notice because people do not know this person exists at all. Next one, nominal partner. What is a nominal partner? Nominal partner is basically a partner who gives his name to the partnership firm because his name has some reputation in the society. Now looking at his name, the business of the partnership firm will go up. Now few of you will have a doubt here. Sir, is the ambassadors or endorsers, that is the celebrities coming and doing ads for the companies, are they considered as nominal partners? No, people. For doing ads, they are getting paid. Nominal partner does not, he may get paid or he may not get paid. Meaning he may share profits, he may not share profits also. So he just becomes a partner. If at all profits are there, he may take or he may not take also. Sir, will he be liable for losses? Yes, he will be liable for losses. If at all the partnership goes into losses, he will have to bear the loss as well along with other partners. Yes, it is required. Partner in profits only, simple. When one partner takes all the losses, rest of the partners are called as partner in profits only. Examples of that can be even minor or any other person also. Yes, possible. Incoming partner, add-on of a partner coming inside the business is called as incoming. Outgoing is a resigning. Death, removal, all they are called as outgoing. Partner by holding out. We have seen in estoppel what is partner by holding out till now. Partner by holding out is nothing but when a person is not a partner, but to the world he is introduced as a partner. Now he will be deemed to be a partner to the outer world. Yes, sir. That is called as what people? Partner by holding out. Differences probably we'll see in the Companies Act chapter. What is the difference between partnership as well as company? Yeah. So we'll see difference between that and LLP also when we're doing LLP chapter, so that we would have done everything. So that is your unit 1. There is nothing much under unit 1. Next one, people, is unit 2, relation of partners. So whenever a partners are doing business, what is the relation they share with each other? Even relation, sir, that it will be partnership. What relation they will share? You never know, Noda Macha. Okay. Now, what is the partnership? What is the relation they share? Basically, there are 3 relations they share. What is their relation with the partnership firm? What is their relationship with each other? What is the relationship with the outsiders, third party? So that is what you will be seeing under this particular unit. First one, relation of partners to one another, amongst us. What is expected out of you? Simple, be fair, don't do fraudulent activities, and if at all anything of that sort is done, you will be responsible and we will not be responsible. So, general duties, carry the business to the greatest common advantage, be just and faithful, render true accounts. Duty to indemnify the firm for loss caused by fraud. What is this? Indemnify. If firm suffers any loss, it is your duty to indemnify. Meaning what, people? Imagine this person did fraud. Outsiders came and filed a case on the firm. Firm will repay the money. The partner, whoever did the fraud, he will have to give the money to the firm from his pocket. That's the meaning of indemnify. Right and duties of the partner, it is according to, as decided by the contract between them. Nothing but partnership deed. Whatever it says, that is the rights and duties. This is what I told you. Indian Contract Act, Sale of Goods Act, Indian Partnership Act. The first statement will always be, unless otherwise agreed between the parties. First, what you guys agree, you follow that. If it is silent, then come to the act. It may be varied by consent of all the partners. If you guys want to change anything in the partnership deed, you can change it. But provided all the partners have to agree for such change. Agreement in restraint of trade is valid for reasonable time. What is agreement in restraint of trade? Imagine if a partnership firm started, we had a clause that once you stop to be a partner in this partnership firm, if you go out, you cannot do the similar business. For how long? Reasonable time. 2 years, 3 years, fine. 7 years, 10 years, unreasonable. So such condition will become invalid. As long as you're a partner here, you're not supposed to work anywhere else. Is this restriction valid? Yes, it is valid because it is reasonable. We are expecting your full time here. Understood? Okay. Next one, conduct of business. Partner to do his duties diligently, meaning don't be negligent. Any differences of opinion in ordinary matters, it is to be decided by majority. Whether to do this or that, go with the majority. For change in nature of the business, we are doing education. Shall we do finance business? Yes, you can do it. Provided you have to take unanimous approval. All the partners have to agree. Simple changes, majority. If we are 5 partners, 3 partners agree, you can change the simple terms. But if you want to change the nature of business only, you want to do a different activity. Not 3 partners, all the 5 partners have to agree. That's the meaning. Clear? Next one, every partner can inspect and take copies of the books, that is your accounts and all, except the transferee. When we are doing the transferee point, we will see transferee will not share the same rights as the existing partner. Remember, that can be a questionable point also, but we will be seeing more in detail when we are doing the transferee point. Mutual rights and liabilities. Right to remuneration. By default, no remuneration, but can be given if agreement provides. Sir, there is one thing here. They can ask you a question here also. Remuneration. So people, there can be a question here, remember and go. What is that, sir? Right to remuneration. Imagine, sir, by default, there is an active partner. This is how the question will be asked in your exam also. An active partner, there are 4 partners. One active partner is working more than the other partners. So going forward, he is demanding for 30,000 extra salary. He is telling, I will take it as my remuneration. Now the question is the partners, are they entitled for remunerations? Are they entitled? They are telling you, partner is not entitled to receive any remuneration in addition to his share in the profits of the firm or taking part in the business of the firm. The first thing says by default you cannot get any remuneration. That's the first point. However, but this rule can always be varied by an express agreement by course of dealings, in which event the partner will be entitled to remuneration. Meaning what, sir? If your agreement provides, add a point in your partnership deed that the active partner will be entitled for 30,000 as remuneration. Now can we pay him? Yes, you can pay him. So in your question, what will you say? An active partner will be entitled for remuneration provided if the agreement provides so. Look at the words. Next one, thus second place, can we still give it, sir? A partner can claim remuneration even in the absence of a contract also. Sir, what if our partnership deed is silent? Can we still claim remuneration? See here, where it is customary to pay remuneration to a partner for conducting the business of the firm, he can claim it even in the absence of a contract for payment of the same. What do you mean by that? There are three rules here. By default, no remuneration. If your agreement provides, yes, you can pay. What if agreement also does not provide? Now check your competitors, check your customs. See what the others of your similar business do. Are they providing the remuneration? Is it provided according to your competitors, fellow competitors? If it is accepted in the society, then yes, people, this person will be entitled for remuneration. 99% of the chances the question will be asked on the third point. Clear? Huh? They will say whether we can pay or not. So you need to state all this and you need to say. So now are you getting if they are asking a question, how to present also I am telling you. Now they will ask you a scenario. Can a partner be entitled for remuneration? You give your opinion to this partner. He is of an opinion that he needs to get 30,000. Your answer will be, according to section 13A, the law says, in general, by default, a partner is not entitled for remuneration over and above his share of profits in the partnership firm. That's my provision of law, first point. Second point, however, a partner can be paid remuneration if at all it is decided by them by a contract between them. I can provide. That is, a partnership deed can provide, I can provide. The third point will be, I'll say, if at all the contract is also silent, you can still provide a remuneration to the partner if at all the customs provides so. Facts of the case, I will say, in the given question, Mr. A demanded for 30,000 as salary, whereas other partners are of an opinion that A is not entitled for this remuneration because it is not there in the partnership deed. Conclusion, referring to the provision as well as facts, whether this person, Mr. K, he is entitled for remuneration if at all it is in the customs of the partnership firm, according to the customs or according to the competitors, it is allowed to pay remuneration to the partner, then yes, Mr. K can draw 30,000 as remuneration. Now this will be my framing of the answer. The first point will be provision of law. You have to write, take it and write the first paragraph as provision of law. Write it, do not hesitate writing this provision of law also. I will underline and I'll start my answer here. As per section or according to the section 13A of Indian Partnership Act, which speaks about the partners' remuneration in a partnership firm, which says, write down the 3 points, split it, point 1, point 2, point 3. General partnership deed customs. Next will be my facts of the case. Underline and again write what has been given in the question. Split the question into 1, 2. The next one, write conclusion. Referring to the facts as well as the provision of the law. Yes, it is possible. Yes, it is not possible. In the question only they would have given, is it tenable? Is it not tenable? Is it maintainable? It is not maintainable. Can we sue? Can we not sue? They would have given in the question only. So accordingly take it up, write the same words in the conclusion. Sir, now what if there is any landmark judgment? What should I do? before writing conclusion, you would have written provision, you would have written facts. Now check whether if there is any judgment, you guys know, case laws. You will write referring to the landmark judgment. Referring to the landmark judgment, and you will write the facts in the case are similar to the decided case law so and so. And you will write the conclusion. Now you guys have a question. What is that? Sir, if I do not know the section correctly, can I write a random guess? Irli? Remember people, no section, it's okay. Wrong section, capital punishment, hanging only. Meaning people, you are telling the valuer, you are telling the examiner, sir, it is section 13 Allah, it is section 20. But the valuer knows that the question being asked is from section 13. You might also be writing section 13 only, but what have you given in the first line? Sir, I am answering this question not as per section 13, I am answering it according to section 20. So definitely people, first impression will be wrong. Getting it? And always remember, your first question should be the most confident question. Ange beautiful cursive writing. The valuer should come and hug you. Ange. Like that you need to write. Is clear? Pakkana? That's what I am saying. So it is always important to nail the first answer. The first answer, don't judge the book by its cover. Not in your exam hall. That philosophy is wrong in our exam. We will judge the book by your cover. That is whatever is in the first answer. That is the opening preface for your next 26 pages. Here only, Bul Bulaya, everything is coming. In the next page, what and all you guys would have shown. Manjalika, Rashmika, everyone will come. So, if I don't write, will they deduct marks? I will not say they will deduct the marks, but I will tell you what unfortunately happens. Imagine there are 5 students, one student might write and they would have seen such paper also, you have not written. Now you tell me, how do I differentiate the person who has written and who has not written? I am not deducting the marks for not writing, but I have to award one extra mark for the person writing it. Yes sir. So I will not use the word they will deduct the marks, but for the person writing they may give an extra mark. So, Andre sir, 5 marks, they will give 6 marks. Out of what, if you get 5, it will be 5 on 5. But yes, whenever they are saying you got 3, you got 4, you will not know where the mark is deducted. But if the entire thing is correct, if the section alone is wrong, the chances of deducting the mark only for section is almost negligible. Now it is not there. In the previous RTPs, I don't know if you guys have seen that in my material. In the preface, I would have put an underline. You have the book?
No, sir, not our material.
I think in the initial RTP, it should be there. Seen near the index or after the index page. There is something given below the index.
Every time.
No, not that.
Closing this book.
No. So, I think it was there in the old syllabus. That's the reason. In new syllabus, even I did not put. In old syllabus, in one of the RTP, ACCA had only told that will not writing the section, will we deduct the marks? ACCA had told for your level, we will not be deducting the marks. However, we will be differentiating between the person writing it and not writing it.
Wow.
So, deducting, I'll say I don't know. They won't deduct. But how will they differentiate? I don't know. It is the point, yes, So, don't take tension. Everything is possible, everything is achievable. In the last month, we should not worry on the section numbers. Content is more important. All is well. Let us go forward. Yes, don't worry, people. You all will pakka pass. Sir, inge heladri last time. Inge maartira bari. Okay. Yes. But one thing what I tell you, even now, it's not late. Take a scanner or something. You guys have taken scanners? The first thing, take scanners. Solve questions. You should see as many questions as possible. If you don't want scanners, go to ICA, take guideline answers, take old syllabus, download papers. Every day at least see one paper. Yav paper, sir? RTP, MTPs, old question papers. That is what will help you a lot. In law, as many questions you see, you know what is the difference? In the class content, how everything is being communicated. But unfortunately, now only when I ask you guys question, what is coming? You guys are answering what? You guys are answering in your own words. I'm not saying it is wrong.
That was my last time mistake, sir. I knew everything. I knew all the concept perfectly, but I didn't know how to apply it to
present
the
it. That's why I said multiple questions. When you see the questions, it will make you register, okay, my conceptual thinking was this, but the writing analogy is different. You need to write it in a different way. Now, if I go back and ask, what I generally tell, you need to write at least 2 papers before going for the exam, law. If 2 is not happening, at least write 1 paper. Don't even depend upon any person. Take one random question paper from the institute, download it, have a timer, write it. See how much time you are taking, and don't even wait for an examiner value or nothing required. You guys will have guideline answer in the institute only. Take and compare. You will know where you are only going wrong. You don't need an external person. And that's how I'm saying, from an attempt to attempt, as we go, it need not be in the same attempts also. As we go by, in CA final, CA inter, we'll have a even more, probably a little more matured version of law. That is more of corporate law. Here at least it is stories. That's more of probably an aligned law without any stories as such. Now we need to know, we need to get habituated to write the words, what is there. See, you can imagine this way, you can say, so the examiner has to give us marks for what we are writing. If that is the case, people, everyone will have their own interpretation. Law is based on interpretation. Now one of the student was again asking, sir, why should we write that case law only? If we know some other case law, why can't we write that? Now even I will also write Muniana versus Kempamma. Do you know whether that case is there or not? Then, so how will you put an end to the curriculum? How will the valuer know that, okay, this case is there or not in reality? Now I am sitting here. Do I know all the cases? No, I don't know. 100% I don't know. Then how can you expect a valuer to know all that? So it is impossible. That's the reason there is a boundaries for the curriculum. Understood? Yes, sir. Okay, yes. So I will see. I'll try. The first preference will be your RTPs, MTPs, and we'll see how much time is left for tomorrow. If there is still time left, let us take more and more questions as well. Yes. Okay. And meanwhile, in the previous attempt, I would have done RTPs of that previous attempt. So go and search for business law, CA Foundation marathon. Earlier, last attempt also I had done the marathon. Go towards the last part, or someone would have put the timestamps. Go see that for the person who is putting timestamp. So you are doing a great job, really very good. So please do for this video also. Okay. Now, so last time I would have done some RTP. So please watch that also. As many questions as possible. Previous to that, I have uploaded some question papers also on YouTube. If possible, watch. Just sitting, you guys can go through, keep on going through some question papers. What more than that? In the class, we have done assignment questions also. If you guys have access to the recorded videos, I'll upload again, no? In the recorded videos, if you guys still have access, watch the assignment questions. Around 40 or 50 questions have been solved in that. I think you, even this batch. Assignment sheet also, I think I had shared with you guys. So go through all of that. That is what is more important as well. Clear all of you? Yes? Okay. Next one, people. Right to share profits. Yen ಮಾಡ್ತಿದ್ದೀವಿ? Okay, we were doing
3 points. Customary.
Remuneration. Correct? So that is more important. Remember, people, that is very, very important. I expect a question here. If not now, someday. Right to share profits. In absence of any agreement between parties, in absence of any agreement, P&L to be shared equally. Very, very important. They can ask you a scenario here. They can ask you multiple questions. Meaning, sir, if at all there is no, people, the profits and losses will be shared according to the ratio agreed. What if no ratio is agreed? They will try to confuse you with capital contribution. So if there is nothing given, people, it will be shared equally, not according to capital contribution. Important. Interest on capital only when agreement provides, or trade or customs, or statutory provision. Important. Meaning, if you have given capital, should I pay interest on it? If agreement provides, you can give. If agreement does not provide, if your agreement is silent, again same thing, trade or custom, or statutory provision. What do you mean by statutory provision? In any other law, does it provide you to give interest on capital? Refer Income Tax Act. It says you can give, then give. Understood? Yes. Okay. Interest on advances you can take up to 6% per annum. Right to be indemnified, right to indemnify. Whatever we saw here, indemnify. If you do any fraud, it is your duty to pay the money to the firm. Next one, sir, partnership property. What and all is included in partnership property? Whatever you bring in at the time of commencement, it can be as cash or it can be as property. Everything is included in the partnership's property. Next one, property rights earned during the course of business. Using 1 lakh, you guys made it 2 lakhs. The 1 lakh you earned. This 1 lakh is also partnership's property. The last one is goodwill. Nothing but the reputation or the brand of the company. Next one, sir, personal profits earned by partners. Sir, in the partnership firm, imagine there is a partner, if he is also making some profits. How is he making profits? He is making profits. Partner earns profit for himself from transaction of the firm. What do you mean by transaction of the firm? Imagine there are 3 partners. Now I am a partner. I need to get the best raw material supplier to the partnership firm. I will go and get a quotation from 3 people. And I will select one person. Why did I select that person? Because he told, give me the tender, I will give you 10 rupees per kg of raw material as commission. Oh, I am getting commission. Then who cares about who supplies the goods to me? I gave the contract to them. I am making a profit out of the transaction of the firm. Secret profit, not allowed. Sir, use of firm's property. Using firm's property, I am making money. Meaning, people, imagine there is this tuition now. The tuition gets wound up by 9 o'clock. After 9 o'clock, I launch one after 9 o'clock batch. Shastrastra batch. Night we will do Brahmastra. Come. So, I am telling, so I am using the firm's property, Maiko, all this. I am accountable. Any money I make, I have to give back to the firm. Firm's business connection, meaning? Same thing, you take this one only. For me, there is one particular supplier of app. Our website is ArivuPro website or app. It has been configured and developed by one service party. I'll take his service and I'll also deliver my services. So, using the firm's connection, if I take any personal gain, that also I'll have to pay back to the partnership firm. Next one, firm's name. I will keep saying I'm a teacher here, I'm a teacher here, and I'm using that I'll get a job. Sir, again that they're telling you, any profit you make, I have to account to the firm. Next one, carries on any competing business. I'll not use anything of the firm. I'll learn how it is. I'll also start something of my own simultaneously. So they're telling you, no, you are not supposed to do it. Clear? Any secret profits made, you have to pay back to the partnership firm. Okay. Next one, liabilities to third parties. All the partners are jointly liable for the acts of the firm. Liability of the firm for wrongful negligent acts of the partner provided he acted in ordinary course within such partner's authority. What do you mean by this, people? In an ordinary course of business, just like agency, if any partner did any mistake, example, A, B and C, B's duty is to take care of operations in the factory. That is the duty we have given to the partner B. So there were big machineries in the partnership firm. B's duty was to make sure everything, safety devices, everything is properly taken care. B, in spite of repeated reminders, he has forgotten to case or fence the machineries. Generally what happens in a factory is, if at all there are big machineries, if at all employees by mistake, if they something unfortunate things happen, they might get into deep trouble. Accidents can happen. So to avoid that, these fencing of machineries will happen. Imagine something will be rotating without knowing, your dress gets stuck there. You'll get pulled. So to avoid that, fencing of machineries will happen. B's duty was to get this done, but B missed doing it. The employee people, his hand got cut. He filed a case on the partnership firm for compensation. Now, whether the partnership firm is liable to pay, the answer is yes. In the course of business, if you do any mistake, this is not fraud, it's a mistake. You missed doing it. All the partners will be liable. Clear? Okay. Next one, liability of a firm for misappropriation. Simple. A, B, C partners, they go to a bank, ICICI bank, they get a loan, they keep it in the drawer. After A, C goes, B will take the money and he will run away. Sir, is the the other partners, are they liable to repay the loan? Yes, they are liable to repay. Take the second scenario. B alone goes to ICICI bank. He borrows the money in the name of A, B, C and co. He takes the money, he runs away. Without coming to partnership firm back, he runs away from there only. A and C, are they still liable to repay? Yes, they are liable to repay. As long as if the money is borrowed in the name of the firm, all of you get and you run away, you alone take and you run away. All the other partners are liable. Who, sir? Who said, sir? Unfair, no, sir. That's why you call it as mutual agency, cardinal principle. One of them acting for all, or all of them acting together. Firm is liable to make good the loss. Sir, now we have one doubt. What is that? Relation of partners to third parties. Partner is an agent of the firm. Whatever partner does, the firm is liable. Now what is that called? That only is called as implied authority. Meaning, now imagine people, I told that one partner has to take care of operations. So that machinery, any problem. Imagine if the plant and machineries require AC. I will not again write in the partnership deed. You have a right to install AC. You have a right to install lights, bulbs. I will not say all of that specifically. I will tell you, you can take care of operations. In example, I think in the class we had seen some cricket match or something we would have seen. Organizing the cricket match. So I will give you one activity. Under that, whatever comes, everything you have to do. I cannot write each and every point. So that is called as implied authority. If I tell you to take care of operations, whatever comes under operations, it can be hiring people, firing people, adding more machineries. You can do everything. For everything, the partnership firm will be liable. Ayo sir, it is so risky. No sir, can't we restrict this power? You can restrict this power. How? By adding scope to the partnership firm. You can say a partner cannot do any activity beyond 5 lakh rupees, beyond 2 lakh rupees. If he wants to do anything beyond 2 lakh rupees, he needs to first consult all the partners. If you add that, if he has to do anything, he has to first come and consult all the partners. If they agree, only then you can go ahead. If not, you cannot go ahead. Understood? Pakkana? Okay. Now, there are certain cases where implied authority won't work. Meaning, you cannot come and bind the firm alone. If you do this as a single person, the firm will not be liable for this. What is that, sir? These activities you cannot do alone, you have to do it as a group. What is that? First one, submit a dispute relating to the business to arbitration. There is a case going on between outsider and us. You are telling, let us not go to court, let us go and settle this matter out of the court. If you want to settle it, they are telling you, you can settle it only after discussing with all the parties. Next one, open a banking account on behalf of the firm in his own name. Ayyayo, Deshdroha. He is telling, let us not have a common account. I will have my account. Let us take money in this account. I will give you guys genuinely, fairly I will pay. Not required. Compromise or relinquish any claim or portion of a claim by the firm. There is a case going on between us and an outsider. I am going and compromising. Or I am telling you, hey, it's okay, Goda Macha. You also be happy, I will also be happy. You don't pay us. Consult all the other partners. Withdraw a suit. Ayyayo, Mahapapa. Capital punishment. Idala capital punishment. Next one is capital punishment. Withdraw a suit. The firm has filed a case in the court. You are going in the court and saying, sir, no sir, Papa, they are very innocent people, sir. We wish to withdraw the case. If you want to do it, you have to ask all the partners' approval. Next one is Deshdroha, Mahapapa. You are going in the court and saying jihad. Meaning what? Sir, we only did everything. They did not do anything, sir. It's our mistake. You are admitting the liability. We are fighting, you are admitting in the court. Imagine one person, Katappa is with you only. What can you do? Acquire immovable property. The value will be more. What if I do a favorable transaction? If I am acquire immovable property means what? I am buying a land, I am buying a building. What will be the value? Minimum 1 crore today. So it has to be consulted. You take a wrong decision. Where will we go? So whether you want to buy or sell, acquire or transfer immovable property, first has to be consulted with all other partners. Only then you can sell. Next one, enter into partnership on behalf of the firm. If you want to do a business with other partners or with other outsiders, if you want to do a business, you have to take as a group call, not a single call. That is not allowed. Correct. So if these things, yes. If any other things, you can do it even individually also. Okay. Next one. Mode of binding the firm, it's simple. If at all I want to make the partnership firm responsible, how do I make it responsible? I have to say Mr. B, after writing the entire contract, in the end, I'll have to say Mr. B for A, B, C, or you can say Mr. B partner for A, B, C and co, and then you will sign. If you do it this way, the partnership firm will be bound by your sign. Sir, if I just write it as sign and Mr. B and this part is not there, then the partnership firm will say, you did not enter into a contract for the firm, it is your personal contract. So the partnership firm will not be bound by whatever is a contract you entered. You will be entering it in your personal relationship, not in that relationship of the partners. Understood? Yes. Okay. Next one, partners authority in emergency can do any act to protect the firm in good faith. Same thing like agency in necessity. What happens, people? Imagine there is a trading firm, ABC and Co. They are a full-time traders, shares. A and C are in vacation now. All of a sudden, people, something happened, political change. Share market started falling down. To protect, to safeguard the losses, what did B decide? B decided to sell all the shares. They incurred loss. But why did he do? Because to stop them from even more losses, I had to exit from the stock market. Now can A and C come and say, why did you do? You should have consulted us. No, he did whatever is right at that point of time. Same thing is agency by necessity also. Same thing is partnership during emergency also. He can go beyond his scope. Whatever is given as a scope, he can go beyond that also during emergency. Clear? Okay, next one, third party. Okay, transfer of partners, interest and transfer is right. Important, they can ask you a question here. Can a partner transfer his share to an outsider? Is it possible?
Extension and restriction of partners implied authority.
Extension and?
Restriction of partners implied authority.
Okay. Implied authority of partner, the authority of a partner to bind the firm. If it is done in the ordinary course, acted within the scope, he should have entered in the name of the firm. In such case, the firm will be liable. It can be specifically restricted. Can I restrict the implied authority? Is it possible? Yes. How? By a contract. Now sir, what am I saying? Let us imagine in my partnership firm, I have clearly said, the partner cannot do anything beyond 2 lakh rupees. That is the scope I am restricting to. In the partnership deed, I am writing it as 2 lakh is the scope. Now my question is, imagine the partner also went and entered into a contract with an outsider. And the value of the contract was 4 lakhs. We entered into a contract with an outsider also. Now my question is, he has gone beyond the scope we have given to him. Now what will happen to the third party? Is this contract valid? Is the partnership firm responsible for him, or is the partnership firm not responsible for him?
Not
If the third party
Not
knows about the restriction.
If the third party knew that there was this 2 lakh restriction, then yes people, you cannot hold the firm liable. You went beyond, it is your mistake. What if third party did not know?
Then he can take the personal liability of that partner.
Partner or partnership firm will be liable.
The whole partnership firm will be liable.
Even though he is acting beyond the scope, partnership firm.
And he doesn't know, no?
Correct. Remember, partnership deed is not a public document. So deemed to know and all won't
This
come.
kind of question comes in Companies Act also. According to the MOA, only 25 lakh crores is there.
So according to Companies Act, it will become a deemed public document. Whether you know or no, you are assumed to know. That's what is given here. Third party is liable or implied authority is restricted when third party knows about such restriction. What if I do not know? Then third party is not liable. Third party does not know that he is dealing with the partner of the firm. When are they saying that the partnership firm will not be liable and third party will be liable? He entered into a contract with B. He didn't even know that B is a partner in our firm. He just entered into a contract with that person. So why should the partnership firm will be held liable? So in these two cases, the authority will be restricted. Understood? Clear? Okay. Transfer of partner's interest, sir. What is the scenario? Can an existing partner transfer his rights to a outsider? Is it possible? First thing people remember, in a partnership firm, if you want to transfer your rights, the first thing you need to do is ask all the existing partners, I want to sell my shares. Are you guys interested? If none of them are interested, everyone says no, then no one can stop you from selling your rights to an outsider. You can sell it to an outsider, it will be valid. But the rightful thing is, first you need to ask the existing partners and then you have to go to the outsiders. Clear? Okay, done, sir. Now, whenever the outsider comes into the firm, now this person is called as transferee. Now, what are his rights? Will he enjoy all the rights same like our existing partner? The answer is no. He will not be treated like a normal partner. He cannot interfere into the business. Whatever we give as a profit, he needs to take. So he will never be treated as the same person. They can ask you from the exam point of view. So first of all, to the transfer, consent of all partners is required. At the same time, partner is not barred from transferring his interest. Because I need money, what do I do? If you guys are not interested to buy, I will sell it to an outsider. Assignee cannot enjoy the same right and privilege as original partner. The new partner during continuance of partnership, transferee coming inside, he cannot ask these things. What are that? He cannot interfere with conduct of the business. They can ask you a question here. Second one, he cannot even require, meaning he cannot even ask for accounts. He cannot even inspect the accounts. You will not be given right. He is only entitled to receive the profits, that to whatever they give. However, what and all I am entitled to? If at all the partnership firm enters into dissolution, I am entitled to the share of the assets, whatever I should have, whatever the previous partner should have got, now I will take. And he is entitled to account from the date of dissolution. Meaning once we go to the dissolution, now I will get the accounts. Now I can cross check, I can verify all that can happen. Clear? Yes, sir? Okay. Next one, sir. Minor admitted to the benefits of the partnership firm. Okay. Simple people, minor rules we'll see at once. What is that? First of all, when a minor is admitted to the benefits of the partnership firm, what are the rules says people? Is the minor, is he liable for the losses? The answer is no. Minor is not liable for the losses. He is only eligible for the benefits of the partnership firm. The next thing, sir, imagine if a minor, upon the attainment of majority, now what should I do? Should I continue as only taking benefits or what will happen to my scenario? Remember, as and when you become a major, there are two things that will be told to you. What is that? One, you can either continue or you need to exit. Now when should I tell? Do I have a time frame? Yes. Whenever you get to know that you are taken as a partner or within 6 months from the date of maturity, that is you are 18, whichever is
later.
Earlier or later?
Later.
Whichever is later. So whenever I got to know or 6 months, whichever is later, I need to intimate the public my decision of whether I want to continue or not continue. Sir, what if I get to know when I was 25? So 25 years or 6 months, whichever is later. So I have to tell when I was 25 years, no. That's the reason the lawmaker put another condition. This condition is subject to maximum of 6 months from the date of attaining majority. So at any given point of time, you have to give your decision within 6 months only. It cannot go beyond that. So when you are writing the answer also, you will write the same way. At the time you get to know or 6 months from the date of majority, whichever is later, subject to maximum period of 6 months, you have to communicate the decision by a public notice. You have to tell whether you continue or you do not continue. Sir, what if I fail to give a notice? If you fail to give a notice, you will be assumed to be the partner. Sir, what if I am assumed to be the partner when I am doing yesterday minor contracts only I told you? What is that? If you are continuing to be a partner, you are liable for all the contracts you entered since you were admitted for the benefits of the partnership firm. Meaning when you were 15, 16 years they had taken you from that day whatever are the contracts entered, for everything you will be held liable. Clear? This part. Sir, what if I do not choose to continue, sir? Then the day you give a decision that you do not want to continue, that day, until that day, you will be treated as a minor only. Meaning you give your decision at 18 years, 4 months. For the 4 months, are you a minor or major? You will be treated as a minor only. That's clear? Sir, and if at all you want to file a case for the accounts and all, you can file after you choose to come out of the firm. You can ask for the accounts, you can file a case, you can ask for the settlement. It's clear? Yes, sir. That's your minor rights. Next ones are legal consequences of partners coming in and going out. Meaning people, let us imagine there was a contract that was entered on, let us take 2nd May 2025. We entered into a contract. Sir, there is a new partner that came on, say for example, 1st November 2025. Now sir, the partner who is coming in on 1st November 2025, basically an incoming partner, is he liable for this contract?
No.
But can he be made liable? By default, he is not liable, that is correct, because it happened before he coming in. But can he be made liable?
Yes.
How? Remember, the coming in partner, whoever is coming in, he has to give an acceptance. The existing partners, they have to give an acceptance. Whoever is the creditor, he also needs to give an acceptance that yes, C can also be made liable for the past debt of the firm. If all of them agree, then yes, the new partner coming in will be liable for the losses of the existing losses of the firm. Sir, till today A and B were liable to pay. Now I am telling even C is liable to pay. What is this called?
Novation.
This is called novation. Parties to the contract are changing. Agreed? Sir, same with outgoing partner. A, B, C left. Once he left, does his liability come to an end?
Yes.
Even after you leave, you continue to be liable to the past debts of the firm. When you were partner, whatever were the debts, for that you continue to be liable. For the new debts, you are not liable. For the past debts, you are liable because your name is there in the agreements. In the loan agreements, your name is there. Now what do? If at all you have to be excluded, A have to agree, B have to agree, and even the creditor has to agree. This is also called novation, change in parties. Yesterday's cross-reference. Clear? Okay, sir. Next one, sir. Admission, no? Retirement. Next one, expulsion of a partner. Can I just remove a partner just like that? Rock, paper, scissors, out. Good. Can I send him out like that? Then what should I send him out as? First thing, expulsion of a partner. That right to expulsion should be there in the agreement. Exam point of view important. All conditions should be written. Expulsion, power to expulsion. Expulsion means what? Removal. To remove a partner, that right should be given to you guys in the agreement. Second one, majority of the partners should vote. The third one, you have to remove in good faith, not like rock, paper, scissors, goda. That is not how it works. Sir, what is that good faith? Good faith means, people, it should be for the benefit of the partnership firm. By giving him an opportunity of being heard, meaning I'll give him a notice, call him, listen to what he needs to say, and after that only I can remove him. If at all I do not follow this procedure, then such removal will be considered as null and void, meaning it is not effective. Remember, important, all those points should be there in your exam. Next one, insolvency of a partner. Ceases to be a partner. Obviously, his rights come to an end. Meaning what, sir? The liabilities of the partner comes to an end when the moment he becomes an insolvent. From that day, his assets assets are not bound to be liable to the partnership firm's debt. The moment it becomes liable, the moment he becomes insolvent, he will quit the company and go. From that day, from the order of the court, his assets will no longer be liable for the partnership's losses. Clear? Next one, liability of the estate of the deceased partner. Upon the death, his liability will come to an end. Until that, whatever his assets are, to that extent, he will be liable. Clear? Yes, sir? Yes. Okay. And the last thing, I think they would have seen one more thing also. Imagine whenever there is upon a person's death or upon a person resigning, if at all the partnership firm does not settle their accounts, without settling their accounts, meaning without paying them, they continue to do the partnership firm business. If they do not settle them, then they are eligible for a particular percentage of profit or interest will be paid to them. This or this. If at all their settlement is not done within time. You remember this, huh? Yes or no? The last part will be that only. Right of outgoing partner in certain cases to share subsequent profits. Yes, sir. You remember? Meaning if a partner goes or dies, you have to settle his money. Without settling his money, you are still continuing the partnership and you earn some profits. You still, even after they have stopped, even if they have resigned, if you have still not yet settled their money, you will pay them a percentage as profit or interest at the rate of 6% per annum. You will give it as a return for not settling their accounts on time. Correct? Yes, sir. Yes, sir. That's all. Revocation of continuing guarantee. What is continuing guarantee? We had seen this in indemnity and guarantee only. I have given A, B and C have taken loan from ICICI Bank. D gave a surety for this loan. Sir, C quit the firm or E joined the firm. Constitution of firm is changing. Even my surety will also come to an end. If this happens without my approval. Clear? D's approval. Surety's approval has to be taken. Clear? Okay, done. Not me, sir. They are implementing different sounds. Of course, this is first day. Okay, let's look at the last. Last unit of
I thought next chapter.
Third unit is there, no? We'll skip off, huh?
No.
Oh, yes, sir. How can I do that, sir?
Actually, while doing the actual class, you did unit 1, unit 3, then unit 2.
Correct. Because there is a continuity. Because it speaks about registrations. Yes, sir. Okay, last unit of Indian Partnership Act. Yes, people. Online, no?
Yes, sir.
Online, no? Macha, come back. Where did you go? Okay. Registrations and dissolution of the firm. Meaning, sir, should I register my partnership firm? Is it mandatory? First of all, is registration of a partnership firm mandatory? They say no, but they say yes only. So they will say not mandatory. Sir, you are important for us. You take your decision. No hurry. You take, if you want to continue like that, only continue. But they will take you to the last floor and they will push you. Yeah, they will say, hey, who told you do not register? You should have registered. That's what they say. That's what is given here also. Registration and dissolution. First of all, how to register a partnership firm, sir? The partnership firm, that is the proposed partners, they need to give an application whether in post or in person with the fees, with the statement. If at all they have registered in the year 2015, but they are giving an agreement today in 2020, after 5 years they are giving it for registration. For every year you will have to you have to pay something called as late fees of 100 rupees per year, because you are giving the agreement for registration after 5 years of forming it. That's what is called as late fee, 100 rupees per year. You will give it to the registrar of each area. So once all the details like the name, like the activity, the names of the firm, if everything is fair, the registrar will make an entry in his register of firms. He will write down A, B, C and Co. and he will write down the details as A partner, B partner, C partner. All the details will be made a note of. Now sir, first of all, is the registration of partnership firm mandatory? The answer is no, it is optional. However, there are some consequences of non-registration. If you do not register, you will have to face a consequence. Now, what are the consequences of non-registration, sir? First one, no suit in civil court by firm or partners on third party for breach of contract. A, B, C and Co. We have supplied some raw materials to Mr. D. He has not paid the money. Can we file a case on them? The answer is no. If at all you have not registered your firm, then you cannot file a case on the other party. Sir, what if we have not paid? Can he file a case on us? Just because you have not registered, that does not stop the other parties from filing a case on you. They can file a case on you. Their right will not come to an end. Is this clear? Okay, next one, no set off. What is that, sir? Sir, we have supplied him material of 1 lakh. Okay, let us imagine this way. This person D has supplied us a material of 1 lakh rupees, raw material. Sir, we have paid 20,000 rupees. 80,000 is outstanding. We did not pay. We did not pay. So he also got irritated. He filed a case on us. We are an unregistered partnership firm. We are seeing set off, no? Oh God. Okay, other way. Sorry, people. Okay. Now, okay, take it this way. Sir, he has supplied how much, people? 1 lakh. We have paid 20,000 and we have not yet paid 80,000. Now, we have not supplied. He filed a case on us. Now, he has filed a case on us to recover completely 1 lakh rupees. He has filed a case for recovering 1 lakh because that is what is the raw material he has supplied, no? Yes or no? Sir, we are saying, sir, we agree, sir, we have to pay. But we have paid 20,000, sir. Consider reducing that. Who are you, da? Who are you? Unregistered, then get out. They are telling you, you have to pay 1 lakh. The set off and all will not be allowed to you. Whatever is there on invoice, I will help him recover the entire amount. Understood? Yes, sir. Next one, aggrieved partner cannot bring legal action against a firm or partners. He may go for dissolution. What is that, sir? In between the partners, if we are fighting, can we file a case against each other? Imagine one partner did a fraud. Can I file a case against that partner? ABC, B took the loan, ran away. Can I file a case on him? The answer is no if you are unregistered. The maximum you can do, go to the court, cry and get your partnership firm dissolved. That is allowed. Apart from that, nothing else is allowed. Third party can sue the firm, that will not stop. Third parties can sue the firm. Partners can sue for dissolution or settlement of accounts. See, even if you are unregistered, you can go to the court and you can ask for dissolution. That is allowed. Next one, power of assignee of the court to release property of insolvent partner. Now what is that, sir? Just because your partnership firm is unregistered, imagine one partner becomes insolvent. What will the court do? The court will appoint a person called as an assignee or a liquidator. He will come and take in charge of all your assets. Like that only, whatever are the shares of yours in this partnership firm, that also I will take. The other partners cannot stop him on the grounds of non-registrations. Even if you are non-registered, the assignee or the liquidator will have a right over his assets of the partner. Next one, claim set off. Sir, just now you said you cannot claim set off. Where? You said no sir, 1,20,000 cannot be reduced. We did dikkara. What is this sir? This is injustice. We said because you guys are crying, do one thing. 1 lakh minus 100 rupees. Pay 99,900 rupees instead. Yes sir. Sir, Adyan Nyaya. That is what is Nyaya. You can claim set off people. They are allowing you up to an extent of 100 rupees. Beyond 100 we will not give you the set off. Up to 100 you can claim set off if you are unregistered. Why?
Because the law is not amended or like.
Not amended. 1872 say aisa hi hai. It was there in
No one even thought of amending.
purpose. What happens is, regarding those points, there has to be fights and disputes. If at all people are fighting regarding those points, then lawmakers will look into it. If there are no disputes only, as I told you yesterday, I was talking about that Maternity Benefit Act. People made disputes on it. So new code has been passed. So when there are disputes, people will make an amendment. If not, what happens? You see lawmakers, for them they are sitting. There are more than how many? 5,000 laws in the country. Adralli Indian Partnership one. Why should they even relook into Indian Partnership Act? Something should have happened. As long as if everything is going smooth, even they will not bother. Next one, suit by legal representatives. Now what is that sir? Imagine a partner died and the remaining partners are not settling the accounts to the family. The family can go and file a case on the other partners for settlement, because just because you are unregistered, on death the family will not be let suffer. So they can go and file a case even on the unregistered partnership firm for the settlement of accounts. It's an exception for non-registration of partnership. Understood? Clear this part? Yes? Okay. Next one, effect in change of constitution. I think we have seen this in the class. What is that? Whenever people, imagine A, B, C and a new partner joins. Next one, A, B, C and one partner dies. Remember, whenever there is an admission, it is considered as a constitution of partnership firm unless this is communicated to the registrar again. ABC was registered, D joined. Now this information should also be communicated. Until it is not communicated, you will be treated as an unregistered partnership firm only. What do you mean by that? You cannot file any case during that period. Sir, what if in this case, A, B, C died? We have not yet intimated. It's okay because the rest of the partner's name is still written in my register of firms. You can still come and file a case. It is fine. We will accept it. So whenever there is admission, you have to intimate the change and only then you can file a case. If there is a death, even without intimating, you can still file a case on the third party. Remember, they can ask you a question. Next one, sir, modes of dissolution of the firm. One can be voluntary, one can be dissolution by the order of the court. Voluntary dissolution, people, one is by agreement. All of you agree mutually and you guys dissolve. That's the easiest way. Next one, all the partners or all but one become insolvent. If everyone becomes insolvent, how will you carry on the partnership firm? Because the Indian Contract Act says you are disqualified to enter into a contract. Happening of any event which makes it unlawful, meaning change in law. You were doing, say for example, liquor business in Gujarat. They said it is not valid anymore. You have to shut down the business. Happening of contingencies, like you said, we are open for 3 years. 3 years is done. You can dissolve or you can continue also. You remember, partnership for fixed period. After 3 years you can dissolve. If not, you will become partnership at will. Completion of business. We came in for a particular purpose. Purpose is served. Dissolve. Death of a partner. Remember, this is your option. If you want, you can dissolve. If not, you can continue also. Adjudication of a partner as an insolvent. One partner became insolvent. Should we continue or not? It is your discretion. Remember people, this voluntary dissolution is absolutely like If you want, you can dissolve on these grounds. If you do not want, you can continue also. Next one, dissolution by notice of partnership at will. What do you mean by that, sir? Whenever, what is dissolution of partnership at will? Where one partner intimates his intention of dissolution of a partnership firm by a notice. In the notice he says, let us wind up the partnership firm from 1st January 2025. Let us dissolve. If a name is mentioned, if the date is mentioned, effective from that day, the partnership firm will be dissolved. Sir, what if no date is mentioned? Whenever the letter is communicated, from that day, it will be considered as effective date of dissolution. Clear? Okay, next one. Dissolution by the order of the court. Meaning what, people? Court on its own won't know that when to dissolve a partnership firm. Partners only will go and file a case in the court if the court is convinced. Again, it's may. If the court is convinced, the court will order for dissolution of the partnership firm. Now, when is that? Insanity or unsound mind. Imagine a partner or whoever became unsound mind, his friend or relatives, will come and tell the court, sir, this person has become unsound mind. Can you please wind up the partnership firm? Generally, when will we do this? When the person who became insane is an active partner. When he only became insane, then it is very difficult for us to carry on the business of the firm. So in such cases, yes, we can do it.
If he's a dormant partner, it's okay.
A dormant partner is generally okay because there is nothing much to lose.
But the other partner can gain because he's an unsound mind, like he can cheat.
Because this person is unsound mind, the other person can cheat. To avoid that only, whoever became unsound mind, their relatives, their family, see what do they say? He should be an active partner. Whoever became unsound mind. On a suit by other partner, that is other partners or next friend of insane partner. What do you mean by next friend?
His close relatives.
I'll tell you one very interesting fact. In a court, whenever you want to file a case, there will be some scenarios where you cannot file your own case. There will be some scenarios you will not be able to file. In such cases, someone else can come and file a case on behalf of you. And whenever someone else comes and files a case on behalf of you, such people will be called as your next friend. It's not like next friend means the person sitting in the next bench. Yes, sir. I'll tell you a very interesting fact. Ram Lalla's case, Ayodhya. The case was filed as Rama cannot himself file a case. I am filing a case instead of him as a next friend, and that's how the case starts. So it is like Ram himself has filed a case through his next friend.
Why will Ram fight?
He cannot now, can he come and file a case? He is fighting for that property as his Janma Bhumi. Now, is it recognized in the law? The answer is yes.
Even he will itself not fight the stupid people.
No, that's what I'm saying. No, what I'm saying is, it is recognized by the law in this scenario. Wherever there are scenarios where you cannot file a case on your own. See, I'm not getting into religious, I'm not getting into anything. I'm telling you, see the relevance of law in real life in different scenarios. Now here next friend means we will generally be saying, oh, macha will come and file a case. That's not the macha we are speaking here. I get in the point. I'm not at all getting into religious context. I'm telling you, whenever you see a law, try to see the reference of what you have read.
So what's the case law name? In Ram's name or the next friend's name?
Ram's name. Whoever files the case has a next friend. His name won't be taken.
So Ram's name is there in the case?
Yes.
Ram versus.
Yes. Nice, no? Okay. Next one is permanent incapacity. What is?
In a case law, the first name is the one who files the case.
Not always. Generally, it is always the person who files the case, plaintiff. His name will come first. Chinnaya versus Ramaya. Chinnaya would be the plaintiff. Ramaya will be the defendant. That means who files the case will come first. But generally what happens, there is something called as an appeal. Appeal means what? When a lower court says something, if I am not okay with it, I will go to the higher court asking for justice.
So the other party goes, then their name
Yes. Now, if Chinnaya versus Ramaya, Chinnaya won the case, let us imagine. Ramaya is not happy with the decision. Who passed the decision? High Court. Ramaya will go to the Supreme Court and say, can you please relook into the order? Now, the case law will become Ramaya versus Chinnaya. Because now it is appellant.
Reading about the High Court case law, that name will, the Supreme Court case law.
No, no. In your High Court judgments, it will come as Chinnaya versus Ramaya only. So what happens is, now whenever you are seeing case laws, especially in your module, not in the book I have sent, in the end you will have something like AIR, citations and all will be given, 1908. Now what is that? AIR means All India Records. Rank Allah. Yes, sir. What is this? This is nothing but people. Supreme Court judgments can be referred in this book. So company law judgments, earlier we used to refer in CLB, Company Law Board Judgments. That's a book. So in that, which page number, which year, if you refer, you can find the case law in that book. This is only called as citations.
Because in this Khwaja Muhammad Khan versus
Hussaini
Begum,
Begum.
actually the
She fought.
daughter-in-law will file the case. But yesterday I was confused.
Why did he come first then?
Why did he come first? I got
Hussaini Begum
it.
sounds like girl. That should come first.
That's always like that. Because they would have gone for an appeal and everything will change.
Sir, I mean, Hollins versus Howler, that diamond
Correct.
case. Who is Holland and who is Howler? The Howler is the restaurant owner.
Correct, yes. Restaurant owner versus the customer.
Okay, so Howland filed the case.
Holland filed the case, Howler is a defendant. Yes, sir. Permanent incapacity is nothing but whenever a person meets with an accident or coma, you are not able to contribute anymore. People, again I am telling, this is not mandatory. Whenever you go and file a case, only court will order. If at all it is, imagine I lost my arm. Now if I can still do my work and if my partners are okay with it, that's absolutely fine. Misconductor, meaning if at all you have behaved in such a way that now people do not want to buy our products because of you. It can be your personal or related to business. But if it is impacting the business, then yes, we can take a decision. Dissolution. Breach of agreement relating to management of affairs, meaning embezzlement. What is embezzlement? There was cash in the counter, you took it. Theft. Erroneous accounts, maintains fraudulent accounts. According to the generally accepted principles, you are not accepted to hold more than 10,000 rupees in cash. If you are holding more than that, because cash transactions can make more frauds, you cannot stop it. I'll say, imagine, Ola, Uber, even if it is expensive, you go in a cab or you go in an auto, you get me an invoice. I know you have traveled only for 230 rupees worth. Instead, imagine I'll say, sir, I took an auto, you charged me 700 rupees, sir. Oh, you 700 rupees. Papa, he was also in tough times. He asked me more money, even I gave. How do you check?
There are no proper records.
Correct. Refusal to show accounts. People are asking for it, you are not showing it at all. Transfer of interest to a third party. Meaning what? A, B and C. C sold it to D. We could not stop that. But he comes in. We do not want to continue. A and B goes to the court and says, sir, please dissolve the firm. Can you do it? Yes, you can do it. Continuous or perpetual losses. Then why are you there? Just and equitable grounds. What is just and equitable grounds? It's like etc. On these grounds also courts can look into the matter. So based on various case laws, they have come at these cases. They can add more also even in the future. Example, a discretion of partners, deadlock of management. What is deadlock of management? Two people say yes, so two people say no. What do we do? They are not compromising, they are also not compromising. That is called deadlock. Decisions are always locked. We are not able to go forward. Management not in talkative terms. They fought. 80% of the partnership firms fail because of this point only. That is, there will be fights. Unorganized sector, no. Loss of substratum. What is loss of substratum? Purpose. The reason why we started, Nokia, keypad phone. Substratum is lost. I cannot make this business today. What is that? Typewriters. Is it accepted today? Loss of purpose. Gambling by partners on stock exchange. Gambling obviously not allowed. Correct, Am? Yes, Sam. Okay, chalo. Okay. Shall we start off Companies Act? We'll finish it off. We have good 45-50 minutes so that we can finish it off.
Sir, now 2 chapters are added in new syllabus. Now the rest, there are 5 chapters. Now if we study 5 chapters also, we can pass.
No.
No, I'm
You
asking.
said you wanted to
I want to
attend
study, I
100
am asking. I am attempting 100. I am asking.
See, out of the 7, 6 is easy to cover. The Indian regulatory framework is easy.
Yeah.
It's hardly some 8 pages. So one extra thing that comes is negotiable instruments. Now if you ask me negotiable instruments is important or not, in Indian Contract Act they have added 3 units.
Okay.
Correct? That and this will have a equal weightage. So 3 units versus 1 unit will have equal weightage. Yes, sir. Sir, is it difficult? Very easy. No basics and go.
I felt
Ah.
it a little tough when I saw
It was like bill of exchange.
Bill of exchange, promissory notes. And that too, CA Inter, everything has not been put in CA Foundation. Some parts have been put.
So the rest is there only.
Not there only. They have removed it, that's all.
They are
In CA Inter, around 50 odd pages was there. For you, 30 odd pages have been taken. So 20 odd pages have been removed. Yes, sir. Okay, next let's do the last part, people. Today, let's end up with Companies Act. So tomorrow we have easy, achievable targets. So Companies Act, people. First of all, what is the nature of company? One is separate legal entity characteristics. So separate legal entity means shareholders are different, company is different. Case law, Salomon versus Salomon. In this case, what had happened? There was a sole proprietorship that was transferred into a company form of business. The company took loans. The company also had to pay some money as secured debentures to Salomon himself. And the company had taken loans from the banks also. Finally, at one day, the company went to a stage where the company is no longer able to continue. They reached a stage of insolvency. On that day, they had 6,000 pounds worth assets, 16,000 pounds worth liabilities. And the 16,000, 10,000 was secured debentures and 6,000 was unsecured debentures. Now, what do you mean by secured debentures? Secured debenture is a document which entitles you to get the money at any cost. If the company is not able to pay, now let us imagine I gave secured debentures to a particular company. If they are not able to repay me the money, this instrument allows me to go sell their assets, take whatever those securities are. It can be land, it can be building, it can be their movable properties. I can sell it and I can encash it. So when compared to an unsecured debenture and secured debenture, a secured debenture will always hold more value. Now because of that, this sentence, that is the only available assets, 6,000 was given to Salomon himself. Now the bankers filed a case. In this case, it was for the major time, the first time I will not say, but to the very big extent, it was decided, do not look Salomon as him and one are the same. Because the company's name and him are the same, they both do not become the same. We are giving him the priority just because of the instrument he holds, not because the company is his. From the company's point of view, Salomon is also an outsider, you are also an outsider. So in this case, they arrived at a very popular theory called as separate legal entity. Shareholders are different and the company is different. Clear? Yes, sir. Okay.
Sir,
Makora versus Northern Assurance Company. In this case, what had happened? There was a company, the company was into timber. They had a lot of woodwork. There was a shareholder, director, employee, everything was one person and that person was Makora. The Makora, what he did, he took a insurance policy on the assets of the company, on the wood. And the insurance policy was taken in his name. If anything happens to the wood, I will get the money. One day the entire wood burnt, there was a short circuit and Makora applied for the insurance amount. The insurance policy denied the payment. Why? Because of wrong reporting. He said all those assets were belonging to him in the policy. But when we got to know, that the assets does not belong to him. There was a company, and to that company all these assets belongs to. Makora said, sir, no sir, in fact that company is also mine only. Instead of recording it in company's name and me taking it, I record it in my name. And in this case it was held, Macha, you are not getting it. Imagine there is some other bike. Can you take insurance on his bike in your name? Not possible. In the same way, for us, you are different, your company is different. Just because you hold maximum and you, everything is one and the same, that doesn't become, you and your company does not become one. On these grounds, people, the insurance claim was rejected. And Makora went to court and filed a case on the insurance company. That's why it's called Makora versus Northern Assurance Company Limited. That's why it is always called as plaintiff versus defendant. Understood? Yes, sir. Again, it is a case law for separate legal entity. Okay, next one, perpetual succession. Companies may come and go, members may come and go, company will go on forever and ever, even if there is a death, even if, for example, the best example, who started Reliance? Tata? Good to time aitu, Tata helana, but who started? Dhirubhai Ambani started. Is Dhirubhai Ambani alive? Who started Tata? Tata only, sir. Which Tata? Ratan Tata is alive. Who started? JRD Tata? JRD? Jamshed G Tata. Jamshed. Correct, Ada? I forgot the name, but it is Jamshed Tata. In fact, I'll tell you something. Because of Jamshed Tata is why India's labor industry is at least like this today. He was the first person who implemented for maternity. Pregnant women should not be given work, but should be paid. That time they paid around for 8 weeks. This was, I'm talking in the year 1925 to 1930. And Maternity Benefit Act in India was implemented in the year 1950s and 60s. 35 years back they paid voluntarily. Entire country until 1950, Sundays was also working. There was no concept of Sunday. 365 days was a working day when we were working with Britishers. We were laborers, no? 365 days was working day. And there was no concept of 8 day, 9 to 6. We used to work for 16 hours in a day, in shifts. Father comes, goes, son will come and work. Children used to work. That's why they brought in some legislations called as Minimum Wages Act, Factories Act, wherein they will say for 7 days, for 6 days, 1 day, leave should be there. In Tata's company back then, when Britishers was there, that was the only company which had Sunday off. Voluntary. And no work beyond 9 hours. Jamshedji Tata. No, open-minded. There is a lot. I'll tell you one thing. If there is something which, if I have to tell you, buy, we'll say, prefer Indian products over make in India and things like that. If you find Tata, anything you want to buy, even if you're paying some 100 rupees, 500 rupees more, it's okay, buy Tata. The reason is that will come back to you only, to the society in some way or the other. 100%. A good company. Okay. It's a fast track. It's a marathon. Limited liability is people. So limited liability means people, my liabilities is limited. We'll see when we are seeing limited by guarantee and limited company. Artificial legal person, a company will have a separate legal entity. They can file a case in its own name. People can file a case on the company in its own name. They can enter into a contract in its own name. They can buy properties in its own name, as the case may be. Best example, Makora versus Northern Assurance Company Limited. Salomon versus Salomon Company Limited. So all these are companies. You are filing a case on the companies only, no? Common seal. Earlier people, in 2015 they made an amendment. Until 2015 common seal in a company was mandatory. Now it is optional. Then how do we have to sign a document, sir? Instead of common seal, instead of a seal by a company, 2 directors has to sign, or 1 director and a company secretary, if appointed, will sign. If not, 2 directors only will sign a document in the place of a common seal. Next one, sir. Let us look at of types of companies.
Yes, sir.
Or we'll see of the characteristics only. We'll be done with it. Okay. Lifting of corporate wheels, sir. What is the general tendency? The general tendency is people, the person is different, the company is different. Sir, in between them, there is something called as what people? A corporate wheel. Meaning there is always a cloth in between them. This cloth only is called as separate legal entity. For whatever company does, the shareholders will not be liable. The best example I can give you in today's date, Videocon company went into losses, but the shareholders were not told to pay even 1 rupee also. The company is into totally 83,000 crores loss. What is the total liability? 83,000 crores. And now totally they settled it around 73,400 crores as loss. That's the loss. How much? 73,400 crores. Sir, does the shareholders have money? Very good money. Very rich parties only. Now why can't they pay money? Because they did not do any fraud. Genuinely the business failed. That's all. It did not fail because of fraud. Now in such case, should the shareholders pay the liabilities of the company? They won't pay. But I'll tell you the another scenario. On the other hand, Kingfisher, they just had to pay 9,000 crores. Vijay Mallya, Papa, even today you guys go behind him and you hit him. Why? Because even there it is a liability only. But the reason why we are asking him for the money is because he did not conduct the business properly. Fraudulent activities happened in Vijay Mallya's company, Kingfisher. That's the reason whatever is a Kingfisher's loss, we are asking Vijay Mallya to repay. Technically he is not liable to repay, but we are telling you there is no separate legal entity. This cloth will be lifted and we will say for whatever is the losses of the company, as a shareholder you will be responsible. And this concept only is called as lifting of corporate wheel. So general scenario is that there is a corporate separate legal entity, but we will take away this in-between cloth and we will say that whatever the company does, you as a shareholder, you are liable. Sir, now when will this generally be done? It will be done, people, first one, to identify that whether the company is doing a trade with the alien enemy or not. Case law, people, Daimler Company Limited versus Continental Tires and Rubber Company. Daimler Company Limited versus Continental Tires and Rubber Company. In this case, what happened, people? There was a company in UK. There was a company called A. Company A used to supply tires to a company called Company B. So there was a contract to supply tires for a period of 2 years. But in between, Company A said, we do not want to supply this tire, Company B said, we do not want to buy the tires from Company A anymore. We want to stop this contract. Company A said, no, you can't do this because there is a contract between us. You cannot break the contract. They said, no matter what, we do not want to go ahead. The matter went to the court. Company A filed a case on Company B saying that, Your Honor, these people stopped buying the tires according to the contract. Company B said, Your Honor, do you know why we stopped buying the contract? Because the Company A, you know who are the shareholders in Company A? The court said, who are the shareholders in Company A? The shareholders of Company A are nothing but the citizens of Germany. Whoever are the citizens of Germany, whoever stays in Germany, they are the shareholders of Company A. Now Company A said, so what? Don't you know separate legal entity? We are registered in England, in UK only. You are also registered here, we are also registered here. Separate legal entity. They are different, we are different. But Company B proved that, Your Honor, if we give money to Company A, their profits will go up. If their profits will go up, the dividends given will also go up, sir. So ultimately, if we give money to them, they give money to them, and end of the day, this is called alien enemies. Why, sir? When this entire case law was happening, World War was going on, UK and Germany had declared each other as alien enemies. And because of that, referring to Indian Contract Act, whenever it's an alien enemy, you cannot go ahead with the contract. On those grounds, this contract was suspended and Company B won the case. That's the case law, Daimler Company Limited versus Continental Rubber Tires. Clear?
Sir, how did Indian Contract Act go to Germany?
Technically, we took that act from them only. Germany no Allah, UK.
Contract Act we took them
Yeah. If you actually read the entire Indian Contract Act, where is Balfour versus Balfour coming? Oh, are these even our name? Carlil versus only Chinnaya and Lalman Shukla versus Gauri Datto. Except that everything because of the, you will be seeing that even in the first chapter also, regulatory framework, case laws also become a valid judgments. Even when you're in your exam, when they're asking you a similar fact, you're using this case law and answering. No, that's what is the significance of case laws. Similar cases would have happened. You're giving this as an example and you're telling we might apply the same scenario because it is already tested. Someone has already done a big argument and the courts have felt this is what is the scenario. Yes, sir. And ours is a complete, our commercial laws have been, or if I have to tell like that, Contract Act, it has a major influence from Britishers, UK. Yes, sir. So next one, to evade tax, Dinshaw Manakji Petit. In short, what happened? There was one person called as Dinshaw Manakji Petit. He formed some 3 dummy companies, and for each of the dummy company, he gave 10 lakh, 10 lakh, 10 lakh. The dummy companies in turn invested in further companies. Example, ITC, Infosys, Tata, Reliance. I am telling simply, that were not the companies which were existing. Now they are performing good. They started giving return to these dummy companies. Now what did this person do? This return is still in this company only. He is only everything. Shareholder, director, employee, manager, everything him only. He took that money again back from the companies as loan. He took it as loan. And he never repaid. His companies only, no? So profits he will take back as loan. And again they will invest. Again dividend will come. Again I will take it as loan. I will never repay. He did it for almost 7 years. Not even 1 year he paid tax. One day Commissioner of Income Tax, when he is seeing, he saw, what is he doing da? Aren't you guys seeing what he is doing? He is evading tax da. Why, sir? The company is earning profits. Correct. Equally they are making losses also. Bad debts. So company is also in loss. He is getting money how? In the form of loan. On loans there is no tax. So they are not paying tax at all. So case was filed. Corporate wheel was lifted. Companies and Dinshaw is one and the same. And the conclusion was made, and it was held that yes, Dinshaw has to pay taxes for all the 7 years what the company had made profits. And this is, you would have seen the case law as Dinshaw Manakji Petit. That's the case law, no? You would have seen as Dinshaw Manakji Petit. Re stands for in the case of. Wherever they say RE means in the case of. This complete case law is called Dinshaw Manakji Petit versus Commissioner of Income Tax. No, that's different. Next one, sir, subsidiaries to act as an agent. What is that, sir? There was one company called as Company A. Now they formed one subsidiary company called as MTL. MTL applied for some license of their lorries. They wanted to work as a cargo company. They applied for license. So the British Transport Commission, just like your RTO officer, they rejected the licenses of these vehicles. When questioned people, they got to know this company A, they were rejected the license because they were not doing the business properly. That's why their license were rejected. So what did they do? Whatever they could not do directly, if they only apply, the British Transport Commission was never going to agree your your license. So what did they do? They tried to apply the license indirectly by opening one subsidiary company. The British Transport Commission found that they evaded, they removed the cloth in between them and they said, sir, A and MTL are one and the same. They tried to evade the direct route. They are trying to do something indirectly, whatever they could not do directly. And in this case, what happened? It was decided that the MTL license was rejected. Clear? Next one, sir. To avoid obligation, workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. What happened in this case law? There was a company called as A. There was another company called as B. Under company A, there were a lot of workmen working under company A. According to the law of the country, there was a rule that whenever a company earns a very good profit, you have to give it in turn to your employees in the terms of bonus. Because of them only you guys are there. Company A had also made some investments in various companies. In that, there was one more company called Company B. Company B was a very profitable company. So every year they used to get dividends. Nice dividends. So whenever dividends come, my profits used to go up. Whenever profits go up, my bonus will go up. One day the shareholders of A thought, hey, why are we giving so much bonus to our employees? Not needed at all. So what did they do? They formed another dummy company called C. And whatever were the shares that they held in the company B, the shares, they transferred the entire shares in the company C's name. They transferred everything to company C's. Now, who is a shareholder in company B? C is a shareholder in company B. Dividends started coming here. And the profits started increasing here only. And what is the effect? The profits started reducing in company A. The bonus also started reducing in company A. The workmen saw it for an year and 2 years and they figured out something is definitely wrong. We know we are working hard and still compared to the past, the profits are going down. How is it possible? So when they filed the case, they got to know they have opened one dummy company, shell company, just to avoid the law. What is the law? The law says that a percentage has to be given as a bonus. To avoid that bonus, they have created this company. And that's the only purpose why they have opened this company. And hence it was decided, they decided to, lift the corporate wheel. It was decided that the company A and company C are one and the same. Nothing else really happened there. Whatever the profits were made by company C, the bonus was to be paid to the employees even on those profits as well. Yes, sir. The last one, sir. Company formed for fraud, improper conduct or defeat the purpose of the law. The case law people is Gifford Motor Company versus Horn. In this case, what happened? There was a company called as Gifford Motors. They hired one manager with a condition clearly written in his agreement, appointment letter. It was clearly written that if at all you leave the company and go for the next 3 years, you are not supposed to do any business which is competing to our business, and you are not supposed to solicit our customers. What do you mean by solicit our customers? Solicit means you cannot attract, you cannot take the customers of our company. This was written in his appointment letter. After 6 months of him working in this company, because of some reasons it did not work out properly, and hence they had to fire the manager. The manager's name was called Horn. Now what did Horn do? Horn came out, he started doing the business on his own. And what is the business he started doing? He started selling the spare parts of the Gifford Motor Company. Now whenever you start selling the spare parts, now imagine people, whenever you have your mobiles, correct? If anything happens to your chargers, what will you do? Will you buy the original charger again? No. 100 rupees, 200 rupees, will I buy it from Amazon? Yes or no? Now technically, don't you think, because of that, Gifford Motor Company customers are coming to whoever is the dummy charger company. You are buying his because you will get it for a less price. The same thing started happening here also. All the motor company spare parts, it can be like alignments, wheels, tires, all that he started selling for this particular motor company. They saw for a while, they wrote a proper warning letter telling him, reminding him, dear Horn, you forgot the agreement between us. You are not supposed to do this because we had a non-compete agreement. You cannot do. Now what did Horn do? They God, I know law better than you. Horn, he incorporated one company. And you know what he did? The shareholders of this company was his wife and his friend. And now what did this company do? The company did the same business, selling the spare parts of Gifford Motors only. Now this time Gifford Motors directly filed a case on the Horn, because even though the company is not yours, the company is being controlled by Horn. Whatever he says is what these people will listen. And in this case also they lift the corporate wheel. It was decided, yes, they both are one and the same. Even though these people are the shareholders, the control is with Horn. Whatever they say, these people are doing. On this case again it was decided, yes, lifting of corporate wheel, Mr. Horn, you're not supposed to do this. And he was told to wind up the business. Yes, sir. That was Clifford Motor versus Horn. Yes, sir. That is the case laws. All case laws very important. Exam point of view, directly they will ask the same facts also and they will ask a question. Remember, case laws are very important. Clear? Next concepts are classes of company. Types of company, people. The types of company can be three types. One is company limited by share, unlimited company, and company limited by guarantee. What do you mean by company limited by share? Company limited by share means whatever is the money we brought in as a capital, our liability is also limited to that capital. Once that liability is coming to an end, once our capital is done, that's all. We are not liable for any other amount. Example, Videocon. We are not taking the assets of the shareholders, right? We try to pay the liabilities from whatever are the assets there in the company. If that is not sufficient, it's a business loss. The creditors won't even get 1 rupee. It's a loss only, that's all. Clear? Pakkana? Okay, so that is called as company limited by share. Liability of members is limited to the extent of unpaid calls, if any. What do you mean by that? If at all I have taken 10 shares and if the face value is 10 rupees, my liability is limited until I pay 10 shares, 10 rupees. Until I pay my 100 rupees, my liability is still there. Correct? Next one, company limited by guarantee. What do you mean by company limited by guarantee? Instead of directly paying the share capital on the initial day, we will not pay anything on the initial day. We will tell that you start doing the business. On the last day, if the company is not able to repay the money, we will pay it from our pocket. In company limited by share, you will give the money to the company, capital on the day one. Because company has to function, right? You will give the money on the day one. In company limited by guarantee, you will give the money on the last day when the company is not able to repay its loan. That is when you will give the money. Who? Shareholders. And such companies are called as company limited by guarantee. Examples of such companies are? What are the examples? Examples of company limited by guarantee are people, nothing but Section 8 companies, non-profit organizations. They will get subsidies, donations, charities. Why do they need capital? Reliance Foundation. There are so many. Infosys Foundation, Reliance Foundation. They get subsidies from you. They get funds from you. Charities. So why do they need capital? So when that money is not sufficient, in such case what you will do? You will repay the money from your pocket. But day one you will tell to what extent you will be liable. Guarantee you will give today only. I will pay up to 2 lakh, 1 lakh, it is your choice. That is called as company limited by guarantee. The third one is called as unlimited company. Now what do you mean by unlimited company, sir? Unlimited company means people, you are telling that my liability will be unlimited. I don't need limited liability at all. And such companies are called as unlimited liability company. Examples we had seen was what? Reebok and GSK, GlaxoSmithKline, Range Rover, Boost to Horlicks, we had seen.
Boost you said, first something you said, no, that you will.
That GSK, GlaxoSmithKline.
What is that?
You know Ippy noodles, Ippy noodles belong to ITC. In the same way, Boost belongs to a company. Boost is a brand. And the brand is ITC. So Boost belongs to a company. Boost is just a brand. Company is GlaxoSmithKline. So whenever you are seeing Boost, Horlicks and all, just turn the turn the box or dabba or something. Somewhere they would have, you will have one triangle. Orange color, in white color they would have written G, it will be something like this. G will be something like this. It will be like this. Only for us people, competitors between Boost and Horlicks, we think are competitors. They both belong to one company only. No, it's simple, no? You can't, in your life, once you start drinking this Boost or Horlicks and all, you would have had Boost for some time, you would have switched to Horlicks for some time. Correct, huh? You would have, because you get bored. So he only created his competitor. You will buy his product of this or his product of that.
Horlicks is kind of sweet milk, sir. Boost is very chocolate.
Chocolatey. So he only gave an option.
Difference.
No, if you are, like if you drink too much sweet and all, you feel like drinking chocolate, then you would switch this coffee.
Okay. So unlimited company, those were until certain point of time. Now later they also became limited liability. Next one, on the basis of control, a company can be classified into holding company, subsidiary company. What do you mean by a subsidiary company, people? For a company to be subsidiary company, 3 conditions are to be satisfied. I mean, not all 3, any one. First one, whenever one company controls the composition of board of directors of another company. Imagine people in company B, there are totally 5 directors. 3 directors people are controlled by company A, meaning whenever they want they can change them, they can appoint new directors, everything is controlled by company A in company B. Then they are telling you company A will be called a holding company, company B will be called a subsidiary company, because you are controlling the board only. That means you are controlling the company only. Next one, what else is a holding subsidiary company? When one company controls more than 1/2 of the total voting power in the other company directly or through its subsidiaries. What do you mean by that, sir? Now imagine there is company A. Company A holds 51% of shares in company B. This is called as holding company. This is called as subsidiary company. Second scenario, imagine there is company A. Company A has one more subsidiary company called company B. In company B, we hold 51%. Now imagine there is one more company called company C. Company A holds 20% of the shares in company C. Company B holds 31% of the shares in company C. Now the question is, company B is definitely a subsidiary company. Company A is a holding company. Now what about company C? What do we call company C as? You need to add 20 plus 31, because A controls B to the extent of 51%. Whatever I say only B will do. Correct? Now I am telling B, 31% I am controlling. B is controlling C. So if I say yes, B will say 31% yes, sir. I will directly say 20% yes, sir. That means I am telling 51% directly yes only, no? They are telling you C will be a subsidiary company of company A. Then the third scenario, sir, there is company A, there is company B. Sir, company A holds 51% in company B. Sir, company B holds 51% in company C. Company A is a holding company. Company B is a subsidiary company. Sir, what about company C? Yes, it is a holding company. It is also a subsidiary company. But whatever I tell you to do, you are telling the same thing to C to do. Technically, I am only telling you what to do. That's the reason you will be a holding company. I will be a deemed subsidiary company. Deemed here means people assumed to be a subsidiary company. Yes, sir. And the last one, sir, deemed subsidiary company. Clear? Subsidiary company, any doubts, sir? Simple? Clear all of you? Okay. The last one, sir, is called as associate company. What do you mean by associate company? Sir, there is company A, there is company B. When one company holds at least 20% of the shares in other company, but which is not a subsidiary company. Meaning what, sir? If company A holds 20% to 50%, any amount between this, sir, in another company, company B is called as an associate company of company A. Again I repeat, sir, when one company exercises significant control over another company, but not a subsidiary company, I am having significant control. How much? Not as much as subsidiary, but I have some control. How much? That some control is 20 to 50%. Now company B is called as an associate company of company A. Understood? Sir, associate company definition also includes a joint venture. Meaning what, sir? There is a example, there is Tata, there is Starbucks. Together they started something called as Tata Starbucks. Now imagine Tata holds 50% here, Starbucks holds 50% here. Now for Tata, what do I have to call Tata Starbucks as? What will you become to me? You will be called as an associate company only. It becomes subsidiary. So joint venture is also considered as a associate company only. Is clear all of you? Pakka? 100%? Understood? Okay, done. Next one, sir. Subsidiary company, associate company. People, subsidiary of, that is important. Remember, whenever I am seeing, whenever there is a government company, subsidiary of a government company will be a deemed government company. In the same way, subsidiary of a public company will be a deemed public company. Remember these two important. So first of all, what is a government company? Simple, whenever central government or state government or central and state or state governments, Tamil Nadu, Karnataka, Andhra, Maharashtra, everyone coming together. If you guys hold at least 51%, do not get confused when you are writing subsidiary and government company. Subsidiary you have to write more than 1/2 of the total voting power. Government company definition only says 51% of the total paid up share capital. Difference is there. Correct? So you will be writing the words 51% only. If it is held by governments, then the company is called as government company. If the government company has a subsidiary company, that is also a deemed government company. Is clear? Pakkana? Okay. Associate company visa subsidiary holding a. Okay. Let us do one thing. Let us see OPC. Or shall we stop it till here? We have another 9 minutes. No, we have MOA doctrines also, no? Okay, do one thing. From associate we'll continue tomorrow. So third one, just remind me of basis of number of members. We'll continue from that. No worries, tomorrow we can do it hardly within what is left? LLP hardly 30 minutes. Negotiable instrument I'll do it detail. I hope you guys want it. Some 40 minutes. This probably another 25 minutes.
So tomorrow as soon as we come we'll start this.
And we'll do LLP, we'll finish it off. Then we'll go to negotiable instrument and then we'll do the regulatory framework.
So tomorrow is the
Last day. 100%.
Why is it so happy?
No, it has to happen, no, because I have. Okay, we'll meet tomorrow. So we'll continue from here. Yes, people. So we'll continue from this topic in the tomorrow. Tomorrow will be the last day. Tomorrow we'll be winding this up and we'll be recording your RTPs and MTPs as well. Yes. So yes, we had done till here. So we'll be starting with on the basis of number of members. So we were discussing about what is that the types of companies. We had done subsidiary company, associate company. We completed government company, and so we'll see what in all are the rest of the things left. So on the basis of number of members, a company can be classified into a public company, private company, and one person company. Now, what do you mean by a private company? Basically, a private company which is defined under section 2 clause 68 of Companies Act, which defines that there are three things that a private company should have. What is that? All three should be there. If not, if these three conditions are not there in the articles of association of a private company, then
the private company, I mean this company cannot be considered as a private company. Now what are those three conditions? Condition number 1, there is a restriction on transfer of the shares. Condition number 2, it limits the number of members to 200. Condition number 3, there is a prohibition from inviting public to subscribe the shares of the company. What do you mean by restriction to transfer the shares? Simple. Now whenever in a private company, whenever there are shareholders, if the existing shareholders, if they want to sell their shares to an outsider, now can they directly sell their shares to an outsider? Can they transfer? There is one restriction. What is that restriction? You cannot directly sell it to outsiders. First you have to offer to the existing members. If at all the existing members say no, only then you can transfer it to an outsider. So the first option should be given to your existing shareholders. If existing shareholder says no, only then you will be giving it to an outsider. That is the restriction. Directly you can't give. The second one, it limits the number of members to 200. Meaning what, sir? The total number of shareholders in a private company cannot be more than 200. The maximum limit that they can have is 200. And in this 200 also, certain people are not included. Who are they? Whoever are the existing employees of the company, if you have given shares to them, they are not included in this limit. And imagine you had given shares to the employees of the company and you had given. Now they left the company and still they are holding those shares. Meaning even after leaving they are holding the shares. That's still fine. You need not count them. So whoever are the employees, whoever were the employees, if at all you have given them the shares, then they need not be included in the limit of 200. And members includes equity as well as preference. So both the shareholders are included. And next one, sir, whenever there are joint shareholders, you need to treat the joint shareholders as one. Meaning what, sir? Just like your bank account. Imagine if 3 people together holds one account or one share or 10 shares, whatever, however they are holding. 3 people hold 10 shares or 100 shares together. When I am counting the total number of shareholders, you should not count them as 3. All of them put together will be counted as 1. Yes, sir. And the last one is, sir, now whenever there is a private company can never issue prospectus. What do you mean by that? You cannot call the public to buy the shares of the company. That is restricted, prohibited. You cannot call. Only your known circle can come and invest. So this is what is the definition of private company. A company which by its articles restricts the transfer of shares, limits the number of members to 200 and prohibits the subscription of shares by public. If 3 conditions are satisfied, then it becomes a private company. Sir, what if even one condition not satisfied? Or all 3 conditions not satisfied, or even one condition not satisfied? If conditions not satisfied, then by default you will be called as a public company. So what is a public company? A company which is not a private company is called a public company. Always remember, what is the minimum number of shareholders in a public company? The minimum number of shareholders in a public company is how much? They online. What are the minimum number of shareholders in a public company? How much? What are the minimum number of shareholders in a private company? How many shareholders has to be there in private company? A private company should have minimum 2 shareholders. A public company should have minimum 7 shareholders. Remember that. Is this clear? Pakkana? Yes. Okay. Sir, now once the public company, if at all you are not a private company, you will be called a public company. If at all there is any subsidiary of a public company, even this, if there is a subsidiary of a public company, imagine if this is a private company, it will still be called as a public company only. So if there is a subsidiary of a private company, it will still be called as a public company only. Yes, sir. So remember that. And the next type of company is called as OPC. Now what do you mean by a OPC? If at all a company is to be called a OPC, there are 3 conditions that are to be satisfied. Condition number 1, OPC can be started by only a natural person a person should be a natural person. What do you mean by that? One company cannot start another OPC.
So can I hold the 100% of the shares in another company and can I call it as a one-person company? Not possible. It should always be an individual. Remember. Next one, sir. And the person, whoever is forming the OPC, this benefit is given, one-person company, this benefit is given only to Indian citizen. So if there is a foreign citizen, imagine, sir, this, what is that, Maxwell, Duplessis, all these people are coming, no, can they come and start a OPC in India? It is not possible. And see, all conditions are to be satisfied. The third condition is whether that person has to be resident. And there was an amendment, people. Now they say whether you are a resident or not, meaning resident or otherwise, you can still start a OPC in India. So, sir, now three conditions to be satisfied. Now the third condition is almost technically not relevant at all, because they have only put a condition saying resident or otherwise. So, you have to be an Indian citizen, you have to be a natural person. Whether you are resident in India or not, you can start a OPC. So, to be a resident in India, what are the conditions I need to satisfy? If you are to be called a resident in India, you should have stayed in the preceding financial year for a minimum period of 120 days. Imagine if at all you want to start a OPC in the year 24-25. In the year 23-24, the person should have stayed in India at least for a period of 120 days in the financial year. If at all you do this, people, then you will be eligible, or you will be called as a resident. That was the whole purpose of the amendment. But what did they do? They added one more word also called resident or otherwise. So because of that, this condition almost becomes negligible. So it is not relevant at all. When you are writing in the exam, you have to write completely. Resident in India or otherwise. Resident means a person who has stayed in India for a minimum period of 120 days. This entire condition has to be written. Remember that. Yes, sir. Okay, next one, sir, there has to be a nominee. Sir, who can be a nominee? To be a nominee, is there any eligibility criteria? Same thing, whoever can be a shareholder, they only can be a nominee. All the conditions again has to be met. Clear? Sir, at one given point of time, one person, in how many OPCs can he a member? In how many OPCs he can be a nominee? At one point of time, he can be a member in one OPC and he can be a nominee in another OPC at one point of time. Remember, for your OPC, you only cannot be member as well as nominee. That is not possible. But you can be a member of this OPC, you can be a nominee of another OPC, that is fine. However, you guys can have a question, what? At any point of time, how many OPCs can I be a member of? The maximum is one. You cannot be a member of more than one OPC. Sir, what if wherever I am nominee, what if that shareholder dies? Tomorrow I will only become the member? No. In such case, you will have to decide between the two OPCs in which OPC you want to continue as a member, and in another OPC you will have to resign. That is the total condition and criteria. Now what do they say? See here. One person can be member and nominee of not more than one OPC. However, if at all there is a breach of condition, it is to be satisfied in 180 days in the case of violation. What do you mean by violation? In any point of time, if you become a member of two OPCs, then you will have to quit one. That's the meaning of it. Clear? Okay. And you guys will have this doubt also. Sir, you say I can be a member of one OPC, I can be a member of one nominee. Can I be a shareholder of other companies, private, public? There is no limit. You can be a shareholder of any number of public companies, any number of private companies. There is absolutely no limit. When it comes to OPC, only one OPC is possible. So remember that. Next one, it cannot be converted into a Section 8 company, not possible. And not only that, a OPC cannot undertake NBFC activities. If you remember, we would have discussed in the class. What do you mean by NBFC activity? Non-banking financial companies. What do you mean by that? Non-banking financial company means, imagine Muthoot, Manappuram, all these are NBFCs. They are not banks, but they are doing financial business. One person company can never do that non-banking financial company business. They can convert it into any other type of company at its discretion whenever they want. So today I am a OPC.
In next week I decide I want to convert myself to a private company. Can I convert it? Yes, possible. There is no restriction. Sir, can I appoint a minor as a nominee? No, not possible. A nominee should be a major. Sir, can I change my nominee any given point of time? Yes, you can change your nominee any given point of time. Sir, can the nominee only resign from the OPC? Yes, possible. Nominee also can resign. Basically, he can withdraw his consent any given point of time. If they ask you regarding OPC, these are the maximum questions they will ask. You'll have one question, under that there will be 3 sub questions. It will be somewhere revolving around this only. Clear? Okay. Next we saw government, OPC, public companies done. Okay, next one is other type of company. Government company we did know, minimum 51% of paid up share capital. Do not get confused between this and subsidiary company. Subsidiary company says more than 1/2 of the total voting power. That's the definition. This says 51% of paid up share capital. See, they have given you the percentage only. You cannot write 51% in subsidiary company. That's an example. Technically, if you see, it says more than 1/2 of the total voting power. How much is 1/2? 50. What do you mean by more than 1/2? Now, this becomes even a subsidiary company. But we will never look into it in that way. Because what happens, that means the other person has 49.9999. This person has a majority, no? Yes or no? That's how we generally see it. But because in general, this is a percentage, not shares. You cannot have a fractional share. You cannot have half share, 0.1 share. That's why popularly when examples are given, it becomes 51 and 49. That's the main reason about it. Nothing else. Clear? Okay, next one is foreign company. What do you mean by foreign company? A company which is incorporated outside India and it has a place of business in India. Then it will be called as what people? Foreign company. Now what do you mean by that? Let us imagine there is a company called as Google. Okay, now is Google present in India? The answer is yes. They are physically only present. They have an office only. Next one, there are some companies like Alibaba and all. Now is, which one?
You have given Shein as an example. SHEIN.
SHEIN. We had seen the example of that company only. Yes. So now imagine there is Alibaba. Sir, is Alibaba having a physical office in India? I doubt. I don't think they have. But can you buy products from Alibaba? Yes, you can. How, sir? Their website is accessible in India. You can buy the products of Alibaba being in India. Now people, for us, Alibaba becomes a foreign company. It is registered outside in India, but it has a place of business in India. What do you mean by place of business? They are having some operations in India. They are carrying on some business, sir. Only then you will be called as foreign company. Imagine there is company which is incorporated outside India, XYZ. They are not doing anything in India. They will not call them as a foreign company. For according to Companies Act, they are not foreign company. In our general scenario, in English language, they are a foreign company because they are registered outside India. But for Companies Act, it won't be considered foreign company. According to Companies Act, if a company has to become foreign company, you should be registered outside India and you should also be operating in India. Both conditions to be satisfied according to Companies Act. Got it? Okay, yes sir, done. So, whether physically or in electronic mode. So, this is a physical office, this is a website or Instagram or whatever you sell. The next condition is people, Section 8 company. Now, what do you mean by Section 8 company? A company which is formed for promotion of charitable objects, commerce, art, education or research or sports, etc. So basically what do? Their intention is not to make profits. They will have income. They will earn a lot of income. But that income, they will not take it home. They will put it back into the business only. They will, whatever they started the business for that only they will continue the money for. Now for best example, if I have to tell you, there is one company called as Reliance Foundation. They will be doing, this, what is that? Recently they started one thing also. Vantara. Have you guys seen that Anant Ambani? He's Ananta Akasha. Anant only, no? Anant Ambani wedding. You saw one, he gave an interview also. That elephant rescue thing, jacuzzi and all is there. It seems elephant massage. You can see that he will only eat that food. Food prepared for elephants. They are preparing food. Watermelon juice and all they are preparing. Okay. So now imagine Reliance Foundation is a Section 8 company. Now there will be lot of donations that Avantara will be receiving. See, first of all, they only have money. But there are people. Now on that day, Bill Gates came there. Mark Zuckerberg went to Avantara. Don't you think they would have given 100 rupees? Take the macha, you also keep. Don't you think they would have given? Probably few people might have donated some machineries also. Some probably that elephant operating, something they would have donated. Now, don't you think all these are income? Now, can Anant Ambani take it home? Hey, give the, I'll also take it as my company. That's what they say. You can accept money, you will have income, but you have to put it back into Vantara only. You cannot take it and do Kantara out of it. So, you have to put it back to the business itself, is what they are telling you. Is this clear?
That's the whole point of him keeping pre-wedding in Jamnagar.
I don't know, no controversy. Clear, yes, So, but that's what at least they have money. They're doing at least something good. Let them do. You saw that video, no, where Mark Zuckerberg says, nice watch.
Yeah.
Then that watch is around 17 crores. They have money, what to do? 17.
My watch is 700.
That's all. That's how it is. They have money. What to do? Probably.
What different watch the same time it will show?
No, there is one. Ronaldo, in one of the interview, he has said, your watch also shows the time. My watch also shows the time. But your watch says what are you? My watch says what am I? Meaning success is defined. Time is same. But in which watch you are saying defines success. Ronaldo says it seems. Once achieved everything they will say. Before achieving they have to say all this. One thing I will be telling it to students also. Sachin Tendulkar did not clear his 10th. He is a 10th dropout. Sir, Sachin is 10th dropout, sir. In 150 crores, one person is a 10th dropout. And rest of 100 crore people have passed 10th. Once he achieves something, he will tell 100 things. I am not accepting what he is saying. I am not discouraging what I am saying. What I am saying is, once you prove, you can tell anything. That becomes a message to the world. Now what Sachin says is true for the very passionate cricketer. I will not do anything. Morning I will wake up in the ground only. That is for such people. Idu illa. Sachin did not tell you, promote you to go and play gully cricket. He is telling, play professional cricket, then it is worth. Yes, but we will take only half message. Sachin did not clear 10th. Then we will also become successful. That's not how the life works. Okay, the question will be asked here, people. These two are important. They can ask you a question here. What? Can the Section 8 company earn income? Yes, they can earn income. Then what are they prohibited? They have to put it back into the business only. That means what? They can ask you one big story. The shareholders of a Section 8 company, they are demanding for dividends. Should the company pay dividends? The answer is no, because a Section 8 company is prohibited from paying dividends. Remember, that point can be a questionable point. That is where they will ask you also. Next one, it operates under a special license given by the central government. So central government, to open a Section 8 company, today they need to have one special license given by the central government. This license will be given if at all you are worth. If central government feels no, you do not have a prospect or your intention is not right, central government is not going to give you the license. Sir, if section is contravened, now what is that? Special license is given. Now imagine after 2 years, people, you started contravening, violating the sections. Now what will happen, people? If at all you violate the section, whatever is a license given by the central government, I have a power to give. I have a power to take it back as well. That's what they have given. If at all there are any provisions that are contravened, violated, it shall be revoked. What? License shall be taken back. And central government may pass an order for converting its status. Meaning you are a Section 8 company. You want to earn profits, right? Convert to a private company. Wind up or amalgamate with another similar objects. A Reliance Foundation, merge with Infosys Foundation. You are not able to carry on business properly. At least he is doing it properly. You just merge with him, he will carry on.
So the central government can order for any of these things. Next one, all the public companies, private companies and all, they will have to use the word private limited in its name. If you are a public company, you should have a word limited. If you are a private company, you need to have the word private limited. If at all you are a OPC, you need to have OPC private limited. If at all you are a Section 8 company, you need not have these words, then you need to have Chandan Baro. If at all you need not have these words, then you need to have one word. And what is that, sir? Instead of private limited and limited, you can have the words like foundation, you can have the word like federation, or it can be any such other thing. So instead of the word limited or private limited, these words can be used. Yes, sir. Come this side only, da. Yes, sir. Sir, remember, if at all you are an LLP, you can use the word LLP in your name. This is mandatory. So these are mandatory whenever you are naming your companies. Yes.
What is the main difference between an NPO and a Section 8?
NPO is basically a non-profit organization which is just a tag a society uses. Meaning, I want to do a business, not a business. I want to carry on an activity which is not for profit. Okay. Now, how and all I can do? Now, you have to play cricket. Where and all you can play? You can play on a ground. You can play in your home. You can play in gully. You can play in road. You can play near your home. You can play in all these places. But cricket is common. Your intention is common. How you are doing that intention is differs. Example, non-profit organization is your intention. Meaning I should not earn profits. In India, you can do this type of activity in three ways. One in the form of company, Section 8 company. One in the form of society. Society, example is BCCI, Board for Cricket Council of India. What is BCCI? Your Indian Cricket Board, it's a society which is registered under Tamil Nadu Societies Act. It's a non-profit organization. Non-profit, we are richer than ICCA. Non-profit organization. What do you mean? They are not earning profits, they are earning income. Then where are they giving it back? When World Cup was hosted in India last year, each stadium in India was given around 75 crores towards development. Because you are hosting an event, no? 75 crore for each stadium. Don't we have 10 stadiums in India, na? 750 crores were given. Where did you get it from? I'll tell you where you get it from. In 2 IPL matches you get. 1 IPL match revenue is 350 crore. How? Why? You see where and all advertisements come. One slot of advertisement costs very hefty amount. Very, very hefty amount. Well, okay. For example, I'll tell you one thing. Now, who is the title sponsor of IPL? Tata. You call it as Tata IPL, Just to put the word Tata, how much did they pay? How much do you think they would have paid? I am telling you everything in public domain, nothing here and say. 100?
Why not
10,000 crores? People, title sponsors, they have paid 24,000 crore. This is the title sponsor, just to use the word Tata. What do you think is the streaming rights? Streaming rights means Jio has purchased, no? How much? 20 plus crore, 20,000 plus crore, that is the money. Then why do you think all Pat Cummins, Mitchell Stark, they will forget their country? In spite of having World Cup, T20 World Cup, why do you think the international players are still here only? Money will speak everything. Pakistan Cricket Board, basically the players are very jealous on one point. This is the point. Even a gully cricketer who is playing IPL, you know the names. If you guys are watching IPL, who and all have come da? Rinku Singh. Where was Rinku Singh today? Already he got a house. Rinku Singh already got a house. Then Prithvi Shaw recently moved to a house. Delhi cricketer Prithvi Shaw. He has once played to the country, that's all. And his house is around 17 crores. Once he played. Where is the money coming from? Imagine, I'm talking about, these are just normal players who are playing in our cities. Then imagine, all over the world, everyone is earning money. Don't you think the country next to you will feel jealous about this? Shoaib Akhtar has told this in multiple interviews. multiple interviews. Because the one thing that is not there in that board is money. And look at this. With this you can train one team only. Yeah, so like that. Understood? Yes, BCCI is a society. The third type of NPO is trust. Biggest example, this one will just shake.
BCCI is only
I'll tell you, richer than BCCI.
what is this?
Tirumala Tirupati Devasthanam, trust, TTD. No, that's a trust. How much money? So, even the Ananta Padmanabha Swami also. 18 feet gold chain is there in that treasure, one of the, this one. I'm just telling you all the facts, that's all. It's,
Is it true, sir?
yeah, it's all in RTI, no? People, if I say, there is nothing here and say. Being a law teacher, I cannot say, nam tata helidru. I can't say that. I have to say whatever are the facts. And I always refer to RTIs because RTIs is always given by the concerned person. So if you file it a request to the concerned authority, the authority will give you the information. So RTIs are the most authentic informations because it is given by them. And not everything given in Google also is right. That can be wrong also. So try to take the authentic information, that's all. Yes, okay, done. So these are the types of companies. Next one, people, is incorporation of a company. How do you incorporate a company? First of all, you need to have minimum number of shareholders. OPC 1, private company 2, public company 7. Now you guys have to come together. You have to fill certain documents. Like there is one main form for incorporation. It is called as SPICE Plus. Simplified Proforma of Incorporating Companies Electronically. I will have to fill this form. I will have to file this with ROC. Along with this form, what and all I have to give? I have to give ID proofs, address proofs of my directors, my shareholders. I have to give the capital of the company. I have to give the objects of the company. I have to give MOA. I have to give AOA. I have to also get a declaration from a professional. Who is that professional? The professional can be CA, CS, CMA or an advocate. They have to sign your form. Until they sign the form, ROC will not accept this form. This is where you guys will mint money. And this, the entire process is called as incorporation of a company. If at all ROC is satisfied with whatever details you guys have filed, ROC is going to issue something called as a document that is called Certificate of Incorporation. In Certificate of Incorporation, what will be there? Name of the company will be there. SIN, corporate identification number, like a roll number given to the company which is unique, and there will be PAN of the company, and also there will be date of incorporation. Whatever is the date mentioned here will be considered as a evidence for the date of incorporation. That's basically like a birth certificate of a company. Yes, this process is called incorporation. Okay. Next one, sir. When a company is incorporated by furnishing incorrect details, meaning imagine whenever I am filing, I have given a fake Aadhaar card, fake PAN card. Can we do it? Yes, people do it. And that's only called as shell companies. Sir, shell companies means people, there will be no activity. The purpose of you running this is basically to do money laundering. What do you mean by money laundering? There will be no purpose. Simply you will be doing, you will be rotating the money, or you will be trying to finance terrorism, things like that. So, things like that, people will give fake details and they'll open a company. If at all any given point of time, the court gets to know about it. Court here is tribunal. If at all the tribunal gets to know about it, the tribunal can pass certain orders. What is that? Hey, you have given all incorrect details and you have formed a company. That's the reason you guys have to do any of these things. What is that? First one, I can pass an order for regulation of the management of the company. Hey, you board of directors, you guys come down because you guys are all fraud. I will replace the board with my own board. Who says? The tribunal says. So the entire board will be replaced. Next one, I can also make changes in MOA OA. I felt you guys have done something wrong in MOA OA. I can make changes to MOA OA. Or liability of the members shall be unlimited. You registered yourself as a limited liability company. I can make your liability as unlimited. Or I can direct the removal of name from register of companies, meaning your name will be struck off. That's all, your company comes to an end. Or I can even order for winding up the name of the company. Sir, here also company is coming to an end. Here also company is coming to an end. What is the difference? This happens whenever the company has not yet started operations. Simple, one line, strike off, done, that's all. This happens whenever the company has started the operations. There are some assets and liabilities. Then the company has to get into liquidation. They have to sell all their assets. The process is a little huge. And the last one is such other order as it deems fit. Tribunal can pass these orders. Agreed? Okay. Next one is types of shares. The shares can be classified into two things. One is called as equity share. Next one is called as preference shares. Equity shares can be further classified into two things. One is called as equity shares with normal voting rights. Equity shares with the differential voting rights, popularly called as DVR. Now, equity shares with normal voting rights. What is this, sir? Generally, people, one share is equal to one vote, and they can give the percentage of dividend also as the company deems fit. Like one share can be giving you 1 rupee as dividend. I'm just giving you an example. So when you enjoy one share is equal to one note, and one share is equal to whatever is the percentage of dividend decided by the company. Such a share is called as a normal equity share. The another type of share is called as DVR. DVR stands for differential voting rights. What is the benefit of it? I'll give you my example. Now there is a company called as Tata Motors. Now in Tata Motors, people, the number of shares in Tata Motors are in crores. Hundreds of crores of shares are there in Tata Motors. Now the maximum how much I can own, people? 100, 500, 1000. I'm telling you there are 400, 500 crore shares. My 100 shares, what impact will it make? So my voting is of no use at all. So with that intention, what did Tata do? Tata first issued Tata Motors shares only. First they came up with equity shares. Later in the year 2007, they realized a normal equity shareholder like me is not at all getting benefited. So they introduced the first concept of DVR, and that share is called as Tata Motor DVR. Now today this share is also listed on stock exchange. This share is also listed on stock exchange. I hold somewhere very minimalistic shares of this also. I hold shares of this also. Now whenever a voting is coming, now I will have one share is equal to one vote here. Whereas when I have Tata Motor, for me the number of shares, 5 shares is equal to one vote. So even to exercise one vote, I need to have 5 shares. If I have 4, I will not have voting rights at all. So that's even more loss, no? Now whenever dividend is given, here when I get 1 share is equal to 1 rupee as dividend, here I may get 1 share is equal to 1.5 rupees as dividend. I'll get more when compared to a normal share. So for giving me more dividend, they are reducing my voting rights. And that is the beauty of DVR. Differential voting rights. Clear? So Tata Motors was the first company.
You've told no, sir, 5 shares is equal to 1 vote. So it depends on the company. What they put.
Correct,
suppose
yes.
For a few companies, 100 shares is equal
So the maximum you can have is 10 share is equal to 1 note. It cannot go beyond this. That's the maximum cap given under the law. Clear? Yes. Sir, next one, sir, is called as preference share. What do you mean by preference share, people? The word preference only means what, people? I prefer you over someone. So there is a priority that has been given. Now, what do you mean by preference here? Now, now there are two types of shareholders. One is preference shareholder, one is equity shareholder. Now, why did we write preference first and why are we writing equity next? Because we are giving a priority for this shareholder. Sir, priority in what? You will give priority in two things. Whenever every year you are paying dividend, the first dividend will be paid to him, called preference dividend. After paying him, if there is still money left in the company, then they will pay to equity shareholder. If at all there is no money left after paying preference shareholder, equity shareholder may not get dividend also. So this is the first priority they enjoy. Second priority is at the time of repayment of the capital, at the time of winding up. Imagine the company is about to shut down. There is the money we need to repay to everyone. After paying everyone, now there are two people left. One is preference, one is equity. Now if I have to repay, whom should I repay first? I can only pay to one person. Now whom can I pay? You have to first pay to preference. Now after paying to them, if there is no money left, then equity will not get the money. So the priority is always given to the preference. That's the reason they are called as preference share. You are giving them a priority, preference when compared to a equity share. That's why they are called as a preference share. That's clear?
So preference shares will not be given to the public, no, sir?
Need not be always, it can be issued also. For a listed company, they will issue. But they are not very, very popular. Not every company will issue. That's the basic difference between. The reason is it is hard to maintain another class of company for, from a company's point of view. Just because I've given you preference dividend, I will be under an obligation to pay you dividend every year. Instead of that, I can even take debentures, no? There also I need to pay interest. At least I'll get tax benefit there. Dividends will not allow me tax benefits. After paying tax, whatever is the profit left, on that a dividend is issued. When you guys come to your next level and all, you will see net profit after tax, you will be having calculations. So you will get the main difference between Y debentures, Y shares. Yes, sir. Okay, done. Next one, sir, company's documents. There are two main documents of a company. One is called as MOA, one is called as AOA. MOA generally has 6 clauses. If you are a OPC, you will have 7th clause also. Now, what are the 6 clauses? The first clause is called as name clause of a company. The name clause signifies the name of the company. Basically, what are they signifying? They will be signifying whether it is a limited, private limited, public limited, OPC. Looking at the name, you will get to know. Next one is registered office of the company. Basically, this signifies the state where the company is situated. So why do we write this situation clause? To know the jurisdiction. Imagine if company does wrong. Infosys is present in more than 30 places. More than 4 countries Infosys is there. If something goes wrong, where should I go and file a case? You have to file a case where the company has its registered office. Now how will you know where it has registered office? That is how you will know. Karnataka. So you will have to file it in High Court of Karnataka. You cannot go to any other court in entire India. Pune it is there, Hyderabad it is there, but you have to come to Karnataka, wherever the case is. Clear? That's the main significance. Next one is object clause. Object clause signifies what a company can do. If at all in the object clause you have not written something, then the company cannot do that activity. Next one is liability clause. Liability clause says whether the company is a limited company, unlimited company, or a company limited by guarantee. And the next one is capital clause. Capital clause is nothing but what is the maximum authorized capital of the company beyond which a company cannot raise. The next one is called association clause. It's nothing but what does the first shareholders, when they are filing incorporation form, Spice Plus, they will be telling ROC, we will be buying 7 shareholders or 2 shareholders, or as the case may be, private or public. Now let us imagine public company, 7 shareholders are there. Each of the shareholder promises to take 100 share or 10 share or 1 share or each. Where will that be written? It will be written in the last page of MOA, and that is only called a subscription clause. So you are promising to ROC that we will be taking these many shares. Just for your information, I am telling you, in the life of the company, if there is one clause which will never be changed, that is your association clause. What the company started, that will be the constant one. It will never get changed. It will always be same. So even today, if you look at MOA of Infosys, 1981 registered, it will still have that day 7 shareholders who started Infosys. You will not have today's shareholders' name. When they started, who and all promised to take how many shares, that will be the name. And who are those people? All these people only. Narayan Murthy and Nandan Nilekani, the current managing director of Infosys. So all these people are the founders of Infosys. And in the case of OPC, you will also have nominee clause. Only in the case of OPC. Next one is called as Articles of Association. What is Articles of Association, sir? A company which is an internal document. What is the difference between MOA and AOA? MOA is for the external parties, AOA is for the internal parties. Basically, it talks about the rules and regulations of the company, how the company should function internally. For your directors, what are the rules? For your shareholders, what are the rules? Imagine whenever there is forfeiture, calls we will make. Within how many days you need to pay? Within how many days you need to pay? If at all you don't pay, what is going to happen? Forfeiture, notice of a meeting, how many days notice has to be given? All that will be written in the Articles of Association. Sir, now we have a doubt. What? is there any minimum thing which we need to write in our articles of association? Yes, minimum thing is prescribed in the Companies Act only. Example, imagine if you are calling for a general meeting, you have to give a 21 days notice. Where is it written? It is written in the Companies Act only. So in your articles of association, you can write 21 days. Yes, you can write 21 days. Sir, I have a doubt. Can I do it as 19 days in my articles of association? Can I write it instead of 21, which is given in the Act? Instead of 21, can I write it as 19 days in my articles of association? Now Companies Act says you have to give minimum 21 days notice. For my company, can I make it as minimum 19 days notice? Possible, huh? Yes. Second question, can I make it as minimum 24 days notice?
No.
What is not possible? What is possible? Or both are not possible?
It is not possible. 19 is possible.
24 is not possible, 19 is possible. Agreed? Yes, yes, people. Exactly opposite. 24 is possible, people. 19 is not possible. Why? Logically think. Your exam, CA, passing marks is 40. Can I say in the class, if you have to pass, you have to score 45. Because if you get this, you will get this also. Imagine in the class if I conduct your test for 35. If you get 35 here, will you get 40 in the exam? What logic will that be? No sir, we didn't get that. Law says you need to give minimum 21 days notice. Minimum 21 days. Now when I say in my MOA that you have to give, in my AOA, if I have to say you have to give minimum 24 days notice, am I covering what the lawmaker has said or not? Lawmaker says give minimum 21. I am telling you give minimum 24. 21 is covered, no?
Yes, sir.
Now if I say 19, is 21 covered? That means you are going against the law. Remember, law has put an arrow mark. You can increase the arrow mark. You cannot put a ulta direction. This is not possible. That's what you guys would have seen, which document is superior. The first circle comes is always AOA. The next circle that always comes is MOA. The next circle that always comes is Companies Act. Meaning AOA should always be within MOA. What do you mean by that? Imagine my MOA says that we are an education business. Your articles of association rules should be supporting your education business. You can't write rules for finance business. The superior document is MOA. AOA should be subordinate to it. So our MOA says object. Now can I write something? You can write anything but which is legal, which is given under Companies Act. So all of this should be under Companies Act. Sir, now whatever you said, you can make 21 days as 24 days. What is this process called? This process is called as entrenchment of articles. What do you mean by entrenchment? Entrenchment means making the provisions applicable to the company stricter than what is given under the law. Law says follow this much. I am telling you, you have to follow this much. Is it allowed? Yes, allowed. But you cannot do or you cannot give what is less than given under the law. You can give more than what is given under the law. Understood? Pakana. So remember, entrenchment provision important from your exam point of view. Yes, sir. You can expect a question there. Okay. The next one, sir, doctrines. Yes, sir. There are three doctrines, people, that are applicable on the company. One is called as doctrine of ultra wires, doctrine of constructive notice, doctrine of indoor management. Now, what do you mean by doctrine of ultra wires, sir? Doctrine of ultra wires means very simple, people. Now, if my object clause says that you can do education business. Now, a company, whenever the object clause says what you can do, that means your scope is defined. You cannot go beyond what is given in your object clause. That means, sir, can a director go and, okay, there was a case law, the case law is called what? Ashbury Railway Carriage Company versus Iron Company versus Ritchie. In this case, what happened? A company is technically into manufacturing and supply of railway parts. There was one more person who came from a place called Belgium, and this person name is called as Ritchie. Now Ritchie comes from Belgium. Ritchie goes and asks the company called as Ashbury Railway Carriage Company, can you guys give me money? I will also go and start one railway platform in my country as well. Can you please give me money? Ashbury Railway Carriage Company said, yes, you have to give us some percentage as profit every year. If agreed, then we will agree to give you the money for construction of your railway thing. So they entered into a contract also, who the directors of Ashbury Railway Carriage Company. But their object clause says that they can only take up manufacturing and supply of railway related parts. That was a contract. Now what happens, sir? After some days, they went back to the shareholders. The shareholders said them, whatever you guys did is not right, because you guys do not have the power to sign this contract. The director said, who told you we do not have power? You have authorized us to do any activity up to 10 crore. We have agreed to give them only 5 crore. It is within the power you have given to us. But the shareholder said, yes, the money is within. But why you gave the money for? That you guys do not have the power. In the object clause, we have said you can do only railway related manufacturing or supplying related business. What is the agreement you entered with Richie? The agreement you guys entered with Richie is what? This cannot be considered as railway, even though it is for construction of railway. We can only supply railway parts, manufacture railway parts. But what did you do? You guys agreed to give loan. Loan is what? Is it a manufacturing company? Loan can be given by a finance company. Are we bank? The answer is no. So are we allowed to give finance? The answer is no. Why? Because your MOA does not allow you to do. On these grounds, it was held that people, whatever the company signed, directors signed the contract, no, that contract was considered as ultra vires. Is the company liable for this contract? The company is not liable for this contract. The contract will be considered as null and void. Now you guys can have a question, sir, Papa knows, sir, Richie, why should he bear the loss? Remember people, company will not be liable. If Richie wants, Richie can file a case on the board of directors of the company. Whoever signed the contract, he can hold them liable. Understood? Pakka na? 100%? Okay. That's called as what? Ultra wires. So, now sir, we have a question. What? One day what happened? People? They entered into a contract, they entered into a contract, the same directors only, let us imagine. They entered into a contract for manufacturing of railway parts only. They wanted to buy some raw materials. The raw materials were available for a very cheap price. So they entered into a contract and the contract value was 15 crore. And how much they were authorized to do? They were authorized only to take up 10 crore. Now tell me, whatever is the activity they did, is this valid? No. But can this be made valid?
If it is severable?
No. Can the shareholders come and make this act valid?
No, they cannot. There is no ratification.
Ratification is possible?
No.
Okay, remember, there are two things. Ratification. In MOA, there is two things. Ratification. What is that, sir? Whatever is ultra vires, the company cannot be ratified by the shareholders. However, on other hand, if at all it is ultra vires the directors, but intra vires the company. In this case, it can be ratified. It can be ratified by the majority of shareholders. Understood? So this is the rule.
Can you give
Examples,
examples?
sir. Now, according to the MOA, what a company can do is defined in a MOA only. So in our MOA, we have clearly written that we can only take up education related business. If the director goes and enter into a contract for finance related business, does our MOA allows us to do? It is beyond the power of the shareholders. It is beyond the power of the company only, because for the company's data you have written, you cannot go beyond this. You have intimated this to ROC, we will not do anything beyond this. So it is beyond the power of the company only. Shareholders also cannot change this activity. Whereas on the other hand, the directors were authorized to do anything up to 10 crores for railway related business. But what did they do? They got a very good opportunity for railway related business only. They took up a contract for 15 crore. Now, for what business it is? Railway related. Is it within the company's power? Yes, sir. Now the shareholders can say, if it is beneficial for us, we will ratify this. The contract will be made valid. If at all the shareholders wants. If at all shareholder says, no, this is not beneficial for us, shareholders can deny the contract. Now you can again take it. Is it separable? If separable, up to 10 crore company will be liable. For the 5 crore, directors only will be liable. Company won't be liable. However, it can still be ratified. Is clear? Pakkana? 100%? Okay, done. Remember that is important. Next one is what is doctrine of constructive notice. Now in this case only, Richie said, sir, you are saying that this ultra wires or intra wires and all, how will I know, sir, what a company can do and what a company cannot do? How will I know? The company law and ROC said, hey, what are you telling da? Don't you know that there are something called as public documents? All the documents of the company are considered as public documents. You can view it whenever you want. Whether you have read it or not is none of my concern. But because it is available in the public domain, ROC always assumes, courts assumes that you know what is there in the MOA. You are assumed to know. That is the beauty of the next doctrine. That doctrine is called as doctrine of constructive notice. Meaning what? Whether you read it or not, we assume that you have read that particular content. Understood? Pakkana? Sir, in the same way, the last case law is called as doctrine of indoor management. What is the case law? Royal British Bank versus Turkand. So in Turkand's case law, popularly it is also called as Turkand's rule. What happened in this case law, people? A company had written in its articles of association as, my company's board of directors can borrow such amount of money as authorized by the shareholders in the general meeting. How much ever we have authorized, that much the board of directors can borrow. So one day what happened, the board of directors of this company, they went and they asked Royal British Bank for some loan. Imagine they borrowed $10 lakh as loan. Now the tenure was 1 year. After 1 year they said we will repay. So after 1 year, when the Royal British Bank went and asked for the money, the company said, we are not liable to pay this $10 lakh. Why, sir? Because what was authorized in general meeting. We said no, the directors can maximum borrow whatever is authorized in general meeting. In the general meeting, what was authorized? In the general meeting, only $5 lakh was authorized. We never gave them the power to borrow $10 lakh. Though why did you give? The bank said, hey, if you guys close the four walls, close the door, and inside if you guys authorize something, how will we know? If you guys wanted to safeguard yourself, you guys should have put it in your articles of association. You should have put it as $5 lakh only. Why to put as much as authorized in the company's meetings? So you only deceived me. So in this case it was held correct. Whatever Royal British Bank is telling is true. The outsiders are never allowed to attend the meetings. They are not allowed to come within these four walls. So what happens within the four walls? Outsiders cannot be held liable, and that is only the rule called as doctrine of indoor. Within the door anything happens, outsiders are not allowed. So this is called as doctrine of indoor management. Always remember, in constructive notice, company will be protected from the outsiders. In doctrine of indoor management, outsiders will be protected from the company. Correct? Any doubts? However, this doctrine of indoor management has three exceptions. One is actual or constructive knowledge of irregularity, meaning if anyone knew that there was restriction, you still give the loan, then there will be no excuse, you will be liable. Next one, suspicion of irregularity. Use your brain a little. If you think something is not fine, then do not do the contract. The case law is that only, Anand Bihari Lal versus Dinsha and company. In this case, what happened? An accountant sold the property of the companies, land of the company, accountant sold. Now I'll come and sit, I'll sell this laptop. Will you guys buy? You need to know whether company's property. As a teacher, do I have a right to sell? Imagine I'll come and sell this book is for sale. Believable. I'll come and say this laptop and TV is for sale. Not believable. Your mind should work. That is what they're telling you. Suspicion of irregularity. You should feel something is not fair. The third one is called forgery. Always remember, forgery will never give you a good right. Remember, I'll connect this point again when we are doing in negotiable instruments also. Forgery will never give a good right. Yes, sir. Case law, Reuben versus Great Fingall. In this case, what happened? A person applied for the shares. A secretary took the money, he went into the cabin, he forged the signatures of directors. In this case, it was held, no matter how genuine the case is, in forgery, it will never give a right to the opposite person. That is what was decided in this case law. Clear? Yes, sir. So that is your Companies Act. Any other doubts, sir? Any other doubts, sir? No? Done now? Okay. So that's your company law. Let's do LLP. Okay, that's the last corporate law. We'll finish off the corporate law. Okay. Now, sir, what do you mean by LLP, sir? We'll see that. Now, we have done Indian Partnership Act also. We have done Companies Act also. Now, what started happening, people? The people whoever are running partnership, they started saying, sir, the company people are enjoying so many benefits, sir. For them, the law is so much beneficial. For us, the law is not at all beneficial. You are playing a completely unfair game. What you are doing is not at all right, sir. You have to give us also flexibility. What partnership people started fighting against the company. Company people also started fighting against the partnership. Sir, they have so much flexibility. You will not govern them at all. There is no regulator at all. Their documents are not public at all. They have so much of privacy. So these people started complaining against them. So everyone started saying dikkara, dikkara. So what did the lawmakers do? The Ministry of Corporate Affairs, they took a mixie jar. They put the partnership into the mixie, company into the mixie. Garra, garra, garra. What came out is called LLP. What is LLP, sir? Name itself signifies in the year 2008, a new type of entity that was formed, and that is called as Limited Liability Partnership. Name itself has two components in it. One is limited liability, which was taken from company form of business. The next one is called partnership, which was taken from partnership form of business. Now you guys tell me, what is the difference between partnership to LLP company? If you tell this, you can write this in all three places, because difference between is given in LLP also, Company Act also, and Partnership Act also. So say the difference, everywhere it is applicable. Who runs a partnership? First of all, Act, that is the first one you will write. Indian Partnership Act, Limited Liability Partnership Act, Companies Act. That is what governs everything. Who runs a partnership? Partners. Who runs LLP? Who runs LLP? Partners only. Here also there is no difference and all. Who runs companies? Shareholders. Here, no. In who runs companies? Directors run the company. Sir, in partnership and LLP, ownership and management is with the same people. Partners only run the company. Partners are only the owners of the company in partnership as well as LLP. In Companies Act, in company form of business, ownership is with shareholders. The management is with directors. Today I am the shareholder of Tata Motors. Am I the director of Tata Motors? No. Can I take major decisions? Answer is no. So management is with directors. Correct? Okay. The next one. What is the maximum number of partners? First of all, tell me what is the minimum number of partners in partnership? 2. What is the minimum number of designated partners?
2. 2, sir. No, 1.
I don't know, I'm asking.
2, sir.
2 only, no? 2 only, no?
2 only, sir.
So there should be minimum 2 designated partners, 2 partners in LLP. In partnership, what is the minimum number of partners? How many minimum partners are required to start a partnership? 2 only. In company, how many minimum shareholders? 1, 2, 7. OPC, private, public. Correct? What is the maximum number of partners in Indian partnership? 100 is given under the Companies Act sections. In Companies Act rules, 50 is given. Which we need to follow? We need to follow 50. So the maximum number of partners in partnership is given under Companies Act. And what is the maximum number? 50. Beyond that, it will be considered as illegal association. Yes, sir. Next one is called LLP. LLP, what is the maximum number of partners? Correct, unlimited. There is no limit in maximum number of partners in LLP. In company, what is the maximum number of partners? OPC, 1, private company, 200, public company, unlimited. Sir, and in the partnership firm, how is the partnership firm? How does it carry on the business? It is carried on according to the partnership deed. In the case of LLP, LLP deed or LLP agreement. In the case of Companies Act, MOA and AOA. And in the case of partnership, will there be any profits given? The answer is yes. How? According to the ratio decided by the company. In LLP, according to the ratio decided by the company. Here, will it something of that sort be given? Yes. And how? That, and the word is called as dividends. Correct? Okay. LLP, sorry, partnership is registration mandatory? No. Partnership registration is optional. In LLP, registration is mandatory? Registration of LLP is mandatory. Companies Act, registration is mandatory? Yes, it is mandatory. Agreed? Yes, sir. And like this, you guys can write any number of points. In the number can go. Partnership, now come to the basic differences. Partnership, limited liability, unlimited liability? Unlimited. Partnership has unlimited liability. LLP, limited liability. Name itself says company. Limited liability, exceptions are there. Unlimited liability companies also there. I told you GSK and all that. Okay, next one, perpetual succession. Is it there in partnership? If at all there is a death, what will happen? Will the partnership continue? It may continue, it may not continue. It may come to an end also. Death is one of the reasons for winding up of the partnership firm. LLP, death, what will happen? It will continue. Perpetual succession is there. In company, of course, there is perpetual succession. Separate legal entity concept. Is it there in partnership firm? No. Partners and the firm are one and the same. In the case of LLP, is there a separate legal entity concept? Yes, it is there. In company, is it there? Yes, it is there. Yes, sir. So you guys can write all these points. Yeah. Okay, done. So there is a difference between partnership, LLP, Companies Act. Somewhere they can ask you one question. Difference between these two, things like that. Clear? All of you? Okay, done. Sir, now let us come to the model of partners. How many minimum partners are required, people? Minimum 2 partners are required. What if that minimum number goes below 2, sir? What will happen? If at all the number goes to minimum less than 2, you have to increase the number to minimum 2 within 6 months. Sir, what if within 6 months I do not bring in a new partner? Now what is going to happen? If at all you fail to increase the number of people, then whoever are the continuing partners, after that 6 months, they will be considered as unlimitedly liable for all the contracts entered after that 6 months. Correct? Sir, they can ask you a question. Remember, this provision is cut, copy, paste, applicable in Companies Act also. Same concept is there also. Now, what do you mean by that? Now, let us imagine this way. Take it in the case of public company. There are 7 shareholders. 2 shareholders wanted to leave the company. So, what did they do? The 2 shareholders sold their shares to the existing shareholders only. So now how many shareholders are there? 5 shareholders are there. Yeah? How is that, sir? There are 3 shareholders plus 2 shareholders who acquired the other 2 shareholders' shares. They acquired. So technically it is 5. Understood the scenario, na? Pakka na? Now, does the 3 shareholders know about this? They do not know. That these people sold their shares to them. Do they know? They do not know. Do they know? Yes, they know. Is this clear till here? Okay. Now what is the minimum number of shareholders required in public company? 7. Correct? Now if the number falls below 7, has it fallen now? Yes, it has fallen. Now they have to bring back another 2 shareholders within 6 months. Now within 6 months, if they do not bring back the next 2 shareholders, what will happen? After the 6 months, whatever are the contracts entered by the company, whoever are the shareholders, pay attention to the word I say, whoever are the shareholders who are aware of the fact that the number of shareholders has come less than the minimum number, those shareholders will be unlimitedly liable. What do you mean by that, sir? Now the number is 5. Did we increase the number to more than 7? Or 7? No. Now how many shareholders are there? 5. How many of them know that our shareholders have fallen below 7? 2. These 3 people do not know. Now there will be unlimited liability. Who and all will be unlimitedly liable? Not everyone. Only these 2 will be unlimited liable. This is the entire provision. Same provision, cut, copy, paste is applicable to LLP also. Whereas in LLP, because it is 2, and the maximum it can fall to is 1. That's the reason I do not give this example in the case of LLP. But here if he knows, he will be liable. Understood this one, na? Pakka na? Okay. And it may also lead to dissolution. One of the grounds for dissolution. Is this clear, all of you? Okay. Sir, and there is something, a concept called as designated partner in LLP. Now, why should they introduce this concept called as a designated partner in LLP? What was the even purpose of this? The purpose was that people, now imagine the moment I tell that you are a limited liability company, you have perpetual succession and all that, that means you should be accountable. Accountable to whom? You are accountable to the regulators. Regulators are, who are they? GST authorities, income tax authorities, ROC, there are so many people. You have to file returns every month, every year. If you do not file, whom should I hold liable? In company there are directors, 3-4 directors will be there. I can hold them liable. Now in Reliance, there are crores of shareholders or lakhs of shareholders. Can they send notice to all of us? No, they will only send to that 14 people who are sitting on the board. Like that, whom should I send in the case of LLP? Because the number of partners are unlimited. We will send a notice only to the partners you tell me to send. You tell me whom should I send to. Oh, like that, okay. The partners, what will they do now? Out of the 50 people, they will nominate 2 people. Macha, raise your hand. So they raised. So the 2 people out of 50, we are designating you for taking the notices issued by the authorities. If there is anything which you need to file, you should only take care of it. We will not come and interfere. So you are designated for this job. That's why the word came called as designated partner. Sir, in terms of salary, in terms of involvement in the business, are they anywhere different from a normal partner? Not at all. Normal partner, designated partner are the same. The only extra combo they have is with regards to regulators. In fact, it's not a boon, it's a bane. Anything happens, they will be accountable and responsible, not the other partners. Is clear? Yes, sir. Sir, now, how many minimum designated partners should a LLP have? A LLP should have minimum 2 designated partners. Earlier people, it said that only individuals could be a designated partner. In the last year, previous year people, they made an amendment here. They said even body corporate can also be a designated partner. What do you mean by that? Infosys and Reliance together, they can come and start one LLP. Can they start? Yes. Earlier it was not possible. You should have had one more individual also, because individuals are mandatory. Now what did they do? This individual becoming a partner not required. You guys are body corporates. No, it's okay. You guys can come and become a partners in LLP. For designated partners, do one thing. You both nominate one of your directors or whatever, whomever you want. You nominate them as authorized representatives. Now they will be treated as designated partners. You need not hire one more individual as partner. You can nominate them for receiving notices, because end of the day, in certain sections, if you guys do not do the filings on time, there are imprisonment provisions also. You will be put in jail. Now whom will I put in jail? You will put in jail these representatives. That's the meaning of it. That's the purpose of it. Understood? Pakka na? Okay. Sir, now, not only that, sir, now with this designated partners, can foreigners come and, can they be designated partners? Can they be partners in India? Can a foreigners be partners in India?
Yeah.
Possible, na? Yes, possible, sir. Just one condition, just that At least one designated partner should be a resident in India. Don't write off resident or otherwise here. He has to be a resident. Sir, what do you mean by a resident, sir? Resident means a person who has stayed for 120 days.
In the previous financial.
During the final.
Remember people, OPC. P stands for preceding financial year. Try to remember it this way. In OPC also you saw 120 days. 120 days in the preceding financial year you should have stayed. In the case of LLP, designated partner, D, during the financial year. Meaning in this financial year you should have stayed. Meaning if I am starting my LLP in the year 24-25, in the 24-25 only you should have stayed for 120 days. That's the meaning. At least one person has to be a resident. And don't write off other characteristics here. I am not at all concerned about citizenship here. Foreigner can be, just that he has to be staying in India. Clear?
Who's going to check 120 days they are going to stay?
They will check your, what is that, passport will have entries, right? You have to give those entries and all. Now who is checking? You will only check. Who else? Now whenever you are becoming when a company is appointing a designated partner, one person has to see all these records. Who is seeing? You are seeing. You are only signing. If something goes wrong, misstatement in incorporation documents, liability will go up to 2 lakhs. And if you have done it wantedly, then there can be suspension of your partnership, your firm also, your practice also. Then? ಚಂದ ನೋಡು ಸಸ್ಪೆನ್ಷನ್ ಅಂತೆಲ್ಲ ಅಂತಾರೆ. ಓಕೆ, ಕ್ಲಿಯರ್ ಅಡ ಸರ್? ನಾವು ಗೊತ್ತಲ್ವಾ, ಅವನ್ನೇ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಇಲ್ಲೇ ಇರೋ ನಾನು ಕಣ್ಮುಂದನೇ ಆಫೀಸ್ ಮಾಡ್ಕೊ ಅಂತ ಹೇಳೋದು. ಎಸ್ ಸೊ ಯು ವಿಲ್ ಬಿ ಲಯಬಲ್ ಫಾರ್ ಆಲ್ ಆಫ್ ದಟ್. ಇಟ್ ಇಸ್ ಕ್ಲಿಯರ್ ಆಲ್ ಆಫ್ ಯು? ಓಕೆ, ಡನ್. Incorporation of LLP. How do you incorporate a LLP? Same process. Here also there is name clause. You have to identify a unique name which is not similar to any of the registered trademarks, any of the registered LLPs, any of the registered companies. You have to come up with such name. Along with that, you have to file the incorporation document of LLP, and that form is called as Form Filippo. Form for incorporating limited liability partnership. Clear? LIABILITY, liability. That's why it is LI. Yappadra. Clear? All of you? So you need to file this form called Form Philip. In Form Philip you will give all the details. Name of the partners, name of the designated partners, the details of capital profit sharing ratios, capital sharing ratios, object of the LLP, name of the LLP, address of the LLP, and finally it will be certified by you guys. Again you guys only will come. So you will give a certification that all the content given here above are true and certified by me, a professional. Your number will be taken. That's how the form will be made.
What if it's not true?
You are wrong. It is liability, direct liability only. Obviously, you cannot say, sir, I didn't know. Mannu chudunge. All that and all won't happen, because ignorance of law is not an excuse. It is your duty to check. I'll tell you one thing. There was one scenario in the year 2016, 2014 or 16, I don't remember exactly. One person has registered a company. So I will come to you and I say that, sir, I want to form a company. You also are getting money. You are more excited. I will say, okay sir, madana banni. You will ask what and all documents you need. And say, I want to form the company in the name of my parents. So they only will be the shareholders because of obvious income tax issues. Now I am an employee. I cannot form a company in my name. Already my income is there. On this income also I have to pay tax. That's why what people will do, they will always form a company in the name of the wife or in the name of the parents. That's the main reason to divert your income tax. So he has given all PAN, Aadhaar, everything was given, and the company was also formed. After 3 years, it came to the light that the parents have passed away. It's been 3 years. On the dead people's name, a company was run. Now imagine if money laundering happens, if illegal activities happen, who are liable? Lifting of corporate will. What will you lift? In which record you have taken that his son came to me to take the signature? Where have you taken? Whose signatures you have taken? You have taken the signatures of parents. Go and catch them only. Go and catch them. Is it real incident? Real incident. Really it has happened. That's why a new process was introduced. Once in 2 years, your signature will expire. Now there is no physical signature to avoid these scenarios. Now what I think I would have showed you in the class also, digital signature, that USB key. Now they introduced a concept called digital signature. And the digital signature has to be renewed once in 2 years. It will expire. For expiring, you have to again renew. Again, sir, again I will only sign. In that, there is video verification now. You have to show your PAN card and Aadhaar card, you have to do a video verification. And you have to certify the document. Who? Again, you only. Clear? So money will come.
At that time, they lifted the corporate wheel and those people died. So who was held liable?
So here they did not do anything illegal. So they did not go to that level. But I am telling, if at all such activities were involved, it is a pure negligence of the professional, no?
Have you certified any companies?
Why, sir?
I am only teaching, I will only certify. So I always maintain something called as certified register only. I have a register. So whoever comes, their details, everything we will make a note. So that tomorrow if something happens, your institute can come and ask you a question after 5 years also. Do you remember what happened yesterday? Which chapter we discussed? Taka try to recall. It is not coming, no. So you don't remember what happened yesterday. 5 years back, with evidence, you have to prove that you were not guilty. How will you prove? So you need to have some written evidences in your favor. As a professional, take a tip from today only. Wherever you are signing, make an entry, have a record and save it somewhere. You should have it for your reference. So that tomorrow the gun is not on your shoulder. Someone will shoot, keeping the gun on your shoulder. For the society, it is you who is visible, not the person who shoots. So always that's an important thing you need to pay attention. Clear? Okay, so you give all these documents, everything will be filed with the ROC. ROC convinced will give you a certificate of registration or certificate of incorporation. In that, name of LLP will be there, and LLO PINO will be there. LLP identification number, just like SINO. And there is one more thing called as, for directors you have something called as DINO. Here you have something called as DPINO. Clear? Designated partners identification number. From here, sir, from this day, you will be considered as what? You will be considered as a separate legal entity. You can sue, you can be sued, you can hold properties in your name, you can enter into a contract in your own name. All those things will happen. Clear? Pakkana? Okay. Sir, now there is one important provision with regards to name of the LLP that is important. Now, whenever a name of a LLP, let us imagine, is similar with another name of another LLP. Now imagine there is a company called as Arivu, correct? Now another company will form another company called as. Now what are these two LLPs? This is also LLP, this is also LLP. Can we find such one? Yes, system cannot identify this. Now is Arivu, ARIVU, is it so popular that ROC will know about it? When he is approving, will he know that there is one company with ARIVU? Obviously no, he is a human, phonetically same. How will you make out? This will be considered as a dummy LLP. You cannot make it, it's not valid. Understood? Sir, now can Arivu LLP can take any action against Arivu LLP? Yes sir, Arivu LLP, dummy LLP, we can take an action. Now how do we have to take? Remember, there are three things you need to remember. What is that? First one, if Arivu LLP has been registered, within 3 years of the dummy LLP's registration, have to go and file within 3 years. Have to go and file a complaint with the central government. Sir, one dummy LLP with same name, sir, phonetical. It is called as phonetically same. Have to go and complain within 3 years. If within 3 years if I do not go, I lose the right to go forever. You can expect a question here. Within 3 years of its registration I have to go. If I do not go, I lose the right forever. Now central government will pass an order saying, hey you Arivu LLP, you have to change your name da. If not, chanagirala nodko. So Arivu LLP has to change the name within 3 months of the order passed by the central government. So within 3 months, if the dummy LLP does not change the name, now what is going to happen? Central government will say, I will only name you. Sir, this is like a favor, sir. You are only giving me a name. It's a very good thing, no? The name will be given people, but the name will not be so much attractive and decorative and all. The name will be central government's order, not complied. Order number, order date. LLP, that will be the name of your company, and you have to continue. They will issue a fresh certificate of incorporation. Your LLP deed will be updated. Your name of the board, which is put in the name in front, everything has to be updated. So now we have a doubt. Can we change the name of our existing LLP? I mean, you have given this name. Can we change that name again whenever we want in the future? Yes, you can change. Punishing you is not our intention. Changing you is our intention. Can you do? Yes, you can do. Possible. Clear? What if Arivu did not get to know about Arivu, sir? We can't do anything, sir. I think in the class also I told you, if you guys remember, we had one client only who came to us at the end of 2 year 11 months. That there is one dummy LLP which has been registered in the similar names. They came to us at the time of 2 year 11 months. We were able to, there is one procedure that is given. Even though they came to us within 2 year 11 months, they were not okay to come on board within time. You know that mentality, right? They came, they checked with us, they went, they another also they checked, they are trying to get quotation, who gives cheap rate. Meanwhile, it crossed the 3 years mark. We could not save it. Now dummy LLP is also there, that new LLP is also there. What to do? You did not do anything. Understood? So yes, it's your loss. Understood? Pakkana. So this is what is there in LLP. That's the main thing. Did we cover everything? Important. Small LLP definition. Exam point of view, it will come. Sir, there is a company. In Companies Act we did not know. What do you mean by a small company? Small company definition is there? What do you mean by a small company? A small company is a company which is, you have it or not?
Small company is there, sir.
What is a small company?
Small LLP.
Small LLP is there. Small company is there or not? What is a small company? A company other than public company. So a public company can never be a small company. Agreed? And which has a paid up share capital not exceeding 4 crores, a turnover not exceeding 40 crores. Up to 4 crore and up to 40 crore, you are a small company. If any one limit is also going above, then you will not be considered as a small company. However, certain companies can never be considered as a small company. Who are they? One is holding and subsidiary companies, Section 8 companies, statutory companies. Example, ICAI, RBI, LICs, these can never be called as a small company. Remember, important from exam point of view. The same provision as an amendment now was introduced for LLP also. Now there is a new provision called as small LLP. Now what do you mean by small LLP? Small LLP means, people, it's an LLP whose contribution does not exceed 25 lakh rupees or whose turnover does not exceed 40 lakh rupees. Meaning what, sir? If at all my capital does not exceed 25 lakh rupees and my turnover does not exceed 40 lakh rupees, I will be called as what? Small LLP. Is this clear? Condition is and both conditions have to be satisfied. My capital should be within or up to 25 lakh. or my turnover should be within 40 lakh. Both conditions have to be satisfied. Exam point of view, very, very important, remember. Designated partners, features, we saw features and all. Incorporation, change of name, incorporation document, Philip, effect of registration, okay, done na?
Yes.
Understood? Okay, that is your LLP. Okay, now we have last two. One is negotiable instruments, one is Indian regulatory framework.
We'll start. Yes, sir.
Yes. So within 1 hour we'll complete negotiation.
Oh, easily. 100%. Very easily. मैं हूँ ना सर, आप हो बट एग्जाम में हम हैं. Little in depth, we'll go in detail. We'll go Dubai. Okay, online now. Sir, explain negotiable instruments more. Day. What happened? Why this negotiable instrument fever? New chapter. They, what did you do in the class? No? Sorry. Manne chudingida. Absent. Chandana? ಅದೇ ಅಲ್ವಾ, ನಿಂಗೆ ಅರ್ಥ ಆಯ್ತಾ ಇಲ್ವೇನೋ? ಸರ್ ಹಿಂಗೆ ಕೇಳಿದ್ರೆ ಏನು ಹೇಳೋಣ? ಹ್ಞೂ ಅಂತಲೇ ಹೇಳಬೇಕು. ಓಕೆ, ಪಿನ್ ಪಾಯಿಂಟ್ ಮಾಡಬಾರ್ದು ಸರ್. ಯು ಶುಡ್ ನೆವರ್ ಪಿನ್ ಪಾಯಿಂಟ್ ಎ ಸ್ಟೂಡೆಂಟ್. ಶುಡ್ ಆಸ್ಕ್ ಒನ್ ಕ್ವೆಶನ್ ಆಸ್ ಅ ಹೋಲ್. ಇಫ್ ವಿ ನೋ ವಿ ವಿಲ್ ಆನ್ಸರ್. ನೋಡ, ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಇವನ್ ಐ ವಾಸ್ ಅ ಸ್ಟೂಡೆಂಟ್. ಓಕೆ, ಸೊ ಲೆಟ್ಸ್ ಸ್ಟಾರ್ಟ್ ಯುವರ್ ನೆಕ್ಸ್ಟ್ ಚಾಪ್ಟರ್ ಪೀಪಲ್. ನೆಗೋಷಿಯಬಲ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ಸ್ ಆಕ್ಟ್. ಓಕೆ, this is also negotiable instrument is from Inter only.
So regulatory framework is also from Inter?
No. That is a fresh chapter that has been added. Technically, if you remember, when you were in your syllabus also, what was the first thing that was discussed when we started law? So, even otherwise, you guys are seeing law for the first time in your life. So, introduction is necessary and required. Earlier, we used to cover it just like that. Now, they have added it in the form of the first chapter. Because, see, you are seeing the chapter called law, for subject called law, first time in your life only. Without introduction of who is there, what is a court, what are the different types of courts, or what are the different organs of government. Without knowing that, how will you understand basic things of law? So to understand that is why they have given this particular first chapter. Yeah. Okay, done. So let's start, people. Negotiable Instrument Act, 1881. Okay. Now again, as I told you, Indian Contract Act, Sale of Goods Act, Indian Partnership to an extent is okay. But if possible, even for Indian Partnership Act and Negotiable Instrument Act, for all these 4 chapters, write a example when you're explaining anything. And remember, only for example you will not get marks. There has to be a provision and then there has to be a example. And remember, if it's a direct question, write it in points. And then one last point has to be your example. Is clear all of you? Okay, done. So the last chapter, people, Negotiable Instruments Acts 1881. Sir, today we call it as so posh, negotiable instruments and all. Is this negotiable instrument a new concept to India? First of all, in 1881 only Act is there. But even in 1881, was it new? The answer is no, people. Even before Negotiable Instrument Acts, we were having this document. This was still there. Panchayats were, this panchayats head were there. What do you call them? Sarpanch, all these things were there in India. And they used to give you loans. That was still there. Now, whenever those things were there, then what were those documents called as? We obviously cannot call them as negotiable instruments in 17th century, 18th century and all. Then what we used to call it as? We used to call it as hundi. Hundi's concepts used to be there in 17th, 16th century. There are so many names. Namjog hundi, Shahjog hundi, Muddati hundi. These are all different types of negotiable instruments which were there in the, India before Britishers came. I'm telling you types of negotiable instruments before that. That has been formalized and they have made one document and that law was made called as negotiable instruments. Now sir, what is a negotiable instrument, sir? If someone asks you, there is no definition of negotiable instrument. But there is a definition for how many types of negotiable instruments are there. There are 3 types of negotiable instrument. One is called as promissory note, one is called as bill of exchange, one is called as check. Try to understand what is what here only and then let us go in detail. One is called as promissory note, one is called as bill of exchange. First of all, people get confused between what is promissory note, what is bill of exchange. First, make that clear. Let the ground be clear here. What is promissory note? Whenever I borrow money from someone, I have to repay this back someday. I am promising today that, sir, thank you for giving me loan today. I promise that I will repay this money to you after 3 months or 6 months or 1 year or at which place, at what percentage rate of interest. Everything I am promising today to repay to the person. So in a promissory note, there will always be 2 parties. One person is called as maker, one person is called as payee. In a promissory note, see, remember the word, I am unconditionally undertaking to promise that I will be repaying the money. I am promising. Whoever takes the loan only drafts the instrument. I will only draft it. I will write it, I will give it to you. You will come back to me after 1 year. Hey, you remember Ada? You have taken loan. Repay. You will show me that instrument. I will see, I will repay the money. This type of instrument is called as promissory note. Now what is bill of exchange? Why is it called exchange? Because bill of exchange generally happens in a trade. Is it always like that, sir? Generally. 90% of the times it is always happens in a trade. What do you mean by that? Today I will give you some raw materials. I will supply you some materials. You will tell me, sir, I cannot make a cash sale. I do not have money. Please allow a credit sale. I will say, okay, we have studied Sale of Goods Act. There is a concept called as unpaid seller. There is a right to lien. And that right to lien you would have seen. I shouldn't have sold the goods on credit, or if I have sold the goods on credit, the credit period should be over. That credit means what? So I am selling you the goods today, you are promising me that you will pay. And how can I believe your promise, sir? Remember, negotiable instruments can never be in oral. It has to be in writing. So you will say, sir, I will promise, sir, I will pay, sir. I will say, hey, I am seeing so many people like you in my life, I can't believe you. So do one thing. I am giving you the goods. Along with the goods, I will only draft one note and I will send you. The value of the goods I have supplied is 1 lakh. You have to pay me 12% rate of interest every, per annum. You have to pay it to me and accept that you will pay me all of this. So I will give you material also. I will give you this note also. In that note you will say, I accept, and you will give it back. and this is called as bill of exchange. What is the difference, sir? Promissory note is drafted by a debtor, whereas bill of exchange is drafted by a creditor, basically a seller. He drafts it and he gives it to you. You check, because you need to know that what he has. See, promissory note you only wrote, so you know what is the amount you have written. Hey, in this, what if he writes some fancy numbers and all that? The value is coming to 1 lakh. What if he writes of 10 lakh? So, in a bill of exchange, always the debtor demands to see the instrument first. So, when I see the instrument, I write on it as I accept, and I give it back to you. Now, after 3 months, you will come and ask for the money, I will repay. Such type of instrument is called as bill of exchange. In bill of exchange, there can be 2 parties or there can be 3 parties also. So 3 parties in bill of exchange are called as drawer, drawee, payee. Always remember, promissory note, maker, payee. Maker is the person who writes the instrument, debtor. Payee is always the beneficiary who gets the money. Same thing even in the bill of exchange also. Drawer is the person who writes the instrument. Who is that? Creditor. Drawee is the person who needs to make the payment. Payee is the person to whom the money is paid. We'll again see. We'll see everything in writing so that you will remember. Yes, sir. So these are the 3 parties in the bill of exchange. And the last one is called as check. Check is also a form of bill of exchange only. There are again always 3 parties. Drawer, drawee, payee. Who is a drawer? Drawer is the person who tears the check and gives. The person who needs to make the payment. Payee, whose name is written on the check. Who is entitled for the money. Who is drawee? The person who needs to make the payment. Correct? Drawee is always the person who needs to make the payment. In the check, drawee is always the bank. Clear? Yes, sir. So these are the different types of instrument, parties involved in the instrument. Now, sir, it is called as negotiable instrument. What do you mean by the word negotiable? Negotiable means what, sir? We negotiate, no? Sir, 10 ರೂಪಾಯಿ ಕೊಡ್ತೀರಾ? ಇಲ್ಲ, 8 ರೂಪಾಯಿ. That is only called as negotiation, no? That is not the meaning of the word negotiation here. Negotiable here stands for people. You can transfer it any number of times. What do you mean by transfer it, sir? Imagine people, A has taken money from, okay, imagine A has given money to B, B has to repay that money. So B signs one instrument called as promissory note and he gives it to A. And what does A do? A has taken money from someone else. So instead of me going and collecting the money from B, I will get the money, I will give it to C. Instead of all of that, what will I do? On the same instrument, I will turn it, I will write pay to Mr. C and I will sign. A will sign. Now I will give this instrument to Mr. C. Now after 3 months, instead of A going and asking for the payment, C will go and ask for the payment. B will say, hey, who are you? C will say, hey, turn the page, you will know. He turns it, oh sir, it is negotiated. What is negotiated? Negotiated means transferred. The instrument is transferred to C. Sir, now I have a doubt. How many times can I transfer? Now C can transfer it to D. D can give it to E. Can it happen? I have taken money from you, you have taken money. Can it happen like this? It may happen according to this chapter. Yes, sir. Sir, for how many times can you transfer? Chandan says you can transfer, sir, whatever is the page length, you can transfer so many times. After the page is full, then what we can do? That's all. That is the maximum you can transfer. Kamran says, hey, Chandan, that day I told you, Noda, that's not how it is. Once the page is full, you can take one more additional sheet, just the way you will ask in your exam, you pin it. And you can transfer even on that also. Meaning you can add an additional sheet for transfers. That additional sheet in negotiable instrument is called as allonge. Is it important, sir? No. Just know and go, that's all. Allonge it's called. Allonge. Allonge means an additional paper. Yes, sir. So you can transfer it any number of times, 100 people.
But now promissory note is like physically written?
Yes, yes.
Yes. Where do you see all this promissory notes and all?
10 rupees, 20 rupees note you had told.
No, not like, even that is also a promissory note only. But where do you see this promissory notes? All this happen in indigenous loans. What is indigenous? Local. You go to village. Even today, Sarpanch, hey, village allada, you take this HG Palya only. I will show you how many unorganized transactions are there here. I'll tell you, one day I was drinking one tender coconut. Two people came on a bike. They gave one paper. The tender coconut Anna signed it and he gave some money, they left.
Wow.
I asked, why, what is happening? Tender coconut Anna says, we take loan on the initial day of the month, we invest it into our business and we repay a particular amount every day to these people. If I miss one day, they will come to my home. I said, coming to home means, sir, they will recover. I asked, what if you run away? Sir, they will recover. How? I don't know. So, this happens with a huge network of people. He is not an ordinary person. Here we are seeing, we are making him sit like a statutory boss and we are
So
explaining.
like promissory note is only for like indigenous people and not big companies. The corporate world doesn't have it.
It will happen. I'm not saying no. They will also take loans. They will also sign agreements. So loan agreements is nothing but promissory notes only. So anyone can borrow. When they are just promising that we will repay, that is called as promissory note. Correct? Yes, sir. We had seen one example also in the class. See, this is a promissory note. I don't think if you guys are able to read or not. Able to read? Okay, wait.
Bank of India,
India, Rangoon, Bangladesh, Allah. Imperial Bank of Rangoon. India, Bangladesh, something and all.
Imperial Bank of India, then Rangoon is written.
You said what? India, Rangoon, you said.
It is written India, comma Rangoon.
Now read. Legible, See, rupees 20,000. Can you see? Imperial Bank of Rangoon. Okay, Rangoon, 16th December 1926. Yara Nimtardora handwriting, see. A 6 ಏನದು ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಬೇಕು 10 okay. Okay, on demand, we promise to pay. What do you mean by on demand?
On demanding.
On demand means on demanding ante. On demand, we promise to pay at the Imperial Bank of India, Rangoon, to OA, OK, CJ, Karupan, Chettiar, sir, or order for value received, the sum of rupees 20,000 only with interest thereon from this day at the rate of 6.5% per annum. Yes, sir. Now see, so many details are there in this particular thing. One is saying on demand. What do you mean by on demand? He has not said I'll give you after 3 months or 6 months or 1 year. Whenever you come and ask, I'll repay the money. That's the meaning of on demand. Sir, what if nothing is written? On demand also is not written. Again, date is also not written. 6 months, 3 months, nothing is written. Then again, if nothing is written, the instrument is considered, assumed to be on demand. If nothing is written. Effect is like that. Yes, sir. What else we can see? To pay at the Imperial Bank of India, Rangoon. What do you mean by that? Inland instrument, foreign instrument. What is this? They are telling you where we will come and pay the money. You will come and pay the money at that place. So on demand, you have to come here. This day, you have to come to that place. Imperial Bank of Rangoon. Sir, what if that day it is closed? We'll see. There is some rules regarding that and all. So you'll go on that day, Imperial Bank of Rangoon. I'll go and ask for the money. Okay. You can say, to whom should I pay the money? OA, OK, CJ, Karupan, Chettiar. And next word is or order. What do you mean by or order? Anna, I will pay to you. If you don't want money, you tell me whom should I pay? I'll pay to him. Oh, anga, turn it. Now he will say, pay to Mr. C and OA, OK, CJ, Karupan, Chettiar, sir will sign. Now on that day, when you go to Imperial Bank of Rangoon, if at all on the back of it, if someone else's name is written and if this person has signed,
then we will make the payment to him. And what these people have done is called as negotiation. That's the meaning of the word or order. I am telling you to pay to me or to the person I tell you to pay. You have to pay to him. That's the meaning of or order. Your order. Whomever you tell me to order, I'll pay.
Attorney means?
Attorney means the person who is signing on your behalf. Basically, it will be legal lawyers. Sir, 20,000 lawyers. Look at the date. I told you when this agreement was made, 1926. I told you what was the value of 500 rupees in 1980. 1926, 20,000. You can buy Bangalore only. I don't know if you guys know it or not. In 18th century, in 1880 something, Bangalore Palace is there, no, was purchased for 40,000. The land, acres of land, Bangalore Palace. I'm telling you the value of that 10 or 20,000. So 20,000 you can purchase half Bangalore only. Yes, sir. That's why attorneys are coming, meaning lawyers are coming. Understood? Pakka na? Was LLB there that time? Hey, Mohandas Karamchand Gandhi ji went to London. Why? To study. To study law. Would have studied somewhere. Yes, law. I mean, law was there. Da? What question? Da? Okay. Is this clear, all of you? Allah, I'm telling you, they are asking, was that time in 1920s LLB was there? I'm telling you, that time only Gandhiji and all went no to study. Okay, is this clear, all of you? Got some basic idea of what is happening around? Okay, now knowing all this, now see here. Essential characteristic of a negotiable instrument. First thing, it has to be writing. Oral, not valid. It has to be signed. If not, it is never valid. Freely transferable up to satisfaction, meaning 3 months validity. 3 months keep on transferring. Unconditional promise, meaning what? Now I took money from B. I will say, I have taken money from B. Is it a negotiable instrument? No. I will say, I will pay money to B. Is it a negotiable instrument?
No.
I am saying no, I will pay money to B. Is it a negotiable instrument? No. Why? Amount is to date, time, at least I can take it as demand, sign, so it has to be clear. You saw how clear it is. We undertake, Anna, OA, OK, CJ, Karuppan, Chettiar, Rano. So we are clearly telling that whom we will pay, where we will pay, what we will pay. Everything is written. That clear the negotiable instrument should be. And sir, negotiable instrument should be unconditional. What do you mean unconditional? So remember, when they say here unconditional, when I say unconditional here, it should be not a condition which is impossible to achieve. Any condition which is meant to happen can be valid. Meaning what? I cannot say I will pay you 1 lakh rupees on your marriage. Now is marriage guaranteed to happen? Correct. Sir, he is like, you see a foundation result barely. You see, next year I will get married. What more engagement that day? Yes, sir. So people, if that is the case, then I cannot say that marriage is guaranteed to happen, no? How many people you want to give an example? I will give you. Now probably one day he thought he wants to get married, but today is not getting married. Is it a certain event? You think it has to happen, but it may not happen. After you get foundation result, you might be motivated to go to CA Inter. Correct, huh? Yes, sir. Now, sir, that's what they're telling you. Now, this is unconditional. You cannot have this condition. On marriage, I will pay 1 lakh is never a negotiable instrument. Sir, give us a certain event which is going to happen, sir. I will pay you 1 lakh rupees tomorrow by sunrise. Is it meant to happen? Meant to happen. Sunrise won't happen, huh? By tomorrow sunset. Is it happening? Huh? It is happening. It will happen. Yes, it will happen. Sir, I will pay you the money on 1st of January 2025. 1st of January won't happen. Huh? From 31st it will go to 2nd. Huh? Meant to happen, no? So this is valid. Conditional only, no? Yes, sir. Huh? 31st? ಈ ತರ ಜೋಕ್ ಹೇಳೋದ್ರೆ ಹೇಳ್ತೀಯ 31st Feb, is it meant to happen? No. Now this becomes a conditional one which is not enforceable. Clear? Yes, sir. Now I can write 29th, leap year, meant to happen 4 years once. Is it valid? Yes, it is going to happen. I can write 29th. Clear? Okay, next one. To pay money only. It cannot be a barter system because it becomes a sale. I will give you coconut. I will give you money. That becomes Sale of Goods Act. Negotiable Instruments Act Allah. Yes, sir. So it has to be money only. Next one. Instrument must be delivered. I will pay you macha. I will only keep the instrument. Then what will you come and give it to me after 3 months? Sir, promissory note. Meaning, it is an unconditional undertaking. You have to write this, it has to be underlined. Promissory note is unconditional undertaking. Undertaking means I am promising, unconditionally I will pay. When you are writing a bill of exchange, it is an unconditional, we will see that. We will see that. Okay. Unconditional undertaking signed by a maker to pay a certain sum of money only to or to the order of certain person or to the bearer of the instrument. Agreed? Okay. Parties, sir. Maker is a debtor. The person who borrows the money is called a maker. Payee is the person who is entitled for the money, who is getting the money. Remember, payee in promissory note as well as the bill of exchange is the same. You are getting the money only. Okay, characteristics, writing express promise to pay. The sum payable should be definite and unconditional. Pay money only. It should be stamped. I will put it down and I will stamp it. Okay, na sir? How many times you want me to stamp? That many times we will stamp. Yes, sir. What is that they are telling you stamp here? Can you see that stamp? Why? According to the Indian system, if at all a document does not have a stamp, it cannot be accepted as an evidence in the court. So the instrument to be valid in India should always have a stamp attached to it. The first stamp you would have purchased also, but you will pakka purchase is once you join your articleship. The first day, you and your senior will enter into an agreement. Anna, sir, I will work for 5,000 rupees. Or 6,000, whatever they are giving it to you. 5,000, sir, what are you saying? I'll just walk out. Yes, sir. So, whatever it is, you guys will enter into an agreement. And that agreement, you have to submit it with your institute, ICAI. Because what is the guarantee that you are going to do articleship? Sumne you will get off experience letter. You guys might do, no? To not do that only, there is this. Sir, I'll just randomly put a date. To avoid that, you will go and take one e-stamp on which date will be there. That will be the effective date of your commencement of articleship. Because everything else can be manipulated. What if your brother is only a CA? You will say, from the last 2 years I am working here only, sir. See, date. We have entered 2 years back. So that any dates are written. Now it is authentic. You cannot manipulate it. So everything will be real time. Understood? Pakana? Yes, sir. So without this, it will not be a valid instrument. Clear? So it has to be there. Stamp duty has to be paid. How many stamps has to be put? It's not like that. Based upon the value of the instrument, a particular percentage will be paid as a stamp duty. Imagine the percentage can come to somewhere around 0.15% of the value of the instrument. Meaning if the value of the instrument is 1 lakh, the stamp duty you will pay is 0.15% of it. It can come to 150 rupees. Yeah, I'm just giving you an example. Is this clear, all of you? Yes. So now you need to go to a bank or cooperative societies. You have to pay 150 rupees. You have to take this stamp paper. They will give you that e-stamp. You have to put it to your agreement. Only then your agreement is valid. Maker and payee to be certain and different person. So I cannot say I will pay money and I cannot write it. Whom will you pay? I'll pay it to me only. Not possible. There has to be two different people. A promissory note cannot be made payable to bearer. Only RBI or central government has the power. What is this, sir? Section 31 of RBI Act says. Now, sir, instead of writing here name and or order, can I just put it as bearer? Bearer of, what do you mean by that? Tomorrow whoever comes and give me that instrument, I'll give them the money. Can I just put a bearer here instead of writing all these names and all? The power to use the word bearer in promissory note is only with RBI or central government. The example is your currency notes. Again, it is not something has happened. Okay, here you will have, you see any currency note. I hereby promise to pay to the bearer of the instrument a sum of 2000 rupees. Governor of RBI would have signed. Meaning, if no one in the country accepts this note, governor will go and accept the note. Governor, when I say don't go to his home, they are telling the capacity. Meaning you have to go to RBI. Understood? Pakka na? Yes, so you cannot use, a private person cannot use the word bearer. It is only the RBI or central government who can use the word bearer. So you guys need to write a name or it will be written as order. Clear? Pakka na? Okay, done. So sir, can the private people can never make a bearer instrument? They can make a bearer instrument. Sir, hing madbedi. You just said we cannot do, then again you are telling you can do. Simple. If a private person has to make an instrument, bearer instrument, now you have this name, no. Name column is there, no. Leave the name column blank. Don't write bearer. Just leave it blank. That means whoever you keep on changing the names, the last person will write off his name. It is a bearer only, no. So you are not allowed to use the word bearer in the instrument. But if you want to make an instrument bearer, leave the name column blank. It becomes a bearer instrument. Now can we do this? Yes. How, sir? That is what the lawmaker said. The power to use the word bearer is only with RBI. Okay. We are not using the word bearer. Clear? Okay, done. Next one, sir, is bill of exchange. Meaning, look at the word. It is an instrument in writing containing an unconditional order. Promissory note, unconditional undertaking, because maker is only making the instrument. That's why I am promising. Here, drawer is ordering the drawee to make the payment. I am writing the instrument and I am sending it to you, no? Along with the goods. So I am giving you an order to pay. That's why I always remember, in a bill of exchange, it is always an unconditional order made by one person to another person, signed by the drawer, directing a person to pay a certain sum of money to order to certain person or the bearer of the instrument. Who are the parties involved, sir? The parties involved is called drawer, drawee, payee, acceptor. Acceptor for honor is not there for us. So there is drawer, drawee, payee, acceptor. Sir, you said 3 parties. 4 parties are coming here. Why do you do this for us? Sir, the person who writes the instrument and sends it is called as drawer. This person will always be a creditor. Along with the goods, I will also give the instrument. To whom? To the drawee. Sir, why to drawee, sir? End of the day, the instrument should be with the creditor. Because he should go and ask the money after some time. No. When will we give it to the drawee? If the drawee is having a little doubt on us, meaning he does not trust us, whatever, if I write some amount and all, how can I believe you? So I need to see the instrument before I am liable. If that condition is put by the drawee, then what we will do? We have to give the instrument to the drawee. Now drawee sees the instrument. Now drawee is convinced, yes, everything is right. Now drawee will sign the instrument. Once you sign the instrument, you become an acceptor. Sir, so drawee and acceptor, are they different? Both are same only. Drawee, if he demands for the instrument, to see the instrument, if he sees and signs the instrument, he becomes an acceptor. If he does not demand for seeing the instrument, he never asks for this at all, then he will just be called a drawee, that's all. Now once he sees the instrument, he is called an acceptor. Now he is a drawee as well as an acceptor. Drawee, end of the day, is nothing but a person who is supposed to make the payment. And the next person is called as payee. Who is payee, sir? The person who is entitled for the money. It can be drawer himself also. Meaning I can tell you, pay the money to me only. Or I can write any other person's name also. I can write the third party's name also here, allowed. Clear? So in a bill of exchange, it can have 2 parties also, it can have 3 parties also, as the case may be. Clear? Okay, done. Next one. Okay. Okay, there is something called as holder in due course. Now, what is this holder in due course, people? Okay, important concept. Now, imagine, sir, there is A, there is B. Now, A had sent okay, let us imagine A got a promissory note from B that I will repay the money after say 3 months. Now, the promissory note is with A. In the instrument, people, they have not written the name, they have left it blank. Getting the point? Now, sir, this instrument was, there is one more person in the same house called C. Who is C? A's son or son beda. Let us imagine C works in A's house. C is the maid of A. When she was sweeping, people, she saw this particular promissory note. She picked it. My God, name is not written. Name is not written means wait, negotiable instrument act, bearer instrument. I cannot. Oh my God, I'll get the money. So she took the instrument. Basically theft. She did a theft. She took the instrument. After 2 months, she is going and presenting it with B for money. Now you tell me whether B should pay the money to C or not.
Actually, we should pay the money to C, but it is.
A told A, I lost the instrument. Don't pay if anyone comes and gives you the instrument. Then he should not pay. Agreed? Yes, sir. Now why, sir? A for us, C for us is called as a holder. What do you mean by holder, sir? Holder means, people, the person who gets the instrument before the maturity, and in the instrument your name should be written. I will take the instrument. I will write my name. If all these 3 conditions are satisfied, I will be called as a holder. Now question is, how did C get the instrument? Sir, it is by theft. So A told B, don't make the payment. B will not be under an obligation to make the payment. Now look at the second scenario. A had taken loan from, okay, you take it this way. C got the instrument. C people long back had taken loan from another person called D. D had given loan. So C thought this is a wonderful opportunity. C took the instrument from A. C immediately wrote off D's name in it, and C gave the instrument to D. Now D people went after 2 months and gave the instrument to B. A informed B, don't make the payment. Now tell me, should B make the payment to D or not?
If B was in good faith, then B.
D did not know how C got the instrument.
No, sir. Good faith.
D did not know about this theft to nothing. He thought C gave.
Okay, B cannot pay to D, but C is liable to D.
C will be liable. That's a different story. First tell me, B will pay or
No,
not.
sir, because A said not to.
A said not to pay. Remember, sir, now I'll ask you some 4-5 questions. What is that? Is your name written on the instrument? Yes, sir, name is there. Did you get the instrument before maturity? Yes, sir, I got the instrument before maturity. Third one, sir, is how did you get the instrument? Why did you get the instrument? Sir, because I had given loan, sir, and because of the loan, they had to repay to me. Because of that, they gave it to me. So you got it for some value, meaning you earned it. Yes, sir, I earned it. I did not get it for free of cost. I earned it. So I got it for a consideration. Oh, okay. And did you know that how C got the instrument? No, sir, I thought he was a genuine person. That is only called as good faith, meaning you should not know any of the backstory. If you know the backstory, you will not be treated as this person. Sir, if all 4 conditions are satisfied, you will be given one VIP badge by the Negotiable Instrument Act. That VIP badge only is called as, you will be called as holder in due course. Sir, what if you are given a badge called holder in due course? If you are given a badge called holder in due course, no matter what has happened in the past, you will not be held liable for any of those actions. Meaning, I take the instrument to B, I ask for money, A has told don't pay, but should B pay or not? B should make the payment. You cannot stop the payment because he is an innocent person. Sir, in this 4, even if one condition is not satisfied, you will not be called as a holder in due course. Then yes, B will not make the payment. Sir, what do you mean by that, sir? Imagine people, D is C's son. Sir, birthday came, D's birthday. What did C do? C gifted this to D. Gift.
No value.
Yes, sir. Now, sir, D will go and present it to B. Now, I will again ask all the 4 questions. Name is there? Yes, sir. Name hai dekho. Maturity, yes, sir. Dekho. Value, sir. Value. I don't have value. Did you earn it? No, sir. I got it bitty. Bitty means, sir, I did not earn it. I just got it for no consideration. I did not earn it. My God, you did not earn it? Do you know how did C earn it? No, sir. Okay, this is tick mark is there. Now, because one tick mark is not there, you will not be considered as HDC. D will not make the payment to you.
But still, C is liable.
C will be liable, yes. Previous parties are always liable. But whether this person will be liable? No. Answer is no. Is this clear? Pakkana? This concept is called as holder in due course. Important from your exam point of view. Holder in due course. They will give some stories and all like this only, and they can expect some question to be asked. Clear? Okay. And the next topic, sir, in holder in due course only, there is one topic called as the privileges of HDC. You can expect a question there also. Okay, what are the privileges enjoyed by HDC? What are the privileges? So, privileges of HDC. First one, people, in case of inchoate instrument, holder in due course can recover money. Let's do one thing. Privileges let us do after doing the classification of negotiable instruments, so that you will know what is inchoate and all that. Clear? We'll come back to that part. Okay, classification of negotiable instrument. Negotiable instrument can be classified into various types. The first type is, people, based on parties involved. If at all the name is left blank, it is called as bearer instrument. If the name is written, it is called as order instrument. So based on the parties, negotiable instrument can be called as bearer instrument as well as order instrument. What D called as? If D is son of C, what is D called as? In our example, you can always call the parties into 3 things. One is called holder, one is called as holder for value, one is called as holder in due course. Now, in the case of D, he did not earn it, he got it for free. Then in these 3 categories, where can I put him? He will be called as a holder. Now imagine the other thing. D got it for value only. C had taken loan, C repaid the loan to D. Now I'll ask again all 4 questions only. What? Name is there? Yes, sir. Maturity? Yes, sir. Did you get it for value? Na? Yes, sir. Did you know about all this? Yes, sir. Meaning, I knew how C got the instrument. Then what should I be called as? You will be called as holder for value. You will not become HDC. Good faith is also important. Understood? Yes, sir. Sir, holder for value is also protected under the law? No. Holder is protected? No. HDC? Yes. Clear? Sir, any other case where a person will become holder apart from gift? Yes. Inheritance. Meaning, sir, C dies. In C's custody, there was this check or this promissory note. By default, D will get the instrument as inheritance. Can D go and ask? Again, I'll get asked 4 questions. How? Name? Yes. Maturity? Yes. How did you get it? Did you earn it? No, sir. Bitti. Inheritance. Then no. Into mark. Understood? Yes, sir. Okay. Sir, based on validity, the instrument can be classified as 2 things. One is called as inchoate instrument. One is called as ambiguous instrument. What do you mean by inchoate? Inchoate means, people, incomplete. Inchoate stands for incomplete. What do you mean by incomplete, sir? Take that Imperial Bank of Rangoon only, that example. Sir, this instrument is there. Imagine, people, that 20,000 is left blank. Take the same instrument, on top there is 20,000 rupees written. Now, how much is the stamp duty we need to pay? 20,000 into 0.15. How much will it come down? 20,000 to 0.15? 10% comes to how much? 20,000. 1% comes to 200. 0.1% comes to 20. 25 0.15. 20 rupees, exactly. 30 rupees, So 30 rupees. Now, we pasted the stamp duties 30 rupees worth accordingly. Let us imagine. Now, let us imagine these 4 stamp duties value is 30 rupees. Yes, sir. Sir, now what do you mean by inchoate instrument? Now, imagine people, we have negotiated one contract. Earlier what used to happen, there were various transactions where the amount will not be known until a particular thing goes through. You imagine your parents will come and you do admissions here. They give a blank check and they will put the value of the instrument. Now, you are not sure how many subjects you want to take with ArivuPro. For 4 subjects, it might come to 80,000. For 3 subjects, it might come to say 60,000. I am telling you random numbers. Da. Now, your father will say, okay, da, you see how many subjects you want to do. I will pay for the maximum price and I will go. So, I will put the stamp duty for 80,000 worth. 80,000 into 0.15. How much it is? 80,000 into 0.15. How much is it?
120.
12,000.
Not 12,000.
120.
120, yeah. So what will I do? I will take the promissory note. Imagine your parent. They will take one stamp paper for 120 rupees because it is the maximum you will take 4 classes. Now, why did we do this? Because you are not sure whether to take 1 or 2 or 3 or 4. Now, what will your father do? Your amount column, your parents will not fill this. They will say, ArivuPro, take it. If my son or daughter takes all the 4 subjects, then you can fill 80,000. If my son or daughter takes only 3 subjects, fill 60,000. 2 subjects, 40,000. 1 subject, 20,000 accordingly. But I will pay stamp duty for everything. Understood? Now imagine people, my amount column is blank. Now what do I call such instrument? Such instrument is called as inchoate instrument. Incomplete instrument. Inchoate. Is clear? Next concept is very important here. ArivuPro. Now what does ArivuPro do? One day what happens, after the results have come, ArivuPro organizes one event and they want to thank the winners and they want to congratulate the winners. So there is one person who has cleared CA distinction, topper, all India rank 1 or something has come. So we want to give him something. So what does ArivuPro do? ArivuPro decides to give this promissory note to that student. And we will say that the cash you are entitled to is 80,000. How much? 80,000. Clear? The same instrument ArivuPro gave to that student for 80,000. Now, you guys, whoever joined ArivuPro, how many subjects you took? You were happy with 3, so you discontinued 1. So you attended only 3 subjects. So what is the fee you need to pay? 60,000. But how much ArivuPro has written and how much did they transfer? They have written 80,000 and they have transferred. Now the student will go to your parent and they will ask, sir, please give me 80,000. Parent will check with the student, how many subjects did you take? 3. The parent will say, I am only liable to pay 60,000. Now tell me how much should the parent pay?
80,000.
80, yeah? 60, yeah?
80.
80, yeah?
Yes.
Pakka na? Yes, people, parent is liable to pay 60,000. Understood? Pakka na? Now listen carefully. What second scenario? ArivuPro gives that promissory note to me. Why? Let us imagine that is my paycheck, my salary. I came and taught you. I need to get the payment. Arivu thought, sir, me going, taking, again you giving it to you. Do one thing, you only go and collect it from that person. I said, okay. So again they wrote, my pay is coming to 80,000. So they wrote 80,000 and they gave it to me. Now I go there and I'll ask for the money, 80,000. Again the father will ask you, how many class you attended? You say 3. You say 3. So how much they should pay? 60. Now I'll go and ask 80. Now how much should the father pay to me? Sir, now it is 80, sir.
How much? Think and answer. Sir, wait sir, we'll see the provision sir. How much? ಹೇಳ ಚಂದನ್ ಸರ್ ನಾನು ಮ್ಯಾರಥಾನ್ ಯಾಕೆ ಹೇಳಿ ಬಂದಿದ್ದು ಟು ಕ್ಲಾರಿಫೈ ದಿಸ್ ಕಾನ್ಸೆಪ್ಟ್ ಓನ್ಲಿ. ಹೌ ಮಚ್? 60ಯಾ 80ಯಾ? Yes people, you are absolutely wrong. I will get 80,000. Sir, ಏನು ಆಟ ಆಡ್ತಾ ಇದ್ದೀರಾ? Do you know the value of marathon? You can't do all this. Remember people, in the case of the CA achiever, why did we give it to him? We gave it to him as a gift. Is the instrument written in his name? Yes. He got it before maturity? Yes. Did he earn it? It's a gift. Now what will he be called? He'll be called as a holder. If you are a holder, you can never encash the money. What the other person has promised to pay, you cannot encash more than that. So 60,000 is what was agreed. I will be liable to 60,000 only. Sir, in the second scenario, in my case, I earned the instrument. Now, value also comes into picture. I become a holder in due course. In case of incomplete instrument, remember these words carefully. In case of incomplete instrument, holder in due course can write any amount on the instrument up to the stamp duty covered. Now, how much have you paid? 120. 120 is 0.15%. Now, I will do math. If 120 is 0.15%, then how much is 100%? I will do a cross multiplication, I will get a number. Whatever number comes, I can take the money, irrespective of how much the parent has to pay to the academy, I can recover the entire 80,000 because I am a holder in due course. Understood? Pakkana? Yes, that's what is this entire note. Holder in due course. He cannot recover the amount in excess of what was intended. 60,000. CS student, holder in due course can recover any amount on such instrument up to the stamp duty affixed. Online? Yes, you have doubt.
Sir, but you should be in good faith. Like you shouldn't.
Good faith only. Even I didn't know.
Oh, if you know that the father.
Any one in that 4 condition, one is a into mark. You will never be a HTC, and all these benefits are for HTC only.
So you didn't know about.
Correct. That's the reason. Privilege. First privilege in HTC. What is that? In case of inchoate instrument, holder in due course can recover money up to the stamp duty covered, not up to what you are liable. Clear? Pakka na? Understood? Heavy concept?
No, sir.
Easy only, no? Okay, next one, ambiguous instrument. What do you mean by ambiguous instrument, people? Ambiguous instrument. What do you mean by ambiguous? Ambiguous means confusion. When will we have confusion? When we explained, I clearly told you, promissory note will have 2 parties. Bill of exchange will have 3 parties or 2 parties as the case may be. I clearly told you, promissory note is written by the maker. It is payable to a payee. In the case of bill of exchange, I told you, it is made by a drawer. It is given to the drawee. But in certain cases, if you guys have you remember your accounts, you guys would have studied something called as accommodation of a bill. Generally people, there is something called as a self-drawn bill. When can this happen? Have you
Discounted it with the bank.
You will say, exactly. I will only say, I will have to, now generally what has happened, drawer says drawee to make the payment to the payee, correct? Now what I will do, I will draw a bill upon myself. I unconditionally agree to pay a sum of money to Mr. B, I will only sign. So I will draw a bill upon myself. Instead of drawing it on drawee, I will draw it upon myself. I will only sign. And I will write B's signature.
That is promissory note.
Correct, no. Sir, technically it should not have happened like this. But he is doing it that way. Now, bill of exchange, as you rightly said, is similar to promissory note. Now, I don't know what do you want me to treat it as.
Do you want me to treat it as bill of exchange? Do you want me to treat it as promissory note? What do you want me to treat it as? The law says, hey holder, do one thing, it is your choice. End of the day, the last person, whoever holds it, option is given to them. If you want, you treat it as bill of exchange. If you want, you treat it as promissory note. Once you treat it as promissory note or bill of exchange, imagine you treat it as promissory note, all the rules applicable to promissory note will apply. If you treat it as bill of exchange, all the rules applicable to bill of exchange will apply. Clear? Question can come here. Once you treat it as BOE, you cannot again treat it as promissory note. Done now? That type of instrument is called as ambiguous instrument. Sure? Next type of instruments are based on place. If the instruments are, see here, three conditions very important. There are two types of instruments based on the place. One is called as inland instrument, one is called as foreign instrument. What do you mean by inland instrument? Inland instrument means in the same land, meaning Indian instrument. When will you call it as Indian instrument? See these three conditions. These three conditions you can see whether it is India or foreign. It should be drawn in India, mandatory. Sir, what if here we have a into mark? Directly read it as foreign instrument. Got it? I'll again not explain foreign. See that here only. Drawn in India, tick marka inland, into marka foreign. Okay. Sir, this one is into mark. Next, there is one more condition you need to satisfy. So there are another two conditions. In this two, at least one you need to satisfy. If one is satisfied, it is a Indian. If both are not satisfied, it is a foreign. Pakka na? Okay. If main condition not satisfied, it becomes foreign. If main condition is satisfied, it becomes Indian provided come down. Now what does it say? And where is it payable? Imperial Bank of Rangoon. Is it in India? Na? Condition satisfied, you will call it as Indian instrument. If it is not in India, na, it will not be called as foreign instrument. Now come here. Or drawee resides in India. Who is making the payment? There's some name. You guys only should say, I don't know. This person is making the payment.
You want the Tamil or the English?
Tamil one only,
That's not
Chettiar, some Chettiar, sir.
ನನಗೂ ಕಾಣಿಸ್ತದೆ ಇಲ್ಲಿದೆ ಚೆಟ್ಟಿಯಾರ.
Some Chettiar, there's
ಸೋಮಸುಂದರಂ.
Somasundaram Chetty.
ಸೋಮಿ.
Somasundaram.
Correct? Now Somasundaram. Somasundaram I think is Indian only, no? I don't think he's a foreigner, right? Correct? Somasundaram, correct? Drawee resides in India. Where is drawee? Sir, Somasundaram sir, where are you? Tamil Nadu, are you there? India, na? So sir, whether place should be in India or the person paying should be in India. So there are three conditions. Where is it drawn? Where is it paid? Who is paying? Where is he? Correct? Now, where is it drawn? In India. Come down. Where is it payable? In India. Two conditions satisfied. Indian instrument. Or, where is it drawn? In India. Who is paying? Sir, person resident in India. Two conditions satisfied. Indian instrument. Sir, where is it drawn? Outside India. First condition only not satisfied. Foreign instrument. Where is it drawn? Sir, it is drawn in India. Okay. Where is it paid? Sir, it is paid in England. Oh. Okay. Who is paying it? Where is it being paid? Sir, it is being paid by a person who resides in, say, France. Oh. Sir, this is satisfied. This also not satisfied. This also not satisfied. It becomes a foreign instrument. So, keeping this in mind, you draw a condition.
No, ma'am. If the check is drawn in India, but it is paid in India, but the person is not the resident of India.
It's Indian instrument, yes.
Okay, suppose the check is drawn in India, but it is paid in some other country, but the resident is in India.
The person paying, is he in India?
Yeah.
Then it is also Indian instrument. Now, keeping that in mind, you only see. First condition, foreign instrument, drawn outside India, na?
Pakka no? Then don't check anything. If it is drawn outside India, don't check anything. Okay, drawn in India and payable outside India and drawee outside India. Can you see this and?
Okay. Yes, sir. Understood.
Pakka na? 100% you can expect a question here. Foreign instrument. If not this attempt, probably next attempt. ಅಲ್ಲ ಅಂದರೆ ಜನರಲಿ ಕಣೋ ಬೇರೆಯವ್ರಿಗೂ ನಿಮಗಲ್ರು ಯಾಕ್ರೋ ಡಿಸಪಾಯಿಂಟ್ ಆಗ್ತೀರಾ ಕ್ಲಿಯರಾ ಎಸ್ಸಾ ಅಂಡರ್ಸ್ಟುಡ್ ದಿಸ್ ಒನ್ ಓಕೆ ಡನ್ ನೆಕ್ಸ್ಟ್ ಒನ್ ಬೇಸ್ಡ್ ಆನ್ ಟೈಮ್ ಆ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ಕ್ಲಾಸಿಫೈಡ್ ಇಂಟು ಡಿಮಾಂಡ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಟೈಮ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ವಾಟ್ ಯು ಮೀನ್ ಬೈ ಡಿಮಾಂಡ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್
There is no
ಇಟ್ಸ್
time
ನಾಟ್ ದೇರ್
mentioned. There is no time.
correct for you your syllabus it's not there correct sorry thank you maturity of negotiable instrument also it's not there for you grace period is not there for you okay negotiation of negotiable instrument it's there for you now how do I have to transfer the negotiable instrument it depends upon what type of instrument it is if it's a bearer instrument how will you transfer it ana ಕೂತ್ಕೊಳ್ಳಿ ಒಂದು selfie ತೆಗಿಯೋ you will give it like this correct sir now a negotiation can happen in two ways negotiation means what transfer a transfer can happen in two ways what one is just a delivery when will you just deliver when there is no names written you need not sign the second type of delivery you have to write your name sign and then give the instrument in both the scenarios giving the instrument is mandatory delivery is mandatory but in bearer instrument sign is not required in an instrument where your name is written, signature is mandatory. Understood? That's what is given. If payable to bearer, negotiation can be done just by delivery. Agreed? Because name only is not written, then why signature? On the other hand, if payable to order, negotiation can be done by endorsement plus delivery. Endorsement is nothing but signature. Parties in the endorsement, the person who transfers is called as an endorser. The person to whom it is transferred is called as an endorsee. Some books they use endorse, some books they use endorse. Both are one and the same. Clear? Done? Done. Various kinds of endorsement is not there for you. Modes of discharge, types of crossing, check. Okay.
Dishonor of checks for insufficiency of funds in the accounts.
That we will do. That's nothing but check bounce. Okay, let us do of check bounce. Check, as I told you, check will have always three parties. Who are there? Check people, see, the person who gives the check. Now I will give the check. I will sign and I will give no. I am a drawer. Whoever tears the check. Sir, my friend will tear, he will become drawer. I am telling whoever has to make the payment, that person becomes a drawer. I give you the check. Whosoever name I write here, Kamran. Now Kamran becomes payee. Who should make the payment? Drawee should always make the payment. So Kamran will take this check to the bank and he'll ask for the payment. So who is making the payment? Bank is making the payment. SBI here is the drawee. So in a check, drawer is always the person who needs to make the payment. Basically, who is liable to pay? And the person who is entitled to money is called as payee. The person who actually makes the payment is called banker. In check, always the drawee is the banker only. It cannot be another person. Clear?
Yes, sir.
Sure?
Yes, sir.
Pakka na? Okay. Sir, essential characteristics of a check, all essential characteristics of bill of exchange, because check is also a bill of exchange only. It must be drawn on a specific banker. Correct? I cannot take one page, I cannot say this is a check. It has to be a check which is given by the banker. It must be payable on demand. So whenever you go and present it, you will get the money. Correct? Yes, sir?
Yes, sir.
Okay. Let us do the next part, important part, check bounce. You know? Check bounce.
This chart is there in ArivuPro app, sir.
Which one? The start book, huh?
Yesterday, first day only he told no.
I mean, see, I'll tell you, probably in another 2 days, I'll upload the new material only. If you guys want, you can order for a hard copy.
This summary book.
Summary book I'm talking about.
Sir, actually on
I didn't
Saturday
listen.
or something, a YouTube video is premiering for Business Law Marathon. So, will it be the video which you are taking now for the past 3 days or like other video?
Why will he speak up after this?
Same thing will be premium. Yes, sir?
Where you should order, sir?
ArivuPro website. Why da? You were there in class, noda? Emergency. ಈ ಎಕ್ಸಾಮ್ 1 month ಇಟ್ಕೊಂಡು ಯಾವುದೋ ಎಮರ್ಜೆನ್ಸಿ ನಿಂದು ಓಕೆ ಸೊ ದ ನೆಕ್ಸ್ಟ್ ಒನ್ ಇಸ್ ಕಾಲ್ಡ್ as people check bounce case or dishonor of a check case. Section 138 to 142 I have put everything in one place and I am trying to explain it in one place. Okay.
Sir, why is it so putty, sir? You can't make it like this.
Which one?
The TV frame only, it's like only one square.
I will tell them to check the I think something is
So TV is so big. Why not this?
every day. How will it be?
It is like
Every day
Full,
it will be like full TV
okay.
only. Like before it was full TV.
Now it became like this, huh? Now just now.
no sir.
Today.
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 From morning it is like that only, huh?
We don't
And you guys are telling it now.
No sir, because now this
Now
is very
this
small.
is like very small, sir. Others and all you have zoomed in, no? So this one
It
it's
is
full.
kind of a table. No?
Now it is visible, no?
It is
Visible.
visible.
You come here.
Sir.
Okay. The down part is not visible.
Now
Huh?
this
Stage
side
one.
half is missing.
Okay. I'll tell them to check. Probably we'll finish this after the break. We'll fix it. Okay. People, the next one is check bounce or dishonor of a check. What is check bounce, people? A has given a check to B to go and deposit in SBI bank. Now, B Papa goes on the date of maturity. He asks for money. SBI checks the A's account. It comes as insufficiency of funds. My account does not have balance. Now, what will B do? B will say, when SBI will give back the check to B. Now, what and all are B's rights? What can B do? So, B people first will intimate to A. Macha, check you gave, no, check bounce. You also know, because your account only. You know that there is no balance. So, A will have to make the payment. If A makes the payment, then there ends the case. If A does not make the payment to B, now what can B do? B can go and file a case in the court. Now, how will that happen? They have given you the chronological order. Stage 1, drawer. So, he issues a check for discharging a legally enforceable debt. Why is that important? Meaning, A has given a check to B against some legally enforceable debt. You know what do you mean by that? Imagine A gives a check to B as a gift. The gift cannot come under check bounce case. It has to be a money.
Also money only.
Correct, but you should have earned it. You cannot go and demand it as your right. See, check bounce is a criminal offense. I can put you in jail. Hey, gifted, for gift, if you don't get money, you will put me in jail. Because it's a check bounce case, a criminal offense.
He promised to give.
Correct, everything is correct, but for that, do I deserve to sit in jail?
2 years.
Then check bounce. Understood? Pakkana. That's why the word used is called legally enforceable debt. So what do you mean by that? If it's a donation or if it's a gift, all that will not come under legally enforceable debt. Understood this part? Okay. Now it is given to holder or the payee. Correct? Okay. Now what does the holder do? Holder will go and present it for payment in the bank. The bank within or 3 months, basically you have to go and give it within the time period. If not, it is called as a stale check. And the check is always valid for a period of 3 months. Okay. Now what does a bank do? Does it has money? If it has money, it will pay. It does not have money. So what will it do? Check is returned due to insufficiency of funds to the holder. Now what will the holder do? Stage 4. Holder, he will give the notice of dishonor. Hey, you drawer, you know what has happened?
I will intimate him when within 30 days of receipt of information from the bank. Whenever bank tells me within 30 days from that day, I will have to intimate to the drawer. Now what will drawer do? Drawer, payment to be made within 15 days. I will give you a notice, settle the matter. You pay me now. Even now we can end the case. So within 15 days, you have to give it to the holder. If not, what will the holder do? Complaint will be given in writing within next 1 month. Which court and all is not there in our syllabus. For you, only court is there. So you will go to the court. Now what will the court order? Court may order for imprisonment maximum up to 2 years, or fine can go up to 2 times of the amount of the check. So if the check was for value of 1 lakh, I can say you will get to 2 lakh. I can put you in jail also for a period of 5 months. That is also possible.
When they will put for imprisonment and when they will give for
How will I know, sir, when is this and when is that? Is this your first offense? Or you are doing it atte mane, matte. Second time, third time, fifth time. Now I will tell you, give fine also. Have to correct your behavior also. Now sit in jail. First time will never go to jail.
Oh, they can do both. They can do give imprisonment and fine both together.
Generally, no. It will be either this or that.
If there are a lot of check bounces in one account.
If they give imprisonment, he also should pay the amount and then get the imprisonment.
Paying the amount is mandatory. Check whatever is amount you need to pay. But am I supposed to collect the extra money because I am talking about fine here? Extra also should I collect? That will not come. Imprisonment may come into picture. Clear this part? Sir, in the sections people, they have clearly given one point. What? There is one thing which will not be accepted as an excuse in the court. You coming to the court and saying, sir, I did not know that in the future my account will not have balance. Unknowingly it happened, sir. Vittidinga, sir. Please, sir. This will not be taken as an excuse. It is given in the section only. Is this clear? Pakka na? 100%?
Yes, sir.
Yes. So that is your check bounce case. That is only this section 140. Defense which may not be allowed. It shall not be defense in a prosecution of an offence under section 138 that drawer had no reason to believe when he issued the check that the check may be dishonored on presentment for the reason stated in that section. When I issued, I did not know that this day would come. Please forgive me. So that will not be taken as a valid evidence. Clear? Pakka na? Yes, sir. Okay. People, we have to do presentment of instruments and
Presumption in favor of holder means reputable presumption.
which one? Section 139, huh?
Section 139.
When a check is dishonored, it is presumed that the holder of a check received the check of the nature referred to in section 138 for discharge in whole or in part or any other debt or other liability. Presumption prescribed here is rebuttable presumption, as the provision clearly provides that person issuing the check is at liberty to prove to the contrary. The effect of this presumption is to place the evidential burden on the accused. Now what do you mean by that? If a person goes and says in the court, Your Honor, there is a check bounce. It is presumed that in this check I was entitled to the money for value. It will be presumed. But A can come and say, sir, it is not for value. I gave it to him for a gift. But you need to come up with an evidence. But the law will presume that B got the check for value. It is presumed.
Even if it is for gift.
Court will say it is presumed. Now A is free to prove it is not for value, sir, it is gift. You have to prove it. But what is the court's presumption? Court's presumption it is for value. Understood? Yes, sir. Simple. Presentment of instruments. This is going to take another 20 minutes. We'll go for a break and come?
Yes, sir.
Yes? Okay. The last two parts are there. Let's go for a break and come. 12:50. Can we meet by 1:25? Yes, 35 minutes. Go for a break. Okay. So,
We were, what are the topics we were supposed to do? Presentment of instruments and this one, right? Rules of compensation. These two we were supposed to do, correct? So these two topics are left. Presentment of instruments and rules of compensation. Okay. See, presentment of instrument. Now what are they talking here? See, this entire thing from 61, it starts, everything is presentment only. It goes on up to, see, till here it is presentment only. Yeah. So I'll try to tell you what is the entire summary of the presentment. Now, whenever I talk about presentment, now what is this presentment? See, presentment means whenever you have a bill, promissory, no, okay, there is always two things. Now, whenever I speak about presentment, the presentment will come in two places. One is for acceptance, presentment for acceptance, one is presentment for payment. There are two types of presentment that is done. Now, what do you mean by presentment? Very simple. In bill of exchange, you remember there was a person called as an acceptor. What do you mean by an acceptor? The person who accepts the bill and he gives it back, and later you will again give, you will ask the payment. So here presentment for acceptance means the bill is drawn, it is given to the drawee to check once and write as accepted and give it back. So what is the presentment here? Whenever drawee has put a condition that once the bill is ready, you have to show it to me. Until I see it, I will not be liable. If drawee has said that, it is the duty of the drawer to give the drawee the bill. He needs to see, he has to write as accepted on it. Until then, drawee will not be liable on the bill. And that is the first presentment they are talking about. Presentment for acceptance. Nothing but you are giving the bill for him to accept the bill. He will accept it and he will give it back to you. Okay, now there will be validity, maturity period. It will be 3 months, 6 months, as the case may be. Upon maturity, people, you will go and again now present again to the drawee. Why? You are presenting this time for the payment, for the money. Remember, what do you mean by dishonor of a bill? Dishonor means if he does not pay. What we know is only dishonor due to non-payment. Remember, dishonor can also happen due to non-acceptance as well. What do you mean by that? You have taken goods from me, you have asked the bill, you wanted to see the bill, but you never accepted the bill. According to the condition, you have to accept the bill. If you do not accept the bill, that day only I can consider that the bill is dishonored. What if the bill is dishonored? I can go to the court, I can file a case. So, dishonor of a bill can happen even due to non-presentment for acceptance also, at time of payment also. If he doesn't accept the bill also, it is dishonored. If he doesn't pay the bill also, it is dishonored. So remember, we always generally think that dishonor can happen only due to non-payment. It can also happen due to non-acceptance as well. Clear? That's one thing. Now second thing, sir, non-acceptance, so how much time do I have? You come immediately, I have to sign and I'll have to send it back to you. Am I given some time to check the bill? What time? 48 hours is the time given to you. Within 48 hours, if the bill is not accepted, it is deemed to be dishonored. Understood? Sir, now where should I go and give the bill, sir? Technically, wherever it is specified in the contract, you have to go and give the bill in that place. Sir, what if there is no place specified, people? Generally, what do? We will go to the place where it is specified within the business hours. Business hours means I can't go there at 12 o'clock midnight. Business hours widely accepted is 9 to 6. But should we write 9 to 6? No. That's the accepted business hours. You have to go and you have to give the bill within that time. And if at all between us, if we have an agreement, sir, I will not come personally, I will send it to you by post. Are you okay with it? If the drawee was okay with it, even it can be sent by post as well, it will be valid. You need not come personally. This is presentment for acceptance. Is this clear? The next one is presentment for payment. Now, what is presentment for payment? Same thing. Again, I will give you the bill. I am giving it to you because you have to pay me the money. Now, again, where should I come and give it to you? You will come and give it in the place of where it is specified in the agreement. What if it is not specified? I will come to the place of your business. What if the place of business is not specified? Or I come, you are not there. I will come to the place of residence. Sir, what if place of residence is not there? Law says do one thing. Wherever you find him on the road, just throw it on his face and ask the money. So 4 things: agreement, business, residence, wherever you find him. If he doesn't pay, it is considered as dishonored. Sir, if it is a bank, you have to align yourself with the bank timings. Remember, each bank will have its own timings, each bank will have its own working days. You have to follow the banking hours. Second Saturday is holiday, you cannot go on second Saturday. So that you need to have it. Sir, why is bank coming here? Because even check is also a bill of exchange. Check will also be given for payment. So presentment of payment will happen. So that is also considered. So you have to go during the business hours. Is clear? Pakana? Yes, sir. So these 3 are the main things they have given. And the next one is, sir, always should I go and give the bill for a payment? Should I always go and present the bill? Sir, always it is required. Or is there any exception? What do you mean by this? If at all I need to get the payment, should I always go and take the bill and give it to the drawee and ask for the payment? Or is there an exception? Without even me giving the bill, I will get the payment. Is there any exception like that? By default, you will not get paid without presenting the bill. However, there are 4 exceptions. Understood? There are 4 exceptions. Now, what is that 4 exceptions? Important from exam point of view. Remember this, section 76. When presentment is unnecessary. Understood? When presentment is unnecessary. What do you mean by that? Whether you present or not, you will get the money. So even presentment is not required at all in these scenarios. Understood? Presentment means what? The drawer is coming and giving the bill to the drawee asking for the payment. They are telling you it is unnecessary. Meaning in these scenarios, it is not required. Still you will get the payment. When? See here. No presentment for payment is necessary and the instrument is dishonored at the due date for presentment in any of the following cases. Now what is that, sir? If the maker, drawee or acceptor intentionally prevents the presentment of the instrument. What do you mean by this, people? You told me to come. I have come. On that day, you are stopping me from coming inside. Probably like shutting down the business. Shutters are open, but doors are closed. I am trying to call you. You are not receiving the call. So you are telling you will make the payment. But when I am trying to reach you, you are avoiding me. That's all. I am free from obligation. Even tomorrow if I come without the bill, you will have to pay me. Because on the due date, you did not receive my call. You did not allow me to present. So I am discharged. Tomorrow I will come without the bill also. You will have to make me the payment. Understood? Second scenario. If the instrument being payable at his place of business, I have gone there. You told me to come to your office. I came there. He closes such place on a business day during the business hours. You told me to come on Monday. I came. You know it's a working day. You know it is business hours. You have closed. I am discharged. Understood? Next one. If the instrument being payable at some other specified place, neither he nor any person authorized to pay it attend such place. What is this, sir? You told me you come to this place on this day. Imperial Bank of Rangoon. You told me to come there to collect the money. I came there. Nothing. You also did not come. No one else as an authorized representative of yours. No one came. I came. You did not come. That's all. I will consider it as dishonored. Tomorrow I will come to you. Without bill, you have to make me the payment. The fourth scenario. If the instrument not being payable at any specified place, he cannot after due deliberation search be found. What is this, sir? I'll go to your business, not there. You told me some other place, not there. Sir, then what is the next one? I'll find you wherever I find you on the street. I'll have to throw it on your face and ask for the money. Correct? Sir, I'm trying to search you even on the street, sir. You're basically missing. Meaning what? You generally say, no, parari kesa. This is only parari kesa. Your chit funds and all will come here only. They will take, they will run away. They will not be there. What to do? Where will you go and find them? So you are not there. Sir, in these cases, automatically I am discharged from presentment. Even if I do not get the bill tomorrow, you will be liable. Understood? 4 scenarios under A. You will be seeing B, C, D also. Under A, where presentment is unnecessary. The first one, people, where you intentionally prevents me from presentment. Intentionally prevents. Look at the keywords. Second one, people, it is payable at business place during business hours. He has closed it. Third one, he tells me to come to a different place, some other place. And he also does not come, his authorized representative also does not come. The fourth place, people, it is not playable at any specified place. But I tried to search you, nowhere you are found. Then I am again discharged. Understood the first criteria, na? So now even whenever I want, I can give it to you. I am eligible to get the money even without presentment. Okay, that is A. Look at B. B is easy. What do they say? Sir, drawee only said, Macha, why does this bill and all? You come, I'll make the payment. Allah, Macha, I will bring A. Macha, come da, I believe you da. I said, no, hey, Baro, I'll give you. So, sir, as against any party sought to be charged therewith, if he has engaged to pay, who? Drawee has engaged, he has agreed to pay, notwithstanding non-presentment. What do you mean by that? Have agreed to pay, notwithstanding means without even concerning about the non-presentment. I have agreed, then okay, I'll get the payment. Second scenario. Third scenario, as against any party, if after maturity, with knowledge that the instrument has not been presented, he makes a part payment or promises to pay or waives his right to take advantage. What is this, sir? Karunamayi. What is that? The person does not make the presentment. He has not made. But this person says, hey, it's okay da, hamara admi. He waives off the condition. Or he makes a part payment. 1 lakh I have to pay, no. 50,000 I will make. That means you are binding yourself to make the payment for other 50,000 also. So you are waiving off your right. You are making a part payment, or I make a promise to pay in the future, not today. Meaning what? He will come late. He does not get the bill. I will say, I know you have not got the bill. I will not take advantage of this scenario. I will make the payment after 1 month. Please come back after 1 month. He is telling, I will still make the payment. So in the future, after 1 month, now I need not take the bill again because you only agreed to pay. That is what they are telling. Understood? The last scenario, as against the drawer, if the drawer could not suffer damage from the want of such presentment. What is this, sir? Imagine people, A gave a check. I went and I deposited in the bank also. Bank said people no balance, dishonor, check bounce. Agreed? Now when check bounce happens, what is the first thing I need to do? Inform the drawer, sir, you do not have balance. Now tell me, your account, you know you do not have balance. Why should I again come and show you the check and ask for the payment? You know it. In your life, it does not make any difference whether I bring it or I do not bring it, because you know that the bill is dishonored. So whether I bring also, it doesn't make any difference. If I don't bring also, it doesn't make any difference. In such case, non-presentment is still excused. You need not present it for the payment. Understood? Pakkana? 4 scenarios. Any doubts? Okay. The last one, rules of compensation. Rules regarding compensation. Okay. Rules regarding compensation, technically there are 5. Okay, last rule, important again from exam point of view, remember. Rules of compensation. Now what are they talking, people? Now whenever a drawee has to make the payment to a payee, whenever he is making the payment, there are certain rules you need to keep in mind, it seems. What is that first rule? On the due date, on the date of the maturity, drawee has to make the payment to the payee. Agreed? How much I need to pay? Whatever is given on the bill. How much is that? 1 lakh. Sir, what if I did not pay this 1 lakh? What is going to happen? You remember there is something called as noting, protesting, noting charges, protesting charges. What is this? Legal charges. I went to court. I had to file a case. Lawyers charges and all. Who will pay all that money? Now imagine I won the case. How much will I be able to recover? Only 1 lakh, or can I recover all this also? All this, that is the first rule of compensation. See here, the holder is entitled to the amount due upon the instrument. How much is it? 1 lakh. Together with the expenses incurred in presenting, noting and protesting. Agreed? That is your legal charges. I am entitled to recover everything. Simple? Yes, sir. Okay. Second one, sir, now I have a problem. What? You saw that foreign bill. Now I am in India. The place of payment is in India only, but our drawee is residing in US. Just because there is a payment to be made, do you want me to come to India and make the payment? My flight charge only will be more than your repayment. Agreed? So what does this person say? Macha, is it okay if I do that NEFT? Nefto? Okay, Parvagilva, I will do it from US only. Is it okay? Manageable? He'll say okay, as long as I get the money, I don't care from where you are making the payment. Now from US he'll make the payment. Now how much should I pay? 1 lakh only. What, sir? That is also one doubt. The problem is you are making the payment from US. In which currency you will pay? You will pay in dollars. What should I receive? You will get rupees. I hope you guys know every day rupee and dollar will keep on fluctuating. How many dollars should I send? They are telling you whenever you took the loan, the dollar and rupee denomination will be different. When you are repaying the loan, dollar and rupee denomination will be different. Now on the repayment, imagine $1 is equal to 80 rupees. So they are telling you how much you should pay. Sir, I need to get 1 lakh divided by 80. How much ever it will come in dollars, you need to send this much dollars. You have to basically send the dollars according to the today's exchange rate. Probably when we took loan, it was 72 rupees. If you give that, I will be incurring loss. So you have to give it to me on today's date of maturity. Understood? Pakkana? That is what is the second rule. Read. When the person charged resides at a place different from that at which the instrument was payable. Agreed? In India it was payable. The holder is entitled to receive such sum at the current rate of exchange between the two places. If you want to write down there only, $1 is equal to 80 rupees on the day of maturity. On maturity. This rule will again come. Same rule will come. Yes, sir. Next one. Endorser who being eligible has paid the amount due on the same is entitled to. What is that, sir? Now people, A, B has to make the payment. A endorsed it to C. C endorsed it to D. D went. Bill is dishonored. Who will make the payment to D? C should make the payment. Agreed. But for C, who will make the payment? Now C made the payment today only. When did A made the payment to C? When did he make? Today only he is paying. Or he will pay after 1 month. He will pay after 6 months. When are you paying? Today you pay, I don't have a problem. What if you pay me after 6 months? Macha, why should I pay? You should. It is primarily you who is liable for everyone. If you don't pay, why should I pay it from my pocket? C is eligible to recover the money along with 18% rate of interest until the money is paid. Per annum 18%. Imagine you pay me after 2 months. Calculate it. For per annum it is 18%. You do 2 divided by 12. Whatever is the amount that comes, that is the interest. Understood? That is what is the third rule. Read. An endorser, C is an endorser, who being liable has paid the amount due on the same is entitled to amount so paid. Amount also I am entitled with the interest at the rate of 18% per annum from the date of payment until tender. Understood? Meaning until I receive the money. Clear? Pakkana? Okay, fourth one now. Sir. Oh, sir. Where is C? C is in India. Where is A? A is in US. Same scenario. What? Endorser made the payment to D. Now C has to recover the money from A. How much will I receive? Same condition of B will apply. What is that? Today's exchange rate. Understood? Pakkana? Read.
When the person charged and such endorser reside at different places, the endorser is entitled to receive such sum at the current rate of exchange between the two places. Clear?
Yes, sir.
Sir, next one. Sir, C has to receive the money from A. Agreed? This bill, though I made the payment to D, the bill is done. Now C has to receive the money. What is the guarantee A will make the payment? How do I believe you, da? A says C. Now C has a right to draw a new bill and whatever is the amount payable. How much? 1 lakh, noting, protesting, 18%, add everything as a new bill. Now this will be treated just like your any other bill of exchange. Because I have to receive the money from you, in that place you can draw a new bill for security purpose. Read. The party entitled to compensation may draw a bill upon the party liable to compensate. C on A. Correct? Payable at sight or on demand for the amount due to him together with all expenses properly incurred by him. Meaning what? That bill is also should be payable at sight or on demand. Meaning you cannot add 3 months or 6 months when all. Whenever I come and give you, you have to make the payment. And that is how the terms should be. So these are the rules of compensation. Any doubts? Clear? Pakkana? So this is your Negotiable Instrument Acts.
Sir, from section 62 to section 75?
That's what was at presentment for what is that? One was presentment for acceptance, presentment for payment. Next one is deliberation, 48 hours. Next one is when payment is unnecessary. So these are the main 4 headings. Yes, sir? Okay. Clear, this part?
Yes, sir.
Any doubts here? I hope negotiable instruments is clear.
Yes, sir.
We'll go to the next chapter, the last chapter. Regulatory framework.
Yes, sir.
Huh? Okay. Okay, the last part, people, regulatory framework. Technically we should do first, we are doing last. Okay, so what is regulatory framework? You can expect one question also here. They will ask you, we'll see what are the questions which has a potential to be asked also. Okay. Indian regulatory framework. So whatever I am explaining now, maximum it will be coming around this only, nothing else will come. So Indian regulatory framework, basically Indian regulatory has 3 organs of the government. What is that? One is called as legislature, one is called as executive, one is called as judiciary. What is legislature? Legislature's job is to make the laws. So in legislature, who sits people? Your people chosen, MLAs and MPs, whether it can be state legislature or it can be parliament. So central or state, and that is they sit in your legislature, correct? So they are the lawmakers. How is a law made? Generally, what is the job of the lawmakers? What do they do? Technically, once in 5 years, now only you guys are electing people. Now what do? They see wherever there is a need to make a law, wherever there is a need to make an amendment, they will constantly keep looking into those aspects. If at all they find any place where a law is to be made, imagine things like GST. So they think there is a law to be made. What do? First they will form one committee. A committee who has a special experience and expertise in that subject matter. A group of people will be put in that committee. Now this committee will do their research and they will come up with something called as draft. So this is called as a draft bill. The draft bill will be first submitted to Lok Sabha. Once the Lok Sabha approval is given, we will next submit it to Rajya Sabha. So in both the houses of parliament, you need to get an approval. Once both the houses of parliament you get an approval, now you need to take the bill to the President of India. The President of India will sign this bill. Once the President of India signs this bill, now it is within them only. How will you and me know? Once the President of India signs the bill, that bill has to be published in official gazette. What is this? It is nothing but an official publication of the government.
If it is coming here, that means that the news is valid. So the bill which is signed by President of India will be published in official gazette, and in that gazette they will say from which day the law or the rule will be applicable from which day it will be implemented, effective. That is called as notification date. So they will clearly say from which day the law will be notified. For example, yesterday I was telling you there are some labor laws. The labor laws are passed in the year 2020. They are not yet notified. It's been 4 years. So notification can take time. Remember that. Clear? So this is how the law is made. Sir, now we have a question. Now, who will make a law generally? Is it always Parliament? Is it always Parliament? Sir, remember people, the law making power can be divided into 3 powers. One is called as union list, next one is called as state list, the third one is called as concurrent list. What do you mean by union list, state list, concurrent list? First of all, our government, is it unitary or federal in nature? India is unitary or federal in nature? We are federal in nature with certain unitary features. We have both the colors. We are federal also, we are unitary also. Now what do you mean by that, sir? To avoid the conflict, we have center also, state also. We have central government also, we have state government also. In your syllabus, whatever it is there, everything is central laws. Who has made laws on all these? Everything is made by the central government. So finance will come under central list. So only central government, only unions, but the central government can make law. So these laws are made in Parliament. That is Lok Sabha, Rajya Sabha. Understood? So there are some more items which fall under state list. The example, police department. Central government cannot say how all the state government police. Simple. You see from your respective states to other respective states, there will be change in the uniform color of police. In some places the uniform will be little dark, it will be brown only. But it will be higher shade, low shade, or how you wear it, everything will change. Why? It is state driven matter. Each of the state government, they can make their own laws. Agriculture, state, it can do its own laws. So sir, here union government will not poke its nose. Whatever state government is power to do, central government won't poke its nose there. And that list is called as state list. So union, only Parliament. Central government will make the laws. Example, all your laws till now, Companies Act, everything will come there only. Next one is state list. State list is where both of us have a power to make. The last one is called as concurrent. Concurrent is where both of us have a power. You can also make, I can also make. Labor law is one of the best example. For example, central government has laws. State government also has laws. Both of us will do. Next one is, what is that? Education. State is also there. State syllabus. Central also is there. Central syllabus. Correct? So it is left to state also, central also. Both will do policies there. So this is only called as concurrent list. Understood? Pakkana. So these are the 3 lists that is there. So this is the role of the legislature. Is this clear all of you? Pakka? Yes? Okay. The next one is called as executive. What do you mean by executive? People, lawmakers will tell you people, this road is one way. Will you guys still treat it as one way only? Sir, it depends, sir. Police idre, sir, we will not come. If police is not there, sir, we are free to come. Same thing, helmet to DL, triple riding, everything is like that only. Correct? Why do we need police? Law is simple, clear, no? One way. Helmet is to be worn. It is clear, no? Law is clear. Then why do we need police? There is no self-regulation. We need a lati. Lati and one red mark is an emotion. One red mark on someone else gives us hundreds of lessons. Moral, ethical lessons and all. Correct? COVID, if you remember, until that videos came, that is when we stopped going out. Or else we were also roaming around. You remember? The bike and all, they were going, pillion riders, they started hitting. That is when we stopped going out. Why? Fear of hitting, getting hit. Or else, executive's role is that. law is there. Who makes sure that the rule is getting implemented? Who will make sure? So that is the role of the executive. So in your book, they have given some examples also. For example, the best example, the Companies Act is there. Who will implement it? MCA, Ministry of Corporate Affairs. Yes, sir. See, executive, they have given you some examples. Ministry of Finance. What is Ministry of Finance? Nirmala Sitharaman ji takes care of taxation, takes care of your income tax matters, budgets, everything will come under Ministry of Finance. Agreed? Now I am saying income tax. Who is taking care? Ministry of Finance takes care of that entire industry. Understood? Next one, Ministry of Corporate Affairs. For the 1-2 attempts people, you may not see a question here, but you may see a question also. I am not saying not possible at all.
This attempt it is not possible.
And that's what I don't think so. This attempt, according to me, chances of asking question from the executive is little less only.
So from where they'll ask?
They can ask you legislature, they can ask you judiciary, they can ask you what are courts, maybe. Yes, sir. I might be wrong also. Okay, next one, Ministry of Home Affairs. So, see, Ministry of Law and Justice. So, SEBI. What is SEBI? Correct? Law is made. Who will enforce? Implementing authority. SEBI will make sure penalties and all are imposed. In the same way, RBI. Correct? Banks are there. Act is also there. Banking Regulation Act. What is the guarantee they are following everything? That's why we have RBI. RBI will impose penalties on the banks. In the class, if you remember, we had seen the Insolvency and Bankruptcy Board, IBBI. What is IBBI? Insolvency and Bankruptcy Board of India. What is this?
They will look after the
Insolvency.
So remember, in India, insolvency is a very big matter. If a person becomes insolvent, till today, we used to go to court, we used to file a case, court has to give a decision. It used to go on to ages. Now, where is that possible, people? A person has become insolvent. His assets will be deteriorating. Court will take 8 years. Now, what do I do? So, we needed a special body to take care of insolvency only. And the body that was created is called as Insolvency and Bankruptcy Board of India. Remember, you have a very good scope here. Professionals have a very good scope here. What we will do, sir? Anyways, he is dying. Should we just be an eyewitness? Died much, I'll see you. What can we do, sir? So, IBBI, insolvency matter can be split into 2 things. One is resolution, one is insolvency. Resolution, Videocon failed, but we did not wind up the Videocon directly. You appoint a professional. The professional will bridge the gap between the company and creditors. Creditors will say, close the business, give us the money. Company will say, wait, we will try. But obviously, creditors would have lost hope. Now comes Betegara Beteado Rana Betegara Banda. Who is this person? Now, these people are the professionals. You are called as insolvency professional. You know what you are doing? We will go and motivate creditors even more, sir, to just wind up today only. You tell them, boss, even if the company winds up, you are not going to get extra money.
right?
How will you get? Whatever are the assets, that only we will sell. I'll tell you, Videocon has assets of 2000 crore. Liabilities on record, imagine 72,000 crore. What will you pay? What will you get? Imagine you need to get, okay, you boil down this way. I have to give you 72 rupees. I will give you 2
What
rupees.
did he do with 70,000, sir?
It's a liability. You would have taken loans. I would have
With that loan, what did he do?
business developments, no? Now you know what Byju's is doing? I hope you guys know. Byju's almost done. Another 4-5 months, Byju's will be chapter end. Done. Close. No, because see, it's very simple. Of course, on Byju's I can speak for 1 or 2 days. That's a different story. Some things does not work practically, and you have to realize that. You are playing with education industry. Education has to be affordable. Now, Byju's went on
very, what do you say? It's a marketing, there is one word they use, outrageous marketing. Meaning burn everything you have to make the sales. And you know who was the brand ambassador of Byju's? In India is Shah Rukh Khan. Globally, you know who it is? Messi. Who is Messi, sir? Adhe sir. Footballer. And you know how much they charge? People, crores for one ad. Any value add-on is happening. Seeing Messi, I will go and join. I'll take law classes. Messi will hit one goal. Wow. If I have to learn law, I have to learn from this goal only. How do you, now boost is the secret of my energy. You might get inspired looking at how Kohli, Sachin, Dhoni were built. Probably. But is this related? Now Shah Rukh Khan says, hey, come. How is it? I mean, I might be completely wrong. If it has worked out, it would have worked out. I might be wrong. Now, the founder is going pillar to post to pay the salaries of the employees. Not even one day it is paid on time now. Why? He is selling everything possible to pay the salaries. Now you see, salaries more, sales less. Isn't the liabilities going up?
Why do you think the reason for the downfall, sir? Because Byju's was very
affordable education. You need to make education affordable. I'll tell you one thing. I'll price my classes 10,000. Will you take my class?
Only law.
Law.
only law 10,000.
Why? I will give you value. I'll make sure you will clear. I'll explain with all animations and all. Why not?
That's what, sir. Actually, worth 10,000 we can
Yeah,
give for your
that's
classes.
10,000.
I'll sell it for 20,000.
No, sir.
Kamran is like kottide jaste. Correct. Same thing happened. They are giving a good product, but the problem is there were so many problems with regards to what is being marketed. Marketing people will say, sir, full aerodynamics, everything will come. In reality, in the classes, is it being implemented? Not really. So like this, there was a lot of differences to what you promised and what was delivered. And employees were given more pressure, targets were more to convert the people. So all this will not end up good. He started taking more and more investments, valuations were shown more, debt came into the company, interest has to be paid irrespective of you are doing business or not. All these shows you the falling business of a particular academy. So that's how it happened. Yes, Sam?
Because 1 year before in Byju's, just for sales, like if you finish your 10th or 12th, just for doing sales, they used to pay 40,000. Just for one person. Doing
My cousin only used to work.
Even my sister worked. She was like,
In my circle, ಹಿಂಗೊಂದು ಸ್ಟೋನ್ ತೆಗ್ದು ಹಿಂಗೆ ಹಾಕಿದ್ರೆ ಬೈಜೂಸ್ ಬೈಜೂಸ್ ಇವನು ಬೈಜೂಸ್ ಬೈಜೂಸ್ like that they have hired. And very strict deadlines. No 2 months.
3 months my sister.
They have something called as that initially you need to make some calls. So what they do, that in your training period you have to convert a few people, clients into your, basically they will give you leads, you have to convert them into clients. If you fail, that's all, 2 months done, directly retrenchment. There is no scope of another training, all that is nothing. So imagine every 2 months you are investing so much time to train an employee, he does not meet a target, just that's all, fire. And crazy payments, 40-50,000 when you compare to call centers. Then
I thought nice idea, nice payment.
why CA? CA, Byju's has AC, I can sit and easily work.
When I saw the pressure and all, my sister was like, too much she worked, she left off. She was like, I can't manage. I was like, okay.
That happens. So all that happened, yes. Okay, so you only imagine 72 rupees, you will get 2 rupees. How will you react? You imagine your role. You have to go and convince them, we will give you 2 rupees, be happy. And that's your role. That is insolent. Exactly. And imagine to convince that, what is the win for the company, how much you would get. It's an impossible task. RCB can go to playoffs. Now, can they go in IPL now? RCB can go to playoffs?
I am zero in
Chance is there now? Mathematical chance is there. You don't do, sir, studying, sir.
Devra gives Ashirvada to
Now imagine Dinesh Karthik comes here, he makes sure, now we have to, now versus CSK,
Yeah.
you have to chase the target in 18.1 overs. Or you have to win with 21 runs difference. That's what is the target. If you do that, RCB will may go to playoffs. This is a mathematical thing. Imagine Dinesh Karthik will say, hey, this is what impossible. I will come and play. He will take it. Now imagine what is the value DK is adding. How much money you may pay. Same, it is impossible. You try. Because that is the main intention. Failing of companies, country does not want. Because failing of companies leads to unemployment. Failing of companies leads to fall in GDPs. We do not want that. It is not only the matter between company and creators. It is also the matter of government. If you are good, tax is good. Country will be good. So we want you to sail. So IBBI is the board who takes care of all of this.
That person will go and convince 2 rupees.
That
he can
person
do so
or
much.
you only?
Yeah, I will go convince. What will I get from this side for convincing?
Money will be there. Obviously, you will get paid.
He has only 2 rupees, no sir.
2 rupees, but in reality that is 2000 crores. In that how much you want? On the 10 crores, good enough for some 150 days activity. 10 crores or will give 20?
For 150 days, they'll give 10 crores, sir.
There's a timeline. You have to finish that within timeline. If not, it will automatically go
How
to
will I convince her? I will talk.
That
and
is
convince
your
her, I
talent.
should
That is
do
your
that.
talent.
by next level you will know, okay, like this. By final you will know how to convince.
At final, we should go.
It is all about speaking numbers. If you go into liquidation, how much you will get? 2000 crore. Now can we try for an acquisition? Can someone come and buy the company for 3000 crore? Can we try this? Because Videocon has some reputation. Videocon already has assets. Can we try that? Maybe. Yes, chances are there. Then why did Idea merge with Vodafone? Let's try to compete with Airtel and Jio. If not, you're a small player. Tomorrow you'll fade away. Yes, sir. Then simply we are studying all this. Okay, understood? So that's the role of executive. The last one is called people judiciary. So judiciary will be seeing at the last. Structure of judicial system.
IBBI, when was it formed, sir?
2016.
Now recently.
2016.
Before that, court only was doing.
Yes. So here, now, law can be of two types. Process of making law we saw. Types of law. Law can be of basically 4 types. Technically 2 types only. What are the rest two we'll see. One is called as criminal law, one is called as civil law. What is mean by criminal law?
IPC.
IPC section 420. You have heard of 420. What is 420?
What is 420?
But you have seen that now. Generally also will be teasing no A 420. Why that 420?
Why is it 420?
According to section 420 of IPC, Indian Penal Code, 420 talks about cheating, fraud. That's why we popularly say 420. That's the backstory. Okay, criminal law. What is criminal law? Basically, which speaks about matters which are serious in nature. Murder, theft, kidnap, all that will come there. So it's a criminal law. What is criminal law? It's a violation of the public rights. It's a public wrong. Adi answer public wrong, private wrong. Public wrong is if you do something, the public will lose confidence on the society and the government. Murder happens in this street yesterday at 8 o'clock. For the next 1 week, people will not use this road at 8 o'clock to 10 o'clock or the entire night. It will take lot of, what do you say? Fear, or it will take lot of time for people to heal and to overcome this particular thing. Agreed? That's the reason in criminal law, always remember that Nirbhaya case also, if you remember, Delhi gang rape incident, the case law was called, I think that person's name is Mukesh, the person who did, and it's gang. The case law is called State of Delhi versus Mukesh. Why isn't the family of the girl? Why is it State of Delhi? Carlil versus Carbolik, Balfour versus Balfour, Nirbhaya versus Mukesh, it should be, no? Why Delhi came?
Because it impacts a whole.
Criminal law should be fought by the government, not by the people. It is your wrong, not my wrong.
Criminal law will be fought by the government on behalf of you. Because if they do not fight, people will lose interest, scope, confidence over you. That's why it's called public wrong. Private wrong. Carlil versus Carbolic. Akka, you got influenza. What do I do? I will settle you. How? Money. Remember, second difference, criminal law. Can I come and say how rude will it be? Incidents take place. I'll give you 1 crore rupees. Keep quiet. Will you be okay with it? Murder happened. I'll give 1 crore for the family. Be quiet. Anyway, soul won't come. Will you be okay? No. Then what do you want? We want justice. Why that doesn't come? Because you want him to be punished. Here, death sentence can come. Imprisonments can come. Money does not solve your issue in criminal law. Civil law, bekagirode money. We want money. So whatever examples I was giving you yesterday, I told you also 1200 they came. Why? Now? Why shouldn't I still fight? Hey, Rama was come da. Hang him, sir. Money clears everything. Civil compensation is what you fight for. It's nothing to do with ego. Understood? Pakkana. So civil law is always a private wrong. Correct. Yes, sir. And civil law people, I don't know if you guys know, IPC, CRPC, CPC. There are 3 things. IPC, Indian Penal Code. CRPC, Criminal Procedure Code. CPC, Civil Procedure Code. There are 3 things. IPC, if you do murder, this is what is a penalty. If you do theft, this is what is a penalty. Everything is given in IPC. Sir, but within how many days should I go to court? How should I go? Which evidence should I give? Who and all should come witness? Cross-examination. How should it happen? What is CRPC full form?
Criminal Penal Code.
No.
Procedure Code. IPC says punishment. CRP says how to do this punishment. Next one is CPC.
So you studied IPC and all, sir?
Law, it will be there. No, you
Sure,
need...
sir. Criminal
No,
law,
you are like
lawyer.
All laws will be there, da. Now you are a CA. Are you studying only accounts? Same way, LLB is a ocean, da. One ocean.
They will tell you, sir, I'm civil lawyer.
I'll tell you one thing. Indian Contract Act is a subject in law. Subject, oh my God. Yes, sir.
You have a book.
Book. Then how much should it be there?
Sir, how do you remember all the laws, sir?
When doctors remember so much, the drug name and all, what is this, what is there in that? It is only from exam point of view, that's all. For me, I feel the biggest profession is doctor. You come with a problem, he'll write a prescription and give. Have you seen him referring Google? Then, isn't it really great? Actually try to think, he need to remember the compositions.
Sir, actually you could have become a doctor. You have a good memory.
Just because if I have memory power, if I become doctor, how many people... Correct that. 2 things I have traits of doctor. One is memory, one is handwriting. Both are good. So doctors, I do not mean to hurt you. Okay, it's clear. So one is CPC. CPC talks about Civil Procedure Code. Understood? Yes, sir. Next one is called as common law. Idiyas are common law. Common law is? Common. Common law is nothing but people. Now we'll see that. So there is something, there is a maxim which says stare decisis. Stare decisis. Yen sir, the stare decisis. Stare decisis means what, sir? Imagine people, one day you want to come from one place to another place. You use Google Maps and go. Now you got to know, one straight road, one right. That's all there is a tuition. Next day also you will use Google Maps. Huh?
No.
Why?
I know the route.
Correct. Stare decisis is you know the route. What do you mean by that? There is already a pre-decided case law which exactly walks in the same facts. Again, I need not hear the case again. Kyun? Take the judgment, copy paste. Example, Nirbhaya case, done. Similar incident won't happen? Happens. Take the case law, copy paste. Carlil versus Carbolic, copy paste. That's why you guys will be referring and writing, referring to the landmark judgment. What is that? Is only common law. Common law is nothing but, it's not a new law. Common law is nothing but whatever is already decided. Generally remember, what is decided in one high court will not bind another high court. Adral ego clashes ಇದೆ we have. Hey, we are same da. You might be different, I might be different. But if our superior says, then all of us have to listen. Sir, who is the superior? Superior is Supreme Court. Supreme Court judgments binds on all the high courts. But one high court's judgment might be referred by another high court, but it does not bind it. Understood? Pakana. Yes, sir. The last one is called Principle of Natural Justice. What is Principle of Natural Justice? Principle of Natural Justice means before you hang any person, give him an opportunity of being heard. That's all. That's all. You need to ask why, what happened. I hope you guys, I told you also, no, Ajmal Kasab. We arrested him when he was 17 years. We gave him all Atiti Sarkara. According to the Indian laws, we have to give an opportunity for any person to be, he needs to be given an opportunity to be defended in the court. Now imagine, Ajmal Kasab, will anyone automatically come and represent him? CCTV footage shows AK-47. When he is shooting, it is penetrating the pillars and the bullets are going that side. Imagine a person who is directly shot. I think you guys know that Mumbai, when they came in the port, in the first house, there is one shed, one normal, lower middle class people who stay, literally that port area I'm talking about. One person was having his food, these people went and asked for water. He gave water, they drank water and they have shot him. Imagine the bullet which can pierce the pillar. Imagine his body. Even today their family, I forgot the name. So in his memorial, they give water 24/7 in that house because of that good deed. So in spite of seeing all this, everything is there in front of you. Even last year one movie was also released, no, Major. The Sandeep Unnikrishnan story was made. He passed away. He sacrificed his life. In spite of all of this person survived in our jails for 3 years. And you know what? We said he should be appointed a lawyer. Lawyer should come and do court hearings. Lawyer applied for bail. Lawyer applied for mercy petition. Why? It is mercy. Please, Papa, forgive. Can't you forgive? What? He has killed 60 people. What? You can't forgive? And see,
Sir, so much big heart and all, we don't have for forgiving us.
Yes, so this is what happened. So it is nothing but principle of natural justice. You have to give an opportunity. Who says? Constitution says. Constitution is above everyone. It is above.
But if you have this thing with you, like you have the evidence, he is the one on the mistake. Why give him
Our
chance, sir?
constitution is being very too kind, sir.
I will not provoke you. I can tell you even hundreds of things like this. You know this Nirbhaya case, Mukesh?
That's what, sir.
You have seen that interview, huh? You have not. You have seen that interview, sir? No. See that interview.
Whose interview? Like,
That person who has done that incident, his name is Mukesh. He has given one press had taken his interview after the capital punishment being imposed. You see that interview. If blood doesn't boil, let me know. Yes. Okay. Next one. The last one, people, the third wing is structure of Indian judicial system. Indian judicial system, judicial is nothing but judge. What is the role? What are the functions of the judge? First one, regulation of interpretation of the acts and codes. IOS, CA Inter, very important chapter. IOS is nothing but interpretation of statutes. Lawmaker is not perfect. In law, there might be mistakes. Now in the court, what do I do? In the law, you have made mistake. One person has done something. What do I do? Should I say what he did is right? Should I say what he did is wrong? Courts help you interpret the law. Meaning they will try to say what did this person mean that day. 1872, the lawmakers died. The committee died. Everyone died. Now you have a question in this law. Whom will you ask? The court will give you the interpretation. Okay, this is what they might have meant.
Might have meant or meant?
Might.
Just guess.
Yes, interpretation, that's all. Next one, dispute resolution. Meaning, two people fighting, we will try to resolve the dispute. Third one, promotion of fairness amongst the citizen. Fight, come and we'll say, go on. We'll pat and we'll send. Types of courts. There are 4 courts. Technically there are 5, but yes, there are 4 courts. First one is called as Supreme Court, the highest court, the apex body of the country. Now if I have to go to Supreme Court, can you directly go? In the school, you had a problem, in your friend hit you. School days, you remember? Chalk piece of biscuits, we used to fight for that, pencil. You remember? Madam, he took my eraser, madam. You used to cry, no? Yes or no? Where did he used to go and say? First class leader, teacher, HM, principal, secretary, correct? There is an hierarchy. Can you directly go and say, Madam, Raju took my eraser, madam? Can you go and say that? Not possible. There is a hierarchy, you need to respect that. Agreed? But there is only one scenario where you can surpass the hierarchy. Rajnikanto, ange direct entry, VIP. When is that, sir? If your fundamental rights are affected, you can directly go to Supreme Court or you can directly go to High Court. Your choice.
What is
Fundamental rights, right to speak. I will lock you in this class and I lock the door and go. Can I do it? It is against your fundamental right of movement.
Right of expression also.
That's the reason arresting without a right is against your fundamental right. Police are not supposed to arrest you without a right. That's the reason arresting won't happen until there is a sufficient cause. Understood? So, you can go to Supreme Court whenever your fundamental rights are affected. Hey, where is it given, sir, that I can go to fundamental, I can go to Supreme Court? Where is it given? Article 32 of Constitution of India says you can directly go to Supreme Court. Remember, not for knowledge, not for exam, for knowledge it is important. Tomorrow when you are arrested, someday, imagine something happens. You can say, sir, Article 32 of Constitution of India. Police will say, oh my God, he knows law. Yes, sir. Sir, according to Article 32, you can go to Supreme Court. According to Article 226 of Constitution of India, you can go to High Court. Both speak about the same thing. If fundamental rights are affected, you can go to Supreme Court, you can go to High Court. Yes, sir. So the highest body of the country is called as Supreme Court. Chief Justice of India will sit there. Highest body of a state is called High Court. You can go there as per Article 226 of Constitution of India. The next one is called as District Court. It comes below High Court and deals with civil law. Civil law. Sir, murder. Where should I go?
High Court.
Court of Sessions will come with criminal law. Deals with criminal matters. Pecuniary jurisdiction of suits not more than 2 crores. Up to 2 crores you will go here. Beyond 2 crores you will have to go to High Court. Yes, sir. Sir, last one is called Metropolitan Courts. What is this, people? Have you seen metropolitan? Where do we use this word? Metropolitan.
Metropolitan
Cities is where these courts are. That's all. Understood?
The check bounce and all if you get case. from
Metropolitan.
the school.
Yes. That it was written. No, that only. They are established in metropolitan cities in consultation with High Court. Metropolitan cities where the population is 10 lakh or more is where they will constitute a metropolitan court. Where minimum population has to be 10 lakh or more. They have written long back, it is like that only. Now what? SG Palya has more than 1 lakh. What state I am talking about? Yes, sir. Understood? Yes. So that covered everything? High Court, so metropolitan, yes. So remember, judiciary important, law making procedure important, executive, I don't think for 1 or 2 attempts they will ask. They may also, but they will not ask Ministry of Home Affairs or Ministry of Finance and all. SEBI, IBBI, RBI and Ministry of Finance. These 4 might be important. So that's it. So try to remember these things and go. So by this we complete your content part. So let us directly see your RTPs. Yeah, we'll discuss of the RTPs first. Yes, you need a 5 minutes break or something, or we can do it off. We'll finish it off. We'll just finish off the RTPs only. Yeah. Okay. You guys only try to answer. I know you guys know everything. Let us put your knowledge into use. Okay. RTPs, chances of questions being asked from this is very high. At least 1 or 2 questions may come for your exam also. Remember and go. ICAI only. RTPs are ICAI only.
My RTPs were in this colorful here.
Then I think you would have taken the previous RTPs. These are the recent ones. Yes? Okay. So let's start, people. RTPs for your attempt. The first question, people, you have solved this? You guys have solved this? Just read da. Day. Answers ನೋಡಿದ್ಯಾ ಅಲ್ವಾ? ಮತ್ತೆ ಇನ್ನೇನ? ಲೈಟ್ ಆಗಿ ನೋಡಿದ್ಯಾ? ನಾವೇನು ಕತ್ಲ ನೋಡ್ತೇವೆ. Okay. Indian regulatory framework. What do you understand by Indian judicial system and what are its various functions? What is Indian judicial system? Just now we saw the last part. What is Indian judicial system?
It is the system of judges.
It's a judiciary, it's a third organ of the government. What are the functions? What does it do? Technically, the judiciaries are classified into 4 things: Supremo, High, District, Metropolitan. And what are the functions? Interpretation of law,
Solve disputes.
Dispute resolution, maintain fairness amongst the citizens of the country. Correct? Done.
Sir, what are the various functions? We have to talk about Supreme, High.
Functions is not that. You will be writing about the judicial system, you will write high, so that and
You
all.
have to explain those also.
Here they have just asked you what do you understand by Indian judicial system. You need not have to go in detail. What if they are asking you what are the different types of courts? You might have to say that. And people, one more thing, that laws, different types of laws. Try to remember that and go. Yes, sir. That they may ask. Next one, Mr. Parth applied for a job as principal of a school. The school management decided to appoint him. One member of the school management committee privately informed Mr. Parth that he was appointed but official communication was not given by the school. Later, the management of the school decided to appoint someone else as a principal. Mr. Parth filed a suit against the school for cancellation of his appointment and claimed damages for loss of salary. State with reasons will Mr. Parth be successful in suit filed against school under the Indian Contract Act 1872. So the reason here is an acceptance has to be communicated by the right person. It cannot be informal communication. Communication has to be formal by the designated person. It cannot be random person who has to give an acceptance. On those grounds, you will write the provision. Facts will be the same. Parth applied, Parth got informal acceptance, and later they said it is rejected. Now what will happen to the Parth scenario? Conclusion you will write, referring to the provision and facts of the case, you have to ditto use the same words. Mr. Parth will not be successful in his suit filed against the school as per this provision and the scenario. So use the same words, don't use anything else. Clear? Okay. Third one, Sarthak is employed as a cashier on monthly salary of 50,000 by ABC Bank for a period of 3 years. Mohit gave surety for Sarthak's good conduct. After 9 months, the financial position of the bank deteriorates. Then Sarthak agrees to accept a lower salary of 40,000 per month from the bank. 2 months later, it was found that the Sarthak had misappropriated cash from the time of his appointment. What is the liability of Mohit taking into account the provisions of Indian Contract Act 1872?
Mohit was not liable because change in the terms and conditions.
Correct. So, where does this come? Simple, people. I'll explain the scenario. Okay, there is A. A has taken a job in B's place For this, C has given a guarantee. You remember yesterday the CA scenario, I give a reference. Now, in this contract, yesterday we had seen one thing. Whenever there is a variation in the terms of the contract without asking my approval, if at all any changes happen to this contract, then automatically I will be discharged. Now in this case, what they are telling, Sarthak was there in the company for how many days?
9 months.
After 9 months, the financial position of the company deteriorates. Then Sarthak agrees to accept lower salary per month. 2 months later, it was found that Sarthak had misappropriated cash from the time of his appointment. What is the liability? So, since the day of his appointment, he has been doing misappropriation. They are telling you whether Mr. C will be liable. So, imagine, they have said 9 months he has taken one salary, plus 2 months later, they found that since the date of his appointment, he has been doing misappropriation, fraud.
But for first 9 months, C is the surety now, sir. After 9 months only, C is live.
Perfect. Whenever variation happens, so I will be discharged. For 9 months, there was no variation. No, I will be liable for whatever is salary into 9 months. For 2 months, where the variation happened without my approval, for this I will be discharged. Understood? Nice. Analytical brain. Okay. Rahul was a DJ at a 5-star hotel. As per the contract, he is supposed to perform every weekend. Rahul will be paid 2,500 rupees per day. However, after a month, Rahul willfully absents himself from the performance. Taking into account the provisions of Indian Contract Act, answer the following. So there was a contract for me to come and perform. In between, I absent myself. What and all will be the scenario? Does the hotel have the right to end the contract? Can they end the contract? Yes. Repudiate the contract. You have a right. If at all the other party fails to perform. Okay. If the hotel sends out a mail to Rahul that they are interested to continue the contract and Rahul accepts, can the hotel resign the contract after a month on this ground subsequently?
No, they cannot.
Once you accept it, you cannot later go and point out the same mistake. So, no, you cannot undo it later. Third one, in which of the case, termination of contract or continuance of contract, can the hotel claim damages that it had suffered as a result of this breach?
In termination of contract, they can claim damages, but in continuance of contract, they cannot, because they have only asked him to.
Come and perform the other way. Yes, sir. Chandan, yes, sir. Hela. Tilda. Adanena. Yes. So, whenever you have agreed for something else, then yes, you settle it accordingly. What do they say? Sir, can you say the conclusion to the last question? Which one? This one? Conclusion is, see where they would be writing it. What is the liability of Mohit taking into account the provision? So, the liability of the Mohit will be for 9 months. You can even say whatever is the salary or whatever is the default that has happened. They have not given what is the default. So, I will be liable for the 9 months default. For the rest of the 2 months, Mohit will not be liable. That will be my conclusion. Yes, sir. Here, yes, you got this, sir. Okay. Next
So,
one.
So now, for this, the fourth question which we discussed right now. So, it has 3 parts now. So, like when I'm writing the provision of law, like for the first one, does the hotel have right to end the contract? No, they do not have right to end contract because of so and so. So, like for all the 3, I have to give the provision in the first paragraph.
Correct. So, when you are writing, there are 3 sub-questions. How will you answer? First thing, always remember, when there are 3 sub-questions, the questions will relate to the same topic. It will not be related to multiple topics. So, your provision of law will always be same. My provision will be what is the right and what does it happen. And I will write fact. Conclusion 1, conclusion 2, conclusion 3. I will write yes, so, no, whatever is the scenario. Clear? Yes, sir. If you want, you will just see one example. You see this only. Which one? Fourth one, na? So they would have written provision, Section 39 of Indian Contract Act, it is understood that when a party to a contract has refused to perform or disabled himself from performing his promise, the following two rights accrue to the aggrieved party: to terminate the contract or to indicate by words or by conduct that he is interested in its continuance. In either of the two cases, the promisee would be able to claim damages that he suffers. And they will write again conclusion. It's clear?
Yes, sir.
Next one, people. Examine whether the following constitute a contract of bailment under the provisions of Indian Contract Act. Vikas parks his car at a parking lot, locks it and keeps the keys with himself. Seizure of goods by customs authorities. They're asking you, does these two amounts to bailment?
The first one is not bailment.
Now imagine there is Arivu premises. This is Arivu. I come in a car, I keep my car here, I go to have my coffee, or I say that I'm traveling this week, I'm going to Chennai. I'll keep the car here, I'll board the bus, I'll come back after a week, I'll take my car. For this 1 week, will this be considered as bailment?
No, it is
Why?
not. Sir,
Keyword.
Because you have not informed the authorities of ArivuPro.
Imagine I've informed. Is it a bailment?
No, sir, because there is no.
If I get the word, I'll give you the mark. I'll tell you what is the power of the keyword. So is it a bailment or not? Ninu answer odidre helpida.
There's no like.
Iskamran.
You don't get anything in return, no, sir.
Bailment, you need not get anything in return. No, gratuitous bailment can also be there. What is the main word? If I keep my gold in a bank locker, I keep the keys. Is it bailment? Yesterday we had seen this example. I keep the gold in the bank locker, I get the keys. I don't give it to the bank, right? Is it a bailment? Why? Because it's like that only, sir. Yelladukku there will be no why.
No, because the control is with you.
That's a word.
Control. Or you say for control.
Remember here, custody. Custody is there, you will get 1 mark.
No custody, no one.
No custody, no 1 mark. Yes, so yes or no has an answer. I'm not saying no. If it is a 5 mark question, you might get 1 mark for yes. But for the provision, you will get the marks. That is the point. Seizure of goods by customs authorities.
The custody is taken by the customs authority, so it is a
Again, you will say custody. Do not overlap custody and possession. Control Allah. One is possession, one is custody. Custody means you do not have control. Possession means you have control. Customs authorities, do they have control over the seized goods or not?
They have.
They have. So this is bailment. What is this understood? Imagine you imported some car. You have to pay some import duty. You did not pay. What do? They seize it. They will give you notice. You have to file. If you do not, ultimately it will go for auction. So this is what I tell you. It is your goods, but it is with them. Correct? No parking. Bailment? Is it not bailment?
Not.
Okay. Mr. Sanjay Kotari was a big businessman having 2 sons and 1 married daughter. He decided to gift his house to his daughter.
This one last time.
ಗೊತ್ತಿರೋರಾ ನಿಮಗೆ? For this purpose, ಅಲ್ಲಿ ನೋಡಿದ್ಯಾ? ಗೊತ್ತಿರೋರೇ ನಂಗಂದ್ರೆ. He called his lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of document, they met an accident and both died. Later, the daughter found the document and claimed the house on the basis of that document. Explain whether she can get the house as gift under Indian Contract Act or not.
No, sir, she cannot because it's according to natural love and affection. It should be in writing. It should be registered.
So my answer will start from technically for a contract to be valid, there has to be quid pro quo. Agreement should always be supported by a contract. However, there are some exceptions, and one such exception is natural love and affection. However, under natural love and affection, if a contract is to be valid, it has to be written, signed, as well as registered.
Party should be near relation.
A near relationship, it has to be signed, it has to be written, and it has to be registered. Whereas in a given scenario, near relationship, yes sir, signed, yes sir, registered, no sir. Now because of that, I cannot say that it's a valid contract. In this case, again repeat the same thing. Whether she can get the house, no, she cannot get the house under the Indian Contract Act. Mr. Ayush, most of you will ask another question here. Sir, they have used the word gift here, no sir. Why can't we write it using the gift? Remember people, whenever you are reading a question, you will get the keywords of two provisions. Gift is just one part. The rest of it will become the other part. They are clearly writing you, it is not registered. They are clearly writing you, they are in near relation. So you should not see it from the gift perspective. You have to see it from the natural love and affection perspective. It's clear? Okay. Mr. Ayush, the employer induced his employee, Mr. Bobby, to sell his one-room flat to him at less than the market value to secure promotion. Mr. Bobby sold the flat to Mr. Ayush. Later on, Mr. Bobby changed his mind and decided to sue Mr. Ayush. Examine the validity of the contract as per the provisions of Indian Contract Act.
Undue influence.
Pooja has a question. Sir, she can only go it register, na sir. As the instrument is already signed. That is not how it happens. When you want to get the instrument registered, the parties has to stand in front of the registrar. You cannot get it signed from someone and you cannot go. That is not accepted. Clear? Okay. Yes, people? Undue influencer. Because they are employer-employee. One party is taking the dominance, he is abusing his position also because he has said if you give only you will get the promotion. So yes, answer, conclusion will be same thing. Validity of the contract. The contract is voidable at the option of Mr. Bobby because the contract is induced by undue influence. Very good. Mr. Suraj promises Mr. Manoj to paint a family picture for 20,000. And assures to complete his assignment by 15th March. Unfortunately, Mr. Suraj died in a road accident on 1st March 2023 and his assignment remains undone. Can Mr. Manoj bind the legal representative of Mr. Suraj for promise made by Mr. Suraj? Suppose Mr. Suraj had promised to deliver some photographs to Mr. Manoj on 15th March 2023 against a payment of 10,000, but he dies before that day. Will his representative be bound to deliver the photographs in this situation? Decide as per the provisions of Indian Contract.
There are two questions, no, sir.
Very good.
So
I will give you one clap for recognizing there are two questions. No, that is correct. Correct. First part is correct.
So, according to the first sequence, the legal representative will not be binded because it is a personal skill.
Once the person dies, the contract becomes void and it includes personal skill and so it cannot
So the legal representative.
See, what is the right way? Whenever a person dies, we will first refer the contract. Does the contract say that the legal representative will be bound by it? If at all nothing is given, then we will go to the section. It says, by default, whatever a person does, the legal representatives will be bound by the contract. Whatever it is, they will be bound by it. Unless and until a special skill or talent is involved. Now, referring that, the first point, what is it? Drawing. Obviously, I cannot expect another person to draw on those grounds. Whether can you, what is that? Bind the legal representative. Word is given there only. No, Macha, you cannot bind the legal representative. Second scenario, he has agreed to give some photographs in his home to Mr. Manoj.
It does not involve any personal
That's there is one photograph there. I am telling you, Macha Picasso. Take the. If at all, are you getting what does this mean? Now imagine this belongs to. Let us imagine a person whom I know. Now I am his legal representative. If at all anything happens according to the contract, can I give it in his place? Yes, I can give it. It's materialistic. Is any skill involved in this? The answer is no. I am liable to give this to the other person according to the contract. I cannot stop. Unless and until some special skill is involved.
So one doubt.
Huh.
Mr. Suraj, okay, before he delivers the photograph, he dies. So at that point, that contract comes to an end. Again, a new contract will be found between Suraj and the person who is buying the photographs, right?
Correct. Or you can take it this way. Whatever not new contract will come, whatever was left in between will be completed by the legal representative.
Okay, so when he dies,
New contract won't be placed. Correct. Is this clear? Yes, sir. Okay. Explain the term quasi-contract and state their characteristics. Quasi-contract, even though the essential elements are not present, still there comes a contract in place. And what are the other essential elements of quasi-contract? Other essential elements are not agreed. There is no promise, there is no consideration. Quasi-contract. What is quasi-contract? Similar to contract. Okay. Prakash reaches a sweet shop and asks for 1 kg of barfi. If the sweets are fresh, seller replies, sir, my all sweets are fresh only and of good quality. This is regular, no? Bakeries and all, if you go, you will ask, one fresh bread kodi. Sir, eek madiddu, sir. Prakash agrees to buy on the condition that first he tastes 1 piece barfi to check the quality. The seller gives him 1 piece to taste. Prakash, on finding the quality is good, asks the seller to pack. On reaching the house, Prakash finds that barfi is stale, not fresh, while the piece tasted was fresh. Now Prakash wants to avoid the contract and return the barfi to the seller. State with reasons whether Prakash can avoid the contract under Sale of Goods Act.
Yes.
Will your answer be different if Prakash does not taste the sweets?
yes, Prakash can avoid the contract under Sale of Goods Act because according to sale by description and sample, he has checked and the single barfi did not correspond.
He is
to the
single.
The product
Correct.
did
Now
not
you said the word. The word keyword I will be seeing here is the sample does not correspond to the bulk. Tasted was fresh. Bulk was not fresh. You should be given an opportunity to check. If the sample does not meet with the bulk, you have a right, you can go and give back it to the person. Implied condition, no. You have to write it as implied condition, no. Okay. Will your answer be different if Prakash does not taste the sweet?
no, sir, till see. Even then, he can avoid the contract because it should correspond to description. Because
What is the description? Barfi only, no?
no,
No,
sir,
he
he
said
said it is fresh.
Fresh. Yes, sir.
He specified his need. What do you call this word? He specified his need.
That the barfi should be fresh.
So one is, yes, description. You are selling it as fresh sweets. It did not meet with that. Technically, I mean, you can, Mr. Suraj's family refund back. Suraj, who is Suraj?
Manoj Suraj.
Suraj will not be liable for the painting. Suraj will be liable for the photographs. You have to deliver the photographs because father had taken the money. You are supposed to give back the photographs. Yes, sir. People, this one, I hope this is clear. First one, yes, sir. State with reasons, sir. Because the bulk did not correspond to the sample. Will your answer be different if Prakash does not taste the sweets? No, my answer won't be different because the sweets did not correspond to the description. Sir, what if he never said? I only asked, give me the fresh sweets. Then quality or fitness will come. Because I am giving you my criteria. Sir, what if nothing is weighed, sir? He also did not say fresh sweets, sir. I just took it and went. Then,
Give it
Allah.
Come again, ask the question again.
I did not ask. I said pack this 1 kg. I took home. He never put it as fresh burfi.
You cannot go talk to ask him only.
You tell me, wherever you have gone, you have taken sweets, every place you have tasted, then first of all, do we know that they will give for taste and all?
No, implied condition, trade usage. What is that? There is some one point.
No, here will I get it or not?
You
Who will go and buy
can.
Imagine you are buying a sweet, you packed it, you went home and it was stale. Now what do you do? Huh?
You have the right to come return it.
Yes or no is not an answer. Grounds. You know what are the implied condition. Under which ground, tell me?
Quality,
I never asked only.
trade usage. There is merchantability.
Very nice. Wholesome. Merchantable is used for goods. Wholesome is used for edible products. One tomato. No sir. Yamla baratte sir. Wholesome. The product you get has to be edible. Stale is that is not right. It is stolen. Sorry, stale. Then how will you do? Zomato order. If you get a stale chutney, what do you do? That's what they are saying. Next one. I hope you understood. Here also you can return. Here also you can return. Correct? Akansh purchased a television set from Arvind, the owner of Gadda Electronics, on the condition that first 3 days he check its quality and if satisfied he will pay for that, otherwise he will return the television set. On the second day the television set was spoiled due to an earthquake. Same example we have seen in the class also. Much of an earthquake will come, your TV only will go inside. What will you do? Understood the scenario, na? There was a TV given on a condition, it seems. You tried 3 days. If at all you like, give me the money. If not, give it back. Second day when earthquake came, one TV was kept. No, there only the earthquake came, your TV went inside. Now they are asking you who will bear the loss.
The seller will only bear the loss. The Gada Electronics person will only bear
Why?
the loss. Because it is first thing is it's sale or return basis and if the ownership did
The
not
first answer goes to provision. Sale or return basis. That is correct. Sale or return basis. Now what you will say? In sale or return basis, when does the ownership pass?
In 3 cases,
Has he accepted?
no.
Is the time period over?
No.
Has he done any equivalent to acceptance? Then where did ownership pass?
There only it is there, sir. It is not passed yet.
Now, the second thing, whenever you have someone's goods in your possession, now what is your duty? Reasonable care. Your duty as a bailee will come into picture. Reasonable care means what? Should I go into the earth and bring back your TV? Correct? Entire my products also fell inside. My table also fell. I took reasonable care. In earthquake, what? Or I have to hold both earths. Come this way. What can I do? So, reasonable care was taken. Understood? So, in this case, the liability is on the seller because the ownership is not yet passed. I will write risk prima facie transfers with ownership. Sir, idella baribeka sir. I hope you are getting.
Sir, like you told us, risk prima facie that one, and then can I give only sale or return basis, or I have to give that bailee thing also? Provision.
Like
5 marks. See if you can write one side how much you can fill. Sale or return basis, 3 condition. Also in conclusion, just add that one point. The person's liability, duty as a bailee does not come to an end as long as he has taken a reasonable care. But this was beyond his hands. This was beyond his what he can correct. So the bailee will not be held liable. It is a seller who will be held liable. Mr. Arun contracted to sell his Swift car to Mr. Nikhil. Both missed to discuss the price of the said Swift car. Later, Mr. Arun refused to sell his Swift car to Mr. Nikhil on the ground that the agreement was void. Being uncertain about the price, does Mr. Nikhil have any right against Mr. Arun under the Sale of Goods Act?
If the price is not discussed, they could probably settle on reasonable amount of price now, sir.
Understood the question? A and B, they agreed to, A agreed to sell his Swift car to B. B agreed for that also. But they never negotiated on the price. Both of them never discussed. On this grounds, A is telling, I want to cancel the contract.
No, Nikhil can take has a right against Mr. Arun because the contract is not void. The agreement is not void because even if the price is not discussed, they can agree on a reasonable price for the car and they can continue with the contract.
The provision I will write is ascertainment of a price. How will I have to ascertain the price? How will the parties decide the price? First one is by contract. If not, based upon the course of dealing between the parties. The third thing, when the price is not discussed, the buyer has to pay a reasonable price to the seller. So, sir, buyer can pay reasonable price to the seller. Now, what is reasonable? You open, you see how much is the other cars manufactured during the same year, how much are they quoting? Now, that will become reasonable price. And the fourth one we saw was valuer. Yesterday only we discussed some story and all they will tell. Understood? So, here can he do?
Explain all the 4 points in the provision of law, then I have to give the facts, then I correct.
Correct, yes.
All the 4 points completed.
Easy only, no?
Easy only.
As long as if it is not going way too big, do not invest all your time into one answer. Remember that. Be conscious on your time. That's the only thing I always say. Clear? You cannot invest. Try to divide 100 marks by 180 minutes. You will know what is 1 mark can take your time. 1 5-mark question will come not beyond 7.5 minutes. That's the maximum you can spend. So you imagine if 15 minutes is gone, you have consumed 2 questions time there. And don't think, sir, how will we practice from now then. Yes. What is the answer? Mr. Nikhil have any right against her? Yes, he has a right by paying a price which is reasonable. Online? Okay. Mr. Shankar sold 1000 kgs wheat to Mr. Ganesh on credit of 3 months. Okay, he sold wheat 3 months. Okay. Wheat was to be delivered after 10 days of contract. After 5 days of contract, a friend of Mr. Shankar secretly informed him that Mr. Ganesh may default in payment. On the information of friend, Mr. Shankar applied the right to lien and withheld the delivery. With referring to the provisions of the Sale of Goods Act, state whether Mr. Shankar was right in his decision. What would be your answer if Mr. Ganesh became insolvent within 15 days of the contract? First thing in the exam, take a pencil. When you are reading the question, write off the characters. Shankar sold to Ganesh. Write off the details. If not, you will have to read the questions again. It's a small one, okay. If it's a big one, it will take time again.
Are we allowed to write down question?
Pay pencil, that's the reason. After you, question paper Allah, answer sheet, wherever you are writing the answer, write it on the right side and just erase it off. Yeah, and do not make it, what is that? That imprint should not be very big and all. So, lightly write it down. Yes, don't write anything on question paper. That is an, what is it? It's an offence, punishable offence.
The right to lien can be exercised on 3 points. Goods not sold on credit.
Okay, goods not sold on credit. Here is it on sold on credit? Yes. So first ground doesn't come into picture. Second one?
If the credit term has expired.
Has the credit term expired?
Within the credit term he has taken action.
Credit term is 10 days. He has taken action within 5 days. Whatever is action, is it teenable? No. Because he should wait for 10 days and it's an informal communication.
And if
Will your answer? What would be your answer if Ganesh become insolvent?
yes, the
Right to lien can be exercised when he becomes insolvent. Here yes, so here no. Agreed? Here he can exercise right to lien. Here he cannot exercise right to lien. Here he can exercise right to lien. Clear? So my provision will be this. What? Right to lien can be exercised when the goods are not sold on credit basis. If sold on credit basis, the credit period is expired.
It is sold on 10 days, 5 days only, then how did you decide? You gave him 10 days, he might bring some from somewhere. Third one, insolvent. Yes, sir. So that will be my provision now. Facts you will write to the same thing. Conclusion 1, no? No. Conclusion 2, yes. Indian partnership, Moni, Tony, were partners in the firm, Moto and company. They admitted Sony as partner in the firm and he is actively engaged in day-to-day activities of the firm. There is a tradition in the firm that all active partners will get a monthly remuneration of 20,000, but no expenses, but no express agreement was there. After admission of Sony in the firm, Moni and Tony continued getting salary from the firm, but no salary was given to Sony. Yado idu Tony Moni. Sony claimed his remuneration, but denied by existing partners by saying that there was no express agreement for that. Whether under Indian law, Sony can claim remuneration for the firm.
Yes, Sony can claim remuneration
Provision,
for the firm. Because since it is a, sir, can you come a little listen? Since it is the tradition of the firm that all parties will get monthly remuneration, even if it's not expressly told, it is an implied agreement that she should be getting.
So the partners will be entitled for remuneration in two cases. One, if the agreement expressly provides. Second one, people, it is a tradition or the custom of the firm to pay the salary. In this case, it was a tradition or the custom of the firm. On those grounds, yes, Sony will be eligible for remuneration. Okay. Oh my God. Yen Guru is
Right to remuneration, by default there is no remuneration.
No.
Secondly, it should be
Agreement. Third one is by tradition. Tradition is what? They do not have right to pay remuneration according to the agreement. But these people been drawing salaries. Moni and Tony have been drawing the salaries. So it is in the tradition of the firm. It's a custom they are following. Mr. Ram and Mr. Rahim are working as teachers in Ishwar Chand Vidyasagar Higher Secondary School and also very good friends. They jointly purchased a flat which was given on rent to Mr. John. It was decided between landlords and tenant that the rent would be 10,000 per month, inclusive of electricity bill. It means electricity bill will be paid by landlords. The landlords by mistake did not pay the electricity bill for the month of March 2021. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 and 200 as a penalty to resume the electricity connection. Mr. John claimed 3,000 from Mr. Ram, but Ram replied that he is liable only for 1,500. Mr. John said that Mr. Ram and Mr. Rahim are partners, therefore he can claim the full amount from any of the partners. Explain whether under the provision of Mr. Ram is liable.
Firstly, Mr. Ram and Mr. Rahim are not partners, they are just co-owners.
That's all. Keyword. You get that co-ownership right, you will get 2 marks. Next.
And the second thing is that, what is the question? Mr. Ram is liable to...
He is telling I am liable only for 1,500, I am not liable for the entire 3,000.
No, Mr. Ram is not liable to pay the whole amount to Mr. John because they are just co-owners. So, Mr. Ram is liable only for 1,500 and Mr. whoever is
He'll pay. Okay. So what are they saying, people? Because they are co-owners, they are not partners. You can say, as there is no agreement, as there is no business involved. So you need to say, as all these things are not there, true test of partnership, section 6 says they do not have partnership between them. Then what do they have? They have only co-ownership. In co-ownership, I am liable only for my part of the liability. I will not undertake the entire liability. If it was partnership, I will be liable for everything. So according to that, I am liable only for my share. For the rest of the 1,500, he will be liable. You need to collect from him. So in this case, what he can collect it, people, is only 1,500. Is this clear? Online, understood? Yes, co-ownership has to be there. Good. Next one. X and Y, people, the same, I can route it towards the Indian Contract Act also. Now imagine John paid the electricity bill on behalf of the landlords. Can the John collect the money from landlords? Whenever he is a interested person. Correct? I told you also. Arivu, yesterday we had seen quasi-contract it is. Understood? So you can see the same question in quasi-contract grounds also. X and Y were partners in a firm. The firm was dissolved on 12th June 2022, but no public notice was given. That is only the question probably. Thereafter, X purchased some goods in the firm's name from Z. Z was ignorant of the fact of dissolution of firm. X became insolvent. Z filed a suit against Y for recovery of his amount. State with reasons whether Y would be liable under the provisions of Indian Partnership Act.
If yes, Y will be liable because they did not give public notice that the firm was
If
dissolved.
he was an active partner.
Remember, notice has to be given whenever a active partner resigns. You have to give a public notice. Dissolution also will be effective only upon giving a public notice that the firm is dissolved. We would have seen an example also in the class when we are doing with the dates. We would have seen this. So sir, until the public notice is given, the firm will continue to be liable. In the case of active partner also, in the case of dissolution of firm also, Y will be liable. Yes. Opa, again that question. ABC are partners of a partnership firm carrying on the business of construction of apartments. B, who himself was a wholesale dealer of iron bars, was entrusted with work of selection of iron bars after examining its quality. As a wholesaler, B is well aware of market conditions. Current market price of iron bar was 350 rupees per kg. B already had 1000 kgs of iron bars in his stock, which he had purchased before price hike in the market for 200 rupees per kg. He supplied iron bars to the firm without the firm realizing the purchase cost. Is B liable to pay the firm the extra money he made, or he doesn't have to inform the firm as it was his own business and he has not taken any amount more than the current prevailing market price? Assume there is no contract between the partners regarding the above. I'll summarize.
Yes, B is liable to pay the firm the extra money because
I'll explain you. ABC firm. B, AC will tell B, it is your duty to go and purchase iron for our raw materials. B also has his own business. And what is that business? Again, it is into iron only. Now, during the current market scenario, the iron prices are rocket high. It has reached 350 rupees per kg. Now, B has purchased iron in the last year before the price hike. He has purchased it for a price of 200 rupees per kg. Now, anyways, he has been given a ownership of buying the iron. What is he doing? His business iron only, he is bringing into the business of the firm. And he is selling it at 350 rupees per kg. They are asking, should be disclosed to the firm that I got the iron from my own business and I have charged 350 rupees per kg and I got it for 200 rupees per kg. All this should he disclose, or he need not disclose because he is being fair. I got it at 350, whatever is the market price. Should I disclose?
not disclose because he's not using any of the their partnership firm's property, or so it's not like a secret profit, it's his personal profit.
I think he should disclose.
Why? I think, sir. Nimge yaake? I think.
Sir, he should not, because if he was selling the same thing for some other person, means he would sell it for 350 also.
Correct. So, if it's the same price, fair price, he should not disclose. Okay. Remember people, yesterday what did we say? We never discussed a partner can make legal profit or illegal profit. What is the word I used? A partner is not supposed to make secret profits. Word, keyword. Is it a secret profit?
No, it's not.
Why? At what price did you buy? How do I know? You disclose and tell, no? That's the first one. Now you are saying it is not connected to the firm. That's what you said. Yesterday I told you, if you do any business using the transaction of the firm.
But how is a transaction?
It's now I was given an duty to go and buy the iron. It's a transaction of the firm. In this, if you are making a personal profit, it is firm's transaction, right? It is not that it is not related to the firm at all. In that only you are making a profit. Now the second thing will come. What is that? Secret profits. So what is a duty? You have to disclose and do it. Yes, sir. So whenever you are making money out of the transaction of the firm, yesterday I don't know where we saw that. One more example also I told you. I think the book, paper, bundle or something, I don't know. Or I will come and teach in the night. Transaction of the firm, using firm's property, using firm's network. And the second thing is secret profits. Nowhere I have said legal, illegal. Secret profits is the word we used. Agreed? So you have to disclose. Convinced?
Yes, sir.
Convinced? Kamran? State the modes by which a partner may transfer his interest in the firm in favor of another person under the Indian Partnership Act 1932. What are the rights of such a transferee?
Transferring rights.
See, how and all you can transfer people? You can transfer it by sale. You can transfer it by mortgage. Meaning what? Now whenever I have shares, I can go and pledge my shares in the bank and I can borrow money. In the same way, when I am a partner, I can pledge my partnership interest and I can borrow money. If I do not repay the loan, whoever is the person, lender, he will become the partner. So how and all I can transfer? I can transfer by sale, I can transfer by mortgage. And what are the rights of the transferee?
He's entitled for
His share of the profits in the firm. What and all he is not entitled to?
He cannot interfere in the country.
Interfere, inspect accounts,
Only entitled to
receive the profits. But he will be entitled for the accounts from the date of dissolution. Correct? All this has to be there. Next one, LLP. A and B were friends. Now they have plans of setting up a supermarket in their locality. They are confused as to whether register as a traditional partnership or a LLP. As an advisor, enumerate the differences between the two forms of business, highlighting the compliances and legal formalities. What is that? You have to give a difference between partnership or LLP. Machis. Remember one thing. Never have this mindset. 5-mark question. Each point will give me 1 mark. So I should write 5 marks. So Allah. If you look at guideline answer, in your book if the differences given are 20 points, you are expected to write all the 20 points. That's how the guideline answer is given. So what am I trying to tell? If your end of thinking capacity is coming to 7th point, try to write 1 more point. And never think 1 mark is equal to 1 point. That logic is not right. Yes, and whatever we discuss, they have not given, might be for around 5 or 6 marks. Yes, but everything is expected to write. So today only we discussed, I am not going into that again. Difference between partnership and LLP. Companies Act. Mr. Dhruv was appointed as an employee of Sun Moon Timber Private Limited on the condition that if he were to leave, whenever a company is given, try to look at the name. Not every time, but sometimes it will have a reference. It's a private company, but I'm just telling you. On the condition that if he were to leave his employment, he will not solicit customers of the company. Solicit the customers of the company. Which case law?
This is no.
If he has to leave the company, he should leave the company, but he should not.
His wife and his
What is the case law?
Sir, which corporate name, sir?
Which corporate villa? Something horn. Glyph.
What is horn? HORNE, that corn.
HORNE na sir. I thought bike horn. I only tell you then. Why will it try? Clifford Motor Company versus Horn. Automobile industry, da. I think that only, let us see. After some time, he was fired from the company. He set up his own business under the proprietorship and undercut Sun Moon Timber Private Limited prices. On the legal advice from his legal consultant and to refrain from the provisions of the breach of contract, he formed a new company under the name of 7-Star Timbers Private Limited. In this company's wife and a friend, facts also same. That only I am not continuing. It is Clifford Motor versus Horn. Let us see what is the last one. Seven Stars Timbers argued that contract was entered into between Mr. Dhruv and Sun Moon and company as a separate legal entity. 7-Star Timbers Private Limited has not violated the terms of agreement. Explain with reason whether separate legal entity. Understood?
Lifting of corporate wheel.
You will be writing lifting of corporate wheel,
Formed for
fraud,
improper conduct
or evade the law. You will be writing this. Clear? Case law, very very important. Clifford Motor versus Horn should be there. That is when you will get the marks here. Okay, next one. AK Private Limited has borrowed 36 crore from BK Finance Limited. However, as per memorandum of AK Private Limited, the maximum borrowing power of the company is 30 crore. Examine whether AK Private Limited is liable to pay his debt. State the remedy if any. Ultra-virus transaction. 36 is what you are authorized to do. You have borrowed. Allah. 30 is what you are authorized. You have borrowed 36 crore it seems. The directors have borrowed 36 crore. They were authorized to borrow 30 crore. They are asking you what is the remedy available.
The remedy for BK Finance Limited is they can hold the directors of that AK Private Limited.
That's all. They have gone beyond their scope. They can hold the directors liable. Company will be liable up to the extent of 30 crores. Because it's a money, it is obviously severable. Mike LLC incorporated in Singapore. Having an office in Pune. What it is?
It is the body corporate.
Incorporated in Singapore, having office in Pune. Foreign company. Analyze whether Mike LLC would be called a foreign company as per the provisions of law. Also explain the meaning of foreign company. So what you will write? First you will write the definition of foreign company. Foreign company, any company which is registered outside India and has a place of business in India, physically or through an agent or through electronic mode. In this scenario, yes, this company will be considered as foreign company.
So this can be maximum 4 marks.
3 to 4. Sachin bought 1000 kg rice from Saurabh for 1,50,000 on 3 months credit. For this purpose, Sachin issued a promissory note to Saurabh on the same date, payable after 3 months. On the date of maturity, the promissory note was dishonored. Saurabh filed suit for the recovery of the amount plus fees of advocate paid by him for defending the suit. Referring to the provisions of the Negotiable Instrument Act 1881, what amount could be recovered by Saurabh from Sachin?
1,50,000 plus 18%.
Not 18%, the expenses.
You are eligible to take under the rules of compensation. You are eligible to take the amount mentioned in the instrument, noting, protesting, expenses. If at all it is endorsed, you can also claim 18% rate of interest until you recover the money.
But here they have not endorsed. So you have to, how to write the answer for this, sir?
First I will write the provision. The provision is according to the rules of compensation. I am eligible to take the amount mentioned on the instrument. I am allowed to take the noting charges, protesting charges, any other expenses involved. And whenever an instrument is endorsed, the endorser will be entitled to 18% per annum as an interest until the date of payment. So in the given scenario, all this can be collected. Yes, sir. Clear? Online? A purchased a watch from B. He issued a promissory note to B which was payable on demand, but no specific place for payment was mentioned on it. On maturity, B did not present the promissory note for payment. As the promissory note was not duly presented for payment, whether A would be discharged from liability under provisions of Negotiable Instrument Act 1881.
Since
Okay, since no place was mentioned, you can present it wherever you find him. Okay. Technically, what will we say? If no place is present, you will go to the business. Business. If no place of business, you will go to the residence. If no residence, then on street to throw on the face. Order is important. Okay. Next. As the promissory note was not duly presented for payment. He did not give it for the payment. Whether A would be discharged from liability under the provisions of Negotiable Instrument Act.
If A tried to reach for B and B
I tried to call you, you disconnected. The four grounds, whatever we discussed today only, that is the answer.
purposefully ignored him, then without presenting only A is liable to pay.
He stopped from presentment on the business day. He was closed. You told me to come to Imperial Bank of Rangoon. I came. You did not came. Correct? So these grounds are whether you give me the instrument or not, it is not going to make a difference in my life. What is the provision? Presentment. When is it unnecessary? Today only we saw last topic, negotiable instrument. That only. And if you whether give it to me or not, it is not going to make difference in my life. Check bounce, I told you, no. Next one was what is that? Without giving I waived off. Basically, I agreed. I did not want to take advantage. The next one was I made a partial payment, or I told you to come back in the future. I agreed to make the payment. So there are exceptions for payment. So in certain cases, presentment is unnecessary. So you can write that point. Presentment is unnecessary. And you are expected to write that entire four rules.
Intentionally prevents the presentment of things.
Clear? Pakkana?
Sir, but here they have not given that he has intentionally prevented.
So that's why they are asking you. As the promissory note was not duly presented for payment, whether A would be discharged from liability. In certain cases, no, A is not discharged. What is that? If you are only saying, Kamda, I'll pay, well, you are not discharged. You are only stopping me, you are not discharged. You gave a place, you did not come, you are not discharged. Correct? Yes, sir? Okay, next one. Ashtana. So these are the RTP questions. So what I tell you guys is try to see as many questions as possible. That's very, very important. Questions tell you or it gives you a reality check. So try to see as many questions as possible. I believe if we combine our assignments in the class, question papers and this, so easily 100 plus questions are discussed in the class only. Try to do your part. Try to just open ICAI guideline answers. Try to just see the questions, as many questions as possible. Try to get the knack of writing. Now the answers are there in your head, but how to write? The main provision, I am asking for the word. In the exam, I won't be there to come and motivate you. Ade word. So it is your duty. Try to do that. And how is that? Practice will make you perfect. And that practice, try to stick on to it. Is clear? All of you? So, today's thing will end up because in another 15 minutes, another batch is going to start. So let's end up the session here. And yes, that's it for the marathon. Do best and give your best for the exams. All the very luck, all the very best for you guys. Do let me know what happens after the exam. Yes, whether it's good or bad, it's still okay. It's all about your attempt. Make sure you give a good attempt instead of worrying about the result. Be confident. You guys can clear. If not you, this course is meant for whom? So you guys can clear. Do not worry. You all will fly in colors. Okay. Yes, people. So thank you so much. See you all. I hope you guys learned something. Thank you so much. See you all. Bye-bye. Yes. See you.
All the best. Thank you. Bye-bye.